President Biden gets to make a nomination to the Supreme Court.
Judge Jackson deserves to be confirmed.
Judge Ketanji Brown Jackson would be the first female black justice.
I can only hope that my life and career will inspire future generations.
But confirmation is not assured.
I'm even-handedly applying the law in every case.
Ketanji Brown Jackson has a resume seemingly tailor-fit for the moment. Harvard grad, Supreme Court clerk, and a federal judge with a deep history in public service.
There is a direct line from my defender service to what I do on the bench.
D.C. born and Miami raised, Jackson stood out early, excelling in high school as class president and on the debate team. Even then, her goal was clear. She's quoted in her senior yearbook saying, "I want to go into law and eventually have a judicial appointment." Her teenage years were key to achieving that, as she put it in 2017.
It was my high school experience as a competitive speaker that taught me how to lean in despite the obstacles.
With honors degrees from Harvard and Harvard Law, Jackson scored 3 federal clerkships, including one under the justice she may now replace.
Justice Breyer plucked me from obscurity and gave me the opportunity of a lifetime.
And I will say she is adored among the Breyer clerk family.
She made a lasting impression, said fellow Breyer clerk and former acting U.S. Solicitor General Neil Katyal.
She's fearless, and also she's a real person. And sometimes that's not always true with Supreme Court justices who live in an elite, rarefied atmosphere. But she's a judge who's never forgotten the human side of judging.
She's seen that human side up close, with family on both sides of the justice system. Her brother working for the Baltimore Police Department, and her uncle serving a life sentence for a cocaine conviction.
Justice demands this result.
She worked to understand and improve the system as a public defender and as vice chair of the U.S. Sentencing Commission.
That is an unusual addition and I think a valuable perspective.
Margaret Russell is a constitutional law professor who says Jackson's criminal defense background sets her apart.
There are many former prosecutors who are already on the bench. But what's interesting about a public defender, and really quite rare on the court, it's been a couple of decades, is that focus on the indigent defendant, someone who is really lacking in opportunity, often despised, often overlooked.
On the Sentencing Commission, Jackson continued that work, fighting for more equitable drug penalties.
There is no federal sentencing provision that is more closely identified with unwarranted disparity and perceived systemic unfairness than the 100-to-1 crack powder penalty distinction.
That was the first of 3 Senate confirmations for Jackson. In 2012, she was nominated to the federal bench in Washington, D.C., introduced by then Congressman Paul Ryan, who's related to Jackson by marriage.
But my praise for Ketanji's intellect, for her character, for her integrity, it's unequivocal. She's an amazing person.
She earned a reputation on the district court for being thorough and methodical.
You can tell she has that speech and debate background because she likes to engage with the parties.
Sanchi Kare and Neha Sabrawal clerked for Jackson and say they were struck by her work ethic.
One thing that she would tell us when I was clerking for her is that, you can't always expect to be the smartest person in the room, but you can promise to be the hardest working. And she truly lives by that philosophy.
And by the warm welcome she extended.
And she came out of her office, huge smile, gave me a huge hug, and told me how excited she was that I would be working for her. And that sort of set the tone for the rest of my clerkship experience.
A memory that I had, that I still have of her, is this relay race in which several DC Circuit and DDC chambers participated. And at the judge's suggestion, we made matching t-shirts and set up a training schedule and lined up everyone in chambers to participate, because she just has so much spirit for everything that she does, and her diligence is really contagious.
It was there on the district court that Jackson sentenced more than 100 people and penned some of her best-known opinions. In 2017, she presided over the so-called Pizzagate conspiracy case, delivering a 4-year prison sentence for a man who fired his gun in a D.C. pizza shop, wrongly believing it was home to a child sex ring. And in 2019, she ordered that former Trump White House counsel Don McGahn comply with a congressional subpoena during the Russia investigation. Siding against the Trump administration, she plainly wrote, "Presidents are not kings."
One thing is clear. The 120-page ruling had a purpose.
It came up at her third Senate appearance, this one for the D.C. Court of Appeals, seen as a tryout for a Supreme Court hearing.
I am both humbled and very grateful to be here once again.
Republicans took aim at Jackson's public defender clients.
Have you ever represented a terrorist at Guantanamo Bay?
About 16 years ago when I was a federal public defender.
And her identity.
What role does race play, Judge Jackson, in the kind of judge that you have been and the kind of judge you will be?
I don't think that race plays a role in the kind of judge that I have been and that I would be.
Behind her at those hearings, her husband, Dr. Patrick Jackson, and one of their two daughters. The pair met in college and were, as she says, an unlikely match at first.
He and his twin brother are, in fact, sixth generation Harvard. By contrast, I am only the second generation in my family to go to any college, and I'm fairly certain that if you traced my family back past my grandparents, who were raised in Georgia, by the way, you would find that my ancestors were slaves on both sides.
The yeas are 53, the nays are 44. The nomination is confirmed.
She was ultimately confirmed with 53 votes, all 50 Democrats, plus Republican senators Susan Collins, Lisa Murkowski, and Lindsey Graham. That put Jackson, now 51 years old, in the seat formerly held by another Supreme Court hopeful.
Today I am nominating Chief Judge Merrick Brian Garland to join the Supreme Court.
Before then President Obama made that decision in 2016, Jackson's 11-year-old daughter wrote in with her own suggestion.
Dear Mr. President, while you are considering judges to fill Justice Scalia's seat on the Supreme Court, I would like to add my mother, Ketanji Brown Jackson of the District Court, to the list.
Her opinions are always carefully
6 years
reasoned,
later, it's President
tethered to
Biden
precedent,
honoring that request.
and demonstrate
For the
respect-
PBS NewsHour,
respect for how
I'm
the
Jeff
law
Bennett.
impacts-
It was an historic day on Capitol Hill as Supreme Court nominee Ketanji Brown Jackson stepped into the spotlight for the first of several days of confirmation hearings. John Yang reports on the round of opening statements.
This hearing of the Senate Judiciary Committee will come to order.
Federal Judge Ketanji Brown Jackson made the case for her nomination to become the first black woman on the Supreme Court.
I have been a judge for nearly a decade now, and I take that responsibility and my duty to be independent very seriously. I decide cases from a neutral posture. I evaluate the facts, and I interpret and apply the law to the facts of the case before me without fear or favor, consistent with my judicial oath. During this hearing, I hope that you will see how much I love our country and the Constitution and the rights that make us free.
Republicans on the panel signaled the questions ahead.
The bottom line here is when it is about philosophy, when it's somebody of color on our side, it's about we're all racist if we ask hard questions. It's not going to fly with us. We're used to it by now, at least I am. So it's not going to matter a bit to any of us. We're going to ask you what we think you need to be asked.
I'm a bit troubled by some of the positions you've taken and arguments that you've made, representing people who have committed terrorist acts against the United States and other dangerous criminals. I understand the importance of zealous advocacy, but it appears that sometimes this zealous advocacy has gone beyond the pale.
Will you follow the law? What does your record indicate? Will you protect the rights of every American citizen, regardless of race, regardless of party, regardless of views? That's what the focus of this hearing should be.
Republican Senator Josh Hawley of Missouri raised Jackson's sentencing decisions as a trial judge in child pornography cases.
And what concerns me, and I've been very candid about this, is that in every case, in each of these 7, Judge Jackson handed down a lenient sentence that was below what the federal guidelines recommended, and below what prosecutors requested.
Doing a lot of listening.
Committee Democrats defended her against criticisms.
As you've seen, we're likely to hear more than a few straw men today, worn talking points, imagined grievances, but this hearing really should be about you, not about us.
Judge Jackson is no judicial activist. She is not a puppet of the so-called radical left. She's been praised by Republican-appointed judges for her jurisprudence. Judge Jackson is not anti-law enforcement. She hails from a law enforcement family. She's also won the support of preeminent national law enforcement organizations, including the National Fraternal Order of Police. And no, she's not soft on crime. Her background as a federal public defender would bring an informed perspective of our criminal justice system to the Supreme Court.
You have the experience and record of a jurist who is dedicated to the fair application of the law, committed to consensus, and determined to make sure that the court and the Constitution work for the people of today.
The committee stands adjourned.
For the PBS NewsHour, I'm John Yang.
Good morning. I'm Nicole Ellis for the PBS NewsHour, and I'm joined by my colleague and national correspondent, John Yang. As we kick off our second day of coverage of the confirmation hearings of the Supreme Court confirmation hearings of Ketanji Brown Jackson. John, we just got a sense of some of the highlights of yesterday, but I'm curious to hear, what are the most notable moments that stood out to you from yesterday's opening remarks?
Well, I thought it was interesting that you sort of heard nothing was terribly unexpected. Nothing was sort of out of the ordinary. You heard the Republicans stress their view that the Supreme Court justice should interpret the Constitution based on what the words meant at the time the Constitution was written. The Democrats believe that you should sort of look at how those words affect people's lives now, today. And you also heard the Democrats stress the personal story of Judge Jackson, the historic nature of the fact that she'd be the first Black woman to sit on the court, the story of her parents, the child of parents who had gone to segregated schools in Florida, and then rose to become administrators in the Miami public schools. Her father, an attorney for the school board, her mother, a high school principal. I also thought it was notable, which you did not hear. You did not hear the Republicans talk about this as an affirmative action or a quota nomination, as they did when the nomination was first made. I don't know if that's a suggestion that politically they've discovered that argument, that opposing this nomination based on that is not something that plays well. For the most part, I think you also heard the Republicans voicing their objections or their concerns about Judge Jackson's record based on her record. You heard Senator Cornyn talk about her work as a public defender for some of the Guantanamo Bay defendants. You heard Senator Hawley talk about her sentencing decisions in some cases when she was a trial judge involving child pornography cases. The one exception to that, I thought, was Senator Blackburn of Tennessee, who listed a long list of the sort of conservative hot button issues these days, transgender athletes, parental rights, being soft on crime, without making specific connections to Judge Jackson's record. I also thought that it was interesting that she talked about her role as on the board of trustees at a private school here in Washington, D.C., and talked about that in terms of parental rights and described all sorts of programs at that school, regardless of whether she described them correctly or whether she was putting her own spin on them. It seemed to me to be a bit of a red herring, because it is, after all, a private school. It is the essence of parental rights and parental choice. They can send their children to that school or not. It's not public schools, which is what the big issues are along parental rights. So I think that they did signal, I think, the sorts of questions that she's going to face today.
You know, there's also a lot of interesting nuance in how Democrats and Republicans decided to approach yesterday, and they had noticeably different tones. Democrats reiterated Judge Jackson's qualifications, and Republicans really seemed to focus on, you know, their perception of preserving the court's integrity, and often brought up past confirmation hearings. What's the thinking behind that, and some of the things that you raised that Republicans, you know, sort of intended to draw attention to?
Well, ever since the confirmation hearing for Robert Bork in the 90s, who was defeated in the Senate, there's been this sort of every confirmation hearing, it seems, begins by having grievances about past confirmation hearings. I mean, last year, in 2020, when Judge Amy Coney Barrett had her confirmation hearings, the Democrats brought up what happened or what didn't happen to Merrick Garland. The fact that here they were dealing with a confirmation for a Supreme Court justice very late, very close to a presidential election, when the Republicans denied Merrick Garland a hearing in a presidential election year. And then yesterday, you heard a lot of talk about Brett Kavanaugh's hearing when there were allegations of sexual harassment and sexual misconduct brought up about him. But I think once each side gets those things out of the way in that first day, then I think they get down to business and get down to talking about the judge's record. And I think you are going to hear a lot about Judge Jackson's time as a public defender, which the Democrats see as a great asset. There are not a lot of public defenders and not a lot of defense attorneys on the federal judiciary at any level. The path to the federal judgeship tends to be corporate law or government law or prosecutors. So I think that the Republicans are going to try to use that as an attack point to try to portray her or try to describe her record as being soft on crime or liberal on crime, while the Democrats are going to try to say that this is a missing piece in the federal judiciary, that the federal judiciary needs more people who understand the law from that point of view.
As we look ahead at what we'll see today, it also sounds like she'll have an opportunity to provide context on some of those rulings, but also her history as a public defender and inform how both the public and senators and Congress see that. You know, Senator Dick Durbin called Monday's hearing the easiest day, with each senator speaking for about 10 minutes. But how will today be different from that?
Today's going to be different. She's going to face long questions, a long amount of time for questions from every senator. There will be, I think, at least 2 rounds today and tomorrow. Each senator will get two bites at the apple, as it were. I think it's going to be interesting to watch, because I think that these confirmation hearings, again, since Robert Bork, have become exercises in the nominee saying as little as possible. Saying as little of substance as possible, shying away from issues that may be before the court, maybe before them if they're confirmed. But I think it's also going to be very interesting, because I don't know that we've ever had a championship debater in the witness chair. I was struck as I listened to her opening statement, and I heard her that very precise enunciation that took me back to my high school speech class, that she knows how to use arguments and facts to marshal an argument. And I think that's going to be very interesting to see and to listen to. she's going to be asked about a lot of things. I mean, as she acknowledged in her opening statement, her decisions are long. Her written decisions that she has handed down when she was a trial judge, a district court judge, they're very detailed. She explains her reasonings very, very thoroughly. So that gives a lot of material for senators on both sides to use in their questions and to try to parse her judicial philosophy, to parse her record. People who if they watch today, they may feel that at the end of the day they should get some law school credit, because they're going to hear a lot of discussions about legal theories, about legal doctrines. They're going to hear cases referred to in shorthand. It's going to be some tough going. It may be tough going for viewers, but I think that the Amy Coney Barrett hearings, I thought, were very illuminating and very substantive in her legal thought. And I think it did, and also just in how the Supreme Court works and how sort of the competing theories and competing ways that justices view the law. So it's going to feel like a law school seminar today, but I think it'll be interesting.
As you mentioned, as a debater, that she's prepared to navigate these waters and this space. And as you said, she's written roughly 500 judicial opinions throughout her career, some of which will be scrutinized and be a point of not only conversation, but debate today and tomorrow. Which cases do you think stand out as points of confrontation as we look ahead?
Well, I think clearly her sentencing decisions in the child pornography cases are going to be things that Senator Hawley has already signaled that he wants to delve into, and I thought it was very interesting as he listed the cases and talked about them. She took out her pen and was making notes. So I'm sure that she tonight was going back and reviewing those cases and preparing what her answers for Senator Hawley. I also think that a couple of the circuit court, the appeals court decisions will be discussed. She wrote the opinion that said that Don McGahn, the White House counsel under President Trump, could not just exert executive privilege and refuse to show up before the House Judiciary Committee, that he had to show up. He could exert executive privilege there or take the fifth there. I think that'll be discussed. There'll be a number of things that I think that the Republicans will want to bring up in the more recent cases involving the Trump administration. And so I think that's you're going to hear a lot of discussion about the McGahn case in particular.
There's also that nuance of context when we look at these cases, and when we look at who is bringing them up and why. So I'm curious to hear, how do you expect Judge Jackson to handle that piece of things in the absence of context being provided elsewhere or by the people posing questions?
Well, I think she's going to provide the context. I don't think she's going to be shy about that. I think that she's well prepared. In the past, there have been sort of moot court sort of murder boards of sort of testing, of running through questions and potential questions and answers. And as I say, as a debater, as a high school debater, she's used to that. And I think that she's going to be well prepared and well armed. And I think she'll have, I think it'll be an interesting session because of that.
John, thank you so much for joining us. John Yang, national correspondent for the PBS NewsHour. To our viewers, thank you so much for tuning in, and you should stick around for continued live coverage of gavel-to-gavel live coverage of Judge Ketanji Brown Jackson's Supreme Court confirmation hearings. It's been a pleasure, and we'll see you. Stick around.
This program was made possible by the Corporation for Public Broadcasting and by contributions to your PBS station from viewers like you. Thank you.
Good morning and welcome to day 2 of our PBS NewsHour live special coverage of the Senate hearings on Judge Ketanji Brown Jackson's nomination to the U.S. Supreme Court. I'm Judy Woodruff. Yesterday, Jackson and Senate Judiciary Committee members gave their opening statements. Today, Jackson will field questions from the senators. Each senator will be allotted 30 minutes for the first round of questions, and we'll be turning to our correspondents and other analysts throughout the day. And joining me here in the studio is Marcia Coyle, Chief Washington Correspondent of the National Law Journal. Marcia, very good to see you, and I just want to point out that our correspondent Lisa Desjardins is already at the Capitol, standing by. John Yang watching these hearings. Lisa, I'm going to quickly come to you because we watched yesterday. We didn't hear any questions, but we heard each of the senators make a presentation, if you will, about what they're going to be looking for in these hearings. So we're starting to get a sense of what they want to know from this judge.
That's correct. From Republicans, we expect a couple of lines of questioning. One is about Judge Jackson's judicial philosophy. In past confirmation hearings, she said that she doesn't have any one philosophy. I think Republicans are going to try and build a case that perhaps she hasn't answered questions directly. They want to know more about her philosophy, but they will also try and ask her about if she's tough on crime. They will try and make that line of attack against her something Democrats say it could get out of bounds. They're watching that carefully, but Democrats also say they feel confident about her ability to answer those questions, looking at her very long record. I will say this is the most important day in Judge Jackson's long legal career, and for Democrats, a huge one. They haven't had a nominee for the Supreme Court from a president of their party in over 10 years.
That's right, they have not. We're seeing live pictures from the hearing room. We are waiting for Judge Jackson to enter and to take her place at that center table. John Yang, you've watched a number of these hearings. It seemed yesterday as if the specter of previous confirmation hearings was hanging over the room. We heard a number of Republican senators compare what they called the treatment of Justice Kavanaugh, going back before him, Judge Bork, who was never confirmed, and Clarence Thomas. That came up again and again from the Republican senators.
That's right. I think ever since the Robert Bork confirmation hearings, these have become sort of an opportunity to air grievances about previous hearings. But as Marcia noted during our coverage yesterday, once they get that out of the way, they tend to move on to business. Judge Amy Coney Barrett's hearing last in 2020, of course, had the grievances from the Democrats that Merrick Garland had been denied a hearing. That at a similar time, close to a presidential election. You heard the arguments about Brett Kavanaugh yesterday. I think today is going to be very interesting because I think that I don't know that we've ever had a championship debater like Judge Jackson in the witness chair like this. I think she knows how to marshal arguments and make a case. So I think she's going to be armed, she's going to be ready, and I think it's going to be an interesting day.
Really good point, John Yang. You're right. She was a champion debater. Marcia Coyle here with me in the studio. You and I were just talking about how the individuals who've been up for confirmation to the Supreme Court have had to parry these questions. They want to answer them, but they don't want to give up so much information that they are stepping over that line and indicating how they would judge in a particular case.
That's absolutely right, Judy. And certainly the current Chief Justice, when he was nominated to the Supreme Court, well before, when he was in the Reagan administration, he sort of wrote the guidelines for how to deal with this. He was shepherding Justice Sandra Day O'Connor through her confirmation hearing. And his advice to her was no specific responses to any questions or issues that could come before the Supreme Court, but do that while also showing a firm command of the law and the precedents and statutes that are relevant to the question. And I think they have followed that to a T.
How easy is that to do?
Well,
or hard.
Well, no one likes, in a sense, not to answer questions directly, but I think the pattern has been set since 1987, when Robert Bork was probably the last most forthcoming nominee, which I think played a role in his defeat.
Didn't turn out well.
Exactly. So I think they know how to do it, basically.
Lisa Desjardins, we're watching as the senators do find their way to their seats. We're still waiting for Judge Jackson to take her place. How, with so much going on in the world right now, Lisa, obviously we're all paying close attention to the war in Ukraine first and foremost. But how important is it for these senators as they have their 30 minutes and then their 20 minutes to ask questions? How seriously do they take this responsibility?
The honest answer is it depends on the senator. But on this committee, on the Judiciary Committee, they take these jobs very seriously, as does their staff. Each of these senators has their own staff just for this committee. And this is a nominee, I want to point out, who every member of this committee knows and has already had the opportunity to question less than a year ago when she appeared before them for her now current position on the appellate court. So this is something that a lot of these members of this committee can sink their teeth in. Judy, this committee is full of lawyers, so this is kind of their bailiwick, if you will. 15 out of the 22 members of this committee are attorneys. One of them, Josh Hawley of Missouri, is a former Supreme Court clerk. These are Supreme Court nerds, if you will. So they take this very seriously, but you will see a difference in some senators will use this to make remarks rather than questions. Other senators will use this as a political platform. Some senators will really delve into deeper constitutional issues. A senator like Mike Lee of Utah, for example, he loves pursuing philosophy of constitutional law. I think you will see kind of a more wonky, deep section from him. But other senators in this committee room, as we talked about yesterday, Judy, are interested in becoming president. And this is a time in the national spotlight that they may use not just to get answers to their questions, but to create a bigger platform for themselves.
You mentioned here we see Judge Jackson entering the courtroom with her husband. She's taking her seat there. She's in the red jacket. We assume they're going to get started right away. You mentioned Mike Lee. We heard a little of the Odyssey from him yesterday. There's the gavel. This is Senator Dick Durbin, the chairman of the Senate Judiciary Committee, and we go to him live.
Good morning, Judge Jackson. Welcome back to you and your family.
Good morning, Mr. Chairman.
This second day is known affectionately by a term of medieval justice known as the trial by ordeal. This will be your opportunity to speak, but each member of the committee has 30 minutes to ask. And I know that they're going to be careful to stay within time limits of those 30 minutes. I do want to remind my colleagues that history has proven that speeches don't have to be eternal to be immortal. President Lincoln learned at Gettysburg that 275 words were enough. So I hope my colleagues and friends will stick to the 30-minute guideline. I'll tap on the gavel if you're getting perilously close to extending beyond. We'll take a few breaks throughout the day. A number of them are scheduled, one for lunch, one for dinner, and several perhaps shorter ones in the meantime. If votes are called on the Senate floor, which is a possibility, we'll do our best to keep the hearing going as members go back and forth. And as I mentioned yesterday, we welcome all of our friends in the audience and ask that they be quiet and respectful during the hearing. So let's get started with the questioning, and I'll begin at this point. Judge Jackson, there are two issues that came up repeatedly yesterday from the other side of the aisle that I want to address at the outset. One of them was a question of judicial philosophy. No one questions either your academic law school credentials or your service as clerk and as federal judge, but time and again you have been asked, what is your judicial philosophy? Does it fit into Scalia's originalism, Kavanaugh's textualism? Is it strict construction? Is it liberal? Is it conservative? Lo and behold, I've discovered the answer. It turns out that during the course of your time as a judge, you have actually had written opinions 573 to be exact, I think. Maybe I'm off by one or two. And they more or less express your view of the law as the facts are presented to you in each one of those cases. And then some 12,000 pages from the Sentencing Commission, transcripts of deliberations on important issues. For most of us as elected senators, if people asked, what's your philosophy, we'd point to our voting record. You have a record when it comes to court decisions. And this committee, for the fourth time, is delving into everything that you've published as a judge and even before. So would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Yes, thank you, Mr. Chairman. Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority. I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane. And so what I do is I essentially follow 3 steps. The first step is when I get a case, I ensure that I am proceeding from a position of neutrality. This means that you get a case and it's about something and it's submitted by certain parties. I am clearing my mind of any preconceived notions about how the case might come out. I'm setting aside any personal views. It's very important that judges rule without fear or favor. The second step is once I've cleared the decks, so to speak, in this way, I am able to receive all of the appropriate inputs for the case. That is the parties' arguments. They've written briefs. Sometimes we have a hearing. Sometimes we hear from other parties, amici in a case. And then there's the factual record. I am evaluating all of the facts from various perspectives. I think my experience, all of the various experiences that I've had, really helps me at this stage to see the perspectives of all of the parties and to understand their arguments. And then the third step is the interpretation and application of the law to the facts in the case. And this is where I'm really observing the constraints on my judicial authority. There are many constraints in our system, importantly, because judges have limited authority. And so I am, first of all, looking at my jurisdiction. Threshold matter in every federal case is to make sure that you even have the power to hear the case. In evaluating jurisdiction, you're looking at all sorts of things. The text of a jurisdictional provision, for example, precedent related to it. If I can get to the merits of the case, if I have jurisdiction, then I am observing the limits on my authority concerning the question. So if it is a statute, for example, or a provision of the Constitution, I'm looking at the text. The adherence to text is a constraint on my authority. I'm trying to figure out what those words mean as they were intended by the people who wrote them. So at this point, I'm looking at original documents. I am focusing on the original public meaning because I'm constrained to interpret the text. Sometimes that's enough to resolve the issue in terms of the merits. Judges also look at history and practice at the time of the document was created. If it's a statute, I'm looking at Congress's purposes because, again, I am not importing my personal views or policy preferences. The entire exercise is about trying to understand what those who created this policy or this law intended. I'm also looking at precedent, which is another constraint on judicial authority. I am looking at prior cases and trying to understand what other judges have said. As a lower court judge, I'm bound by the precedent. And even in the Supreme Court, if I was fortunate enough to be confirmed, there's stare decisis, which is a binding kind of principle that the justices look at when they're considering precedents. So all of these things come into play in terms of my judicial philosophy.
Another issue which has come up to my surprise, and I've spoken to my Republican colleagues about their fascination with it, is the notion of the composition of the Supreme Court, which euphemistically is referred to as court packing. I have said on the floor, and I will repeat here, there is exactly one living senator who has effectively changed the size of the Supreme Court. That was the Republican leader, Senator McConnell, who shrank the court to 8 seats for nearly a year in 2016 when he blocked President Obama's nomination of Merrick Garland. Now, that question on court packing was posed to Amy Coney Barrett, Justice in the court, when she appeared before this committee. She was asked about it. She said, and I quote, "could not opine on it." And on many other policy issues, then Judge Barrett said repeatedly she could not share her views, stating, and I quote, "I will not express a view on a matter of public policy, especially one that is politically controversial, because that is inconsistent with the judicial role." I do believe we should have rules and traditions and precedents, but we shouldn't have a separate set of rules for Republican nominees and Democratic nominees. So Judge Jackson, if a senator were to ask you today about proposals about changing the current size of the Supreme Court, what would your response be?
Senator, I agree with Justice Barrett in her response to that question when she was asked before this committee. Again, my North Star is the consideration of the proper role of a judge in our constitutional scheme. And in my view, judges should not be speaking to political issues, and certainly not a nominee for a position on the Supreme Court. So I agree with Justice Barrett.
Let me address another issue that came up yesterday in the opening phase of this nomination hearing. And it's the issue involving child pornography. I want to turn to that issue because it was raised multiple times, primarily by the senator from Missouri. And he was questioning your sentencing record in child pornography cases that do not involve the production of pornographic material. They're known as non-production cases. I wanted to put some context here. The senator from Missouri has, in his tweets, said of your position on this issue, Judge Jackson has a pattern of letting child porn offenders off the hook for their appalling crimes, both as a judge and a policymaker. She's been advocating it since law school. This goes beyond soft on crime, the senator said. I'm concerned this is a record that endangers our children. I thought about his charges as I watched you and your family listening carefully yesterday, and what impact it might have had on you personally to know that your daughters, husband, parents, family, and friends were hearing the charges that your implementation of this law, sentencing, endangered children. Could you tell us what was going through your mind at that point?
Thank you, Senator. As a mother and a judge who has had to deal with these cases, I was thinking that nothing could be further from the truth. These are some of the most difficult cases that a judge has to deal with because we're talking about pictures of sex abuse of children. We're talking about graphic descriptions that judges have to read and consider when they decide how to sentence in these cases. And there's a statute that tells judges what they're supposed to do. Congress has decided what it is that a judge has to do in this and any other case when they sentence. And that statute That statute doesn't say look only at the guidelines and stop. The statute doesn't say impose the highest possible penalty for this sickening and egregious crime. The statute says calculate the guidelines, but also look at various aspects of this offense and impose a sentence that is, quote, sufficient but not greater than necessary to promote the purposes of punishment. And in every case, when I am dealing with something like this, it is important to me to make sure that the children's perspective, the children's voices are represented in my sentencings. And what that means is that for every defendant who comes before me and who suggests, as they often do, that they're just a looker, that these crimes don't really matter, they've collected these things on the internet and it's fine, I tell them about the victim statements that have come in to me as a judge. I tell them about the adults who were former child sex abuse victims who tell me that they will never have a normal adult relationship because of this abuse. I tell them about the ones who say, I went into prostitution, I fell into drugs because I was trying to suppress the hurt that was done to me as an infant. And the one that was the most telling to me, that I describe at almost every one of these sentencings when I look in the eyes of a defendant who is weeping because I'm giving him a significant sentence. What I say to him is, do you know that there is someone who has written to me and who has told me that she has developed agoraphobia? She cannot leave her house because she thinks that everyone she meets will have seen her pictures on the internet. They're out there forever. At the most vulnerable time of her life, and so she's paralyzed. I tell that story to every child porn defendant as a part of my sentencings so that they understand what they have done. I say to them that there's only a market for this kind of material because there are lookers, that you are contributing to child sex abuse, and then I impose a significant sentence and all of the additional restraints that are available in the law. These people are looking at 20, 30, 40 years of supervision. They can't use their computers in a normal way for decades. I am imposing all of those constraints because I understand how significant, how damaging, how horrible this crime is.
It should be noticed as well that the cases which the senator from Missouri referred to yesterday all resulted in incarceration of some magnitude. In the one case, the Hilly case, I want to quote what you said on the record. This family has been torn apart, speaking to the defendant, by your criminal actions. You saw it on the faces of those women, you heard it in their voices, and the impact of your acts on those very real victims who are still struggling to recover this day makes your crime among the most serious criminal offense this court has ever sentenced. And you imposed a sentence of 29 and a half years on that defendant. So the notion that you look at this casually or with leniency, as the senator has said, your record belies that. And in fact, what we're dealing with here is an issue which even this committee and members on the committee have been loath to address again. The original law was written at least 9 or 10, maybe longer, years ago, and the quantity of material was relevant to the sentencing. And now that we have computer access to voluminous amounts of material, it has raised questions, has it not, within the judiciary as to the appropriate sentencing in today's circumstances. This was a question that was raised before the Sentencing Commission, was it not?
It was, Senator. The Sentencing Commission has written at least one report, it did when I was there, looking at the operation of this guideline. As you said, the guideline was based originally on a statutory scheme and on directives, specific directives by Congress at a time in which more serious child pornography offenders were identified based on the volume, based on the number of photographs that they received in the mail. And that made total sense before, when we didn't have the internet, when we didn't have distribution. But the way that the guideline is now structured, based on that set of circumstances, is leading to extreme disparities in the system because it's so easy for people to get volumes of this kind of material now by computers. So it's not doing the work of differentiating who is a more serious offender in the way that it used to. So the commission has taken that into account, and perhaps even more importantly, courts are adjusting their sentences in order to account for the changed circumstances. But it says nothing about the court's view of the seriousness of this offense.
Judge, there have been several news organizations that have taken a look at the senator from Missouri's charges, ABC News, CNN News, The Washington Post, and others, and have concluded that they are inaccurate and unfair to you in their conclusions. In fact, one writer has said they are meritless to the point of unacceptable levels. Nationally, in 2019, only 30% of non-production child pornography offenders received a sentence within the guidelines range, fewer than 30%. Between 2015 and 2020, in the D.C. District Court where you served, judges imposed below-guideline sentences in non-production cases 80% of the time for the reasons you've just explained. Judges in Missouri, the home state of the senator who has criticized your record, did so 77% of the time. One particular judge whom the senator supported to become a federal judge by appointment of President Trump, unfortunately, has 77% record. If I'm sorry, I'm going to make sure that this is accurate. Here it is. In the United States versus Klotz, Trump appointed Judge Sarah Pitlick, the senator's choice for the Eastern District of Missouri, sentenced an individual convicted of possession of child pornography to 60 months, well below the 135 to 168 month sentence recommended by the guidelines. She appears to have run into the same issue or same challenge that you have described here. So going forward, in terms of this issue, it seems that we at least share the burden by your interpretation as to define this statute in modern terms, in terms of technology as it exists today. Is that the way you see it?
Senator, Congress is tasked with the responsibility of setting penalties. Congress tells judges what we're supposed to do when we sentence. And what I'd say is that Congress has to determine how it wishes for judges to handle these cases. But as it currently stands, the way that the law is written, the way that Congress has directed the Sentencing Commission appears to be not consistent with how these crimes are committed. And therefore, there's extreme disparity, as you pointed out. There are judges who are varying because our ultimate charge from this body is to sentence in a way that is sufficient but not greater than necessary to promote the purposes of punishment.
Judge Jackson, we've heard criticism from some about your previous work representing detainees at Guantanamo Bay. In fact, for years, we've heard criticisms leveled against lawyers who have provided Guantanamo detainees with legal representation. This criticism misses one critical point. The right to counsel is a fundamental part of our constitutional sentence system, even for the most unpopular defendants. I want to thank Senator Graham, who served as an Air Force lawyer for decades, for offering his perspective yesterday. He said, and I quote, "The fact that you're representing Gitmo detainees is not a problem with me," Senator Graham said. "Everyone deserves a lawyer. You're doing the country a great service when you defend the most unpopular people." And then Judge Roberts said during his confirmation hearing, it's a tradition of the American bar that goes back before the founding of the country that lawyers are not identified with the positions of their clients. The most famous example probably was John Adams, Chief Justice said, who represented the British soldiers charged in the Boston Massacre. This sentiment is shared by lawyers across the political spectrum. I want to give you an opportunity to address this issue because it applies not just to Gitmo detainees, but to your work as a public defender in terms of the wisdom, if not acceptability, of providing counsel in those cases, and what impact it's had on you personally in terms of your rulings on the bench.
Thank you, Senator. September 11th was a tragic attack on this country. We all lived through it. We saw what happened, and there were many defenses, important defenses, that Americans undertook. There were Americans whose service came in the form of military action. My brother was one of those Americans, those brave Americans who decided to join the military to defend our country. There are others of you in this body who have military service, and I honor that, to protect our country. After 9/11, there were also lawyers who recognized that our nation's values were under attack, that we couldn't let the terrorists win by changing who we were fundamentally. And what that meant was that the people who were being accused by our government of having engaged in actions related to this under our constitutional scheme were entitled to representation. We're entitled to be treated fairly. That's what makes our system the best in the world. That's what makes us exemplary. I was in the Federal Public Defender's Office when the Supreme Court, right after the Supreme Court decided that individuals who were detained at Guantanamo Bay by the president could seek review of their detention. And those cases started coming in, and federal public defenders don't get to pick their clients. They have to represent whoever comes in, and it's a service. That's what you do as a federal public defender. You are standing up for the constitutional value of representation. And so I represented, as an appellate defender, some of those detainees. In the early days, the legal landscape was very uncertain. This had never happened before, not only the attack, but also the use of executive authority to detain people in this way. And there were a lot of questions that the court was asking. The Supreme Court had taken a series of cases to try to understand what are the limits of executive authority, which is important. All of our liberty is at stake if we don't get it right in terms of what the executive can do. The Supreme Court has recently reaffirmed that the Constitution does not get suspended in times of emergency. And so lawyers were trying to help the court to figure out what the executive's power was in this circumstance. And as an appellate defender, I worked on the habeas petitions of some of these detainees. My petitions were virtually identical because we had very little information. Part of the issue at the very beginning of these cases was that most of the factual information was classified. So defense counsel were appointed to represent these defendants. We had no facts, and I was making legal arguments about the circumstances. That is what gave rise to my representation, and I would just emphasize that that's the role of a criminal defense lawyer. Criminal defense lawyers make arguments on behalf of their clients in defense of the Constitution and in service of the court.
Judge Jackson, those of us who read about the workings of the Supreme Court realize it's a close relationship among the justices. You've seen it personally as a clerk and as an attorney yourself. I'm going to close with one question here that comes to my mind. I was in the House of Representatives when the war on drug measure was passed 30 years ago or so. It was at the advent of crack cocaine. It scared the hell out of us. The notion of a cheap narcotic, highly addictive, destructive to mothers and their fetus, led us to impose a sentencing disparity between crack and powder cocaine that was unprecedented, 100 to 1. Our notion was to come down hard, make it clear that it was a federal standard, impose that standard, and stop the advance of crack cocaine. We failed from the outset. The price of cocaine, crack cocaine on the street went down and up instead of down. I'm sorry, I did that wrong, down instead of up. And the number of users went up instead of down. And we found ourselves in a position where we were filling the federal prisons with violations primarily for possession of crack cocaine, hundreds of thousands being incarcerated at that time. I came here to this committee in an effort to try to change it, negotiated a revision of that measure from 100 to 1 to 18 to 1 with Senator Jeff Sessions. It was passed by the committee, by the Senate, and by the House of Representatives and signed into law by President Obama. Then you on the Sentencing Commission had to consider what to do with these new guidelines coming from Congress. And you achieved a consensus. I think most people don't realize the Sentencing Commission is a pretty diverse group and very transparent. Could you close in the last minute or so and tell me about that effort to find consensus on an issue that controversial?
Yes, Senator. As you mentioned, the Sentencing Commission is a very diverse group of people who've been appointed by presidents of different parties by law. And at the time that I was on the commission, we had a range of people, judges from different backgrounds, who had different views about the criminal justice system, but we had a directive from Congress insofar as Congress had changed the penalties, as you mentioned, related to crack cocaine. And so we worked together to make a determination about whether or not the guidelines needed to change, and if so, whether or not to impose those changes retroactively in light of all of the evidence that you point out, all of the Congress's changes, and the need to avoid unwarranted sentencing disparities, which is exactly the charge that this body has given to the commission. And we worked together. We reached unanimous agreement that the change in the guidelines that was necessitated by the change in the statute should apply retroactively to people who had been convicted and sentenced under the prior regime, and then Congress followed shortly thereafter by making it a statutory change to apply those changes retroactively.
Thank you, Judge Jackson. Senator Grassley.
Thank you, Mr. Chairman. Welcome again to our committee. I got home last night about 8 o'clock. The first thing I heard was my wife's opinion that you did very good in your opening statement.
Thank you.
She didn't have anything to say about my statement. Also, besides the fact that we might have some votes on the United States Senate, just so you know I'm not being rude to you, I may have to go across the hall to Finance Committee on some issues with tariffs and down to the Agriculture Committee for some issues on rural health care. Do you believe, well, let me ask it this way. Do the First Amendment free speech protections apply equally to conservative and liberal protesters?
Yes, Senator.
Okay. Do you believe the individual right to keep and bear arms is a fundamental right?
Senator, the Supreme Court has established that the individual right to keep and bear arms is a fundamental right.
Could you tell me how you might go about deciding what a fundamental right is under the Constitution?
Well, Senator, I don't know that I can tell you that in the abstract in the sort of way that you may have posed the question. There is precedent in the Supreme Court related to various rights that the court has recognized as fundamental. The court has some precedents about the standards for determining whether or not something is fundamental. The court has said that the 14th Amendment substantive due process clause does support some fundamental rights, but only things that are implicit in the ordered concept of liberty or deeply rooted in the history and traditions of this country. They're the kinds of rights that relate to personal, individual autonomy. And they've recognized a few things in that category. And that's the tradition of the court for determining whether something is fundamental in that way.
Okay. On another subject, kind of personal to me over a long period of time and about half of this committee, but it's a controversial issue even within this committee. I favor allowing Supreme Court hearings to be televised. What's your view on this? How would you feel about cameras in the courtroom, which about 40 or 45 of our states allow?
Well, Senator, I would want to discuss with the other justices their views and understand all of the various potential issues related to cameras in the courtroom before I took a position on it.
I think that's a fair answer at this point. I'm going to ask you about a bill that I got passed a long, long time ago. And it's something that at some level of courts, sometime the district court, sometime at the circuit court, and even once or twice at the Supreme Court, these courts tend to do damage to a bill called the False Claims Act. This bill has brought $70 billion of fraudulently taken money back into the federal treasury since it's been passed. And courts have weakened it, and then Senator Leahy and I usually find ourselves having to pass legislation to say to the courts, you got it wrong. In fact, there's a very controversial bill right now before the United States Senate on that very subject. It's fought fraud in the Department of Defense, healthcare industry, the pharmaceutical industry. $70 billion is pretty important. So when you if you're approved to be on the Supreme Court and the issue of false claims comes up, I hope you think of Chuck Grassley. It's one of the, and Leahy. Okay. The False Claims Act is one of the best tools that we have to fight against government fraud and to recover taxpayers' money. I've worked for decades to protect whistleblowers who shine a light on fraud, waste, and abuse in the government. So I'd like to ask you a couple questions. And I'm going to start with a former Attorney General, unnamed, once suggested that qui tam's suits were, in his words, patently unconstitutional, and another word he used was dangerous. He argued that it violated the Appointments Clause. So, understanding that you may get a case before you on the False Claims Act, but maybe this Appointment Clause is sound enough, you could answer, do qui tam suits violate the Appointments Clause?
So, Senator, I am not familiar with that
Could you answer,
representation.
Could you answer in writing then?
Well, I'd be happy to do whatever. I'm just trying to assess.
I'm sorry, I shouldn't have interrupted you.
No, that's all right. Sorry. I am trying to, I'm not familiar with the quotation or what the attorney may have said about them. I know that the Supreme Court has considered various qui tam actions and has issued opinions in the area and has not, at least to date, found them to be unconstitutional. But I don't know if that issue has been squarely presented to the court, and I would be loath to comment on it, just because if it's being litigated, it's something I wouldn't be able to address.
Let me, on the same subject, also, this former Attorney General also argued that qui tam suits also violate a broader separation of power principles. Can you tell me whether you think the president's constitutional powers are violated when private citizens are allowed to sue in the name of the United States, and that's what qui tam suits are all about, private citizens going to court?
Well, Senator, it is an important concern. There are statutes that do allow for the kinds of lawsuits that you are articulating. I am not aware of impediments to those, but again, this is the kind of thing that may be litigated, and I would have to look, as I do, consistent with my methodology, at any arguments that are raised about the constitutionality or lawfulness of those actions.
Remember, in about all of these suits that involve the courts in making interpretations of the False Claims Act, most of them are brought by whistleblowers. And remember, the government would not even know about these fraudulent use of taxpayers without whistleblowers coming forth. And they ought to be given some credit for wanting the government to do what the laws say it ought to do and spend the money the way that the Constitution or that the Congress implies that that money be spent. I want to move on. At an event at the University of Chicago School of Law in 2020, you quoted Martin Luther King Jr., who dreamt of a time when, quote, the sons of former slaves and the sons of former slave owners would be able to sit down together at the table of brotherhood, end of quote. You talked about how quickly things in the country then changed, including the civil rights laws, over the next few years because of the civil rights movement. You added that, quote, less than a decade after Dr. King's words, that was the world that you inhabited. Dr. King hoped for a country where we would all be judged by the content of our character rather than our race. Do these quotes still reflect your views on this very important topic today?
Yes, Senator. In that speech, I talked about my background, my upbringing, the fact that my parents, when they were growing up in Miami, Florida, attended and had to attend racially segregated schools because by law, when they were young, white children and black children were not allowed to go to school together. And my reality, when I was born in 1970 and went to school in Miami, Florida, was completely different. I went to a diverse public junior high school, elementary school. And the fact that we had come that far was, to me, a testament to the hope and the promise of this country, the greatness of America, that in one generation, we could go from racially segregated schools in Florida to have me sitting here as the first Floridian ever to be nominated to the Supreme Court of the United States. So yes, Senator, that is my belief.
And I think that it's good that the country had an opportunity to hear what you just told us about your experience. I'm going to go to something that the chairman brought up, and I've written down the three steps you go through. No, another question, but also one that he brought up on court packing and your opinion. I heard what you said, and you said it should be a policy question, but I want to go to something in 2013 during your hearing to be a district court judge. Senator Coburn asked you whether you believed in the theory that the Constitution is a living document whose meaning evolves over time. You said no. In 2021, however, during your circuit court nomination hearing, you declined to answer the same question when asked why the answer to your question of 2013 and not in 2021. In written questions, you noted that you weren't a sitting judge. So please explain to me or describe for us the difference between ethical rules for sitting judges versus judicial nominees who are not already judges.
Senator, I don't know that there are ethical rules that are different. What I'll say is, with respect to my approach to judging, there is not a label, I think, that fits what it is that I do and how I've approached my role. As I mentioned to the chairman, I'm very acutely aware of the limitations on the exercise of my judicial power. And those limitations come in the form of adherence to the text. Assuming you even get to that stage of the process, that you have subject matter jurisdiction, you can reach the merits, then you are looking at the text, and I do not believe that there is a living Constitution in the sense that it's changing and it's infused with my own policy perspective or the policy perspective of the day. Instead, the Supreme Court has made clear that when you're interpreting the Constitution, you're looking at the text at the time of the founding and what the meaning was then as a constraint on my own authority. And so I apply that constraint. I look at the text to determine what it meant to those who drafted it.
On this same subject, I want to point out a difference between you and a couple people that have sat on the Supreme Court. Justice Breyer said that a structural alteration of the Supreme Court motivated by a perception of political influence can only feed the perception of political influence, that's my parenthetical, further eroding that trust. Justice Ginsburg also cited court packing as being, quote unquote, a bad idea. Court packing is creating new seats for political purposes for a president to appoint more judges. Do you agree with Justice Breyer and Justice Ginsburg that court packing is a bad idea? Before you respond, I'd like to say that you say this question should be left to Congress as a policy issue. I'd reiterate that sitting Supreme Court justices have spoken on that matter, so I don't think it'd be inappropriate for you to do if other people sitting there have said that it's a bad idea.
Well, respectfully, Senator, other nominees to the Supreme Court have responded as I will, which is that it is a policy question for Congress. And I am particularly mindful of not speaking to policy issues because I am so committed to staying in my lane of the system, because I'm just not willing to speak to issues that are properly in the province of this body.
Okay. Then I would interpret your answer, and you don't have to respond to this, but I think you're saying Breyer and Ginsburg should not have stated their views on that issue. During his opening statement yesterday, one member of this committee suggested that the Supreme Court has been bought by dark money groups. Do you agree that the Supreme Court has been bought by dark money groups?
Senator, I don't have any reason to believe that that's the case. I have only the highest esteem for the members of the Supreme Court, whom I hope to be able to join if I'm confirmed, and for all of the members of the judiciary.
Thank you for that answer. I'm going to go to international law. During an ABA panel on international law last year, Justice Breyer said that as a federal judge, quote, "You can't do your job properly," end of quote, without considering international law and, quote again, in some cases, and it's a growing number, end of quote, and I assume a growing number of opportunities to use international law. In 2018 op-ed, Justice Breyer said that, quote, "The best way to preserve American values may well be to take account of what happens abroad," end of quote. Under what circumstances is it appropriate to consider international law when interpreting our Constitution?
Thank you, Senator. I have nothing but the highest esteem and respect for my former boss, who I've spent the better part of the past couple decades calling my justice, having clerked for him. But I do think that the use of international law is very limited in our scheme and in our judging. There are certain cases in which it is relied upon where Congress directs or where the standards are such. The case involves a treaty, for example, and you have to interpret international law in order to be able to address it. But there are very, very few cases, I think, in which international law plays any role, and certainly not in interpreting the Constitution.
I think you probably have answered my next two questions, but if you say you have nothing to add, I would still want to ask the questions. Do you think it's appropriate to look to international law when interpreting enumerated and unenumerated constitutional rights?
No, Senator.
Which specific, again, I think you've answered this, but I want to ask it anyway. Which specific constitutional clauses or rights has the Supreme Court held that can be interpreted by looking to international law?
I'm not aware of any that are properly illuminated by reference to international law.
Yeah. Now I want to go to a question that Senator Durbin asked. I'll probably go a little more, but I remember when this is about your judicial philosophy, and you made 3 points, 3 steps you take to go through a case and apply the law, and you say your methodology is limited power and stay within your lane. I'd like to ask you, well, you've served on the district court for several years and spent 8 months on the DC circuit. During yesterday's opening statement, we heard a lot about the importance of judicial philosophy. In your own words, you've described that, so you don't have to go through that again with me. But if Congress writes a law that does not explicitly allow private parties to sue, do you believe that the federal courts have the authority to create implied causes of action? And I'd like to have you elaborate if you say yes to that.
I would say that as a general matter, no, Senator. I mean, our obligation as judges is not to create policy. And if Congress has enacted a statute that establishes a cause of action or restricts causes of action, then as a general matter, I don't think that courts can impose one. Now, you know, I'm saying generally because there may be circumstances that I'm not thinking of. I know that the Supreme Court has, in very narrow circumstances at times, discussed implied causes of action. But I think the charge of the judge is to impose the law as written.
There's 115 justices that serve before you if you are approved by the Senate. Is there any of them now or in the past that has a judicial philosophy that most closely resembles your own?
You know, I haven't studied the judicial philosophies of all of the prior justices. I will say that I come to this position, to this moment, as a judge who comes from practice, that I was a trial judge, and my methodology has developed in that context. I don't know how many other justices, other than Justice Sotomayor, have that same perspective, but it informs me with respect to what I understand to be my proper judicial role.
What aspect of your record as a judge do you believe have been the most important for the good of the country?
Well, I think that all of my record is important to some degree because I think it clearly demonstrates that I'm an independent jurist, that I am ruling in every case consistent with the methodology that I've described, that I'm impartial. I don't think that anyone can look at my record and say that it is pointing in one direction or another, that it is supporting one viewpoint or another. I am doing the work and have done the work for the past 10 years that judges do to rule impartially and to stay within the boundaries of our proper judicial role.
Let's go to immigration. Congress gave the Attorney General, quote, unquote, sole and unreviewable discretion to decide whether expedited removal would apply to, quote, an alien who has not been paroled or admitted to the United States. You decided a case called Make the Road, New York, where you seem to agree that Congress gave the Department of Homeland Security sole and unreviewable discretion to decide which illegal immigrants would be subject to expedited removal. But you still went on to review the department's decision. In fact, you issued a nationwide injunction blocking Department of Homeland Security from removing illegal immigrants who had been in the country for less than 2 years. In that hearing, you told us that if the text was clear, that ended the question. The law specifically says that Homeland Security, not the courts, was responsible for making the decision. Could you please explain why you believed a federal court could review something Congress called unreviewable?
Thank you, Senator, for allowing me to address that opinion and my analysis. with respect to it. As you said, Make the Road was a case involving a challenge to expedited removal, which was a way in which Congress had given the authority to to the Department of Homeland Security to make a decision about how to deport people who are non-citizens. Prior to the challenge that I heard, the Department of Homeland Security, since it received that authority several decades ago, had decided that people who are in this country for up to 14 days and are found within 100 miles of the border are subject to expedited removal. The challenge that I heard involved the department's sudden shift to a determination that expedited removal would be applied to anyone who was found anywhere in the country and who had been here up to 2 years. Importantly, the challenge was not about the actual determination. The challenge was about the procedures that the agency undertook to make that determination. And so the statute said, as you rightly pointed out, that the agency had sole and unreviewable discretion to decide. And in interpreting that, I took into account the language of that statute and the language of another statute that Congress has enacted to direct agencies with respect to the manner in which they exercise their discretion. So I said, and I believed, that sole meant that the Department of Homeland Security was the only agency who got to make this determination as to how many months a person should be in the United States. And unreviewable meant it was final. Once the agency decided, then there was no ability to review substantively their determination. And I should say that, importantly, the statute that Congress enacted gave the agency the discretion to make this determination between 0 and 24 months. There is a limit in the statute. It says Department of Homeland Security, you get to decide where between 0 and 24 months a person who's been in this country can be subject to expedited removal. So I read the statute. DHS gets the sole ability to make that decision. DHS makes that decision and it's final. What wasn't clear to me based on that language was whether Congress intended to preclude its procedural requirements for the exercise of agency discretion. And in the DC Circuit, there was precedent that indicated that even when Congress gives a great deal of discretion to an agency, procedural requirements may still apply. It is presumptive that the APA applies, meaning that an agency can't act arbitrarily and capriciously when it undertakes to exercise discretion. It has to do certain things in order to make the determination that Congress has given it. I looked at those statutes. Oh, I'm sorry.
No.
I looked at those statutes and I considered the canons of construction that say that statutes should be read harmoniously, that as a court you're supposed to understand that Congress has directed, sometimes in more than one statute, what is supposed to happen. And so I read them together to mean that the court could still do what it almost always does in a case involving a challenge to the manner in which an agency makes its decision. And in fact, I thought, as I say in my opinion, that Congress intended for the APA to imply because it had not excluded it, which it had done expressly in other parts of the INA. It had not excluded it here. And it made sense to require the agency to use its expertise. If Congress wanted the agency to act arbitrarily in picking a number, Congress could have done that. Congress said you can do it up to 24 months. It could have randomly picked a number. But it was giving it to the agency, I thought, and reasoned, precisely because it wanted the agency to use its expertise, to do its research, and to figure out what amount of time is sufficient. And so it was important, I thought, to lay that out in the statute, and I determined that both of those statutory directives of Congress should apply.
Thank you, Senator Grassley. Senator Leahy.
Thank you, Chair Durbin. Judge, congratulations again on your nomination to our nation's highest court. You're an impressive jurist. I hope the broader public sees that, and I've enjoyed the opportunity to meet your family here yesterday. And I thought before I begin my questions, I was going to respond to something the junior senator from Texas said yesterday. He suggested the Democrats exacted a political agenda by opposing the nomination of then Judge Gorsuch to the Supreme Court. I kind of chuckle at that because, along with others, I and others repeatedly and clearly stated substantive concerns with Justice Gorsuch's nomination. I explained my votes on the record. There's no political agenda. I contrast that with Republicans' treatment of then Judge Merrick Garland. We're still waiting today for Republicans to explain on the record what kind of substantive concerns they had with Merrick Garland, that they blocked him for over a year and would not even allow a vote on his nomination. Apparently, because of a politically driven agenda. All I'm saying is let's make history this week, but let's not rewrite it. This is a historical time. Judge Jackson, one of the topics we discussed in our meeting was our respective experiences. You as a former federal public defender, myself as a prosecutor. As a federal public defender here in Washington, you were assigned to and then represented clients who couldn't otherwise afford a lawyer. One of the valuable lessons I learned as a prosecutor was this: for our criminal justice system to function properly, you have to have skilled, dedicated lawyers on both sides of the issue, both the prosecutor and the defense attorney. It's equally essential for judges to have a nuanced and a balanced understanding of our criminal justice system if we're going to have justice done. Now, it's really concerning, it's confusing that some view your background as a federal public defender as some kind of a liability. Those of us who have spent time in courtrooms know you have to have both the skilled prosecutor and a skilled defender. I believe it, in fact, I don't think of it as a liability. I think it's going to be a major asset to you. And I think it should be welcome on the Supreme Court. In fact, if you're confirmed to the court, as I look back over, you're going to be the first former federal public defender on the court. You're going to be the first nominee since Justice Thurgood Marshall with a significant background in criminal defense. That's pretty impressive. So, all of us should want that represented in the Supreme Court, because decisions on the Supreme Court can have a lasting impact on our criminal justice system. My question is this: I believe that your experience as a federal public defender has made you a better judge, helped you maintain impartial and balanced perspective in criminal and other cases, and I assume you would agree with that.
Yes, Senator. I think that experience in the criminal justice system, whether, as you say, on the prosecution side or the defense side, having actual experience is an asset as a judge. You understand the way the system works, and as a defense counsel, you have interacted with defendants in a way that, as a judge, at least as a trial judge, I thought was very beneficial. One of those ways is it helped me to develop a sense of the need to communicate directly with defendants. And, you know, it didn't change, I think, in any way the outcomes of the cases when I was a trial judge, but I understood from my time as an appellate defender that a lot of defendants go through the system and don't really understand it. And the problem with that, from our society's standpoint, is that when people go through the criminal justice system and don't have a good understanding, they tend to not take responsibility for their own actions. They tend to be bitter and feel as though the justice system has wronged them, and so while they're doing their time, rather than reflecting on the fact that this is the consequence that they have to face for actually committing a crime, instead of doing the work to rehabilitate themselves, they're, you know, focusing on how wronged they are, how victimized they feel. And so what I decided as a trial judge was that I was going to make sure that everyone who was in my courtroom, and especially the defendant, understood all of the procedures that we were going through, all of the steps. I spoke directly to them. I asked them, do you understand what's happening? Because I wanted them to know. And then, even perhaps more importantly, as I said about my child pornography cases, I focused on the harms of the behavior that was at issue. When I sentenced a defendant, I made clear in every case, here is the problem. This is what you've done. Here is the damage to our society. And I don't know that I would have done that if I had not been a criminal defense lawyer.
Well, and that's sort of what, you know, I was getting to, the fact that you have that experience. It's obvious you don't get, as a public defender, you don't get the right to, you don't get to choose your clients. It's not like you're going out there picking and choosing. You're told you're going to defend this person, but they're given that right under the Sixth Amendment. And we all, you're a member of the bar or judge or public defender, you take an oath to uphold the Constitution. And the Sixth Amendment's a pretty important part of it, wouldn't you say?
Absolutely, Senator.
And it's also a pretty important part for indigent defendants. Is that not correct?
That is correct, especially for indigent defendants, because they are determined to not be able to afford counsel. And as you said, Senator, for a judge, it is crucial that you have arguments that are being made and presented on both sides of the issue. That is what allows for judges to reach just results in cases, and it's what makes our system so exemplary.
It also guarantees that our Constitution is going to be followed. I think it's important you went around with Senator Doug Jones, who's highly respected in the Senate on both sides of the aisle, but you got to meet other senators. I was delighted you came to spend time in my office, and you noted in your public remarks at the White House when you were nominated that your parents were married for 54 years, and both public servants in their own right. They're proudly watching you being announced by the president, and I must admit, watching them the last couple of days, they're proudly watching you here, as have other members of your family. Your younger brother became a police officer detective in Baltimore before serving the Army, two tours of duty in the Middle East, two uncles that served as police officers. So I'm not really surprised that you understand law enforcement. The National Fraternal Order of Police has expressed strong support for your nomination. In fact, in their letter dated February 25th, 2022, they said you have considered the facts and applied the law consistently and fairly on a range of issues. And they went on to say there's little doubt that you have the temperament, intellect, legal experience, and family background to earn this appointment. And they added, we are reassured that should she be confirmed, she'd approach her future cases with an open mind, treat issues related to law enforcement fairly and justly. Chair Durbin, I'd ask consent that the letter from the Fraternal Order of Police be included in the record at this point.
Without objection.
Now, that's a statement from the largest law enforcement labor organization in the United States. What do you say to people who say you're soft on crime or even anti-law enforcement because you accepted your duties as a public defender?
Thank you, Senator. I would make, I'd make three observations in response to those critiques. The first is that as someone who has had family members on patrol and in the line of fire, I care deeply about public safety. I know what it's like to have loved ones who go off to protect and to serve, and the fear of not knowing whether or not they're going to come home again because of crime in the community. As you said, my brother patrolled the streets of Baltimore, and I had two uncles who were career law enforcement, including one who became the chief of police of the City of Miami Police Department in the 1990s. So crime and the effects on the community and the need for law enforcement, those are not abstract concepts or political slogans to me. The second observation that I would make is that as a lawyer and as a citizen, I care deeply about our Constitution and about the rights that make us free. As you say, criminal defense lawyers perform a service, and our system is exemplary throughout the world precisely because we ensure that people who are accused of crimes are treated fairly. It's very important to me in that capacity as a lawyer and as a citizen. I'm sorry. I was just going to say the third thing I would say is as a judge. As a judge, I care deeply about the rule of law. And I know that in order for us to have a functioning society, we have to have people being held accountable for committing crimes. But we have to do so fairly under our Constitution. As a judge who has to decide how to handle these cases, I know it's important to have arguments from both sides, to have competent counsel. And it doesn't mean that lawyers condone the behavior of their clients. They're making arguments on behalf of their clients in defense of the Constitution and in service of the court. And it is a service.
Now, I know in our conversation, I'd mentioned my own experience as a prosecutor. I wanted the best defense attorney on the other side because you want to make sure that as the trial went on, everything was done properly. And let's talk about Guantanamo Bay. It's been controversial, and we've had two presidents, one Republican, one Democratic, who said they wish it could be closed. But the fact is, individuals were detained there. The whole world was watching this. I know I heard from people I respect throughout the world asking questions about Guantanamo. And that's precisely the situation. We want our best and our brightest lawyers to step into the fray, however politically controversial. We have to make sure that we do not become unmoored from our core commitments to the rule of law, but that also, both in our own country and outside our country, people can see that we're following that. So you were in private practice when you took on these cases, uncharted legal waters, war. What principles drove you to get involved with cases in such a difficult time in Guantanamo Bay?
Well, thank you, Senator. And I do want to clarify, when I first started working on these cases, I was an assistant federal public defender. The Supreme Court in 2004 issued 2 opinions that began this group of cases and these issues. And this was in the wake of the tragic and terrible attack on this country in 9/11, and the executive's use of authority to detain enemy combatants at Guantanamo Bay. In 2004, the Supreme Court ruled that the executive did have the authority to make those detentions in one case, and then in another case, the Supreme Court ruled that anyone so detained could file a legal challenge. They had habeas rights, and as you know, habeas is in the Constitution. In 2005, I joined the Federal Public Defender's Office, and those cases started coming in. The requests from detainees asking for legal representation consistent with our constitutional scheme to have help to file their habeas petitions. This was very early in the days of these kinds of legal actions. There was a lot unknown about what these petitions could look like, what the arguments could be made and considered by the court, and perhaps most importantly, what the facts were related to any of these individuals, because almost everything was classified. So defense counsel was getting these people in with no information. I was in the appellate division of my office, and as an appellate defender, I worked on legal issues. I was paired with I was assigned by the federal public defender. I was an assistant federal public defender, and I was paired with a trial defender who attempted to do the fact gathering, who traveled to Guantanamo Bay. I never traveled there or anything like that. I worked on the law. And as you noted, the law was very uncertain. This was brand new. And people were trying to figure out what are the limits of executive authority in this context. We knew that the Constitution was not suspended, even though we had this emergency. So what did that mean with respect to these individuals? I filed as a federal public defender. I was assigned to work on 4 cases. And I filed almost identical petitions, because what you're doing, especially when you have no facts, is just preserving legal arguments for your clients. That is consistent with what lawyers do. And then you mentioned private practice. So I went into private practice in, I believe it was 2007. And by that time, lots of private practices around the country had started taking on these cases, because there were lots of people who needed representation, and so pro bono practices were receiving requests, usually through nonprofits. And one of the individuals that I had represented as a defender ended up being assigned to my firm, unbeknownst to me. So I arrive at my firm, and the partners realized that this same person was someone that, according to the docket, I had previously represented, and they asked if I would review some of his materials and continue the representation. That was the only person that I represented in the context of my private firm who was a detainee. I worked on a couple of habeas briefs for judges and for a variety of nonprofits, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who were all interested in making arguments to the Supreme Court that was considering these very novel legal issues.
You know, I sit here and I think of the 20 Supreme Court nominees I've gotten to vote on over my years here, and I think of the remarkable praise you got from the former Republican House Speaker Paul Ryan, whom most of us know well. He did mention his politics may be different than yours, but his praise for your intellect, for your character, for your integrity is unequivocal. That's powerful praise. And I think it goes to a really fundamental point, and that's this. One doesn't have to have the same political beliefs or ideologies as a judicial nominee to recognize their integrity and intellect. When I voted to confirm Chief Justice John Roberts of the Supreme Court, I cast that vote knowing very well that he and I would disagree on many policy and political issues. But I voted yes because I believed that he had what it takes to serve as an impartial, fair Chief Justice who would uphold the rule of law, and I want to take it out of partisan politics. Now, what would you say to people whose politics may be different than yours, like Speaker Ryan, who has endorsed you? What would you say to those people about your readiness to serve as an even-handed, unbiased Supreme Court justice?
Thank you, Senator. I would say that I am committed to serving as an even-handed Supreme Court justice if I'm confirmed by this body. And I have a record over the past decade that's precisely how I've treated all of my cases. And I've been serving in the District of Columbia, both as a trial judge and as an appellate judge, and we see some of the most politically contentious issues. My record demonstrates my impartiality.
Well, I'd go along with that because, and I watched this court. I used to go there as a young law student, sit in the back and just watch it. I continue to watch it. I see the chief judge of the federal district court, Judge Beryl Howell, who I was privileged to have her serve as my chief counsel on this committee, and learned from her then, I learned from her now. But I also, as a lawyer, I hear a lot of talk about reversal rates. Now, no judge goes without being reversed somewhere. If they're never reversed, they haven't heard many cases. But your time in the DC District Court, less than 2% of your more than 550 cases were reversed. Considering the fact that the DC Circuit reverses an average of 13% of the cases, it hears. You got a pretty good record, and but what does a judge who's been reversed? What do they take from that reversal? What do they, or what should they think about it?
Well, you obviously look at it very carefully. What it means is that a panel of judges who've reviewed what you determined for some reason has decided differently. And there are times when panels of judges decide differently because they are making a new statement about the law, or they're establishing a standard that had not previously been the case in the area. And so you learn, oh, this is a new standard now that I need to apply. There are times when you disagree, that people can disagree about the way in which the law works. And that's why we have panels, because people have different, judges can have different perspectives and in good faith reach different results. And so obviously when you're on the trial court, the Court of Appeals is binding, and they tell you, in this case, no, we're going to, the result is something different. And so you learn.
You know, anytime I had an opportunity to argue a case at an appellate level, I don't think I ever thought about who nominated or appointed the judges as before. I just want to know what I would think about their experience. And I would think about that when I made the argument. Now, I don't think I've ever had the opportunity to argue before anybody had your breadth of legal experience here. You served as a federal trial court, a federal appellate court judge for almost 10 years. You clerked at all 3 levels of the federal judiciary. You practiced law as a federal public defender in private practice, and I know we confirmed you as a member of the U.S. Sentencing Commission. This may seem like an easy question, but I just ask you that you've had such broad experience, but they're all different in a way. How does that shape your approach when deciding a case?
Well, thank you, Senator. As I mentioned at the beginning, I have a methodology that I apply when I'm deciding cases, and maybe my various experiences helped me to get to the point of understanding the importance of impartiality, staying in my lane as a judge, because the prior experiences were different roles in the system. Because I saw the different roles, I think I have a good appreciation of what it means to be a judge and the limitations on my own authority. The Sentencing Commission was a policymaking branch of the judicial branch that the commission and the commissioners developed sentencing policy. Congress delegated that authority to create the commission, and so they're doing the policy work, gathering data, making recommendations. That is totally different than the work that I do as a judge. Advocacy on behalf of your clients, making critical arguments, the best arguments you can come up with, is a service to the court, but it's a totally different thing than operating as a judge. And so I think that having had those various experiences, I'm now really mindful of my role and limitations in the judicial branch.
Well, and the president referred to you as a proven consensus builder, and I think he was also thinking of your predecessor, Justice Breyer, in that regard. And I think over the years how important that is, even in a body like the U.S. Senate. I see Senator Tillis here. He and I have worked together on IP issues. Senator Cornyn and I on freedom of information issue, Senator Grassley and I on other issues, Senator Graham and I on various issues, and usually in the Senate, at least, if you work across the ideological spectrum, you get better results. So let me ask you, how would you describe your approach to building consensus on cases related to issues like intellectual property that are less likely to break along traditional ideological lines?
Thank you. Thank you, Senator. One of the things that I was able to do when I worked on the Sentencing Commission was work with people who had very different perspectives than I did about the criminal justice system and come to consensus. It's very important, as you've said, to try to find common ground. And Justice Breyer was such a wonderful model, a role model for that kind of ability as a Supreme Court justice. It's something I learned from him and something I tried to model in my work on the commission, that I try to model in my work as an appellate judge, and that I would model or do if I were confirmed to the Supreme Court.
Thank you, Chair Durbin.
Thank you, Senator Leahy. And now Senator Graham.
Thank you, Judge. Again, congratulations. I want to talk to you a little bit about family and faith, because in your opening statement and the people who introduced you to the committee, there was very glowing praise of you as a person, a good friend. You have a wonderful family. You should be proud, and your faith matters to you. What faith are you, by the way?
Senator, I am Protestant.
Mm-hmm. Okay.
Non-denominational.
Okay. Could you fairly judge a Catholic?
Senator, I have a record of
I think the
fairly
answer would be yes.
judging everyone.
I believe you can. I'm just asking this question because how important is your faith to you?
Senator, personally, my faith is very important. But as you know, there's no religious test in the Constitution under Article 6, and
there will be none with me.
And it's very important to set aside one's personal views about things in the role of a judge.
I couldn't agree with you more, and I believe you can. So on a scale of 1 to 10, how faithful would you say you are in terms of religion? You know, I go to church probably 3 times a year, so that speaks poorly of me. Or do you attend church regularly?
Well, Senator, I am reluctant to talk about my faith in this way just because I want to be mindful of the need for the public to have confidence in my ability to separate out my personal views.
Well, how would you feel if a senator up here said, your faith, a dogma, lives loudly within you, and that's of concern? How would you feel if somebody up here on our side said, you know, you attend church too much for me, or your faith is a little bit different to me, and they would suggest that it would affect your decision? Would you find that offensive?
Senator,
I would if I were you. I found it offensive when they said it about Judge Barrett. The reason I ask these questions is I have no doubt that your faith is important to you, and I have zero doubt that you can adjudicate people's cases fairly if they're an atheist. If I had any doubt, I would say so. But the only reason I mention this, Judge, you're reluctant to talk about it because it's uncomfortable. Just imagine what would happen if people on late night television called you an effing nut, speaking in tongues because you've practiced the Catholic faith in a way they couldn't relate to or found uncomfortable. So, Judge, you should be proud of your faith. I am convinced that whatever faith you have and how often you go to church, it will not affect your ability to be fair. And I just hope going in the future that we all can accept that and that Judge Barrett, I thought, was treated very, very poorly. So I just wanted to get that out. Let's talk about family. Do you know Janice Rogers Brown?
Yes, I do know her.
Okay, how do you know her?
She was a judge on the court that I now serve. We didn't overlap, and I'm struggling to remember whether I ever met her, but she was a judge on the circuit court.
Right, and you were a district court judge, is that right?
I was, but I don't know whether she had,
I think you were.
Retired at
Are
the
they in the
time.
same building?
they are in the same building.
Okay.
They are in
So
the
you
same,
really don't know her?
I know of her, yes.
Okay. What do you know of her? What's her reputation?
I know that she's a very well-respected judge on my circuit.
Okay. And in terms of family, she was the daughter and granddaughter of sharecroppers. She was raised in Alabama under Jim Crow. Despite this adversity, she put herself through law school as a single working mother. That's pretty impressive, isn't it?
Yes, Senator.
Your background is very impressive. You seem to have a great family. If family mattered, we would not have done to her what was done to her here in the United States Senate. Do you realize that she was filibustered for 2 years when she was appointed to the D.C. Circuit?
I didn't know that.
Did you know that Joe Biden actively filibustered Janice Rogers Brown?
I did not know that.
Did you know that he told Face the Nation, if Bush nominates her for the Supreme Court, I can assure you that would be a very, very, very difficult fight, and she probably would be filibustered. Is that news to you, too?
Yes.
Okay. Now that you know that, how do you feel about it?
Senator, I can't speak to something that I just learned 2 seconds ago in your
Okay, fair enough.
conversation with me.
Fair enough. You're in the Black Law School Society, right? At
The
Harvard?
Black Law Students Association.
Okay, Black Law Student Association.
Yes,
You're a member at Harvard.
yes.
And in sometime, the Mr. Jeffries thing, do you remember that whole dust-up? He got,
Only in preparation for this, and I think I was in college at the time. It was my senior year of college.
okay, so you weren't actually in the group when he was invited to speak?
I don't know which group invited him to speak. I was a black student at Harvard, both in the Harvard Undergraduate Black Students Association and the Harvard Law School Black
Right.
Students Association.
Do you remember going to a speech given by Mr. Jeffries? I think he's the uncle of Akeem Jeffries.
I did not go to a speech
Okay.
given by Mr. Jeffries.
Are you now familiar with the press reports about what Mr. Jeffries' views are?
Just in preparation for this.
Okay, and do you associate yourself with those views?
I do not, Senator.
As a matter of fact, he's been called by many as very anti-Semitic. He called you skunk who stink up the place. You don't agree with that, do you?
I do not, Senator.
And it would be wrong for me or anybody else to hold his statement against you because he spoke at some group you're a member of, right?
Senator, I don't have, yes,
It would be, yeah, that's right. That's the right answer. I thought that was the right answer with Judge Alito. When they made a big deal about some group he was in that had views that he didn't agree with and tried to call him basically a racist, and found out that Senator Kennedy, God rest his soul, who beat the crap out of the guy for being part of some supper club that was actually in some organization called the OWL that didn't admit women. So I guess the reason I'm bringing all this up is it gives me a chance to remind this committee in America there are two standards going on here. If you're an African-American conservative woman, you're fair game to have your life turned upside down, to be filibustered no matter how qualified you are. And if you express your faith as a conservative, all of a sudden you're a effing nut. And we're tired of it. And it's not going to happen to you. But it just appalls me that we can have such a system in America, that if a conservative woman wants to stand out and say, I love my family just as much as you love yours, and my faith means just as much to me as it does you, that all of a sudden there comes some kind of weirdo. And a guy like Justice Alito, who's in the same type situation you're in, being in a group, doesn't agree with everything they do or what people may say at a meeting he didn't go to, all of a sudden they own it. You know, this stuff needs to stop. Our people deserve better respect, and I hope when this is over, people will say you were at least well treated, even if we don't agree with you. So now let's talk about Gitmo. Being a public defender, did you consider that rewarding?
Senator, yes, I did, because public service is very important to me. It is an important family value. It is something that now I've dedicated my career to.
Yes. And do you think it's important to the system that everybody be represented?
Absolutely. It's a core constitutional value.
You'll get no complaint from me. That was my job in the Air Force. I was a Area Defense Counsel. I represented anybody that came in the door, whether I liked them or not. I did my best. Is that what you did?
Yes, sir.
Okay, good. Now, so the American people deserve a system where everybody's represented, where you like them or not, and anybody that takes up that cause, no problem with me. You're just doing your job, and I think you make our country stronger. But there's the other side of the story that never gets mentioned when I talk about Gitmo. The American people deserve a system that can keep terrorists off the battlefield. They deserve a system that understands the difference between being at war and a crime. Do you consider 9/11, you said, a terrible, tragic event? Would you consider it an act of war?
Yes, Senator.
Okay, I would too. I think it was an act of war by Al-Qaeda and associated groups against the people of the United States. So as you rightfully are proud of your service as a public defender, and you represented Gitmo detainees, which is part of our system, I want you to understand, and the nation to understand, what's been happening at Gitmo. What's the recidivism rate at Gitmo?
Senator, I'm not aware.
It's 31%. How does that strike you? Is that high, low, about right?
I don't know how it strikes me overall.
You know how it strikes me? It strikes me as terrible.
Yes, that's what I was going to say.
Okay, good. We found common ground. Of the 229 detainees released from Gitmo, of 729 released, 229 have gone back to the fight. Here's some of the notables. Former Gitmo detainee Zakir was named the interim defense minister of Afghanistan. I don't know exactly what his job is today, but during the transition, they made him the defense minister and he was in Gitmo. Of the 5 men we released from Gitmo as part of prisoner swap for Sergeant Bergdale, here's where they're at. Mohammed Fazal was appointed Deputy Minister of Defense. Noor was appointed Acting Minister of Borders and Tribal Affairs. Waziki was appointed as Acting Intelligence Director. Kerr, again, Acting Minister of Information, Culture, Defense. Omar was appointed as the new governor of the southeastern province of Khost. These were 5 people that we had in our control that are now helping the Taliban run the country. Would you say that our system in terms of releasing people needs to be re-looked at?
Senator, what I'd say is that that's not a job for the courts in this way. That
as an American, does that bother you?
Well, obviously, Senator, any repeated criminal behavior or repeated attacks, acts of war, bother me as an American.
Well, it bothers me. While I will not hold it against you, nor should I, the fact that you represent Gitmo detainees, I think it's time to look at this system new, folks. When 31% of the people are going back to fight to kill Americans and now running the Taliban government, we have gone wrong somewhere. Are we still at war?
So the AUMF, the authorization for military force is still in effect. Congress has authorized the use of force against people in this way.
But do you personally believe that Al-Qaeda, ISIS-type groups are still at war with us?
I think, yes. I mean, I think we.
So we're still in a state of war with certain elements of radical Islam to this very day?
I believe that's documented, yes.
Okay. Now, what's the process to determine whether one's an enemy combatant under our law?
Well, I believe that the executive branch makes an assessment of whether or not someone is taking up arms against the United States somewhere in the world related to all of this.
Okay, so it's an executive branch function to determine whether or not this person qualifies as an enemy combatant
Well, I believe that they make a
under current law.
Under current law, I believe that determination is made by the executive branch and the person is detained. And then the question becomes whether they are able to bring some sort of legal challenge to that
They have a
determination.
habeas right.
Yes.
Okay, so the law is that the executive branch determines if you're an enemy combatant. And under our law, you can appeal that decision to a federal court through habeas. Is that correct?
I believe that's correct.
Okay. Is it your view that we can hold enemy combatants as long as they're a threat to the United States?
I believe that's what the Supreme Court has determined.
Okay. Did you argue that that should not be the case before in an amicus brief?
I'm trying to think. I had 2 amicus briefs that I worked on, or 3 technically, but 2 different cases.
Well, we'll have another visit tomorrow. So
Yes.
Go back and check.
Yes.
I'm pretty sure that in your brief, you argued that the executive branch should not have the ability to hold an enemy combatant indefinitely. You need to try them through some process or release them.
Yes, Senator, as you were talking, my clients, the Cato Institute, the Rutherford Institute, and the Constitution Project, made that argument and asked me to draft their brief.
Yes. Well, do you agree with that argument?
Senator, my responsibility was to make my clients' arguments, and as a nominee to the Supreme Court, that's the kind of issue. The Supreme Court did not address that issue. They, in fact, the case became moot.
Did you organize an effort to get 20 judges to file a brief to the Supreme Court on this issue?
Not on that issue, no, Senator.
On another issue?
Yes, Senator.
Okay, did you actively go out and recruit 20 judges to help you file a brief on another issue regarding law of war detention?
Not technically.
What do you mean by that?
What I mean is that I was at Morrison & Foerster, which was my law firm, in the Supreme Court and appellate group. One of the partners at Morrison & Foerster was a former federal judge who wanted to make this argument and who said, I have former federal judges who are friends of mine who would like to join with me to make this argument. So I worked with her, the partner at my firm who was a former federal judge, to make.
So it was her idea to get former judges to write this,
Yes.
not yours?
Yes.
And you just helped in the implementation of that idea?
So, Senator, as a member of the Supreme Court and appellate group in a law firm, that is the practice.
Right. Now I'm asking.
Amicus
was-
practice, yes.
It wasn't your idea, it was somebody else?
Yes.
Okay. So now, there are people still held at Gitmo today. Do you understand that?
Yes.
Okay. What system is in place regarding their future?
I am not aware of the system right now. I'm not sure exactly what you mean.
Let me tell you what it is.
Yes.
There's a periodic review process made up of an interagency where they go through the files of these folks and they determine whether or not they still present a threat to the United States or the world at large. And I think it's 6 months, maybe a year. But that goes on at least on an annual basis. And if there's a determination that this person still represents a threat to the United States, they're continued to be confined. That's the way the system works. Are you okay with that?
As a policy matter, Senator, I'm not speaking to my views. That's my understanding is that the periodic review system is an executive branch determination of whether or not they're going to continue to hold people that they.
Does that make sense to you as a way to deal with these detainees?
Senator, I'm not in a position to speak to the policy or the discretion of the executive branch regarding how they're going to handle detainees.
The reason I mention it is because in one of the briefs, you argued that the executive branch doesn't have that option. That if you had had your way, the executive branch could not do periodic reviews about the danger the detainee presents to the United States. They would have to make a decision of trying them or releasing them. Is that not accurate?
Respectfully, Senator, it was not my argument. I was filing an amicus brief on behalf of clients, including the Rutherford Institute, the Cato Institute, and the Constitution Project, who...
When you sign on to a brief, does it not become your argument?
It does not, Senator. If you are an attorney and you are representing a client in amicus...
Is that your position when you were in private practice? I mean, you sign on to this brief making this argument, but you say it's not your position. I mean, why would you do that if it's not your position? Why would you take a client that has a position like that? Now, this is voluntary. Nobody's making you do this.
Oh, Senator, I would refer you to the same sorts of statements that Chief Justice Roberts made when he came before the committee, which is that lawyers represent clients.
I get that. I'm not holding the client's views against you. The people you represent at Gitmo, they deserve representation. But this is a amicus brief where you and other people try to persuade the court to change policy. The policy I described is a periodic review. If the court had taken the position argued in the brief that you signed upon, we'd have to release these people or try them, and some of them, the evidence we can't disclose because it's classified, you're putting in America in an untenable position. This is not the way you fight a war. If you tried to do this in World War II, they'd run you out of town. We hold enemy combatants as long as they're a threat. There's no magic passage of time that you got to let them go. So my question is very simple. Do you support the idea, did you support then the idea that indefinite detention of an enemy combatant is unlawful?
Respectfully, Senator, when you are an attorney and you have clients who come to you, whether they pay or not, you represent their positions before the court.
I'm sure everybody at Gitmo wants out. No, I got that. This is an amicus brief, and I just don't understand what you're saying, quite frankly. I'm not holding it against you because you represented a legal position I disagree with. I mean, that happens all the time. I'm just trying to understand what made you join this cause. And you say somebody hired you, but did you feel okay in adopting that cause? I mean, when you signed on to the brief, were you not advocating that position to the court?
Senator, as a judge now, in order to determine the lawfulness or unlawfulness of any particular issue, I need to receive briefs and information making positions on all sides.
And
No,
with
I got what a judge is all about. Listen, I'm not asking you to decide the case in front of me right here. I'm asking me to explain a position you took as a lawyer regarding the law of war, and I am beyond confused. I know what you said in your brief. Whether I agree with it or not, it's not the point. I just want you to understand that it's important for all of us to know where you were coming from. If that brief had been accepted by the court, it would be impossible for us to fight this war. Because there's some people going to die in jail in Gitmo and never go to trial for a lot of good reasons, because the evidence against them is so sensitive we can't disclose it to the public. That we're not charging them with a crime. What we're doing is saying that you engaged in hostile activities against the United States, that you are an enemy combatant under our law, and you will never be released as long as you're a danger until the war is over or you're no longer a danger. That's the difference between fighting a crime and a war. Did you ever accuse in one of your habeas petitions the government of acting as war criminals for holding the detainees? The holding of the detainees by our government, that we were acting as war criminals.
Senator, I don't remember that accusation, but I will say that.
Do you believe that's true? That America was acting as war criminals in holding these detainees?
Senator, the Supreme Court held that the executive branch has the authority to detain people who are designated as enemy combatants for the duration of the hostilities. And what I was doing in the context of the habeas petitions at this very early stage in the process was making allegations to preserve issues on behalf of my clients. A habeas petition is like a complaint that lawyers make allegations.
You know, I've been a lawyer too, but I don't think it's necessary to call the government a war criminal in pursuing charges against a terrorist. I just think that's too far. I don't know why you chose those words. That's just too far. But we are where we are. So let's talk about the nomination process. Have you ever had any interaction with a group called Demand Justice?
No.
Directly or indirectly?
No.
Have you ever had an interaction with a group called American Prospect?
No.
Do you know anything about Arbella? Is that the right term? Have you ever heard of a group called Arbella?
I've heard of a group that I think is Arabella or something like that.
Yeah, I think you're right. Not
Yes.
Arabella, yeah. Do you know anything about them? Have you had any contact with them?
No.
Okay. In your nomination, did you notice that people from the left were pretty much cheering you on?
A lot of people were cheering me on,
That's
Senator.
true. That's true. Did you know that a lot of people from the left were trying to destroy Michelle Childs? Did you notice that?
Senator, a lot of people were supporting various people for this nomination.
So you're saying you didn't know there was a concerted effort to disqualify Judge Childs from South Carolina because she was union-busting, unreliable Republican in disguise?
Senator, I'm a sitting judge. I was focused on my cases.
The answer is no, I didn't know that.
No, I didn't know that.
Would it bother you if that happened?
Senator, it is troublesome that people are or were doing things related to
I think
the
that's
nomination.
the best way to say it. People have a right to speak out and pick the person of their choice. But all I can say is that if you miss the fact that there was an organized effort, well, here's President Biden has only a certain amount of political capital for keeping his party united. If he needlessly angers progressives on this SCOTUS pick, that could create all sorts of problems for him down the line. Jeff Hauser, revolving door projects. Let's see. I just got so many quotes It's difficult to imagine someone with a record like Judge Childs winning votes from criminal justice advocates like Senator Cory Booker, even Dick Durbin. Childs' experience is nothing like the diversity of experience that the Biden administration has championed. Let's see. Picking her, Childs, would demoralize the base, side with corporate America. The fact that Lindsey Graham is vouching for her should give the White House pause. Our revolution, Joseph Gervangi, or whatever his name is, I'm sorry about that, Joseph. He's Bernie Sanders' PAC director. You didn't know that all these people were declaring war on Judge Childs?
Senator, I did not.
Okay. Well, no, I'm not saying you did. You said you didn't know. I'll take it at your word. But I am saying that what is your judicial philosophy?
So I have a methodology that I use in my cases in order to ensure that I am ruling impartially and that...
So your judicial philosophy is to rule impartially?
No, my judicial philosophy is to rule impartially and to rule consistent with the limitations on my authority as a judge. And so my methodology actually helps me to do that in every case.
So you wouldn't say that you're an activist judge?
I would not say that.
Okay. So we'll have 20 minutes more later on, but here's what I would say. That every group that wants to pack the court, that believes this court is a bunch of right-wing nuts that are going to destroy America, that consider the Constitution trash, all wanted you picked. And this is all I can say, is the fact that so many of these left-wing radical groups that would destroy the law as we know it declared war on Michelle Childs and supported you is problematic for me. Thank you.
Thank you, Senator Graham. Let me mention a few points here. Congressman Jim Clyburn was a strong supporter of Michelle Childs, and now I believe he is publicly supporting your nomination. And Michelle Childs has been nominated by President Biden to be a circuit judge, and she will be considered by this committee as quickly as possible. On the issue of Guantanamo, there are currently 39 Guantanamo detainees remaining. The annual budget for Guantanamo is $540 million per year, which means each of these detainees is being held at the expense of $12 or $13 million per year. If they would be incarcerated at Florence, Colorado, the Supermax prison, federal prison, the amount would be dramatically less. Since 9/11, nearly 1,000 convicted in the United States on terrorism charges. Since 2009, with the beginning of the Obama administration, the recidivism rate of Guantanamo detainees released is 5%.
Mr. Chairman, according to the Director of National Intelligence, is 31%. Somebody is wrong here. If you're going to talk about what I said, I'm going to respond to what you said. If we close Gitmo and move them to Colorado, do you support indefinite detention under the law of war for these detainees?
I would just say I'm giving the facts. And
The answer is no.
I want to make sure that it's clear. The 31% you referred to goes back to the year 2009? 2000.
What does it matter when it goes back to? We had them and they got loose and they started killing people.
Well, I could just say that.
If you're one of the people killed in 2005, does it matter to you when we release them?
Suggest that a president of your own party released him in.
I'm suggesting the
creating that
system has
danger.
failed miserably, and advocates to change this system, like she was advocating, would destroy our ability to protect this country. We're at war. We're not fighting a crime. This is not some passage of time event. As long as they're dangerous, I hope they all die in jail if they're going to go back and kill Americans. It won't bother me one bit if 39 of them die in prison. That's a better outcome than letting them go. And if it costs $500 million to keep them in jail, keep them in jail, because they're going to go back to the fight. Look at the friggin' Afghan government. It's made up of former detainees at Gitmo. This whole thing by the left about this war ain't working.
Let me also note that Larry Thompson, who served as Deputy Attorney General under President George W. Bush, Oren Kerr, Special Counsel, Viet Dinh, who served as Assistant Attorney General for Legal Policy in the George W. Bush administration, John Bellinger, and former D.C. Circuit Judge, Solicitor General, and Independent Counsel Ken Starr were also prominent conservative lawyers signing a letter defending attorneys who represented Guantanamo Bay detainees. I don't believe that we should associate that activity as being inconsistent with our constitutional values. We are going to at this point recognize Senator Feinstein and then take a break after she has completed her questioning. Senator Feinstein.
Thank you very much, Mr. Chairman, and I just would like to compliment the witness. I think you're doing very well, and as you can see, this is a bit of a tough place. So, Judge, one of the issues that I often discuss with nominees, particularly to the Supreme Court, is the issue of abortion. I've asked the three most recent Supreme Court nominees about this issue, and so I'd like to discuss it a bit with you today. In 2017, I asked Justice Gorsuch about this during his confirmation hearing. I asked him to expand on a comment he had made about his belief that precedent is important because it adds stability to the law. In response, Justice Gorsuch reiterated his belief that precedent is important because, and I quote, once a case is settled, that adds to the determinacy of the law, end quote. He also stated that Roe has been reaffirmed many times. I also spoke with Judge Kavanaugh about this issue in 2018. I asked him whether he believes that Roe was settled wrong, and if so, whether it was correctly settled. Justice Kavanaugh said that Roe, quote, is settled as a precedent of the Supreme Court, end quote. He said that Roe, quote, has been reaffirmed many times over the past 45 years, and most prominently, most importantly, reaffirmed in Planned Parenthood v. Casey, end quote. And he described Casey as having the value of a precedent on precedent, end quote. I most recently spoke about this issue with Justice Barrett in 2020. I asked her whether she agreed with Justice Scalia's view that Roe was wrongly decided. She committed to, quote, obey all the rules of stare decisis, end quote, if faced with the question of whether to overrule Casey. She said she had, quote, no agenda to try to overrule Casey, end quote. So here's the question. Do you agree with Justice Kavanaugh that Roe v. Wade is settled as a precedent? And will you, like Justice Barrett, commit to obey all the rules of stare decisis in cases related to the issue of abortion, end quote?
Thank you, Senator. I do agree with both Justice Kavanaugh and Justice Barrett on this issue. Roe and Casey are the settled law of the Supreme Court concerning the right to terminate a woman's pregnancy. They have established a framework that the court has reaffirmed, and in order to revisit, as Justice Barrett said, the Supreme Court looks at various factors because stare decisis is a very important principle. It provides and establishes predictability, stability. It also serves as a restraint in this way on the exercise of judicial authority because the court looks at whether or not precedents are relied upon, whether they're workable, in addition to whether or not they're wrong, and other factors as well. So I agree with both of those statements that you read.
Well, let me add one to that, and then we'll move on. I'm particularly interested in the case of Roe v. Wade. Roe was decided by nearly 50 years ago, and it's been reaffirmed over a dozen times since then. So my question is this: does Roe v. Wade have the status of being a case that is a super precedent? And what other Supreme Court cases do you believe have that status?
Well, Senator, all Supreme Court cases are precedential, they're binding, and their principles and their rulings have to be followed. Roe and Casey, as you say, have been reaffirmed by the court and have been relied upon. And reliance is one of the factors that the court considers when it seeks to revisit, or when it's asked to revisit a precedent. And in all cases, the precedents of the Supreme Court would have to be reviewed pursuant to those factors, because stare decisis is very important.
Thank you. If you are confirmed, you would be one of only 2 justices who has also served on a federal district court, the other being Justice Sotomayor. In your 8 years as a trial judge on the D.C. District Court, you wrote nearly 600 opinions and presided over 9 jury trials and 3 bench trials. As you know from your service on the district court, it's important for appeals courts, and especially the Supreme Court, to be clear in their decisions. The clarity is necessary, as you well know, for trial judges to effectively do their job and properly apply legal precedents that are fair and consistent. As a district judge, you were responsible for applying precedent from the Supreme Court and the courts of appeal to your case. And now as a judge in the D.C. Circuit, you're drafting those precedents. Your experience as a trial judge is one of your most significant assets. And I just want to add a personal comment. This is a tough place, and you are handling it very well. And I appreciate your directness and think that's important. Here's a question. I have 2 related questions. How did you make sure that you were properly applying the relevant precedents as a district court judge? And if you're confirmed to the Supreme Court, what would you do to make sure your opinions are clear so they could be applied correctly by district courts?
Thank you, Senator. As you noted, in my time as a district court judge, I had the opportunity to apply precedents that were handed down by the Court of Appeals and the Supreme Court. The district court is bound by the law as stated by those other tribunals, and I was very focused on making sure that I found the right precedents and applied them faithfully. As I mentioned, with respect to my methodology, part of the process is receiving information from the parties in a case. And the parties write briefs, and in most cases, they identify the precedents that they at least believe are applicable. And then the court does its own legal research as well to determine whether all of the relevant cases have been identified. And then you look to see whether there's anything that directly controls, and if it does, that's your answer. In many cases, the precedents might be a little bit different in certain ways, and you are assessing the parties' arguments and determining within your proper role whether what the appellate courts have said provides the law of decision for the case. But what's important, as you've mentioned, is the clarity by which courts of appeals and the Supreme Court need to operate, and so that the lower courts can actually follow the precedents. And I'm very conscious of that, as you said, as someone who has had to follow precedent. And I would think carefully about that and use my communication skills to ensure that the precedents are clear so that lower courts can follow them.
Thank you. I'd like to discuss quickly a letter this committee received in support of your nomination from the International Association of Chiefs of Police. And as you know, this is the world's largest professional association of law enforcement leaders. And the letter states, Judge Jackson has several family members in law enforcement, and we believe this has given her a deep understanding of and an appreciation for the challenges and complexities confronting the policing profession. During her time as a judge, she has displayed her dedication to ensuring that our communities are safe and that the interests of justice are served. And so, Mr. Chairman, I'd like to put this letter in the record, if I may.
Without objection.
Thank you. I understand that your brother served with the Baltimore Police Department for several years. So here's the question. How, if at all, has having several family members in law enforcement impacted your understanding of the law or your approach to your judicial service?
Thank you, Senator. Some of my earliest memories, in addition to my father at the kitchen table with his law books, were of my uncles. Two of my uncles were career law enforcement, and one was a detective, uniformed detective. One was City of Miami Police Department officer, patrol officer for a long time before he became the chief. And I remember very well, we would go to my grandmother's house on Sundays, and she would make a big dinner for our family, and my uncles would sometimes come off of their shifts. So I see in my mind their uniforms coming in, and they would always, they'd be carrying their weapons, and they'd take them off and put them way up high on the china cabinet so the kids couldn't get to them. And I remember feeling very proud of them and the service that they provided. And I think it's probably what led my brother, who is 10 years younger than I am, to decide that after he graduated from college, he would want to also be in law enforcement. So I'm very familiar with law enforcement, the important service that they provide, the perils of being out on the street, protecting and serving, and having a family that cares about you and worries about your safety. And so this is not something that is unfamiliar, and I'm very gratified by the support of the group that you mentioned and other law enforcement groups as I go through this process.
I joined this committee in January of 1993, and a few months later, we considered the nomination of Ruth Bader Ginsburg to the Supreme Court. Justice Ginsburg's confirmation made her only the second woman to ever serve on the Supreme Court after Justice Sandra Day O'Connor. So we have come a very long way since then, though still not far enough. Women now make up about 35% of active judges on the federal district bench and 37% of active judges on the federal appeals courts. Judge Jackson, if confirmed, you would become the sixth woman to ever serve on the Supreme Court. You would join Justices Sotomayor, Kagan, and Barrett on the bench. This would be the nearest we have ever come to gender equity on the Supreme Court. There would be 4 women on a court with 9 justices. So I have my own thoughts about why gender balance is important on our nation's courts. But I'd really like you to tell us all, what are your thoughts on what it means for our country to have women serve in meaningful numbers on the federal bench, and in particular, what it would mean to have 4 women serving on the Supreme Court for the first time in history.
Thank you, Senator. I think it's extremely meaningful. One of the things that having diverse members of the court does is it provides for the opportunity for role models. Since I was nominated to this position, I have received so many notes and letters and photos from little girls around the country who tell me that they are so excited for this opportunity and that they have thought about the law in new ways because I am a woman, because I am a Black woman. All of those things, people have said, have been really meaningful to them. And we want, I think, as a country, for everyone to believe that they can do things like sit on the Supreme Court. And so having meaningful numbers of women and people of color, I think, matters. I also think that it supports public confidence in the judiciary when you have different people, because we have such a diverse society.
Well, I just want to say thank you very much. This is often a hard place, and how you go through those hard times, I really think, is the most important thing. And it's pretty clear to me that you go through hard times by holding your head up high and doing well. So I thank you very much.
Thank you, Senator.
Thank you, Senator Feinstein. We're going to take a break. Let's see, let's take 15 minutes starting now, and then we'll return to more questions. We'll have a lunch break later this afternoon, in the earlier part of the afternoon.
And with that, Senator Dick Durbin, chair of the Senate Judiciary Committee, is giving the committee and the nominee, Judge Jackson, a break. He said 15 minutes. We're watching the senators there arrayed around the hearing tables at the United States Capitol in the Senate office building. I'm Judy Woodruff, part of PBS NewsHour's live coverage of the Senate confirmation hearings today. I'm joined by our correspondents who are following this, and also by our analyst, Marcia Coyle of the National Law Journal. Marcia, we just heard Senator Feinstein speaking about the importance of someone who would be the 4th woman on the Supreme Court of 9 individuals. It would be historic. And we've all been talking about the fact that Judge Jackson, if she's confirmed, would be the first Black woman. I think before we get into all the
first public defender.
And the first public defender, thank you for reminding us. But before we get into some of the controversy that came up during this morning session, I do want to ask you about that just quickly, because that's what most people are thinking about. As they look at this woman, she would be the first Black woman to sit on the Supreme Court.
Absolutely. And I mean, there's just no denying the historic nature of the nomination. And as Judge Jackson pointed out, how meaningful it is to so many in the country. Perhaps not to everyone in the country, but certainly to little girls, and not just Black little girls, but to see that there will be 4 women on a court of 9. I mean, that's really something. I mean, the visual is so important to so many as well. And I think she was accurate in saying that it's also meaningful and important because it supports the fact that we have a very diverse nation, and that in turn imbues confidence in the Supreme Court itself when it begins to look like that diversity.
And it was interesting to hear her say how much she's heard. She said notes, letters from little girls who watch her, and and take heart from that. I'm joined also by John Yang, who has been watching these proceedings, who follows the Supreme Court for the NewsHour. John, I think it's fair to say the fireworks in these last couple of hours came primarily from Republican Senator Lindsey Graham of South Carolina, who very much is carrying the weight on his shoulders and the aggrievement. He's clearly still aggrieved by the treatment of not only Republicans, the Republican nominees to the court, Judge Amy Coney Barrett, Justice Amy Coney Barrett and others, but also by other conservatives who've come before the Senate and have received, in his view, much tougher treatment. But John, what I specifically want to ask you about is his focus on Guantanamo Bay and the work that Judge Jackson did both as a public defender and then as a private attorney in representing some of those who are being detained at Guantanamo Bay.
That's right. I think the administration and the Democrats on the committee always knew this was going to be a point of contention, and perhaps one of the sharpest points of contention in this hearing. She tried to make the distinction that these were not her personal positions, but she was advocating positions for her clients. And as a public defender, she can't choose her clients. And in private practice, she described being chosen for these cases because she had the expertise from her public defender role. She also tried to point out, and I don't know whether it landed or not, that the clients in these cases were the Cato Institute, which is a libertarian think tank in Washington, D.C., and the Rutherford Institute, which is a conservative Christian think tank or legal advocacy group. I suspect, and Senator Graham also has his own, I don't know if grievances is the right term, but office positions on Guantanamo Bay and the detainees who are being held there. And I don't know that those issues fully landed. He was, in a lot of ways, making a lot of points about in the previous grievances, as you discussed, Judy, and as Marsha's been talking about in our coverage, and that didn't really have much to do with Judge Jackson herself.
And to Jeff Bennett at the White House now, who's also been listening this morning. Jeff, you were telling our producer that President Biden has made time to listen to some of this morning.
That's right, Judy. Even as President Biden is focused on his trip overseas to Brussels to focus on Russia's invasion of Ukraine, he is, as you would imagine, paying close attention to the proceedings just down the other side of Pennsylvania Avenue here on Capitol Hill. I'm told he watched yesterday Judge Jackson's opening remarks, and then he watched again this morning the Q&As with Senator Durbin and Senator Grassley. And according to a White House official, his immediate feedback was that Judge Jackson was sharp, powerful, and impressive. The White House counsel's office had for weeks been running hours-long practice sessions with Judge Jackson, really trying to anticipate any sort of line of attack that might come from Republicans. And so far, I'm told that what the White House anticipated is precisely what has happened. They knew that Senators Hawley and Senator Graham, to a certain regard, would try to use her past professional experience as a public defender against her. And so the advice to Judge Jackson, I'm told, was to sort of try to rise above the noise, to meet the moment, to remain non-partial, to make clear her methodology for as she views her role as a judge. And she spoke about that actually in the very beginning of this hearing. She talked about how she tries to start with a neutrality check and sort of take in all of the various inputs and then interpret the law based on the facts available to her, and being very clear about, as she put it, staying in her lane. So the view from the White House right now is that everything is going as they planned it. And I'll also add, based on your conversation you were just having with John Yang, I spoke to a White House official who made clear that everything that Senator Graham brought up today was available to him. All of the information he brought up about Judge Jackson's experience and her role in defending Gitmo detainees, all of that was available to him months ago when he voted to confirm her for the position that she currently has, which we should also say is a lifetime judicial appointment. Of course, not nearly as elevated to the role of being a Supreme Court nominee.
Right, and what Senator Graham and other Republicans are saying is that this is a much different. This is, yes, it's another federal court position, but this is one of greater consequence. But Jeff Bennett, what you just said, I want to turn now to Lisa Desjardins, our congressional correspondent, who's also been listening very closely. The White House was anticipating, and so was the chair, Senator Dick Durbin, Lisa, when he questioned. It was as if he wanted to get Judge Jackson on the record this morning. He asked her about her judicial philosophy, and he went right at the point that Senator Josh Hawley and others have made about Judge Jackson, and that is her record in deciding on the sentencing of individuals convicted of dealing in child pornography. He went straight to that as this hearing got underway this morning.
That's right. I mentioned earlier that this is a room full of lawyers, and I think what you've seen in the beginning of this hearing is lawyers using some of their best techniques to make their various cases. And here was Senator Durbin using an attorney's technique. If you think there's some potentially damaging questions coming up for your client, you ask them first, and you make them a friendly kind of question. The answer may stay the same. Whatever Judge Jackson said to Senator Durbin is probably the same thing she will say to the questions we expect from Senator Hawley, especially on her sentencing on child pornography. But they sound different when they're coming in answer to a friendly person like Senator Durbin. I also want to tell you all, we've engaged our Hill team here on perhaps a fool's errand this morning, which is we have created a spreadsheet where we're tracking every question asked. I don't know if we'll be able to maintain this because it's quite a lot. Judy, this has been such a rapid fire pace. You may remember the 2020 impeachment, the questions senators asked on that long day of impeachment. Already, just this morning in this hearing, more questions have been asked of Judge Jackson than were asked in the entire impeachment trial in 2020. We're over 100 questions so far, the vast majority by one senator, no surprise, Senator Lindsey Graham. 64 questions in 30 minutes, a very specific style. And I think the preparation that the White House went through with Judge Jackson that you heard Jeff report on has proven critical. But I think even Judge Jackson was sort of taking a moment to keep up with the very firm pace of Senator Graham, which was his point. He was trying to make a point of his own, not always seeking answers.
Yeah, it was certainly a rapid fire, and at some points interrupting her, and then there was a point when he apologized for interrupting, but he was clearly trying to move along. And it did not go unnoticed that as soon as Senator Graham finished, Senator Durbin spoke up to, in his words, correct the record about Guantanamo detainees, at which point Senator Graham came back, and after that brief exchange, Senator Graham got up pretty quickly and left the hearing room. I think it's pretty clear where Senator Graham stands. Marcia Coyle here with me.
Judy, I was
in the studio. Yes.
Yeah, I wanted to make a comment, or really more of a memory about the Guantanamo discussion that Senator Graham had with Judge Jackson. I remember, because I was covering the court, when these cases and briefs were being filed after 9/11. And the one thing, and I think she tried to point this out, and it may not have landed as strongly as it probably should have, is that a lot of these legal questions were novel. And the lawyers who were filing these briefs, as she said, didn't have a lot of facts, but also were pushing the envelope as much as they could in hopes of getting guidance from the courts. Very much like during Supreme Court arguments, when a lawyer's making an argument, the justice will probe that lawyer to find out what are the limits of your argument, what is your fallback position if you don't win here. So I think what she did on behalf of clients as a public defender, and then with the law firm Morrison and Foerster, was very much in the tradition of lawyers when they're faced with these complicated new issues. Be aggressive.
And what we heard Senator Graham, at least in my view, attempting to do was to suggest that because she was representing clients with a particular viewpoint, he was trying to say, so that was your viewpoint as well, or was it your viewpoint as well. And her answer on, in several attempts was to say, I was representing them.
Right, exactly.
But it was clear that she made a distinction in her role as public defender and then as a private,
yes,
as a private attorney. Marcia, I do want to come back to her defense, if you will, on the child pornography matter. That she's soft on crime, that she was giving lenient sentences to people who've been convicted of engaging in child pornography. It seemed to me, she went to great lengths to say how offensive, how horrible these crimes are, how they leave a lasting scar on the individuals who've been the victims.
It was very personal sort of discussion that she had, not only in terms of really showing how the victims are affected and how she tries to bring the victims' voices into the courtroom when she is sentencing a defendant in that area of the law. But I also thought she did finally provide the context for the sentencing and her role at the Sentencing Commission. Probably Americans are going to learn more about the Sentencing Commission than they ever knew before out of these hearings.
Question.
But it was very interesting to hear how she talked about how the internet really changed how sentencing really had to be considered and dealt with. And that was part and parcel of what she did.
Because there were so many images that someone can see. Now today, we see Senator Dick Durbin, the chair of the committee, making his way back to his seat. Jeff Bennett, I'm going to quickly come back to you at the White House as we wait for Senator Durbin to gavel this hearing back into session. We heard Senator Graham bring up again, as he did yesterday, the fact that Judge Michelle Childs from South Carolina was not chosen by President Biden. He referred again to this massive campaign, in his words, a lot of money put behind opposing her. What has the White House said about that? We know that President Biden was considering Judge Childs.
That's right. And Senator Graham is not wrong when he talks about that moneyed effort to help the odds that President Biden would have ultimately made the decision that he made, which was to elevate Judge Jackson. But I'm told by White House officials that President Biden ultimately determined that Judge Jackson would be his first Supreme Court nominee based on the merits, based on her qualifications, based on her temperament, her judicial philosophy, her connection to the retiring justice, which was important to President Biden. And so that the notion that the outside third-party effort was the determining factor, that is not the case at all, Judy.
I bring it up because it's the second day in a row, and who knows, we may hear about it again, that Senator Lindsey Graham, it's his home state, it's South Carolina. He had said favorable things about her, but as another senator pointed out, I think it was Senator Durbin, it was the Democratic senator, the House Majority Whip James Clyburn, who would also was backing her candidacy. I think at one point it almost sounded as if from Senator Graham that she was the Republican choice for the position, and in fact she did have Democrats backing her as well. I think if we keep our eye on the hearing room, we're seeing that they are just about to go back. Marcia Coyle, I'm going to come to you as we wait for Senator Durbin to gavel them back, and we see him there talking to Senator Klobuchar. That this is a chance today with these half-hour chunks of time that each senator has for them to bring up the issues that they want to elevate about this nominee.
And I think it's much more effective if instead of a laundry list of issues that they go through boom, 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 that they choose maybe one or two to really hone in on and try to get more substantive answers from her.
And next up is going to be Senator John Cornyn. Lisa Desjardins, are you still with us? Senator John Cornyn will be next. As we know, it's back and forth from Republicans to Democrats. Some have described this in a way as kind of a ping pong match because Republicans ask, naturally, more challenging questions of a nominee who's been selected by a Democratic president.
That's right, and I think John Cornyn is someone who has been in the Senate a long time. He's also a former Texas Supreme Court justice. So he has a great deal of perspective here. He is someone who voted for Judge Jackson in committee just last year, then voted no on the Senate floor, And my reading of his opening statement yesterday is he is not warm to voting yes at this point, but he's someone we're watching to see if perhaps he could vote yes. It doesn't seem like he's leaning that way, but he's important to watch.
And that's right. As you pointed out, he voted for her in the committee when she was up for the appellate position, but then against her when it came up for a vote in the full Senate. It is interesting how these decisions get made, isn't it?
It is, and when some of this is I think increasingly less about senators with their staff and more about senators gauging the political winds in these politically turbulent times. There is a very clear direction that senators of both parties just start off as being opposed to a nominee from an opposing president in general. And I think that's generally a political statement of our times. It's kind of a problem that many people bemoan about the nomination process in general. And we'll see how that plays out today in this very particular hearing.
We're watching Judge Jackson making her way back into the room. She's been chatting with former Senator Doug Jones of Alabama, who's been, I think, what you could call her Sherpa in this process as she's been meeting with senators. And we now hear
Senate Judiciary Committee will come
Chairman
to order,
Durbin gaveling them into session.
to have two senators ask questions and then break for lunch somewhere around an hour from now. Senators Cornyn and Whitehouse will be recognized in succession. First, Senator Cornyn.
Thank you, Mr. Chairman. Judge, I want you to do me a favor. Will you nerd out with me a little bit?
I will try, Senator.
And we'll start with stare decisis.
Yes.
And I've never figured out why lawyers speak in Latin rather than in English when describing these concepts by which judges apply precedent. But would you agree with me that even under an appropriate stare decisis analysis, that Dred Scott and Plessy versus Ferguson were appropriately overruled by the Supreme Court?
Well, Senator, I've not engaged in the actual analysis, but I think it is well established now that the cases that overruled Dred Scott and Plessy were correctly decided.
Yeah, I mean, there is a means by which the courts can correct their mistakes, correct? By overruling previous decisions?
If the various considerations that the Supreme Court has uses to make that determination are satisfied.
Have you ever heard a federal judge talk about super duper precedent or super precedent?
I have not.
I've never seen it either, in any opinion. I've heard it here in the Judiciary Committee on a number of occasions when somebody has a favorite case or outcome that they don't want to see the Supreme Court revisit. Let me ask a minute. Obviously, your nomination by President Biden is historic, and I congratulate you again, congratulated you previously, and I think it's been long overdue. When Clarence Thomas, the second African-American who was nominated to and confirmed by the Supreme Court, was nominated to the court, did you celebrate that as a historic event?
I'm trying to remember where I was at the time. I believe I did, yes.
When we're talking about staying in your lane, and I appreciate your responses to a number of the questions, even though I'd love to get your answer to the question, but where you've deferred answering, saying you want to stay in your lane and not be seen as a policymaker. Would you agree with me that one of the most important questions under our constitutional form of government and the separation of powers is who decides? In other words, some questions are appropriately decided by judges who are elected, or unelected, served for life, insulated from politics, and other decisions are appropriately within the left up to the legislative branch because we are accountable to the people who can vote for us, they can vote against us, if they don't like the policies that we enact in legislation. Would you agree with that? Who decides is an important question in terms of determining the appropriate role for both the judiciary and the legislature?
As a general matter, I agree. It rarely comes directly like that as an issue. It's usually not a jump ball between the legislature and the executive
I get it. You don't get a lot of easy questions.
Well,
but you, as a general proposition, you won't disagree with me.
what I'd say is that the courts are properly tasked with resolving legal questions, and that
Cases or controversies, right?
exactly in
Right.
every case. And
Congress is not similarly constrained. We can pass broad policies, comprehensive legislation, changing policy, but the difference is, one of the differences is the voters can unelect us if they don't like what we're doing.
that is true.
I want to ask you, did you study under Lawrence Tribe when you were at Harvard?
I did not.
Well, as you know, Justice Breyer, your mentor, wrote a little book called Active Liberty. And Lawrence Tribe, who was formerly a law professor at Harvard, wrote a review of that book in the New York Times Review of Books, and the title of it is Politicians in Robes. Are you familiar with that article?
I am not.
Well, in the article, Professor Tribe accuses Justice Breyer of engaging in what he calls a noble lie. And he said, he talks about the morality of resorting to falsehoods and delusions to conceal, usually from the masses, but sometimes from oneself, the truths whose revelation would wreak havoc or at least do more harm than good. Professor Tribe goes on in criticizing Justice Breyer's book. He says in his stubborn avowal that the court, even with its current far-right supermajority, remains an apolitical body, he perpetuates a lie that is anything but noble. You've talked about staying in your lane, not making policy decisions, not being seen as political. Do you agree with Justice Breyer that, or with Professor Tribe?
Senator, I believe that judges are not policymakers, that we have a constitutional duty to decide only cases and controversies that are presented before us, and within that framework, judges exercise their authority to interpret the law and not make the law.
So you would agree with me that judges should not be politicians?
Yes.
Let me talk to you a little bit about some of the decisions that have been made by the Supreme Court over many years, starting perhaps with Dred Scott, that adopts the substantive due process argument to determine the constitutionality of various laws. Perhaps the most recent decision by the Supreme Court that was a dramatic departure from previous laws in the states and in the nation was the Obergefell case, which dealt with same-sex marriage. In the opinions that were written there, it was noted that here we are 234 years after the Constitution had been ratified, 135 years since the 14th Amendment had been ratified, that the Supreme Court articulated a new fundamental right, which is a right to same-sex marriage. You're familiar with that case, aren't you?
I am.
At the time, it was noted that 11 states, including the District of Columbia, had passed laws sanctioning same-sex marriage. But also at the same time, there were 35 states who put it on the ballot, and 32 of those states decided to maintain the traditional definition of marriage between a man and a woman. Do you agree with me that marriage is not simply a governmental institution, it's also a religious institution?
Well, Senator, marriages are often performed in religious institutions.
Well, you agree with me that many of the major religions that I can think of, and they're Christianity, Judaism, Islam, embrace a traditional definition of marriage, correct?
I am aware that there are various religious faiths that define marriage in a traditional way.
Do you see that when the Supreme Court makes a dramatic pronouncement about the invalidity of state marriage laws, that it will inevitably set in conflict between those who ascribe to the Supreme Court's edict and those who have a firmly held religious belief that marriage is between a man and a woman?
Well, Senator, these issues are being litigated, as you know, throughout the courts as people raise issues. And so I'm limited in what I can say about them. I'm aware that there are cases.
No, I'm not asking you to decide a case or predict how you would decide in the future. I'm just asking, isn't it apparent that when the Supreme Court decides that something that is not even in the Constitution is a fundamental right and no state can pass any law that conflicts with the Supreme Court's edict, particularly in an area where people have sincerely held religious beliefs, doesn't that necessarily create a conflict between what people may believe is a matter of their religious doctrine or faith and what the federal government says is the law of the land?
Well, Senator, that is the nature of a right, that when there is a right, it means that there are limitations on regulation, even if people are regulating pursuant to their sincerely held religious beliefs.
You agree with marriage is not mentioned in the Constitution, is it?
It is not mentioned directly, no.
And religious freedom and is mentioned in the First Amendment explicitly, correct?
It is.
Do you share my concern that when the court takes on the role of identifying an unenumerated right, in other words, it's not mentioned in the Constitution, and creates a new right, declaring that anything conflicting with that is unconstitutional, that it creates a circumstance where those who may hold traditional beliefs, like something as important as marriage, that they will be vilified as unwilling to assent to this new orthodoxy?
So, Senator, I understand that concern, and because there are cases that are addressing these sorts of issues, I'm not in a position to comment about either my personal views or whether.
I'm not asking you to. Justice Alito in the Oberfeld case wrote, he said, "I assume those who cling to the old beliefs will be able to whisper their thoughts in the recesses of their homes. But if they repeat those views in public, they will risk being labeled as bigots and treated as such by government, employers, and schools." So the Oberfeld case, to nerd out with you again, was decided under a doctrine known as substantive due process, correct?
If memory serves, yes, substantive due process, and I think there might have been equal protection concerns mentioned as well.
The Supreme Court has applied that somehow fairly mysteriously by saying it's created by the confluence of the Fifth Amendment and the 14th Amendment to the United States Constitution. But historically, it's been applied in ways that seem to sanction explicit policymaking by the courts. For example, the Lochner versus New York case, which I know you talked to Senator Lee about in particular, which it was a New Deal case which set limitations on how long bakers could work in New York. The Supreme Court struck that down and said it violated the right of free contract. Now, Lochner, as you know, was overruled 30-something years later, but it's also been applied in a number of different circumstances. For example, it's been suggested that Dred Scott, which treated slaves as chattel property, was a product of substantive due process. Justice Hugo Black has criticized the doctrine of substantive due process as the arbitrary fiat of the man or men in power, or the court declaring a law invalid because it shocked the consciences of at least 5 members of the court. He went on to say this use of judicial review thus subverts the liberty of government by the people, overturning laws enacted by legislatures who are answerable to the electorate rather than a majority of the Supreme Court. Finally, he said, for the purpose of my question, he said the adoption of such a loose, flexible, uncontrolled standard for holding laws unconstitutional, if ever it is finally achieved, will amount to a great unconstitutional shift of power to the courts, which I believe, Justice Black that is, and am constrained to say will be bad for the courts and worse for the country. Justice Jackson, why isn't substantive due process analysis just another form of judicial policymaking, which you've suggested policymaking is not in your lane, and you strive to be apolitical, something I applaud. But why isn't substantive due process just another way for judges to hide their policymaking under the guise of interpreting the Constitution?
Well, Senator, the justices have interpreted the due process clause of the 14th Amendment to include a substantive provision, the rights to due process. They have interpreted that to mean not just procedural rights relative to government action, but also the protection of certain personal rights related to intimacy and autonomy. They include things like the right to rear one's children, I believe the right to travel, the right to marriage, interracial marriage, the right to an abortion, the contraception. These
treating slaves as chattel property?
I don't quite remember the basis for the Dred Scott opinion, but I'll trust you that that's...
Well, the fact is it not, that you can use substantive due process to justify basically any result?
Well, the court...
Whether it's conservative or liberal, libertarian, or conservative, whatever you would like to call. It's just it's a mode of analysis by the court that allows the court to substitute its opinion for the elected representatives of the people, and would you agree?
The court has identified standards for the determination of rights under the 14th Amendment substantive due process.
And who gives them the right to do that? If it's not mentioned in the Constitution, where does the right of the court to substitute its views for that of the elected representatives of the people, where does that come from?
Well, the court has interpreted the 14th Amendment to include this component, the unenumerated right to substantive due process, and the court has said that that the kinds of things that qualify are implicit in the concept of ordered liberty, or deeply rooted in our nation's history and tradition. Those are standards that identify a narrow set of activities.
Well, Judge, in the Oberfeld case, Justice Roberts, in his dissent, noted that the court invalidated marriage laws of more than half the states and orders the transformation of a social institution that has formed the basis for human society for millennia. So that was the basis for the institution of marriage, is the practice for millennia and the recognition that marriage was between a man and a woman. Now, don't get me wrong, I'm not arguing the merits or lack of merits of same-sex marriage. I believe the states and the voters can choose what they will, and that's their prerogative, and I think that's legitimate. But when the court overrules the decisions made by the people, as they did in 32 of the 35 states that decided to recognize only traditional marriage between a man and a woman, that is an act of judicial policymaking, is it not?
Senator, the Supreme Court has considered that to be an application of the substantive due process clause of the 14th Amendment.
Right. And it doesn't, the Constitution doesn't mention anything about substance when it talks about due process. The 14th Amendment and the 5th Amendment don't talk about substantive due process. It talks about due process of law. Correct?
Correct.
Well, one of the things that concerns me is here is an example of the courts finding a new fundamental right that is mentioned nowhere in the document of the Constitution. That's the product of simply court-made law that we're all supposed to salute smartly and follow, because 9 people who are unelected, who have lifetime tenure, whose salary cannot be reduced while they serve in office, they decide, 5 of them decide that this is the way the world should be. What other unenumerated rights do you believe exist? And how could we possibly anticipate what those might be? For example, the 9th Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people, which suggests to me that there are other, as yet unidentified, rights out there, and somehow, someday, some court is going to tell us we've identified an unenumerated right, and we're going to reject the right of the American people to determine what the policies ought to be as regards that right, because we, the 9 people sitting on the Supreme Court, have decided we've discovered a new unenumerated right, and it shall be the law of the land, and no legislature can pass any law that conflicts with it. What other unenumerated rights are out there, or can you say?
Senator, I can't say. It's a hypothetical that I'm not in a position to comment on. The rights that the Supreme Court has recognized as substantive due process rights are established in its case law.
But, Your Honor, this is not a trick question.
Oh, I understand.
Okay.
I'm just not in a position to speak to the.
Well, can you understand why ordinary folks wonder, who do these people think they are? And where does this authority come from? I think the authority comes from we the people. That's the source of legitimacy of government. But when the courts decide to identify an unenumerated right and negate anything that conflicts with it, can't you see how they might feel that this is illegitimate or a sort of policy making that you have disavowed by saying that you don't want to make policy, you want to stay in your lane? Can you understand the concern?
Absolutely, Senator, I do understand it.
And because I believe the court's legitimacy is very important. That's why I agree with Justice Breyer that notwithstanding what anybody else says, that should be an aspirational goal of the judges, because we're all concerned about the legitimacy of our institutions, and particularly, I would say, the institution of our judiciary. So how do you as a judge, when you are approaching your decisions, how do you try to avoid being seen as a policymaker by embracing doctrines like substantive due process, which is essentially gives judges carte blanche to do whatever they want?
Well, Senator, I've not had that particular situation, but I have a methodology that is designed to avoid my importation of policy perspectives. The judges are constrained in our system. That's part of the constitutional design. And so in all cases, I am looking neutrally at the arguments of the parties, and presumably in a case like this, there would be arguments made on both sides of the issue.
Well, Your Honor, if you'll forgive me.
Yes.
One reason I think the Supreme Court's different is because in your previous capacity as a trial judge, of course, you were bound by circuit court precedent. And on the circuit court, you're bound by the Supreme Court precedent. But as a member of the United States Supreme Court, you will be bound by nothing. You will be unaccountable to the voters. And so you said you can.
Well, respectfully, Senator, I mean, yes.
So you're not going to be able to find the answer in some law book somewhere. You're going to be presented with a case, and the argument's going to be made. This is an unenumerated fundamental right, and the voters, whatever they've said, is irrelevant, because we, 5 members of the Supreme Court, are going to decide what the law of the land should be, and anybody who disagrees with us will be labeled a bigot or be accused of discrimination, even if their beliefs happen to flow from sincerely held religious conviction, like the definition of a marriage between a man and a woman. But you've already told me that you see why this is a concern.
I see why it is a concern, and I would just say that although the Supreme Court is not, bound in the sense of having to apply prior precedent, there is stare decisis in our system. There are now standards in the stare decisis world that the Supreme Court applies when it's asked to.
Thank goodness the Supreme Court has been willing to revisit its precedent, or we'd still be living with Plessy versus Ferguson or Dred Scott. One of the things Senator Whitehouse and I agree on is he and others frequently ask nominees for the Supreme Court, do you think Brown versus Board of Education is settled law? And believe it or not, some nominees won't answer the question. I mean, it boggles the mind. I tend to think that nominees from both parties tend to be overcoached and not and told you can't be. If you don't answer the question, you have a better chance of being confirmed. But some of these things are obviously settled, and I wish we had a more candid conversation about the source of the power that unelected lifetime tenured judges have to basically rule America when they decide that something is an unenumerated fundamental right. Let me, in the 48 seconds I have, ask you about a specific case. You remember U.S. versus Brown? This was a guilty plea, and where you were asked to assess a punishment. And at one point in the proceedings, you said, "I'm going to state for the record, however, that this court has a long-standing policy disagreement with the criminal history guidelines with respect to the application of the 2-point enhancement." Do you remember when you said that?
I don't remember that particular statement.
How is that policy disagreement different from other disagreements where you said that you're not going to get out of your lane, you're not going to get into the policy lane?
Yes, Senator. The Supreme Court in the sentencing realm has made the guidelines, the sentencing guidelines, advisory. They used to be mandatory. Judges used to have to calculate the guidelines for sentencing purposes and then essentially apply a sentence within the guideline range. In a case called United States versus Booker, the Supreme Court determined that the guidelines are advisory now, so they don't have to be applied in every case. You have to calculate them, but judges have more freedom to give effect to Congress's the various provisions in the statute related to sentencing. In Booker and in its progeny, the Supreme Court made clear that judges at sentencing.
Judge, I only have a limited amount of time, so let me just close on one other question, and forgive me for interrupting
Yes.
you, but there's such a thing as a judicial filibuster too.
Sorry, I was trying to get to the point.
Let me just ask. I don't know you well, but I've been impressed by our interaction, and you've been gracious and charming. Why in the world would you call Secretary of Defense Rumsfeld and George W. Bush war criminals in a legal filing? It seems so out of character for you.
Senator, you may have been are you talking about briefs or habeas petitions that I filed?
Talking about when you were representing a member of the Taliban, and the Department of Defense identified him as an intelligence officer for the Taliban, and you referred to the Secretary of Defense and the sitting President of the United States as war criminals. Why would you do something like that? It seems so out of character.
Well, Senator, I don't remember that particular reference, and I was representing my clients and making arguments. I'd have to take a look at what you meant. I did not intend to disparage the President or the Secretary of Defense.
Well, being a war criminal has huge ramifications. You could be subject to the jurisdiction of the International Criminal Court and hauled before that international tribunal and tried for war crimes. So it's not a casual comment, I would suggest. Thank you.
Thank you, Senator Cornyn. Senator Whitehouse.
Thank you, Chairman. Judge Jackson, good to be with you again.
Good to be with you.
I know that a great many people are extremely proud that you are here today. I don't know that there are a great many who are prouder than Bruce Selya. And so, with your permission, I'll take a moment and offer into the record some of his comments about you, and then maybe give you a chance to reciprocate with a word about him. But yesterday in my opening remarks, I mentioned the Boston Globe article in which Judge Selya said that about you, she has absolutely everything you would want in a Supreme Court justice. She has all the tickets in terms of her intelligence, her education, her work experience, and her demonstrated judicial temperament. I see some of the same qualities in her that I saw in Ruth Bader Ginsburg: humility, the ability to inspire others in a quiet way, not at the top of her voice. Some people have the capacity to inspire by example and the force of their reason. Intellectually, she is very smart, very well informed, and she is very hardworking and focused. She gets the big picture. May I ask unanimous consent that the Globe article be admitted into the record?
Without objection.
But he didn't stop there, Your Honor. He went on to WPRI, a local station in Rhode Island, and said about you, she's worked hard. She deserves it. And I literally don't think that the president could have made a better choice. I think she'll be a terrific addition to the Supreme Court. She listens to what other people have to say, but makes up her own mind. She has a very scholarly approach toward the law. She has a very winning personality. She's kind to the people she comes in contact with, and she has a certain humility that I find very attractive in people. May I ask unanimous consent that the statement from WPRI be put into the record?
Without objection.
Judge Selye went on Law 360 and said, I sense that she has the same sort of desire to achieve consensus and a pragmatic streak that has characterized some of Justice Breyer's work. I think she will be quite balanced. I have not found her to be an ideologue. She understands what the job of being a judge or being a justice is. She wants very much to do it in the right way, and she will bend her considerable talents to that direction and won't get distracted by any extraneous considerations or side issues. I think the country will appreciate that, and will appreciate that this is a woman who understands the importance of the position and will give 100% of her talents every day to do that job in the right way and in accordance with her oath of office. Unanimous consent that that be put into the record?
Without objection.
And then finally, the Providence Journal, our home state newspaper, Katie Mulvaney, in an interview, heard Judge Selye say, I think it's a terrific appointment. She's a very thoughtful person and wonderfully well qualified. I'm happy not only for her, but for the whole country. She listens well, she gets the whole picture, has great respect for the rule of law. I think she's got the whole package. Unanimous consent that that article be put in the record.
Without objection.
So, any reflections on Judge Selye?
Oh, well, that was very moving. Thank you, Senator, for reading his lovely remarks. It's exactly who I know Judge Selye to be, always eloquent, always insightful, and I'm so flattered by his admiration, because he is someone that I have admired my entire professional life. He taught me how to look at issues very carefully, how to write in a lot of ways because of the way in which he's so fastidious with his opinions. And he's been an extraordinary mentor and role model for me.
Well, we are very proud of him in Rhode Island. As you know, he's on senior status, and when he went on senior status, we were able to recommend the Rosary Thompson to succeed him, of whom I think Rhode Islanders are equally proud, and she has now gone on senior status. And Mr. Chairman, I hope we'll be considering shortly an equally impressive Biden nominee for her position. On an unrelated subject, and it relates to yesterday's activities. You can relax a moment, Your Honor. This will not be a question for you, but a lot was said in this room yesterday about dark money by our Republican friends, to the point where one of the headlines about yesterday read, Republicans hammer dark money groups. And I'll be the first to concede that there is dark money on both sides, and I hope very much we can get rid of it on both sides shortly by legislation. But there is a difference, I believe, between a dark money interest rooting for someone and right-wing dark money interests having a role in actually picking the last 3 Supreme Court justices. Now, how do we know that they had a role in doing that? Well, we know because everybody involved said so. It was pretty straightforward stuff. President Trump said we're going to have great judges, conservative, all picked by the Federalist Society. That's pretty plain. Senator Orrin Hatch, the former chairman, was asked, some have accused President Trump of outsourcing his judicial selection process to the Federalist Society. I say, damn right. The co-founder of the Federalist Society said that the administration is relying on the Federalist Society to come up with qualified nominees. And then Don McGahn, who ran the operation for Trump in the White House, said, "I've been a member of the Federalist Society since law school, still am, so frankly, it seems like that role has been insourced." So there's pretty clear and pretty broad agreement that that selection process took place out of the public eye, and it appears to have been informed heavily by dark money interests. They were not alone in saying this. Here's Laura Ingraham on Fox News, concerned about abortion cases coming up before the court. "We have 6 Republican appointees on this court. After all the money that's been raised, the Federalist Society, all these big fat cat dinners, if this court with 6 justices cannot do the right thing, then I think it's time to circumscribe the jurisdiction of this court. That's the way to change things finally." So we have people who are in a position to know what was going on behind the scenes describing the 6 Republican appointees on the court who got there after all the money that has been raised, the Federalist Society, and all these big fat cat dinners, and threatening that if they don't do what she considers to be the right thing, they'll be punished by circumscribing the jurisdiction of the court. That's pretty big talk, but it's backed up by pretty big dollars. If you go back to before this enterprise got underway, the money that came into the Federalist Society from what's called Donors Trust, which has been described as the dark money ATM of the right, a Koch brothers affiliated operation. Back, say, in 2002, it got $5,000. No big deal. By 2019, when this operation was in full swing, it got $7 million. We don't know who the real donor was because that's the job of Donors Trust, is to de-identify the donor, to launder the identity off the donation so you can't connect the dots any longer. But $7 million, I think, is quite a lot of money. And unfortunately, the Federalist Society was not alone. Right down the hallway is something called the Judicial Crisis Network. Its office is on the same hallway as the Federalist Society in the downtown Washington building, although JCN's website and tax filings list a mailing address at a different location, an address shared by multiple companies. And right down that hallway at that Judicial Crisis Network, there's even more money pouring. And here's how much poured into the last 3 nominations via the Judicial Crisis Network. $21 million related in time to the Gorsuch nomination, $17 million to the Kavanaugh nomination, $14 million to the Barrett nomination. And of course, we don't know who the actual donor is. Could be the same donor, who knows? And because we don't know who the donor is, we don't know what business they might have had before the court. And I think it matters when people are seeking to influence the makeup of the court that the public understand what business they may have before the court. And anonymity hides all of that. And they didn't stop with the Trump nominees. They got up on the air, a dark money group using dark money to accuse Biden's Supreme Court nominee, at that point a player to be named later. Judge Jackson had not been selected at this point, of being a tool or stooge of liberal activist dark money. This is a screenshot from their advertisement paid for by the Judicial Crisis Network. So it's worth understanding for a moment what the Judicial Crisis Network is and where it lies. And it lies in a network of organizations. The prevailing way that political mischief is accomplished these days is with a paired 501c3 and 501c4 organization. The 501c3 gets the tax deduction, the 501c4 gets to participate in political activity. And sure enough, there's an 85 fund and a Concord fund that are twinned together as a 501c3 and 501c4 organization. And they filed under Virginia corporation law to operate under what they call fictitious names. That's the term of law under which they file, fictitious names. And there's the Judicial Crisis Network, one of the fictitious names of the Concord Fund. It has a parallel judicial education project that is a fictitious name of the 85 Fund. If you're interested in voter suppression, you can move down to the Honest Elections Project Action, another fictitious name, and its 501c3 twin, the Honest Elections Project. And they've even got new ones that are less active, Free to Learn Action and Free to Learn. So these are 8 organizations that are essentially one organization. As lawyers, we think from time to time about piercing the corporate veil. That's corporate veiling that you could pierce with a banana. And it runs back and forth with 3 groups called CRC Advisors, CRC Strategies, and CRC Public Relations that take and send money to these organizations as part of the sort of planning element. You might say that CRC Advisors, CRC Strategies, and CRC Public Relations, this trio, is the command center, and this is the operational torso of the creature. So I show this all because it shows considerable effort when somebody goes to that much trouble to create that many organizations to hide how much money they've spent to control the nomination process to the court. And it's no small amount of money. In the original Washington Post research, they pegged it at $250 million. Further research led to testimony in my court subcommittee that the number was actually $400 million. And we have a recent report that we haven't fact-checked that the number is actually even higher than that. So I may amend this number upward once we're done with our fact-checking. $400 million funding conservative activists' behind-the-scenes campaign to remake the nation's courts. That operation is a very different thing than a group rooting for somebody. And I want to make sure that that difference is clear, since our friends on the Republican side have made dark money such a big focus of their attention already. There is a drastic difference between rooting for somebody and controlling the turnstile that decides who gets on the court, controlling the funding of the political campaigns that pursue the folks on the court. And actually, once you get on the court, we're working now with the judiciary itself to try to clean up the mess of that same anonymous money appearing before the court through phony front groups that file amicus briefs in little flotillas, or if it's an important enough case, in a full armada of dark money funded front groups. So that bears not at all on this nominee, but because this is a very public forum and because we've heard all that so-called hammering of dark money groups, I wanted to make sure that it was clear to everybody how this game is played and what the difference is in the way the two sides play it. So now, back to our business, Judge Jackson. You have served as a trial court judge.
I have.
You have served as an appellate court judge.
I have.
And with any luck, you are on your way to serve as a Supreme Court justice. Now, one of the things that is very different about trial court judges and appellate court judges is what their role is with respect to fact-finding. It's my belief from my time spent as a practicing lawyer that the role of fact-finding belongs at the trial court level. That's where you can look the witnesses in the eye. That's where the evidence can be amassed. That's where the trial judge has the responsibility of sifting through it. If there's a jury, then the jury, of course, is the ultimate fact finder. But if you're in a non-jury trial, the trial judge is the fact finder. Then the case goes up on appeal, and it comes up with a record of fact in the case. And in my view, that record of fact that comes up to the appellate court is actually a constraint on the power of the appellate court to go wandering off. The court is obliged to consider the appeal based on the factual record that was adduced in the district court. So you, having lived in both of those houses, the trial court house and the appellate court house, tell me a little bit about what that change meant to you as you went from being a trial judge to an appellate judge.
Thank you, Senator. It is a really big difference. As you mentioned, at the trial court, you are on the ground level. Parties have filed the case. You have all of the issues usually at the trial level because you'll have the complaint if it's a civil case, and there'll be a lot of litigation about the development of the facts in the case. In civil cases, you have a period of discovery in many cases that is really about the development of the record, what actually happened in this case. Sometimes there's even a trial, and that too is a part of the development of the facts in the case because a jury will be charged with the responsibility of determining what happened, who's guilty, for example, if it's a criminal case, or who's liable, if any, if it's a civil case. And sometimes there are even questions presented to the jury that they have to determine the facts. At the appellate level, as you said, there is already a record, and the court is looking primarily at the law, the legal principles that guided the decision below based on the factual record. And importantly, at the appellate level, there are standards of review that the Court of Appeals applies when it decides how to review whether or not to reverse or affirm the judgment of the lower court. And I've been very mindful, especially as a trial judge, of the standards of review.
When I was prepping lawyers for oral argument before appellate courts, I would often say, please don't quarrel with the facts unless you have a knockdown case, because if you want to get the appellate court to relitigate the facts, you're up against the harshest standard of review available, the clearly erroneousness test. And clear error is no small thing. Outside of that narrow finding by an appellate court that somehow the district court got it wrong, filtered through that clear error standard, are there other circumstances in which it's proper for appellate courts to do their own independent fact-finding outside of the record of the case that they're reviewing?
I am not aware of any. There may be, but in my experience, the fact-finding is done at the trial level. The Court of Appeals only looks at facts under standards like clear error. And so therefore, the record is usually set and established by the time you get to the Court of Appeals.
Yeah. And I think that it's actually one of the constraints on the judiciary that they don't get to go and do free-range fact-finding. They have to be tethered to the record of the actual case before them. It's related to the case or controversy requirement.
That is correct, Senator.
And in that regard, civil juries are, I think, something that Americans have prided themselves on for a long time. You go back to the colonial days, and the civil jury was one of the immediate imports from England. Every colony set up civil juries. When the Crown tried to interfere with the civil juries in the colonies, it became casus belli for the Revolution. It was in the Declaration of Independence of what the king had done wrong that offended the colonists and caused the Revolution. And the documents around the founding and around the creation of the Constitution all reflect passionate belief in the importance of the jury, including the civil jury, which, as you may know from your experience in the trial court, is getting to be a rarer and rarer creature. And in fact, there are trial judges who have written about how do we keep the civil jury alive? And I'd like to hear your thoughts about whether there's more to the civil jury than just a fact-finding appendage of the trial judge, whether it was seen by the founders and whether it belongs in our constitutional structure as a part of the responsible self-governance that was established by our Constitution.
Yes, Senator. It is part of our ordered liberty. It is a mechanism by which citizens can participate in governance. They can be called upon by the court to sit in judgment of other people in the community. And it was something that was a part of the democratic vision of the founders from the very beginning.
Blackstone was one of the legal experts who the early lawyers of the United States relied on. I suppose there were lawyers who had nothing but Blackstone's commentaries in the Bible on their shelf. And Blackstone described the jury as having a role to make sure that the power and clout of big and powerful interests could be protected against, that it was a refuge from the power of what he called the more powerful and wealthy citizens. There was long experience in government of corruption, whether it was getting to a chief executive and getting them to do things your way for improper reasons, or whether it was controlling a legislature, a legislative body. But the jury is fundamentally different because they don't stick around. They're there for one case and one case only, and then they disappear. You can't fix them so that they decide your way over time. And if in that one case you try to fix them, you've likely committed a criminal offense. Tampering with the jury is a pretty significant thing, is it not?
It is.
If anybody tampered with a jury of yours, how would you respond?
Oh, very seriously.
So the jury lives in a protected environment from a lot of the political power and the danger of corruption that the elected branches often suffer. And do you have thoughts about the importance of the civil jury in that regard as the bastion where people can go, where they'll get a square deal from regular citizens and can stand toe-to-toe with the lawyers for however big or mighty an opponent they may have, with almost no danger, let's put it that way, little danger, less than danger, of the fix being put in?
Well, certainly the jury system is designed in that manner, that citizens are brought in from the community. When we pick juries, we ask as judges, do any of you in this pool have any connection to anyone? You know,
So you screen them for conflicts of interest?
You screen them heavily. That's part of the, what we call the voir dire, the sort of.
We don't do that with people who come to Congress.
Well, in the court
They come with their conflicts of interest, often right on their lapels, sometimes hidden in their back pockets. But juries, not so, correct?
Not so. And in fact, that would be a reason to exclude someone from the jury. And we even ask, you know, do any of you, as judges, we say, do any of you know me? And if you do, you'll have to let me know and be removed. Because the idea, as you've indicated, is to get people from the community who have no connection to the case and can hear the evidence that's presented in the courtroom and the arguments
the lawyers and make a decision that is unconnected to any sort of personal interest they might have.
Protecting the jury against the dangers of bias or corruption, giving the parties before it a clean and fair shot.
Yes, Senator.
So, with any luck, you will be on the Supreme Court before long, and I hope you will remember all of this, because it seems to me that the court has been on something of a campaign to deprecate and diminish the civil jury, including by allowing big corporations to build into their standard contracts, buried way down in the fine print that folks often don't read, and even if they do read it, they'll never get through the phone tree to find somebody to complain about it and try to strike it out of the contract. It's a take it or leave it adhesion proposition, and they build into that you've given up your right to a jury, your Seventh Amendment right to a civil jury. It's right actually in the Bill of Rights. And I cannot think of another right that the court pays less attention to or throws more readily under the bus. If you read the mandatory arbitration cases, there's rarely a mention of the Seventh Amendment. And it seems to me that it flies in the face of the purpose of the jury to allow the citizens of the greatest power and wealth, who are today corporate citizens, to actually be able to take on the ability on their own through contracts that the customer has no chance to negotiate. The employee has no chance to negotiate, to actually take away that right that was at the heart of our founding without a squeak of objection or even notice by the court. And I think it's created a dramatic shift in power towards big corporations. And I think it has harmed innumerable employees and customers. So I am extremely happy that you have been able to answer these questions with such clarity about the role and the history and the value of the civil jury and its importance, not just as your fact-finding adjunct, but as an important part of our constitutional structure, part of our structured liberty as Americans. I wish you well. I'll see you again tomorrow. And thanks so much for your patience with all of us here today.
Thanks, Senator Whitehouse. And let me just say a positive word to follow up. This committee, in the last few weeks, has passed legislation signed into law by President Biden, which in cases of sexual harassment, provide that individuals who are complaining have the option of a jury trial, despite efforts to steer them into mandatory arbitration. It is the decision of the complainant, the venue that they will seek. I think that is a step in the right direction, and we've passed out of this committee on a bipartisan basis. And so I'd like to ask everyone to consider returning promptly at 1:30 for the much anticipated Senator Lee of Utah.
And so the Senate Judiciary Committee moves to a lunch break that's going to run a little under 40 minutes if they come back on time. You just heard Senator Dick Durbin of Illinois, the chair, referring to the plan for the afternoon. When they come back, it will be the turn of Republican Senator Mike Lee of Utah to resume questioning. For the last hour, we've heard from two senators. First, Republican John Cornyn of Texas, and then the Democratic senator from the state of Rhode Island, Sheldon Whitehouse. And Marcia Coyle, the analyst who's here with me in the studio, it's been a pretty civil hour. You and I were remarking it's been conversation about the role of a judge, the role of the jury, questions from Senator Cornyn about stare decisis, precedent, a lot of legal discussion.
Yes, with the exception maybe of Senator Graham, right? On Gitmo.
Oh, before the break, you're right. I just was referring to the last hour.
Oh, the last hour,
right.
yes.
The fireworks clearly came earlier this morning from Senator Lindsey Graham of South Carolina, where he spent a good bit of time remembering how other nominees have been treated and also talking about Guantanamo Bay. But some of what we're seeing here, I think, is it, Marcia, it's the workmanlike job of the senators to ask these Supreme Court nominees where they stand on the role of a judge.
Absolutely, and also, subjects like stare decisis, your judicial philosophy, these are standard areas. Your view of what are precedents, and certainly now in the lexicon of Supreme Court confirmations, what's a super precedent, always in reference to Roe v. Wade. And I think we'll hear some more of that as we go along. But we may be getting some more meatier exchanges with the judge when certain senators confine themselves not to a laundry list of issues, but just a few areas that they really want to probe. And I think stay tuned for the afternoon.
For sure. Lisa Desjardins, our congressional correspondent, has been listening to all of this. Lisa, each party, if you will, goes in, members of the Senate, Republicans, Democrats go in with a plan of what they want to get done. Of course, ultimately, it's up to each individual senator for how to execute that. But how would you say at this point, to your trained ear, is each side doing in executing their strategy?
I'm so glad you raised that, Judy, because I can report after I was talking to Senator Durbin about this yesterday, the Democratic strategy going into this hearing was different than the strategy we've seen for at least the last 4 nominees. We've seen Democrats before now really gather as a committee group of Democrats and say, kind of carve out the issues that each wanted to tackle, have a game plan so they weren't overlapping, but instead sort of reinforcing each other. This time, Chairman Durbin told me there is no such strategy, that each senator on the Democratic side sort of not allowed to, but will just ask what they will, being mindful that they don't want to repeat themes. And I think so far that concept, which is hinged on the idea that they have a strong nominee to begin with, seems to be working, that they're reinforcing her where they think it's necessary, and they're also trying to act as kind of, let's say, offensive linemen, I suppose you could say, for her against Republican attacks that are coming. And I think that is working well. So far, you see she's kept her consistent answers, which is exactly what we've expected. She is not moving 1 inch from the concept that she is not going to have an opinion on almost any matter before any court she's sat on, except for what she sees in the legal documents before her. Now, there obviously are going to continue to be questions about what is her judicial philosophy exactly. But she said it very clearly this morning. She doesn't fit any label. That's a problem for Republican senators in particular who are looking for labels, both for some judges on their side and judges appointed by Democrats. But I think so far, no dents have been made on this nominee yet. I think that the same difficult, divisive questions about our judiciary remain, and they remain unsolved. But we are hearing that debate in this hearing room, and it's fascinating to me. But I don't think this is a nominee whose status has been affected by this hearing. She remains a strong nominee, very well respected. It seems on her way to being confirmed if nothing else changes.
And it's not for lack of trying on the part of some of the Republicans, in particular, as we were just mentioning, Senator Lindsey Graham, Lisa of South Carolina, who spent a good bit of time on Guantanamo Bay and Judge Jackson's role when she was both an assistant public defender, federal public defender, and then in the private sector as a private lawyer representing Gitmo, Guantanamo Bay detainees. Clearly, there was an effort there by Senator Graham to have her express her sympathy for the detainees, but she was very careful not to go there.
Right, and I think we're also going to hear a return to the idea that she filed a brief in which she accused former President George W. Bush, former Defense Secretary Donald Rumsfeld, of being war criminals for the way they were detaining those in Guantanamo Bay, that they were against their rights. But I think what Marcia said, we'll see if she puts that out there, that this was a time where lawyers on both sides of those questions were in uncharted territory. And clearly, we haven't seen her directly answer that idea of war criminals, but I think at this point what she's saying consistently is, I was arguing a case on behalf of defendants. I do think that idea is going to come up again. Guantanamo Bay probably will come up again. It's interesting to me some things that haven't come up yet, though. The Don McGahn case, for example, in which she ruled as an appellate court judge that the President Trump's former chief of staff had to testify before Congress. That was overturned. And I thought that we were going to hear about that this morning. Haven't yet. Lawmakers seem more focused on sort of personal conviction issues like Guantanamo Bay, abortion, gay marriage, states' rights. Those things are what we're hearing about.
The Obergefell case and others, of course, the questions about precedent, stare decisis, pointing to potentially the role of the Supreme Court, critical role right now, we know, in looking at to what extent they're going to be rolling back reproductive rights in this country. Jeff Bennett at the White House, you were telling us earlier in the morning break that they're watching this very closely. The president himself has been trying to pay attention, even as he's dealing with Ukraine and so many other issues, but in particular what's going on in Europe right now and the Russian invasion of Ukraine. But reminding us, as you said earlier, of why they chose this judge over the others that they were looking at, why they chose her, and the confidence they had to have that she could make it through this tough confirmation process.
That's right, Judy. And as I was standing here listening to Lisa, I was texting with a Democratic aide close to this process, and this person said that one of the reasons why Judge Jackson was selected has been evident in now these 2 days of hearings. And this person said that she's steady and that she's tested. Not to say that the other two frontrunners wouldn't have been as equally steady and tested, but that she, Judge Jackson, was a known quantity both to White House officials, President Biden, and also to Democrats on the Hill. And so that, she's very adept at not sort of falling into any sort of political trap that one of the questioners might lay for her. And it's also true that Judge Jackson has no record of rulings, writings, or speeches on 3 hot-button issues: abortion, gun rights, and religious freedom. Now, I'd imagine you'll hear more questions on those 3 specific topics for the rest of the day and tomorrow, but there's nothing in the public record that the senators can point to try to pick apart, at least in terms of the direct questioning and any sort of paper trail or a sort of oral history from her that they could point to.
Very good point, Jeff Bennett. At the same time, she does have years of, 500 and some odd opinions that she helped or was involved in deciding as a federal district judge, a trial judge, and then in her brief, less than a year experience on the appellate court. There's a lot of that to work on, and we're hearing about that. And as we've just been mentioning, her role as a public defender and as a private attorney.
Right, and going all the way back to her time at Harvard, you heard Senator Graham mention a speech given by some controversial speaker that she might have attended as a member of the Black Student Union. And you heard her response was to say, I have no recollection of that except for what I was told in my preparation. And what she was speaking to were these hours-long prep sessions where members of the White House staff and some Democratic aides from the Hill had been holding these mock sessions where they were digging into those hundreds of pages, hundreds of rulings and things that she had written and done, even as an undergrad and as a law student, to try to remind her of anything that might be in any way controversial so that she could fully respond to it.
And it is not the first time that a Supreme Court nominee has been asked about what he or she wrote or said or did as a college student or a law school student. John Yang, are you with us? John Yang, you're not quite with us yet. We're going to come back to you later. I do want to bring in 2 analysts who are joining us today. Victoria Nurse, she's a professor at the Georgetown University Law School, previously served as chief counsel to then Vice President Joe Biden and as counsel to the Senate Judiciary Committee when he was its chairman. And Sai Krishna Prakash, he's a constitutional law scholar at the University of Virginia. He's also a former clerk to Justice Clarence Thomas. It's very good to have both of you with us. I want to ask you both and start with you, Victoria Nurse, about what we heard at the beginning of the day under the questioning from Chairman Dick Durbin from Judge Jackson about her judicial philosophy, how she approaches cases. And she went about it in a very sort of methodical way, saying, here are the 3 things that I look at. I'm curious to know what you made of that.
Well, this is very important for, there are 6 justices now who believe they have a methodology called textualism or originalism. That's the term we use in the academy and they use on the court. And it's very important for her to respond with her own methodology so that she appears to be in her own lane, as she said, so that there are constraints. She's not doing what senators do, make up policy, decide she likes this person, decide she wants to rule for that corporation or for that individual, that she has guiding principles so that she can remain impartial. I think we're going to hear from Senator Lee about whether that philosophy is consistent with textualism and originalism as we move forward.
And what about Sai-Krishna Prakash? Tell us from your perspective, what did you make of that? Again, I mean, to me, I mean, as someone who's not trained in the law, she was very careful. And then later, when someone else asked her about it, she was about to go back to those 3 points again. What did you take away from that?
I think, Judy, she did a remarkable job with all her questions. And on the question of methodology, she said a number of things that Republicans and conservatives can take to heart. She talked about judicial restraint. She talked about proper judicial role. She talked about original public meaning, and she seemed to be wary of the idea of a living constitution. And so these are all welcome statements from the nominee and are smart things to say for someone who wants to join the Supreme Court.
Victoria Nurse, we heard our own Lisa Desjardins say a minute ago that at this point, we have a justice nominee who seems to be holding up. She's heard statements from all 22 senators. She's only had questions from 7 of the 22. The other 15 get a chance this afternoon and this evening. It is expected to go into the evening. But how do you think she's holding up so far?
I think she's holding up really well. She has a wonderful temperament, a way of being extremely clear. I'm envious. She smiles, and you know, it's odd for them to be in this situation. You know, I work for the committee. It's odd for a judge to hear some of the senators talk about issues that might seem irrelevant to the Supreme Court. I mean, she can't determine what happens at Guantanamo. That's a political question. And so it might seem odd. That's why I think Senator Feinstein was saying you're doing very well, encouraging her, because it's very strange for them. It's not like a courtroom. It's a very, very different space where the senators are often talking to their own constituents about, oh, my preferred candidate might be someone else, or, oh, I care about the civil jury and dark money, which was Senator Whitehouse. They all have their issues. And often that seems, you know, not the key thing to judicial methodology, to important constitutional issues, which they've been briefed on. So I feel like she's doing a very good job in terms of her temperament and her ability just to sit there and let those things wash over her head and realize that they're not really about her. They're about the constituents of the senators.
And Sai-Krishna Prakash, looking to this afternoon and tomorrow, from the conservative perspective, what more do you want to try to draw out from her? What do you want to ask her to explain or to defend, for that matter?
Great question, Judy. I would have her speak more about her philosophy. I think trying to get her to opine on Marbury versus Madison or Roe versus Wade is just a waste of time. She knows that she shouldn't answer that question, and she's smart enough not to answer those sorts of questions. So focusing on the philosophy that she brings to the court, what kinds of things she thinks are relevant and irrelevant, or is international law relevant to understanding our Constitution, et cetera. I think those more general questions matter more than asking about specific cases. I also think that, you know, I think Victoria's right that many of the senators are speaking to their constituents or speaking to, you know, the American public for a possible run in, you know, in 2 years for president.
I do. We've spent a fair amount of time, and it did get a lot of coverage overnight. Victoria Nurse, I want to come back to you on this whole notion of her ruling, her sentencing decisions around individuals who are convicted of child pornography. I was struck by her, I think you have to say, impassioned defense or explanation of where she was coming from when she was making those decisions earlier in her career. as a member of the Sentencing Commission and the work she did in that field. It strikes me that that you can, in explaining what you did, you can convey something to the American people who are watching this and who may only read a headline that says Republicans accuse her of being soft on child porn, that was something that was important for her to try to get across.
I agree, and I thought her explanation was quite persuasive. Based on what I know about, I taught criminal law for about 15 years. This happens all the time. What happens is that the legislation gets outdated, and you need to update it depending on technology, and so you have to deal with these questions. Now, I think that basically the notion that the International Chiefs of Police and the Fraternal Order of the Police, her brother's a policeman, I think that she has a lot of credibility on this. I think if we'd seen a pattern of her rulings and sentencing that was really very much too generous, that we'd know more about that before now. She might not have even been nominated, to tell you the truth. Senator Hawley mentioned 7 cases, but she's decided more than 500. So it's a small sample, and some of them were about for 5 years for child pornography. So, and they're different. You know, all these cases could be very different, and she understands that. She's very gifted at explaining her own rulings with great precision. I'm a student of her McGahn decision, and I've written about it. It's very long, and but it's very clear. And I think the more chance she has to explain any particular rulings, that she'll be rock solid on those.
Sai Krishna Prakash, what about you? Do you see a vulnerability there in how she ruled, what she said at the time those cases were being heard? We assume that Senator Josh Hawley of Missouri is going to go back at this today. This has been one of his principal areas of focus. It's what he spent a lot of time on yesterday.
Judy, I don't see a vulnerability there because I think she's doing a remarkably good job answering the questions. I think she has the votes already. And I think Republicans don't want to shoot themselves in the foot. The most aggressive questioners will likely be those Republicans who want to run for president in 2.5 years and who might believe that they have to make a name for themselves in this hearing. And, you know, more generally, Democrats are perceived as being softer on crime, and these sort of questions play into that view, but I don't think she's vulnerable at all. I fully expect her to be confirmed.
All right, I'm going to come back to the two of you in just a minute, but right now to Marcia Coyle, who's here with me in the studio. Marcia, you've been listening to all of this. You heard all of yesterday, this morning. There's still a long way to go in these hearings. At this point, is she holding her own? Is she raising questions? What do you see?
I think she's definitely holding her own. I think her responses in terms of the child pornography sentencing was really, quite good, and was a combination of, personal experience, passion, as well as what was happening in the law at the time and on the Sentencing Commission. So I thought that was rock solid. The Gitmo area, that may be harder for some Americans to grasp, but I think she also handled that well. So I'm wondering, what else we're going to hear as we go forward. You mention often that she's written over 500 and some opinions.
Right.
So there is a lot there. I'm sort of hoping for questions about some of those opinions to learn more about how she has ruled in areas like the environment, labor, and maybe we will see more focus on individual opinions as they go forward.
There's a lot more there to talk about and to look at. We are in the middle of a roughly 40-minute break, a lunch break the Judiciary Committee is taking before they come back for questions from the senators. I want to play right now, it's almost a 3-minute clip from this morning while Senator Lindsey Graham of South Carolina was questioning the Judge Jackson. And I think everybody would agree this is the moment this morning. I'm sorry. Oh, this is a different chunk of this morning. It's when Senator Durbin was speaking with with Judge Jackson. This is at the outset of today's hearing. Let's listen to this and come back and talk about it.
Let me address another issue that came up yesterday in the opening phase of this nomination hearing, and it's the issue involving child pornography. I want to turn to that issue because it was raised multiple times, primarily by the senator from Missouri. And he was questioning your sentencing record in child pornography cases that do not involve the production of pornographic material. They're known as non-production cases. I wanted to put some context here. The senator from Missouri has, in his tweets, said of your position on this issue, Judge Jackson has a pattern of letting child porn offenders off the hook for their appalling crimes, both as a judge and a policymaker. She's been advocating it since law school. This goes beyond soft on crime, the senator said. I'm concerned this is a record that endangers our children. I thought about his charges as I watched you and your family listening carefully yesterday, and what impact it might have had on you personally to know that your daughters, husband, parents, family, and friends were hearing the charges that your implementation of this law, sentencing, endangered children. Could you tell us what was going through your mind at that point?
Thank you, Senator. As a mother and a judge who has had to deal with these cases, I was thinking that nothing could be further from the truth. These are some of the most difficult cases that a judge has to deal with because we're talking about pictures of sex abuse of children. We're talking about graphic descriptions that judges have to read and consider when they decide how to sentence in these cases, and there's a statute that tells judges what they're supposed to do. Congress has decided what it is that a judge has to do in this and any other case when they sentence. And that statute doesn't say, look only at the guidelines and stop. The statute doesn't say, impose the highest possible penalty for this sickening and egregious crime. The statute says, calculate the guidelines, but also look at various aspects of this offense and impose a sentence that is, quote, sufficient but not greater than necessary.
So there you have it, an excerpt from this morning's testimony by Judge Jackson at her confirmation hearing. Just a sampling of how she's dealing with some of the worst of the charges that have been leveled at her by Republicans on the committee. In this particular case, it was Senator Dick Durbin, the chair, Democratic chair of the committee, repeating what the charges brought up yesterday by Josh Hawley of Missouri. John Yang, we can expect that this is something that Senator Hawley is going to continue to talk about.
That's absolutely right. I mean, this is what he's made his case on. He started with a long tweet last week about this, and he was the basis of his opening statement yesterday. I just want to note that the way she responded, I thought, was notable. It was not a law school law review answer in which she stuck to the law and what the sentencing guidelines say and that sort of thing. She talked about brought home the sort of the flesh and blood of the victims. She also talked about the victim impact statements that she got in those cases. It really shows that either she or the White House managers of her nomination understand that this is more than just a legal debate. This is a political debate, that this is a political forum that they're in this hearing. I also want to get back to the talk about that Judge Jackson, as an attorney, accused President George W. Bush and Donald Rumsfeld, then the defense secretary, of being war criminals. What this appears to be is a habeas petition that she filed on behalf of a Guantanamo detainee when she was a public defender. In other words, she was assigned to handle this case. And in that habeas petition, habeas corpus is saying, asking for the release of someone from imprisonment. The allegation was made that the detainee had been tortured in contravention of international law. The respondents, the people who were being sued in this case, included President Bush and Donald Rumsfeld. So it appears that her critics are saying that by inference, she said that they were war criminals.
That's I'm so glad you brought that up, John, because I wanted to ask all of you about that. And I want to come back quickly to Marcia Coyle, because Marcia, you raised that when we were discussing what Senator Cornyn brought up in his questioning. If you're the public defender and language like this comes up in the case, how much are you responsible for putting that language in there?
Well, I think what John just said, I'm not sure she actually used the words war criminal. The inference was relating to the torture of detainees. And that is in contravention of international law. And if you do that, you can be a war criminal and hauled before the International Criminal Court. So I think that what was happening with the habeas petition that she was writing was, once again, she was making as zealous an argument as she could on behalf of that detainee at a time when some of these issues were still percolating in the lower courts, in the Supreme Court, and her responsibility was to zealously represent her client, and that's what I'm sure she would say she was doing.
And she emphasized, I know at several points, she said it was early in this process of understanding. She talked about the work she did soon after 9/11 and then defending.
Right, and they didn't have much information either, because so much of the information was still classified. So they could only go on what they had to make their case.
She was saying, excuse me for interrupting, she was saying we didn't have the facts and we were trying to build the case, the law was developing.
Right.
Lisa Desjardins, I understand you have a little more information about what some of the Democratic senators are saying about this.
That's right. Our producer Ian Cousins spoke with Senator Durbin while you and I were talking here. And Senator Durbin told him this about that war criminal allegation. He said that that is perilously on the edge. Essentially, Republicans were flirting there with crossing a line and going too far, making an allegation that they shouldn't, perhaps that they couldn't support. It's something that he thinks is going too far. And Durbin's office is also giving a lot of rapid response to many of the questions that have already been asked or that they anticipate, more on that idea of her sentencing of a child porn offenders. They sent out something that I don't know if he will say in the hearing. So I'm always nervous when I'm repeating something that senators aren't saying in public, but this is attributable to Senator Durbin's office. They're tossing that back at Senator Hawley, who's raising that idea that her sentencing was too low. They're saying that Judge Jackson's sentencing was right in keeping with not only the cases in the U.S. District Court on which she served, but also on the cases in which state? Missouri. They're also pointing to a judge that Senator Hawley himself recommended for the federal bench and saying that this other judge similarly gave sentences that were lower than recommended sentences, almost very similarly to what Judge Jackson did. So they're saying here, Senator Hawley, you know judges, you have supported judges who've done this same thing.
Yes, which of course goes back to what Senator Graham was saying about, what is it? He said at one point the 31% you referred to goes back to 2009, and he was comparing it, as you said, with what judges in other states have handed down. Let's go back to our analyst, to Victoria Nurse, Sai Krishna Prakash. We've been spending a lot of time in the last few minutes talking about the issues that became, shall we say, the most headline grabbing over the last 2 days, child pornography, war criminals. Victoria Nurse, but as Marcia Coyle points out, there's a lot more to Judge Jackson's record than this.
Right. And what's fascinating, and I think Professor Prakash would agree with me, that we haven't really gotten to her opinions. We've gotten a lot of some of the sentencing issue, but she's written over 500, and it would be interesting to know, as Marcia said, where she was ruling on the environment, labor, individual rights, that religion, for example. It would be very interesting to know that. As for we're going to hear more about the war criminal business, and I expect that this is close to a misquotation. At the time, and you have to look back, the dean of the Yale Law School said that Guantanamo was a law-free zone. There was only one precedent on the books involving World War II. There was no real law. People were making arguments that were basically saying the administration was violating international law, and that's why you could infer that they might be a war criminal. I think it's a real reach myself. I haven't read the brief, but I think we'll hear more from her about it, explaining it just as she did with the child pornography.
Sai Krishna Prakash, does this, I think we talked about this a moment ago, but does this add to our understanding of who she is and how she would rule as a justice on the Supreme Court?
Only marginally so, Judy. I agree with Victoria that they really haven't focused very much on her opinions. They focused on the sentencing question, and they focused on her work as an advocate with respect to Guantanamo, but there's been very little focus on her actual opinions. And I think that's in keeping with Victoria's point that many of the senators are really speaking to other constituencies at the hearing and not really as concerned with her answers to their questions.
And Victoria Nurse, I mean, that's in the tradition of these Supreme Court hearing or confirmation hearings, though, isn't it? It's yes, you're trying to discern who this person is and whether they're qualified to serve on the Supreme Court, but it's also sending messages to your constituency, both in your state and across the country.
Right. And I actually think that's a virtue of it. It's like the jury. The impeachment hearings were about the nation as the jury. The people want a justice that reflects them, that looks like them. And I think that's a legitimate function. When you go over the line is when that's the only thing you care about, right? And you're misleading about the evidence. And unfortunately, that has happened in the past on both sides, I'm afraid. And it gives, I have great reverence, maybe the last person who actually studies and talks about Congress with reverence, because it is democracy. And it does serve an important function. One of our very first justices, he rode up down Pennsylvania Avenue in a coach with footmen, and he was promptly unconfirmed because he had appeared to be very aristocratic. So.
I'm so glad you brought that up. Sai Krishna Prakash, I've been hearing comments, conversation we all have in the last few days. Some people calling in on a radio talk show I was listening to this morning, they were saying, why are we even having these hearings? The court is going to be 6 conservatives and 3 liberals, and a very, frankly, cynical view. Why do we spend 3-4 days hearing from somebody when we know where this is probably ending up? What's the answer?
Well, the answer is the Senate's used to a process and it wants to go through with it, and the senators have an interest in going through that process, both personally but also institutionally. And of course, we didn't know for certain that she'd be as smooth and as poised and as knowledgeable as she's proven to be. I'm sure people thought she would be this, and other people had their doubts, but she's proven to be great. We wouldn't have known that if we didn't have the hearing. So I think there's a reason for process. Process serves a purpose, and we're going to go through the process, Judy.
Yes, we are. And Lisa Desjardins, you're closest to the process of all of us because you're the one who's there at the Capitol. What is your read on the room, on people who are getting in or standing outside waiting to get in? Give us a sense of what it's like there.
There is today something we didn't see yesterday, which is a line of people waiting to get into this room. It's an odd configuration, though. There are empty seats for some guest tickets, which are not being used. There are packed seats on a line for another set of guest tickets, which are being used. The vast majority, Judy, to my eye, of the people wanting to get into this room are young people. Many of them young staffers here in the Capitol, a diverse crowd that clearly wants to witness what they see as history. And you do see sort of emotion in their faces. You see that they want to be in this room. They're rotating in and out. It adds a real sense of excitement, even when senators sometimes go down sort of deep philosophical paths here. I also want to say I'm texting with some of my sources here on Capitol Hill, and to back up something that Cy said earlier, Republican sources, some from offices that I believe will end up opposing this nominee, and some from offices that we don't know how they'll end up, are universally telling me they think that this is a nominee who is doing very well in a high-pressure situation. Some of them talking about what they think Republicans could or should do, but they think that she is someone that really cannot be dented here, and that she's doing something. One of them even texted that they're hopeful, no matter how their boss ended, this is a senior aide, they're hopeful that perhaps this hearing helps the legitimacy of the Supreme Court overall, which everyone here in this hearing knows is an issue. And I think that is something that the next Senator Mike Lee of Utah is going to focus on. We heard him talk about that yesterday. Yes. He is someone who cares a lot about judicial history, foundation. I think he's going to ask about a lot of court legitimacy questions.
You're right. We did hear him speak about that yesterday. And Marcia Coyle, I'm going to come to you in the studio while we're watching these live pictures of the hearing room. We know they are due to come back sometime in the next few minutes, and we're keeping an eye, and we'll go back as soon as they do. But the legitimacy of the Supreme Court has become a bigger and bigger issue.
It certainly has, and you have members of the court talking about it in public and raising concerns about it. And I think if the hearings continue as they are at sort of a very polite level, that can only support the legitimacy of the court. Certainly the hyper-partisan nature of confirmation hearings has eroded legitimacy of the court as people see it more and more as a partisan institution. It is a political institution, but as a partisan institution. So I think that it's absolutely true that this Senate committee seems to be trying thus far to keep the temperature down.
Keeping the temperature down, but Jeff Bennett, you're watching. Well, we're getting ready to, looks like maybe to go back into session. The chair, Senator Durbin, is there. As soon as he signals, we'll go to them. But Jeff Bennett, I'm thinking back to what Senator Graham was saying this morning, giving the judge maybe not a hard time. That's maybe not a fair way to put it, but certainly being very vigorous in his criticism of the process. And I'm trying to square that with saying that this is a process that adds to the legitimacy of the court, while you have a senator who's formerly a chair of this committee himself saying the process is flawed because of the way other nominees have been treated.
That's right. And I can give you the view from the White House, in that the White House wanted to help sort of choreograph, with the help of Senate Democrats, a process, and this is a phrase that I've heard time and time again, that meets the moment, in large part because of President Biden's past role as chairman of the Senate Judiciary Committee, the sort of close hand he had in the confirmation processes for a number of Supreme Court justices, and that he wanted a process, and he wanted his nominee to be part of a confirmation that sort of rose above the political noise. Now, clearly, a White House can only have so much control in anything, given that there are a number of senators, Republican and Democrat, who use their 30 minutes however they see fit. But so far, in his choice of a nominee, and to the extent that Democrats can sort of control the tone, the tenor, the temperature of the room, I think the White House is based on their comments and their texts, overall is pleased so far with how things have progressed.
Really interesting, and it's interesting you remind us that President Biden was himself not only a member of this committee for, almost 20 years, I think that's right, or maybe longer, and his name came up from Senator Ted Cruz of Texas yesterday, Jeff, pointing out that he was there as the committee grilled and then did not confirm Robert Bork, and a process that I think many conservatives, Republicans point to today as an example, what they say is the worst of the Judiciary Committee, and also of the way the committee treated Justice Clarence Thomas during his confirmation process, that Senator Biden was very visible in his role on that committee at that time.
That's right. And White House officials make the point that President Biden has said that he has learned from both of those episodes. I think particularly true the Thomas hearing and Anita Hill's role in all of that. And so all of that, I think, helped inform and instruct the mock sessions that the council's team and that the so-called Sherpa team here at the White House under the direction of former Senator Doug Jones held for Judge Jackson.
All right, Marcia Coyle, we think this committee is going to come back into session. They took a lunch break that has already gone a little more than 45 minutes, and then we are in for the long haul. I mean, there's another 15. We've heard from 7 of the senators. They've each been given half an hour. They are aiming to get through the next 15 today. That's half an hour each. You can do the math. That's 7.5 hours with a dinner break. If they each take their time, and then 20 minutes for each senator tomorrow. So it's a big chunk of time.
It certainly is.
To hear from her.
That's right. That's why I think we will hear more about her 578 opinions.
Or hear from the senators, I should say.
That's right.
How much of this time is questions and how much of this time is
speeches.
is making a point.
Right.
But it's a tried and true role for this committee, isn't
it? It is, and you know, they know what they're supposed to do, and they know how to do it. So I think we just have to sit and listen and see how she handles it, because this is really about her, and we will learn a lot, I think, about, and already have learned quite a bit about the kind of person she is, as well as the kind of judge or justice she may become if confirmed. So it's a conversation that isn't just about her or about the senators or between her and the committee. It's a conversation really between her and America and the Senate committee.
And Lisa Desjardins, it's a window for many Americans into the way our process works, the way Congress works. Otherwise, people get a glimpse, they hear a sound clip here or there of a member of the House or a member of the Senate. This is an opportunity to hear at length what senators are thinking about, how they're approaching an issue, how they communicate. It's an education.
That's right. And we know right now trust in government, confidence in our institutions is low. And the Supreme Court is an institution that generally has stayed out of sort of the political firing line, at least for the last few decades, with the exception, of course, of some notable cases that they've ruled on. But the idea of the justices themselves, and that's changed. And so this hearing is coming at an important moment. The nation is starting to change how it operates out of a very difficult pandemic. We'll see if that lasts. But it's a moment where I feel like the country wants to take a deep breath. I can tell you in terms of the process here at the Capitol, for sure, senators want to have that kind of idea of a deep breath themselves. However, I think what we're also hearing in this hearing room is the other side of the Senate process, which is we're in a time of gridlock. Many of these senators are frustrated that they see policy that is abhorrent to them on one end or the other, campaign finance, for example, with Senator Whitehouse, but which they don't have the power to change, in large part because it still requires 60 votes in the Senate. So this hearing room has become kind of a town hall for the senators themselves to talk about these issues that they're frustrated they cannot resolve through the democratic process, through the Senate itself. This hearing isn't going to solve those problems, but what we're seeing here is them venting about really how the Senate works in this moment, as well as how they see the judiciary.
No question about it. And John Yang, I want to bring you back in because, of course, this is all a reminder that the Supreme Court is in session this week. They are talking about important cases every day. They are in session. We're looking for them to make some consequential rulings this session on abortion and on other issues.
Abortion, religious rights, gun control. I think that there are a number of big issues that are coming up that will change. I think there were questions earlier on. I think it was Senator Feinstein asking her about Roe v. Wade. You know, as Marcia well knows, by the end of June, abortion jurisprudence could be quite different than it is today. And also, I should note that the questions that Senator Cornyn was asking about inferred rights, particularly referring to the Obergefell case that on same-sex marriage and whether or not someone who opposes that based on firmly held beliefs could be called a bigot, that is a case that's going to be coming up before the Supreme Court in the term beginning this fall, involving a Colorado website designer who has declined to design websites for same-sex weddings and is defending that refusal on free speech grounds.
We're watching Judge Jackson return to the hearing room as she prepares to take her seat. Marcia, you want to quickly pick up on that point?
Well, yes, absolutely. This term right now is hugely consequential, and we'll know in probably late June on a number of those issues.
Senate Judiciary
I'll
Committee
be turning our
will
coverage over to Amna
I would like to
Nawaz
make a
this
statement,
afternoon, but right now let's
in
go
terms
right
of
back
some
into the hearing
research that
room
was
and to
undertaken
Chairman Dick
during
Durbin.
the break. Judge Jackson, earlier Senator Cornyn said that you had called former President George W. Bush and Secretary of Defense Donald Rumsfeld a, quote, war criminal, unquote. I noticed a little surprise in your reaction, and I was surprised by the allegation. During your service as a public defender, you filed several habeas petitions against the United States, naming former President Bush and former Secretary Rumsfeld in their official capacities. You were advocating on behalf of individuals who argued they were civilians wrongly classified as enemy combatants of the United States, and your filing was part of your professional responsibility to zealously advocate for your clients. In those petitions, the individuals raised more than a dozen claims for relief, one of which was an allegation that the government had sanctioned torture against the individuals, which constituted war crimes under the Alien Tort Statute. The Alien Tort Statute allows courts to hear cases for alleged violations of the law of nations or the treaties of the United States. Apparently, this is what Senator Cornyn was referencing. So to be clear, there was no time where you called President Bush or Secretary Rumsfeld a, quote, war criminal, close quote. Did you want
Correct,
to respond?
Senator. No, thank you. That was correct.
Thank you very much. We now recognize Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Jackson, for being here. I want to talk today about some things you heard about yesterday. There was a lot of talk from members of this committee about judicial philosophy. I want to talk a little bit about what that means and why it's important. We'll start with what it means, at least to me. One of the things that you heard from a lot of members of the committee, whether they couched it in terms of judicial philosophy or not, relates to the idea that justice should be blind, that justice properly administered within our system is blind, and that therefore individual justices and judges serving in Article III courts should be blind in the sense that they are able to see and understand and interpret the law, understand what the law is, while understanding that the idea of what the law should be is left to other branches of government, not to the judiciary. In this respect, we recognize that blind justice and blind justices, those who are blind to the things they're supposed to be blind to, are those willing to recognize that if there is a policy flaw in the law, and if there's a policy change that needs to be made, it's not the role of the court to change it. That belongs to two different branches of government, primarily to Congress. This, of course, requires judicial restraint. It requires judicial humility. And it gets back to what I was describing yesterday when I referred to Justice Barrett drawing on the analogy from the Odyssey of Odysseus binding himself to the mast of the ship. Most of us refer to this judicial philosophy as textualism. Textualism is neither liberal nor conservative. It's neither Republican nor Democratic. It's just the approach that says what the law says matters, and the job of the jurist is to look at the text and figure out what the text means, to ascertain the original public meaning of the text in question. While I doubt there are any members of this committee who would disagree with the idea that justice should be blind in this respect and that policy changes need to be made by the political branches of government, primarily by the legislative branch and not by the courts, you did hear some statements that I think are at least a little bit at odds with that concept of justice. One of my colleagues mentioned that you should interpret the Constitution in a way that works for the people of today. Fair enough. We certainly don't want to interpret the Constitution in a way that doesn't work. But again, that's not the objective. The objective is not to ascertain good policy. The objective is to ascertain what the law requires. You were urged to consider the effects of the court's actions on people's lives. There again, insofar as this relates to policy, it's not really the job of the courts. You were admonished that you must, quote, be able to see the real people at the other end of the court's rulings, like Americans who are one Supreme Court decision away from losing their health insurance, or one court decision away from the ability to make their own health care choices. And the list goes on and on. Now, that type of judicial philosophy would have you step into the role of policymaker and decide what the law should be rather than what the law is. You also heard quoted a couple of times yesterday, quoted or paraphrased or otherwise referenced Federalist 78, in which Alexander Hamilton refers to the difference between between will and judgment. Will, as expressed by Hamilton, refers to what the law should be. Judgment pertains to what the law is. The judicial branch has the latter power, but not the former. The legislative branch has the former, but not the latter. Judge Jackson, I'd love to get your thoughts on this discussion about what it means, what blind justice is, why that's important. Let's start with this formulation of it, though. Does the law determine the outcome of a case, or does the outcome of the case determine the law?
Thank you, Senator. The law determines the outcome of case.
And so anytime you're looking at a case and you're looking at the outcomes for ordinary Americans, for day-to-day Americans, if you're looking beyond the scope of deciding that case, and if you're looking even within that case beyond what the law says, you would be stepping into a province of a different branch. Is that right?
I believe so. The law and the facts of the case determine the outcome of cases.
I think that's an accurate statement. It's important to emphasize this. This is also something that Hamilton describes in Federalist 78, where he goes on to say anytime you start to see the courts start to exercise will instead of judgment, the result is supplanting the will of the people as expressed through their elected representatives through the courts. And that tends to undermine the whole system. You see, there's a reason, of course, why we give life tenure to Article III judges and justices. And that is because we want to make sure that they have the power, the authority, the discretion, and the confidence to issue a decision that they might not be comfortable with. In fact, a judge who always agrees with and is always comfortable with his or her own opinions is, as Justice Scalia used to say, not a very good judge. So we wanted them, you, all, to have confidence in being able to make the right decision, even knowing that you and the public at large might be uncomfortable with the result it produces. Congress makes laws that you won't always agree with. Congress is accountable to the people at regular intervals. You can fire every member of the House of Representatives every 2 years. You can fire 1/3 of us in the Senate every 2 years. We insulate judges and Supreme Court justices from that same accountability precisely for this reason. It's because political accountability is so important. This is borne out in the judicial oath, one of the oaths that you'll take if confirmed to this position as an associate justice, in which you'll swear or affirm that you'll administer justice without respect to persons, and that you'll do it faithfully and impartially. I read this to mean that you do it without consideration of external circumstances, external considerations, policy considerations, or otherwise. Now, this relates to some interaction that you and I had when you came before this committee for your confirmation to the U.S. Court of Appeals for the D.C. Circuit, where you now sit. In connection with that hearing, I submitted some questions to the record in which I asked you whether, to what extent, the Constitution protects rights that are not enumerated in the Constitution itself, and if so, to specify what those rights were. You responded by citing a number of cases, including Griswold versus Connecticut, Roe versus Wade, Loving versus Virginia, and a handful of others. You also suggested that the Ninth Amendment was a source for such rights, unenumerated rights. The Ninth Amendment, of course, states, quote, that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Judge Jackson, what specific rights has the Supreme Court identified as flowing from the Ninth Amendment? And by that, I mean specifically from the Ninth Amendment, rather than in sort of an also-ran list of other features of the Constitution that might back up a particular ruling. What rights has the Constitution identified as flowing specifically from the Ninth Amendment?
Thank you, Senator. The Supreme Court, as I understand it, has not identified any particular rights flowing directly from the Ninth Amendment, although, as you said, the text of the amendment suggests that there are some rights that are not enumerated.
Right, right. Its very existence and its very language suggests that, which opens up other questions as to how those are to be resolved. It's led to considerable debate among scholars and jurists alike as to whether, to what extent, in what way this is enforceable. Those rights are enforceable by the courts. But how would we go about deciding that? How would jurists go about deciding this question appropriately? In other words, would it be more appropriate to say we will ascertain the existence of rights protected by the Ninth Amendment based on contemporaneous understanding at the time of the ratification of the Ninth Amendment? Or would it be more open-ended to protect rights that we think are important today?
Thank you, Senator. The Supreme Court now very clearly has determined that in order to interpret provisions of the Constitution, we look to the time of the founding. And we ascertain, based on what the original public meaning of the words of the Constitution were at the time. Sometimes that yields a particular answer. Other times you may have to look to practices historically from that time. But that would be the way in which you would go about interpreting the Ninth Amendment.
Could it also be that it leaves this to be decided at the discretion of the Supreme Court itself? In other words, not based on any historical precedent, but based on what the Supreme Court justices themselves deem appropriate at the moment?
I don't think so.
Why is that?
Because the way in which the Supreme Court interprets the Constitution is with reference to the meaning of the text at the time. That it is one of the constraints, as I mentioned, in terms of my own way of interpreting the law. One of the constraints is that you're bound by the text and what it meant to those who drafted it.
At the time, gotcha, yeah. Now, on February 1st of this year, President Biden said that he was looking for a Supreme Court nominee. This was, as I recall, right after Justice Breyer announced that he would be stepping down and before he had announced whom he might nominate, that he was looking for a nominee, quote, with, quote, a judicial philosophy that's more one that suggests that there are unenumerated rights to the Constitution and all new members mean something, including the Ninth Amendment. So do you share the judicial philosophy that President Biden described in that statement?
Senator, I haven't reviewed that statement, but I have not discussed anything about unenumerated rights with the president. Yes.
Did President Biden ask you either about your judicial philosophy more broadly, separate and apart from the Ninth Amendment, or ask you about your approach to the Ninth Amendment?
He did not.
In a primary election debate that he had as a presidential candidate in Nevada in 2007, Joe Biden stated, quote, "I would not appoint anyone who did not understand that Section 5 of the 14th Amendment and the Liberty Clause of the 14th Amendment provided a right to privacy. That's the question I'd ask them." If that is answered correctly, that is the case, then it answers the question, which means they would support Roe versus Wade. I assume his reference to the Liberty Clause, I assume he's referring to the Due Process Clause of the 14th Amendment. In context, that appears to be what he's saying. Did President Biden ask you whether you agreed with his analysis of the 14th Amendment as it relates to the right to privacy?
He did not.
Tell me this. When we look at any provision of the Constitution, one of the many reasons it's helpful to look at the original understanding, in addition to the fundamental reason that you described, it can help us understand what motivated it, and it can help us understand the actions of those who voted within Congress to propose text to be amended to the Constitution, and those who voted to ratify it. We've got a number of amendments, including the amendment that he referred to in that last quote I read, that had an understanding, at least an understanding that included certain thou shalt nots for government. The Equal Protection Clause, I think, is a provision of the 14th Amendment that people understood. Among anything else it might do, restricts government's ability to treat people differently on the basis of race. Consistent with the Equal Protection Clause of the 14th Amendment, when is it permissible for government to treat a person differently on the basis of race?
Thank you, Senator. The Supreme Court has interpreted the Equal Protection Clause, as you say, to generally prohibit classifications on the basis of race. And it says that those classifications are to be rigorously scrutinized. They are strict scrutiny, which is a standard that applies, that looks at the purposes of the government and the means by which the government seeks to achieve any end related to such classification. The government would have to have a compelling interest in making that classification, and the means that it selects would have to be narrowly tailored to achieve that interest.
And so those compelling interests can't be for light or transient reasons. They can't just be something like we feel like it, in other words.
Correct.
And the reason for this is because, well, number one, it's bad for anyone to treat another person differently on the basis of race. It's especially bad when government does it, because there's not exactly equal bargaining power when you're dealing with the relationship an individual has with government. By definition, it's a particularly unfair form of discrimination when it's government doing it. Governments have enforcement officers, they have armies, they have the means of enforcing their will and their laws, and that's one of the reasons why it's so important. What about under statute? Consistent with Title VII of the Civil Rights Act of 1964, when is it permissible for an employer to treat an employee or a prospective employee differently on the basis of his or her race?
By statute, under Title VII, it is generally impermissible.
and permissible only in very narrow circumstances.
I believe so, and the statute itself has some restrictions in terms of to whom it applies.
Right.
The employers.
And some exclusions in terms of religious employers, for example, not being able to discriminate on the basis of race, but it exempts religious employers within certain spheres in order to be able to protect that religious employer's discretion to operate within its faith and the rules of its faith. And by doing that, it makes that much clearer. By making that distinction, it makes that much clearer that discrimination on the basis of race in employment is not something that the law smiles upon, nor should it. Let's talk about the Commerce Clause for a minute, if that's all right. Now, at the time of the founding, our founding fathers didn't foresee, and almost certainly could not have foreseen, the invention of radios, televisions, airplanes, the internet, and telephone networks. And yet, all of those things are governed by federal law and not by state law. Why is this constitutional?
Well, Senator, the Commerce Clause was initially interpreted by the Supreme Court to be very broad, to allow for federal regulation of interstate commerce and the growth of the economy in this country. But over time, the Supreme Court has made clear that the Commerce Clause limits the federal government, that there is limited authority under the Commerce Clause. The state of the law now is such that the federal government, through the Commerce Clause, is only permitted to regulate channels of interstate commerce, instrumentalities of interstate commerce, and activities that substantially affect interstate commerce. And with respect to the third category, the Supreme Court has made clear in the Lopez case and in Morrison that non-economic activities are not covered by Commerce Clause authority. And in the NFIB case, the ACA case, the Supreme Court made clear that inactivity is also not covered and not authorized under the Commerce Clause.
Right. And most of the items that I identified in my question, in fact, all of them, I believe, would fall into the category of channels and instrumentalities of interstate commerce. We're dealing with interstate airways, waterways, networks, things like that, things that depend for their existence, for their effectiveness on their operation interstate, such that they couldn't, no one could effectively regulate them and preserve their core function unless that was federal. Those fit into the category of the channels and instrumentalities. With the third item that you described, the substantial effects interstate commerce, is there much of a limiting principle there? I mean, you referred to Lopez and Morrison and NFIB versus Sebelius. To my knowledge, those are the only three cases the Supreme Court has decided since its ruling in 1937 on NLRB versus Jones and Laughlin Steel, which essentially created the modern substantial effects case, the modern substantial effects standard. Those are the only three instances in which the Supreme Court identified as outside the Commerce Clause authority something that Congress had enacted. Are these meaningful constraints in your view, or are they examples of Congress just getting reckless and sloppy in the way it drafted things? Some have argued, for instance, that as long as Congress doesn't get reckless and sloppy, it can do whatever it wants under those. Do you have any view on that?
Well, these cases come through the courts, so I'll be general. The fact that Congress is limited in its authority under the Commerce Clause is established law. It is a fundamental principle of our constitutional order. And those limits that the Supreme Court has recognized do carve out categories of activity that Congress is not permitted, the federal government is not permitted to regulate. Non-economic activity is a category. Inactivity is a category.
Now, the Supreme Court has also, through the Commerce Clause, established rules for things that the states may not do. This is referred to as the so-called Dormant Commerce Clause. The Dormant Commerce Clause acknowledges the power of Congress, the exclusive domain of Congress as being regulating interstate commerce. But there's no federal cause of action to allow for the invalidation of a state law under the Commerce Clause. It's been something that's been adopted by the courts. Is that an appropriate exercise of the court's judicial power, or does that amount to de facto legislation on the part of the courts?
Well, Senator, I wouldn't characterize it. I know that that's what the Supreme Court has permitted. The Dormant Commerce Clause is a principle that supports the interstate nature and regulation and authority of the federal government. And so states are not permitted under that doctrine to discriminate against other states, to preference their own commerce in a way that interferes with interstate commerce.
I want to turn back for a moment to a line of inquiry you had with Senator Durbin earlier today when you were talking about your sentencing in these child pornography cases. I want to make sure that I understand your answer there. If I understand it, you were making the argument that your concern was that the laws in this area didn't adequately take into account the transfer of these materials by electronic means to be transmitted, received, and stored through computers. Is that, am I understanding that correctly?
Well, Senator, the point that I was making was that the Sentencing Commission, back when I was part of it and even since, tasked with the responsibility to evaluate and make recommendations and look at the data and information about cases, has looked at the operation of the child pornography guideline. Not so much the statute, but the guidelines, which the Congress has tasked the Sentencing Commission with developing. And there are aspects of the child pornography guideline that Congress in legislation has required. It required certain enhancements to be included in the guideline. And some of those enhancements, the data is now revealing, don't take into account the change in the way that that this horrible offense is now committed.
But the fact that it's easier to commit the offense shouldn't diminish the severity of the punishment, should it? I mean, any more than the more widespread availability of certain drugs, the more widespread availability of certain weapons might, I mean, you surely wouldn't argue for a lower sentence when certain things become easier in other criminal contexts. So why is this one different?
Well, the sentencing enhancements that are in the guidelines are designed to help courts differentiate between different levels of culpability. Congress will say this is an offense, whatever it is, and the maximum penalty is X. And in most cases, the range is between 0 and something like 20 years that Congress gives when it establishes a penalty. The point of the guidelines is to help judges figure out where in that range between 0 and 20 years a particular defendant should be sentenced. And the guidelines have gradations in them
that relate to various aspects of the commission of the crime.
Go ahead.
Sorry. So the commission does data data gathering and research to figure out how crimes are committed and what gradations should matter in terms of the range of culpability. Because the problem of not doing that or of getting it wrong is that you are not able to adequately assess and determine the differences among offenders on the scale.
I understand that. And so, but in these cases, as I understand it, all 10 of the cases that we've reviewed on record where you've sentenced someone for a child pornography conviction, in all 10 of those cases, you departed from the guidelines and departed downward. It's hard for me to understand departing from those in every case you've got, because isn't a departure supposed to be grounded in a finding that it's outside the heartland of cases in that range, cases of that sort?
Yes, Senator, and as I said before, these are horrible cases that involve terrible crimes, and the court is looking at all of the evidence consistent with Congress's factors for sentencing. The guidelines are one factor, but the court is told that you look at the guidelines, but you also look at the nature and circumstances of the offense, the history and characteristics of the offender. There are a series of factors. In the cases, you are also getting recommendations. And in most of the cases, I haven't pinned it all down, but in most of the cases, if not all of the cases, the government is asking for a sentence below the guidelines because this guideline system is not doing the work in this particular case.
Understood. Section 230 of the Communications Decency Act provides a degree of immunity for tech companies operating in the space of being online interactive service providers. It immunizes them from certain causes of action that would otherwise apply against them. Would it be within Congress's authority to condition the receipt and availability of Section 230 immunity on those online interactive service providers operating as a public forum that is not discriminating on the basis of viewpoint or the viewpoint of those posting on them? Would that be within our authority?
Senator, I can't comment on a particular issue about whether or not it is constitutional or not, but the criteria that you identify, it would be relevant, I think, as to whether or not the government is seeking to regulate along viewpoint lines under the First Amendment. That is something that is generally impermissible.
Thank you, Mr. Chairman.
Thank you very much, Senator Lee. Senator Klobuchar.
Thank you very much, Chairman and Senator Grassley. Welcome again, Judge, your wonderful family. They all seem to be awake throughout this entire hearing. I just wanted to, before I start, get at something Senator Lee was talking about. It's not the Dormant Commerce Clause, but I really appreciated early on how you talked about these child pornography cases. A former prosecutor could totally see where you were coming from when you talked about looking at these cases as a mom and a judge. And would it surprise you at all that other judges, including a number of them that were supported by our colleagues on the other side of the aisle, have given out similar sentences in child pornography cases?
No, Senator, it would not surprise me because these cases are horrific, and there's a lot of disparity because of the way that guidelines are operating in this particular area. But in every case that I handled involving these terrible crimes, I looked at
the law and the facts. I made sure that the victims, the children's perspectives were represented. And I also imposed prison terms and significant supervision and other restrictions on these defendants.
Well, thank you. And I just also want to note, and I know others have brought this up, the letter of support from the Fraternal Order of Police, in which they said, from our analysis of Judge Jackson's record and some of her cases, we believe she has considered the facts and applied the law consistently and fairly on a range of issues. There is little doubt that she has the temperament, intellect, legal experience, and family background to have earned this appointment. We are reassured that should she be confirmed, she would approach her future cases with an open mind and treat issues related to law enforcement fairly and justly, and that matters a lot to many of us. Now, I want to go back to something I was talking about yesterday, and that is why today's hearing is so monumental, including that it is occurring at a time when we as Americans have been reminded again, due to the courage of Ukrainians thousands of miles away, that we can never take our democracy, or for that matter, our courts for granted. It is also happening at a time when we are seeing each other for the first time after a 2-year pandemic, connecting to each other again. And I hope this moment will be a moment where we see a renewed interest in our democracy, that we respect each other's rights and views, and that we see that we are not a nation of 300+ million silos. Instead, we are a nation committed to this idea that what unites us as Americans is much bigger than what divides us. And so in that context, you come before us with this incredible strength, legal acumen, grace under pressure that you have demonstrated today. And you also come before us, as we've noted, as the first Black woman to be nominated following 115 justices who have been confirmed. And I will note, of the 115 justices, 110 have been men. And I actually once reminded a late night show, Trevor Noah, of similar issues in the U.S. Senate. In fact, in the history of the U.S. Senate, of the nearly 2,000 people who have served, only 58 have been women. And he responded that if a nightclub had numbers that bad, they'd shut it down. But today, Judge, we're not shutting anything down, not the court, not the Senate, and you are opening things up. And I think one of the things your nomination presents is an opportunity to address a decline in the public's confidence in our court. Increasingly many, if you see public opinion polls, see the court as over-politicized or out of touch. At the same time, we've seen an alarming rise in threats targeting members of our judiciary for just doing their jobs. How do you think we can work to maintain the public's confidence in the court? What do you see your role in that?
Thank you, Senator. Public confidence in the court is crucial. As has been said here earlier, the court doesn't have anything else, that is the key to our legitimacy in our democratic system. And I am honored to accept the president's nomination, in part because I know it means so much to so many people. It means a lot to me. I am here standing on the shoulders of generations of Americans who never had anything close to this kind of opportunity. From my grandparents, who had just a grade school education, but instilled in my parents the importance of learning. And my parents, who I've mentioned here many times already, who were the first in their families to get to go to college. So this nomination, against that backdrop, is significant to a lot of people. And I hope that it will bring confidence, it will help inspire people to understand that our courts are like them, that our judges are like them, doing the work, being a part of our government. I think it's very important.
Very good. I think along those lines, your wonderful mentor, Justice Breyer, I quoted him about how he said, we can help maintain public acceptance of the court, and these are his words. We can do it best by helping ensure that the Constitution remains workable in a broad sense of the term. Specifically, the court can and should interpret the Constitution in a way that works for the people of the day. Like, as you know, it's, I think, Article 2, Section 2 doesn't refer to the Air Force because we didn't have an Air Force back then. So are there things about the Constitution that, of course, as we've gone along, have been interpreted to meet the moments of our time? What do you think Justice Breyer means when he says the Constitution should be interpreted in a way that works for the people of today? And do you think a justice can be both pragmatic and objective and respect history?
I do, and I think that the justices have demonstrated that. Some of their recent opinions have had to deal with modern technologies that did not exist at the time of the founding. So, for example, the Riley case, the Carpenter case, these were Fourth Amendment decisions in which the court was asked to determine whether or not it violated the Fourth Amendment for the police to search someone's cell phone without a warrant, or for the police to use GPS location data to determine where someone had been without a warrant. And obviously those technologies did not exist. But what the court did was it looked back at the time of the founding and determined what the reasonable expectations of privacy were related to the term unreasonable searches and seizures, which appears in the Constitution. And having assessed what that meant back then, they could use those principles to decide whether or not a cell phone is like someone's home these days, with all of the information and all of the things that are stored there. And the court determined that it was a violation of the Fourth Amendment, that the police officers needed a warrant, and they did so with reference to what the Constitution meant in history.
Mm-hmm. Very good. You know, you were viewed as a judge, and you talked about this a bit yesterday, that writes lengthy opinions, that believes you should spell things out, and believes in being transparent. Is that a fair characterization? I don't wanna
That
put
is.
words in your mouth.
That is.
Okay, good. I'm sure your clerks know that. I want to talk about something to me that's a bit the opposite, and that's something that some have termed the shadow docket. And that includes decisions that the court makes on an expedited basis that are usually unsigned and issued without oral argument or full briefing. In the last few years, we've seen the court increasingly deciding cases in this way, often over the dissent of maybe 3 or 4 of the justices. Last term, the court granted 20 requests for emergency relief, a historically high number. 10 years ago, in the October term of 2011, the court granted only 6 requests in an entire year. When do you think it's appropriate for the Supreme Court to grant emergency relief, use this docket? When are the circumstances that warrant this? And I think you know these decisions have a profound effect on people's lives. I'll just use one example. Last fall, in a 1-paragraph decision, a majority of the court refused to stop the enforcement of a Texas law that severely restricts a woman's access to abortion. In that case, even Chief Justice Roberts objected to the court's decision to let the law take effect, calling the statutory scheme not only unusual but unprecedented. As someone who believes in transparency, could you talk in general about when you think this shadow docket should be used, when emergency relief should be given, and how, if it's overused, it could undermine public confidence in the court?
Thank you, Senator. Well, there's a balance that the court has to consider, and that it, insofar as, on the one hand, It has always had an emergency docket. The need for flexibility, the ability to get answers to the parties at issue is something that's important in our system. On the other hand, the court has also considered the interest in allowing issues to percolate, allowing other courts to rule on things before they come to the court. And I am not privy at the moment to the justices' views and why and how they're using the emergency docket in these cases. If I was fortunate enough to be confirmed, I would look at those issues. But it's an interesting and important set of issues.
Okay. I think just another example of this, by the way, is the day before Wisconsin's primary election on April 6, 2020, Wright, as the first beginnings of some of the health orders that came out with the beginning of the pandemic, the court issued a 5-4 decision halting a district court's order allowing voters extra time to cast their absentee ballots so that they could avoid waiting in line to vote. And back then, people literally got COVID with election workers and the like because of this. And again, I'm not going to belabor this point, but I think some of this is these decisions that are made that don't reflect some of the careful consideration that you have made in many of your decisions as a judge. But speaking of voting, I'll ask you one question on that front. Since the Supreme Court gutted the Section 5 preclearance regime of the Voting Rights Act in its decision in Shelby County, the D.C. Circuit has not seen many voting rights cases. However, as you know, Justice Ginsburg dissented in that case, describing the right to vote as the most fundamental right in our democratic system. Do you agree that the right to vote is fundamental?
Senator, the Supreme Court has said that the right to vote is the basis of our democracy, that it is the right upon which all other rights are essentially founded. Because in a democracy, there is one person, one vote, and there are constitutional amendments that relate directly to the right to vote. So it is a fundamental right in our democracy.
Yes, I know that's how Justice Barrett answered that question as well in her recent hearing. I'm going to turn to an area that Senator Lee and I, we both chair the subcommittee on antitrust, and so it's near and dear to my heart. So I thought I'd spend a little time. It usually gets relegated to the second round, but I'm putting it up on the docket here. U.S. antitrust law has been described as a comprehensive charter of economic liberty, and I agree. And effective antitrust enforcement plays a critical role, as you know, in protecting consumers and workers, promoting innovation, ensuring new businesses have an opportunity to compete. It actually, from really early on in our country's history, has been a very important part of assuring that capitalism works. And in January, for the first time since the dawn of the internet, the Senate passed a tech competition bill out of the Judiciary Committee. It's a bill that Senator Grassley and I lead. Many of the members of this committee supported the bill, 16-6 vote. It's called the American Innovation and Choice Online Act. It's now headed to the Senate floor. I'm not going to ask you about that bill, obviously, but I want to put this in some context. While tech monopolies have seized from 50 to 90% market share in major parts of their business lines, it is clear to me when you look at the plain language of the Sherman Act, Clayton Act, laws that are in place, that these monopolies are not okay. However, court rulings for decades in antitrust have created some major obstacles to taking on these cases. And it's not just court rulings. It is on us with, as I said, the dawn of the internet, decades having passed. It is on us, this Senate and the House, to update our laws this year to give enforcers the resources to do their jobs, something you, if confirmed, would not have a role in. But the role of the courts is also very critical. You have been nominated to replace Justice Breyer, who came to the court with a strong background in antitrust law. I know you handled a case. You and I discussed it in my office. I think it got decided the merger was abandoned, so you didn't have to rule on the merits of it. It was back in 2017, a FTC challenge. But I'll just quote something that Justice Breyer once said. He told this committee, if you're going to have a free enterprise economy, then you must have a strong and effective antitrust law. Do you agree with Justice Breyer's statement, and how would you characterize the goals of our antitrust laws?
Well, thank you, Senator. The antitrust laws protect competition and, as you said, therefore protect consumers and competitors and the economy as a whole. And the Sherman Act and the Clayton Act are broad in their in their statements, in their protections, and there's a lot of precedent in this area. If I were confirmed, I would use my methodology to look at the precedents in these areas to ensure that any legislation that I was considering is interpreted according to the text, consistent with Congress's intent. In the area of antitrust, that is ensuring that there is consumer protections.
Mm-hmm. Very good. And just to play it out a little bit, since the 1980s, the court in cases like Trinco and Credit Suisse, Ohio v. American Express, has really made it increasingly difficult to enforce the antitrust laws and protect competition. And during that same time, and I know many of my colleagues know this, we have seen a rise in industry consolidation, market power, not only in tech with companies like Google and Amazon and Facebook and Apple, but also across our economy, really in everything from pharma to cat food to caskets. What role do you think that congressional intent should play in the court's interpretation of the antitrust laws? And I say that because I think that we're dealing with some cases where justices have actually substituted their own ideologies for the intent of Congress in originally passing the laws. And I think it was Justice Souter who once said before this committee, when we are dealing with antitrust laws, we are dealing with one of the most spectacular examples of delegation to the judiciary that our legal system knows. And he added this, certainly a respect for legislative intent has got to be our anchor for interpretation. So what role do you think congressional intent should play in the court's interpretation of the antitrust laws?
Thank you, Senator. So I've interpreted a number of statutes in my near decade on the bench. And in every case, the text of a statute is what the court looks at in order to ascertain what the legislature intended. And that is important because, as I've said, courts are not policymakers, and judges should not be importing their own policy preferences. Judges are restrained in our constitutional scheme in order to affect the will of Congress in terms of their interpretation of the laws.
Okay, thank you. I'm going to turn to another topic, and that's freedom of the press, New York Times v. Sullivan, 1964 case. We have recently witnessed, as you know, unprecedented attacks on journalists and journalism, whether it's violence overseas, recently losing, sadly, members of the press just in the last month in Ukraine, or threats and intimidation at home. This is very concerning to me, given the important role of the First Amendment. My dad was a newspaper reporter, so the issues hit home for me. Can you talk about your view of the role of journalists in our democracy?
Thank you, Senator. Journalists, freedom of the press is protected by the First Amendment. It is about the dissemination of information, which is necessary for a democratic form of government. The Supreme Court has held as much, and that was the basis for the court's determinations in protecting the press from liability in New York Times versus Sullivan and its progeny.
Okay. As you know, that ruling was a unanimous ruling in support of the First Amendment, and the court held that when newspapers report on public officials, they're only liable for untrue statements that are published with knowledge or reckless disregard for whether the statement was false. The court in Sullivan based its decision on our country's, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. That's their quote. And it recognized that, quote, erroneous statement is inevitable in free debate, end quote, and, quote, must be protected if the freedoms of expression are to have the breathing space that they need to survive. Do you agree that those principles are just as relevant today as they were when the Supreme Court first decided New York Times v. Sullivan?
New York Times v. Sullivan is the continuing binding precedent of the Supreme Court, and it does state the principles that the court has determined are undergirding the First Amendment right to free press.
Okay. And last summer, actually, in Berisha v. Lawson, the Supreme Court declined to review a case in which the 11th Circuit applied New York Times v. Sullivan. Justice Thomas and Justice Gorsuch each dissented from the decision not to grant cert, arguing that the court should reconsider its holding in Sullivan. How would you approach a case that sought to limit or overturn the central holding in New York Times v. Sullivan?
Thank you, Senator. Anytime the court is asked to revisit a precedent, there are criteria that the court uses to decide whether or not to overrule a precedent. New York Times versus Sullivan is a precedent, and stare decisis is very important. The principle that the Supreme Court should maintain its precedents for predictability and stability in the law. If the court is asked to revisit a precedent, its criteria, what it looks at, are whether the precedent is wrong, and in fact egregiously wrong, the court has said, whether there's been reliance on that precedent, whether there are other cases that are similar to the precedent or that relied on the precedent that have now shifted so that the precedent is no longer on firm footing. Whether or not the precedent is workable. Sometimes the Supreme Court will issue a ruling and determine later that it's not actually doing what the court intended, and whether or not there are new facts or a new understanding of the facts. Those various criteria are what the court looks at to decide whether or not to overturn a precedent, and they would be what I would look at if I were confirmed to the Supreme Court.
Thank you. I was recalling as you spoke about stare decisis at one of your first nominations hearing for the district court, and you actually, in response to one of my questions, you said stare decisis is a bedrock legal principle that ensures consistency and impartiality of judgments. And I think, as you know, by how you've talked more broadly about this, moving off of the First Amendment questions, throughout the court's history, stare decisis has been so key, and the court has relied on it to maintain stability in the law, reaffirm its impartiality. As a former justice, I know Senator Durbin just read a very famous book about him, Minnesotan, Justice Harry Blackmun, who actually Justice Breyer succeeded on the court, said in his concurrence in Planned Parenthood v. Casey about the court's decision to uphold Roe v. Wade, he said, "What has happened today should serve as a model for future justices and a warning to all who have tried to turn this court into yet another political branch." What role do you think that stare decisis plays in protecting the independence of the judiciary and avoiding the perception that the court is acting as another, quote, political branch?
I think it plays a very important role as a doctrine that keeps shifts from happening in the court. That, as I've previously mentioned, it's very important to have stability in the law for the rule of law purposes, so that people can order themselves and predict their lives, given what the Supreme Court has already said. And if there were massive shifts every time a new justice came on, or every time new circumstances arose, there would be a concern that public confidence would be eroded. And so stare decisis is a very important doctrine that the Supreme Court has established, and it's one that furthers the rule of law in this country.
Thank you very much. Well, that's a good way to end Judge Jackson. And I do see Senator Cruz waiting in the wing. So by coincidence, and it looks like he has things he's putting up of charts. By coincidence, I was going to put on the record, and since he's here, it makes a lot of sense, from the judge that you clerked for, Senator Cruz, Judge Luttig, who's now retired, and I know you were very close to him. And he actually submitted a letter on your behalf, Judge Jackson, and said in this letter, and he's an appointee of George H.W. Bush, similar to Judge Griffith, who introduced you yesterday, and I've been very impressed by the support you've had from retired judges, obviously not appropriate for current judges, but retired judges appointed by both Democratic and Republican presidents, as well as the bipartisan votes that you have gotten through the U.S. Senate for your other positions. But in this letter, the former Judge Luttig says that you are eminently qualified to serve on the Supreme Court of the United States. And then he actually says Republicans and Democrats alike should give their studied advice and then their consent to the president's nomination. And he adds Republicans in particular should vote to confirm Judge Jackson. So I thought that might be a good segue, Senator Cruz, to your question. So I ask Chairman that the letter of support from former Judge Luttig, who employed Senator Cruz as a trusted law clerk, be admitted to the record.
Without objection.
Thank you very much, Judge Jackson.
Thank you.
Senator Klobuchar finds a Minnesota connection to almost everything. Very proud of the fact, but Justice Blackmun was born in Nashville, Illinois.
Okay, he was a lawyer at the Mayo Clinic, as we know, and spent a lot of time.
I'm going to lose this battle.
A lawyer in Minnesota when he was chosen to the Supreme Court, but thank you for pointing that out.
And now to the great state of Texas, Senator Cruz.
Thank you, Mr. Chairman. Judge Jackson, welcome.
Thank you.
Congratulations.
Thank you.
You and I have known each other a long time.
We have.
We went to law school together. We were on the law review together. We were a year apart.
Happily so, I hope, Senator.
We were not particularly close, but we were always friendly and cordial.
We were.
And you and I had a very positive and productive meeting in my office where we discussed a number of things, including you were there with former Senator Doug Jones. And we discussed how he and I and a number of other senators had, for 2 different years, participated in reading aloud on the Senate floor Dr. Martin Luther King Jr.'s letter from a Birmingham jail, which is one of the truly great advocacies for civil rights our nation has seen. And you and I talked together about our shared admiration for Dr. King. When Senator Grassley questioned you earlier, he asked in particular about Dr. King's speech on the steps of the Lincoln Memorial, where he said most critically, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character." Do you agree with what Dr. King said in that speech there?
I do, Senator.
As we were discussing it, you referenced in my office a speech that you gave in January of 2020 at the University of Michigan School of Law. And after our discussion, I pulled a copy of your speech and read the speech in its entirety. And there were elements of the speech that I thought were really powerful. And let me say, your opening remarks yesterday were powerful and inspirational as well. And I think you and your family, the journey you have taken to becoming a federal judge, to becoming a federal Court of Appeals judge, I think demonstrates the incredible promise and the incredible opportunity this nation offers all of us. As I read your speech at the University of Michigan Law School, however, there was a portion that surprised me. And in particular in that speech, you referenced the work of, quote, acclaimed investigative journalist Nikole Hannah-Jones, and her, and again, this is a quote from the speech, provocative thesis that America was born in, provocative thesis that the America that was born in 1776 was not the perfect union that it purported to be. And indeed, Ms. Hannah-Jones, in her 1619 projects, describes the central thesis of the 1619 Project, which the New York Times laid out as a revisionist look of history, revising American history. And Ms. Hannah-Jones described her central thesis as, quote, one of the primary reasons the colonists decided to declare independence was because they wanted to protect the institution of slavery. Now, that claim is a highly contested historical claim. Do you agree with Ms. Hannah-Jones that one of the primary reasons the colonists decided to declare independence is because they wanted to protect the institution of slavery?
Thank you, Senator. When I gave that speech at the University of Michigan, I was asked to speak on Martin Luther King Day. And every year they have a Martin Luther King Day speaker. And I gave a speech about Black women in the civil rights movement. Most of the speech, if not all of the speech, was focused on African American women, their contributions to the civil rights movement, unsung contributions in many cases, and then some of the more recent African American women who have made claims, who have done things in our society. One slide was of Ms. A journalist, as you say, who made that statement, and I called it provocative. It is not something that I've studied. It doesn't come up in my work. I was mentioning it because it was, at least at that time, something that was talked about and well known to the students that I was speaking to at the law school.
So are you aware that since the 1619 Project came out, that it has been roundly refuted by very respected historians, including Gordon Wood of Brown University, including James McPherson of Princeton University. McPherson called it a, quote, very unbalanced, one-sided account which lacks content and perspective. And indeed, it was so thoroughly refuted that the New York Times quietly altered the digital version to remove references to 1619 as the year of America's true founding and the moment America began. Were you aware of that?
I was not.
So let me ask you, related to the 1619 project, which I believe is deeply inaccurate and misleading. 1619 project is closely intertwined with a movement that is called critical race theory. Critical race theory, as you know, originated at your and my alma mater at the Harvard Law School. In your understanding, what does critical race theory mean? What is it?
Senator, my understanding is that critical race theory is, it is an academic theory that is about the ways in which race interacts with various institutions. It doesn't come up in my work as a judge. It's never something that I've studied or relied on, and it wouldn't be something that I would rely on if I was on the Supreme Court.
So critical race theory, as you know, has its origins in the critical legal studies movement, which also came from Harvard Law School, from a number of critical legal studies professors, crits as they were known when we were in law school, who are explicitly Marxists. And they find their origins in Marxism, although critical legal studies frames society as a fundamental battle between socioeconomic classes. Critical race theory frames all of society as a fundamental and intractable battle between the races. It views every conflict as a racial conflict. Do you think that's an accurate way of viewing society in the world we live in?
Senator, I don't think so, but I've never studied critical race theory and I've never used it. It doesn't come up in the work that I do as a judge.
So with respect, I find that a curious statement because you gave a speech in April of 2015 at the University of Chicago in which you described the job you do as a judge. And you said sentencing is just plain interesting because it melds together myriad types of law, criminal law, and of course constitutional law, critical race theory. So you described in a speech to a law school what you were doing as critical race theory. And so I guess I would ask, what did you mean by that when you gave that speech?
With respect, Senator, the quote that you are mentioning there was about sentencing policy. It was not about sentencing. I was talking about the policy determinations of bodies like the Sentencing Commission when they look at a laundry list of various academic subjects as they consider what the policies should be.
Okay, but you were vice chair of the Sentencing Commission, so let me ask again, what did you mean by, because that was an official responsibility of yours, what did you mean by what you were doing was critical race?
What I meant was that there are a number of, that slide does not show the entire laundry list of different academic disciplines that I said relate to sentencing policy, but none of that relates to what I do as a judge.
So let me ask you a different question. Is critical race theory taught in schools? Is it taught kindergarten through 12th?
Senator, I don't know. I don't think so. I believe it's an academic theory that's at the law school level.
Okay. As you may recall, during the confirmation hearings of Justice Amy Coney Barrett, there was a great deal of attention paid to the fact that Justice Barrett served as a board member on the Board of Trustees of a religious private school, and the press focused very intensely on the views of that school. In your questionnaire to this committee, you disclosed that you are similarly on a board, specifically the Board of Trustees for the Georgetown Day School, and that you've been a board member since 2019 and you're currently still a board member. Is that correct?
That is correct.
In regard to the Georgetown Day School, you've publicly said, quote, since becoming a member of the GDS community 7 years ago, Patrick and I have witnessed the transformative power of a rigorous progressive education that is dedicated to fostering critical thinking, interdependence, and social justice. When you refer to social justice and the school's mission on social justice, what did you mean by that?
Thank you, Senator, for allowing me to address this issue. Georgetown Day School has a special history that I think is important to understand when you consider my service on that board. The school was founded in 1945 in Washington, D.C. at a time in which, by law, there was racial segregation in this community. Black students were not allowed in the public schools to go to school with white students. Georgetown Day School is a private school that was created when 3 white families, Jewish families, got together with 3 black families and said that despite the fact that the law requires us to separate, despite the fact that the law is set up to make sure that black children are not treated the same as everyone else, we are going to form a private school so that our children can go to school together. The idea of equality, justice, is at the core of the Georgetown Day School mission, and it's a private school such that every parent who joins the community does so willingly with an understanding that they are joining a community that is designed to make sure that every child is valued, every child is treated as having inherent worth, and none are discriminated against because of race.
So, Judge Jackson, all of us will agree that no one should be discriminated against because of race. When you just testified a minute ago that you didn't know if critical race theory was taught in K through 12, I will confess I find that statement a little hard to reconcile with the public record, because if you look at the Georgetown Day School's curriculum, it is filled and overflowing with critical race theory. That among the books that are either assigned or recommended, they include Critical Race Theory, an introduction. They include The End of Policing, an advocacy for abolishing police. They include How to Be an Anti-Racist by Ibram Kendi. They include literally stacks and stacks of books, and I'll tell you 2 of the ones that were most stunning. They include a book called Anti-Racist Baby by Ibram Kendi. And there are portions of this book that I find really quite remarkable. One portion of the book says babies are taught to be racist or anti-racist. There is no neutrality. Another portion of the book, they recommend to babies confess when being racist. Now, this is a book that is taught at Georgetown Day School to students in pre-K through 2nd grade, so 4 through 7 years old. Do you agree with this book that is being taught with kids that babies are racist?
Senator, I do not believe that any child should be made to feel as though they are racist, or though they are not valued, or though they are less than, that they are victims, that they are oppressors. I don't believe in any of that. But what I will say is that when you asked me whether or not this was taught in schools, critical race theory, my understanding is that critical race theory as an academic theory is taught in law schools, and to the extent that you were asking the question, I understood you to be addressing public schools. Georgetown Day School, just like the religious school that Justice Barrett was on the board of, is a private school.
Okay, so you agree critical race theory is taught at Georgetown Day School?
I don't know, because the board is not, the board does not control the curriculum. The board does not focus on that. That's not what we do as board members, so I'm actually not sure.
Well, and I'll note that the board is chaired by Professor Fairfax, your college roommate who introduced you yesterday, so the 2 of you serve on the board together. Another book that is on the summer reading for 3rd through 5th grade is a book called Stamped for Kids, again by Ibram Kendi. I read the entirety of the book, and I will say it is an astonishing book. On page 33, it asks the question, can we send white people back to Europe? That's on 33. That's what's being given to 8 and 9 years old. It also, on page 115, says the idea that we should pretend not to see racism is connected to the idea that we should pretend not to see color. It's called color blindness. Skipping ahead, here's what's wrong with this. It's ridiculous. Skin color is something we all absolutely see. Skipping ahead, so to pretend not to see color is pretty convenient if you don't actually want to stamp out racism in the first place. Now, what this book argues for is the exact opposite of what Dr. King spoke about on the floor of the Lincoln Memorial. And are you comfortable with these ideas being taught to children as young as 4 in respect to the first book, as young as 8 and 9 in respect to the second book?
Senator, I have not reviewed any of those books, any of those ideas. They don't come up in my work as a judge, which I'm respectfully here to address. In my work as a judge, which is evidenced from my near decade on the bench.
Okay, good. Then let's go back to your work as a judge. As was noted in the first slide, you discussed sentencing as being related to critical race theory. And earlier there's been some back and forth as Democratic senators have tried to address your sentencing patterns as it concerns child pornography. And I'll confess, Judge Jackson, as I listen to your testimony, I believe you are someone who is compassionate. I believe you care for children, obviously your children and other children. But I also see a record of activism and advocacy as it concerns sexual predators that stems back decades and that is concerning. You wrote your note on the Harvard Law Review on sex crimes. Your note is your major academic work on the Law Review, and yours is entitled Prevention versus Punishment Towards a Principled Distinction in the Restraint of Released Sex Offenders. And in it, you argue, and I quote, a recent spate of legislation purports to regulate released sex offenders by requiring them to register with local law enforcement officials, notify community members of their presence, undergo DNA testing, and submit to civil commitment for an indefinite term. Although many courts and commentators herald these laws as valid regulatory measures, others reject them as punitive enactments that violate the rights of individuals who have already been sanctioned for their crimes. Under existing doctrine, the constitutionality of sex offender statutes depends upon their characterization as essentially preventative rather than punitive. And what you go on to explain is if they're viewed as punitive, they are unconstitutional. If they're viewed as preventative, they are not. And throughout the course of your note, you argue they should be viewed as punitive and therefore unconstitutional. Indeed, in the second to last page, you go through each of those 4 categories. You say requirements that sex offenders register may or may not be unconstitutional, depending upon whether, quote, in which sex offenders have no privacy right in registration information or blood samples. So you suggest that may or may not be constitutional, although you raise doubts about it. And then you raise very significant doubts about community notification, and you heavily suggest that civil commitment for sexual predators is unconstitutional. Do you still agree with the sentiments you expressed in your law school note?
Respectfully, Senator, those are not the sentiments that I expressed in my law school note. My law school note was about sex offender registration laws, which at the time were relatively new. As you know from our time in law school, one of the things that law school students do is they look for new developments in the law and they try to analyze them. That's something that makes for good fodder for a law school note. My note, which came out in 1996, was shortly after there were new Megan's laws. And the point that I was making was not that the laws were bad, that the laws were wrong. I was trying to assess something that is sort of fundamental in terms of the characterization of the laws. I didn't say that they were unconstitutional one way or the other. What I was trying to assess was how they are characterized. Some courts would look at those laws and call them preventative, and that has a certain set of consequences. Some courts would call them punitive, and that has a certain set of consequences. And what I was trying to do is figure out how to make the determination whether they were punitive or preventative.
Well, your note argued that they were punitive, and I would note that that view, there have been some on the bench that have advocated that. The Supreme Court in 1997 decided a case called Kansas versus Hendricks, in which it upheld Kansas's civil commitment statute. That was a 5-4 vote. This has been a question that has been close at the Supreme Court. And I would note beyond that, that in terms of the prevalence of these statutes, all 50 states and D.C. have registry requirements. 47 states have community notification requirements. All 50 states have DNA or blood banks for sex offenders requirements. And 20 of the states, the federal government in D.C., have laws that allow for the indefinite detention of sex offenders. I would note in the state of Texas, a state court of appeals, relying on very much the same sort of reasoning you advocated in your note, struck down Texas's sexually violent predator civil commitment law. At the time I was the Solicitor General of Texas, I personally argued that appeal in the Texas Supreme Court. And the Texas Supreme Court unanimously reversed the Court of Appeals and upheld our statute. And if the views you advocated in law school prevailed, civil commitment laws across the country would be struck down, releasing sexual predators. And under the argument, community notification and DNA bank laws could well be struck down as well. Is that an outcome that should concern people?
Senator, my note wasn't advocating for the striking down of those laws. My note was trying to identify criteria that I thought could be applied consistently to determine whether the laws were punitive or preventative.
But with respect to Jackson, you argued that they were punitive, and you further say in the note, if they're punitive, they're unconstitutional.
I was looking at 4 different kinds of laws, and not all of them, did I say, were punitive.
Okay, so let's take civil commitments laws. If you look at civil commitment laws right now, the UCLA School of Law, Williams Institute, estimates more than 6,300 sex offenders are currently detained in civil commitment programs. If the view you advocated prevailed, presumably those 6,300 sex offenders would be released to the public. Is that an outcome that should be concerning?
Senator, in law school, when I was writing a note, I was looking at a brand new set of laws that had not previously been enacted in any jurisdiction. They were new. And I was assessing at the time, as law school students do, what criteria I thought might be used by courts to make a determination in the future as to whether or not they should be treated as punitive and therefore not unconstitutional, but as therefore ones that carry with them certain rights versus preventative.
Judge Jackson, so you've pointed that these were views in law school, and listen, I will recognize that all of us, when we are students, may have views that as time and maturity passes on, we may change. But what troubles me is this was not just a law school view, it's one that has continued. So when you were vice chairman of the Sentencing Commission, you expressed significant concerns that the White House has argued that your quotes were taken out of context. So I want to provide the full context of your quote, because you said, yes, I want to ask you about the means by which we can distinguish more or less serious offenders. I know that all of you sort of touched on that. Mr. Futrell, you talked about going from singular to one-on-one to group experience. I'm just wondering if there's some sort of inevitable and natural progression from one stage to the other, such that you could say that the least serious offenders are in the singular experience stage. And I guess my thought is, in looking at some of the testimony that other people will have later in the day, I was surprised at some of the testimony with respect to the motivation of offenders, and we're talking about child pornography offenders, and that there are people who get involved with this kind of activity who may not be pedophiles and who may not be necessarily interested really in the child pornography, but have other motivations with respect to the use of technology and being in the group. And here are lots of reasons perhaps why people might engage in this. And so I'm wondering whether you could say that there could be a less serious child pornography offender who is engaging in the type of conduct in the group experience level because their motivation is the challenge or to use the technology. They're very sophisticated technologically, but they aren't necessarily that interested in the child pornography piece of it. Now I find that a pretty remarkable argument that people in possession of child pornography are not actually interested in the child porn. They're not pedophiles. They're just interested in technology. Is that? And I wanted to provide the whole quote because the White House said that portions of this were used out of context. So this is your entire quote. Do you agree with that sentiment that there is some meaningful population of people who have child pornography but are not, in fact, pedophiles or getting satisfaction from it?
Thank you, Senator, for allowing me to address what appears to be a question that I was asking in the context of a hearing on child pornography. You've provided the entire quote, and it looks as though I was asking that of someone, not taking that position. And the position that I've taken in all of my sentencings involving child pornography offenders is to ensure that despite the attitude and view of many of the offenders who came before me when I was a trial judge, that they were just lookers, that they weren't really harming anyone, that they were curating their collections and they never touched a child, I made sure that they understood that notwithstanding their collecting behavior, that they were causing significant harm.
So Judge Jackson, all right, you raise your actual sentencing, and I think that's very productive. Let's take a look at your actual sentencing. And you've had 10 different cases involving child pornography. These are the cases. There are two, U.S. versus Buttry and U.S. versus Can, for which the government did not make a recommendation. And you said earlier, when Chairman Durbin was trying to preempt this line of attack, you said it's a sickening and egregious crime, which I very much agree with. And you said the guidelines lead to extreme departures. Okay. Let's look at what the prosecutors are asking for. And I would note that this was in the District of Columbia, where prosecutors are far more liberal than many of the prosecutors in this country. And in every case in which, so United States versus Hess, there was a mandatory statutory minimum of 60 months, and you imposed 60 months because you had no discretion. In United States versus Nickerson, there was a mutual agreement of the parties to 120 months, and that's what you imposed. In every other case, United States versus Chazen, the prosecutor asked for 78 to 97 months. You imposed 28 months. 28 months is a 64% reduction. In United States versus Cooper, the prosecutor asked for 72 months. You imposed 60 months. That was a 17% reduction. In United States versus Downs, the prosecutor asked for 70 months. You imposed 60. That was a 14% reduction. In United States versus Hawkins, the prosecutor asked for 24 months. You imposed 3 months. That was an 88% reduction. In United States versus Savage, the prosecutor asked for 49 months. You imposed 37. That was a 24% reduction. In United States versus Stewart, the prosecutor asked for 97 months. You imposed 57. That was a 41% reduction. Every single case, 100% of them, when prosecutors came before you with child pornography cases, you sentenced the defenders to substantially below, not just the guidelines, which are way higher, but what the prosecutor asked for on average of these cases, 47.2% less. Now, you said you made sure the voice of the children was heard. Do you believe in a case like United States versus Hawkins, where the prosecutor asked for 24 months and you sentenced the offender to only 3 months? Do you believe the voice of the children is heard when 100% of the time you're sentencing those in possession of child pornography to far below what the prosecutor's asking for?
Yes, Senator, I do.
Could you explain how?
I will. A couple of observations. One is that your chart does not include all of the factors that Congress has told judges to consider, including the probation office's recommendation in these cases.
Well, Judge Jackson, we don't have those probation. The committee has not been given the probation office's recommendation. We would welcome them. Mr. Chairman, I would love to see those. We don't have access to them.
The second thing I would say is that I take these cases very seriously as a mother, as someone who, as a judge, has to review the actual evidence in these cases and, based on Congress's requirement, take into account not only the sentencing guidelines, not only the recommendations of the parties, but also things like the stories of the victims. Also things like the nature and circumstances of the offense and the history and characteristics of the defendant. Congress is the body that tells sentencing judges what they are supposed to look at. And Congress has said that a judge is not playing a numbers game. The judge is looking at all of these different factors and making a determination in every case based on a number of different considerations. And in every case, I did my duty to hold the defendants accountable in light of the evidence and the information that was presented to me.
In 100% of the cases, was the evidence less than the prosecutors asked for?
Senator, the evidence in these cases are egregious. The evidence in these cases are among the worst that I have seen, and yet, as Congress directs, judges don't just calculate the guidelines and stop. Judges have to take into account the personal circumstances of the defendant because that's a requirement of Congress. Judges have to consider things like the victims, and when I was talking about making sure that victims' circumstances are heard, it was about my sentencing practices.
Well,
that I
show victims being heard with respect. Thank you, Mr. Chairman.
In 2012, the Sentencing Commission, on a unanimous bipartisan basis, issued a report recommending changes to sentencing for non-production child pornography, which is the subject at hand. Offenses because of widespread concern among judges and other stakeholders. For example, 70% of surveyed judges said the guideline ranges for possession and receipt offenses were too high. 71% said the mandatory minimums were too high. Notably, the report was supported by every member of the commission. I believe the question which Senator from Texas was referring to was part of the proceedings that led to that commission report, unanimous convention, bipartisan basis commission report.
Mr. Chairman, very briefly, I would ask unanimous consent that the books I referenced be entered into the record.
Without objection. Senator Coons.
Thank you, Chairman Durbin, Ranking Member Grassley. Judge Jackson. Good to be with you.
Good to be with you, Senator.
I'd like to take a few minutes, if I could, and just give you a chance to address some of the issues just raised. My colleague suggested that you've never sentenced a defendant in a child pornography case consistent with what the government requested, what the prosecution requested. But according to my staff's research, that's just not true. So let me briefly ask you about three specific sentencing cases. Do you remember U.S. v. Nickerson? You sentenced Charles Nickerson Jr. to 10 years in prison, exactly what the government requested.
I do, Senator.
Do you remember U.S. v. Fife? You sentenced him to 20 years in prison, exactly what the government requested.
I do, Senator.
And do you recall U.S. v. Nguyen? You sentenced him to 37 months in prison, exactly what the prosecution requested?
I do, Senator.
So in these three cases, it's also true that the government, the prosecution, requested below guidelines sentences. Would that seem surprising to you at all?
It would not.
And is that because overwhelmingly, nationwide, in 70% of cases, and in your district, 80% of cases, downward departures from the guidelines are the norm?
That is correct, Senator.
So to the extent there seems to be some concerted effort to try and characterize you as being soft on crime or somehow unconcerned about child safety, I just wanted to take another moment and give you a chance to respond to that. As a parent, as the member of a family that's had several members who've served your brother, your uncles in law enforcement, could you share a bit about how having loved ones who serve as law enforcement officers, in one case a detective on a sex crimes unit, has had an impact on your sense of the balance of justice and mercy in the case of ensuring that we hold to account those who commit crimes against children?
Thank you, Senator. As a mother, these cases involving sex crimes against children are harrowing. What I think is important to understand is that trial judges who have to deal with these cases are presented with the evidence or descriptions, graphic descriptions. These are the cases that wake you up at night because you're seeing the worst of humanity. When there are victim statements that are presented, when people talk about how their lives have been destroyed as children, how the people who they trusted to take care of them were abusing them in this way, and then putting the pictures on the internet for everyone to see. I sometimes still have nightmares about the main witness, the woman I mentioned earlier who cannot leave her house because of this kind of fear, the vulnerability, the isolation. These crimes are horrible. And so I take them very seriously, just as I did all of the crimes, but especially crimes against children.
So, Your Honor, if I could, the characterization that was just presented in a recent column in the National Review, a conservative publication, has characterized that view of you as a smear that appears meritless to the point of demagoguery and characterizes your approach in sentencing in these cases as mainstream and correct. And I'll just remind my colleagues and those watching that two of the largest, most substantial law enforcement advocacy organizations in our country, the National Fraternal Order of Police and the International Association of Chiefs of Police, have spoken up in support of your qualifications and your capabilities. The FOP letter says there's little doubt you have the temperament, intellect, legal experience, and family background to have earned this appointment. That sentiment was echoed by the IACP. In their letter, they said, you believe you have a deep understanding of and appreciation for the challenges and complexities confronting the policing profession, and you have, during your time as a judge, displayed your dedication to ensuring our communities are safe and that the interests of justice are served. I find it hard to believe that these organizations, having looked closely at your judicial decisional record, your sentencing decisions, your lifetime conduct, would have taken those unusual steps to be that forceful in supporting you if, in fact, you had somehow a disturbing record of coddling child pornographers or being soft on crime. In fact, Judge, your record, in my view, demonstrates you're an even-handed and impartial judge. And I can see that when I look at cases you've ruled on that involve very politically charged or partisan interests. You've delivered rulings on both sides for plaintiffs and defendants, and in my review of your record, you've put any personal views or concerns aside. You've based your decisions on the argument of the parties, the facts in the record, the applicable law and precedent, and the well-reasoned and thorough opinions you've written show to me a judge striving to make even-handed decisions based on facts and law, not on some caricature of a leftist agenda. But don't just take my word for it. We've received an outpouring of support for your nomination. As we'll hear on Thursday, a very wide range of groups and individuals have sent letters or testimony to this committee in support of your nomination. It's no surprise to me that your legal mind, your experience, your temperament inspire strong support from some of the best and brightest of our legal community. And I think it's worth highlighting that among those many who have written to us are included well-respected conservative and Republican lawyers and Republican-appointed judges who agree with my characterization that you're an even-handed and impartial judge. We've received a letter from 24 conservative lawyers who held positions in Republican administrations or are well-known for their conservative political or legal views, who wrote this committee to urge your speedy confirmation. They praised your character and intellect and called you, and I quote, a truly excellent person. I'd like to focus, though, on the way that these conservative lawyers characterized your judicial decision-making, which is, after all, the core issue before us, is whether you are the sort of judge at the district court and circuit court that should be elevated to the Supreme Court. And they note in this letter that in nearly 10 years on the bench, as a district judge and then in the Court of Appeals, Judge Jackson has been involved in thousands of cases, running the full range of federal law. You're approximately 500, I think it's more than 570 now. Opinions written during this time have, and I'm quoting, demonstrated complete command of the legal subject matter, a judicious and even-handed approach, a fine ability to express yourself with force and great clarity. They've also demonstrated, and I'm quoting, another attribute essential for a judge, a sense of empathy for the situations of others. Judicious and even-handed. These prominent conservative lawyers want this committee to know you're judicious and even-handed and recommend you for the Supreme Court without reservation, despite having noted they differ with you concerning some political or partisan issues. And they're not alone. Judge Griffith, in a letter to this committee, and then followed up with personal testimony in your introduction yesterday, a judge appointed by former President George W. Bush enthusiastically supports your nomination. I was struck by his description of your intellectual capacity, your keen legal mind, as well as your character and judicial approach. And now I'm quoting from his testimony to this committee yesterday. Judge Jackson, he told us, is an independent jurist who adjudicates based on the facts and the law, not as a partisan. He went on, as Justice Scalia taught us, an indispensable feature of the republic the Constitution created is an independent judiciary of judges who've taken an oath not to a president or a party, but to the American people and to God, that they will be impartial. And he concluded that you, Judge Jackson, have demonstrated an unwavering commitment to that oath. That's a conservative judge appointed by a Republican president who told this committee he's confident you'll decide cases based on the facts and the law, not as a partisan. Now, I value the working relationships I have with my colleagues on both sides of the aisle. We can and do at times have fierce policy disagreements, but we also work together to try and find ways as lawmakers and individuals to respect each other. And I take it as a personal sort of badge or a source of pride when someone with whom I really disagree on one issue is able to legislate with me on another. And so I imagine, Your Honor, it must be gratifying to know that a judge who literally sat in judgment of, reviewed dozens and dozens of your opinions. In fact, I think he reversed you once.
Oh, more than. More than.
Here is someone who closely read and reviewed your decisions, and as a circuit judge sat in review of your work over years as a district, hundreds of opinions as a district court judge, and has such unequivocal praise for the even-handed, impartial, thorough, and nonpartisan way you've approached judicial decision-making. Could you just briefly share with me what it means to you to hear that someone like Judge Griffith has such confidence you would make an excellent member of our highest court?
Thank you, Senator. It means the world to me to have the support of Judge Griffith. His coming here yesterday and testifying on my behalf was so gratifying. I have tried in every respect to follow my methodology that enables me to rule impartially in every case and to understand the limits of my own judicial authority and thereby reach decisions without fear or favor. My record demonstrates that I am not proceeding from any sort of preconceived notion about how a case comes out. I'm not ruling consistent with any sort of ideology. I'm doing what impartial and fair judges do, which is to decide in every case based only on the facts and the law of that case. And I'm very, very pleased that Judge Griffith has seen that in the years that he supervised me effectively as a Court of Appeals judge when I was a district judge. And I think it's wonderful that he was able to come here and testify to that.
Well, Judge, for those watching and for those following this, that they might be puzzled because my colleague, the junior senator from the state of Texas, has tried to ascribe all sorts of views to you in his recent questioning that try to paint you as some kind of an activist with a radical agenda. And in my review of your experience and your record, these letters from judges and scholars, I don't see anything that remotely substantiates that claim. We are here to evaluate your qualifications, your judicial decision-making. But so let me get at a few of these points specifically, if I could. I've heard references to the 1619 Project and critical race theory, but I didn't hear that cited in any reference to your opinions as a judge. In your 9 years on the bench as a district court judge, more than 570 decisions, have you ever cited the 1619 Project?
No, Senator.
In your 9 years on the bench and more than 570 opinions, have you ever cited the journalist or principal author of that 1619 Project, Ms. Hannah Jones?
I have not.
And in your 9 years on the bench and more than 570 decisions, have you ever used, employed, relied upon critical race theory to determine the outcome of any case or to impose any sentence or as a framework for your decision-making?
No, Senator.
Would you just explain to us briefly what sort of factors you do, in fact, consider in your analysis?
Senator, when I analyze a case, I am looking at the arguments that the parties raise in the case. I'm looking at the record, which is the facts of the case developed, if I'm on the Court of Appeals, developed below. And I'm looking at the law. I'm looking at any statutes. I'm hewing to the text. I'm looking at constitutional provisions to the extent that they are applicable and any precedents related to the case at issue. Those are the inputs that are appropriate for a judge to consider, and those are the only things that I use in my decision-making.
Well, I appreciate your laying that out, and I'll just, let me dig into two cases, if I can, that I think are also probative here, because I agree with the wide range of supporters we've heard from that you've demonstrated an even and impartial judicial approach in your record. But this is true not just in the hundreds of sort of run-of-the-mill quotidian cases that are considered by a district court judge, but in several that have been highly charged and really quite political in terms of their consequences. I'd like to discuss your opinion in the Center for Biological Diversity versus McAleenan. Do you recall that case?
I do, Senator.
It was a dispute between groups advocating for environmental protection and the Trump administration's Department of Homeland Security. The dispute was about President Trump's efforts to quickly construct a physical border wall between the United States and Mexico. I'm sure I don't need to remind you or anyone here that at the time, Democrats were just about unanimous in thinking that physically building a wall from coast to coast was not the wisest use of resources to secure the border. There were other ways to do it, and with Republicans pretty much unanimously willing to defend it. So it was a policy matter with some sharp divisions and some political consequences. You ultimately ruled in favor of the construction of the wall and against an attempt by environmental groups to halt its construction through a legal case. Can you discuss what you recall just briefly of the claims presented and how you came to a decision in favor of the Trump administration?
Senator, the claims in that case, which, as you say, were brought by an environmental organization, related to the Administrative Procedures Act, which is something that we often see in the District of Columbia, and whether or not the agency could waive certain environmental laws pertaining to the construction of the wall, whether or not the agency's determination to do so was lawful. And I looked at the relevant circumstances, and I ended up, I believe, dismissing that case on threshold grounds before getting to that point in the analysis. But consistent with what you've said, I was guided by my understanding of the law and what it required, and not by anything else.
I could spend a lot of time on the details of this case, but let me try and summarize it this way. You analyzed the statute. You concluded Congress had clearly blocked the courts from hearing non-constitutional challenges. There was no jurisdictional bar to the constitutional claims. To decide them, you considered whether the plaintiff's claims were viable. You looked for precedent. You found one. While not controlling, you thought it was legally sound and persuasive. But there was no controlling circuit court or Supreme Court precedent that stopped you. If you were in fact an activist judge, a motivated partisan determined to let these plaintiff environmental groups proceed, you certainly could have. There was no clear precedent that barred that from happening. You analyzed the statute. You applied the best precedent you could find, and you reached a result without regard to the political consequences.
That is correct, Senator.
So in my view, I wanted to talk about this case because there's really nothing unusual or special about it from your perspective.
That is correct.
For those of us up here, there was a lot special and important about it. It was a highly charged partisan and political issue, but you looked at the statute, you found persuasive precedent, you applied it, you went on to the next case. Well, let me ask about another decision. In a case addressing another very politically charged issue, and specifically this involves the emails of former Secretary of State Hillary Clinton. Now, the Republican National Committee, or the RNC, is opposing your nomination, publicly accusing you of being a partisan Democrat. And they argue you could not possibly be an impartial justice. But ironically, back in 2016, you presided over a case brought by the RNC against USAID related to then presidential candidate Clinton, and you ruled in favor of the RNC. Both the substance and the timing of the case are really quite striking.
I did.
The RNC made Freedom of Information Act requests for certain emails involving the former secretary. And despite what the RNC would have us now believe, in this case, you reinforced your deserved reputation for following the law, not a partisan agenda, because you ordered USAID to produce thousands of pages of documents related to Secretary Clinton. Do you recall when you issued that decision, that order?
I actually don't.
Well, I'll tell you, it was just before the presidential conventions. So if there was a moment when the RNC had a political objective, it was right before the convention, and you actually issued a ruling that they were entitled to email production from the USAID on the basis of legal arguments presented to you, the statute at issue, and the evidence. Is that correct?
That is correct.
Well, Your Honor, I'm frankly really struck at the fact that, for all the back and forth in Senate hearings and academic circles about the judicial philosophy of Supreme Court nominees, You've shown what the experience of nearly a decade overwhelmingly spent on the district court has produced. A methodology, an approach that looks at the Constitution, the statute, the facts, the arguments of the parties, and reaches a result without fear or favor, without taking into account the partisan issue at stake. You know, I don't believe that a judicial philosophy is always all that meaningful. The judge for whom I clerked on the Third Circuit had spent years as a district court judge, and when I asked her, you know, what's your judicial philosophy, she looked at me and said, I just call balls and strikes. I'm a judge who rules on the case before me in exactly the same frame that you offered. A judicial philosophy does not in and of itself constrain a judge. What constrains a judge is a judge who is willing to be constrained, who understands that the role of the federal judiciary is a limited one. And so the real question I think a president should consider when they make a nomination, the question that we as senators need the answer to in order to perform our function of advice and consent, and the question that I think resonates best with the American people who are concerned about this hearing and this nomination and how it will impact the country and their lives is sort of, what kind of justice will you be? We want to know if you'll be fair. We want to know if you'll be faithful to the Constitution and to the rule of law. You've been a judge almost 10 years and you've written more than 570 opinions. I'd say your record as a judge is the best answer to the question what kind of justice you will be. How would you say, Your Honor, that your approach to judging on the district court relates to the way you are now judging on the circuit court? And what approach do you think you will bring with you if confirmed to the Supreme Court?
Thank you, Senator. My approach all the way through is one that I believe is required by my duties, by my oath as a judge. We rule without fear or favor. We are independent as judges in our responsibilities. We understand at the district court level, at the Court of Appeals level, and at the Supreme Court that judges are restrained, are constrained in the exercise of our power under our constitutional scheme. My methodology is designed to help me to make decisions within those confines at every level. It's no different now that I'm on the Court of Appeals than when I was on the district court with respect to my understanding of the constraints on my authority and my responsibility to be impartial in my rulings. And I think it would be no different at the Supreme Court.
Well, Your Honor, I know we've walked through just a few cases today now. In some ways, we've only scratched the surface of your decade and the more than 570 opinions you've written. But it's clear to me from what I've reviewed and from just this sample that, as we also heard from colleagues, from conservative lawyers, from judges who wrote to the committee, that you are judicious and even-handed, that you have a demonstrated record of excellence, that you adjudicate based on the facts and the law and not as an advocate, activist, or partisan. And I encourage my colleagues who want to know what kind of a justice you'll be to take a fair and even-handed look at your record, at your impartiality, and at your methodology. Your experience is extensive and broad. Your commitment to follow the law impartially and without the influence of politics is evident in your record. Your keen legal mind, judicial temperament, and impeccable character are plain to all. As Judge Griffith told this committee in a review of your record makes clear, you've demonstrated that the way you approach cases is based on the law and not on some political agenda. You understand the reason why the robes of our federal judges are black, not red or blue. The American justice system, as many have said, is rooted in the impartiality, the independence, and the reliability of our federal judicial system. It is one of the most critical bulwarks of our system of ordered liberty. No wonder that when you came before this body to be confirmed for the district court, then the circuit court, you earned and received bipartisan support. I know President Biden counts nominating a Supreme Court justice among the most significant decisions of his presidency, and our role here in the Senate in confirming a justice to our highest court is among our most solemn obligations and greatest privileges. So in nominating you, I believe our president has met his mission, and it will be my honor to join, I hope, the overwhelming majority of my colleagues in supporting your confirmation as an Associate Justice of the United States Supreme Court. Thank you, Your Honor.
Thank you, Senator Coons. Last week, the committee received a letter, Judge, from the National Coalition Against Domestic Violence, representing survivors of domestic violence, urging the Senate to swiftly confirm you to the Supreme Court. The committee also received a letter about your nomination from 9 separate organizations representing both survivors of domestic violence and sexual assault. The letter said, and I quote, "Judge Jackson is highly qualified for the position as her career and record demonstrate. Her historic confirmation as Supreme Court's first Black woman and the 6th woman overall will represent monumental progress toward a nation it is charged to serve and that values all of its citizens equally." The organizations also noted, quote, "Judge Jackson's rulings reflect the judicial consensus. I move to enter these letters into the record." Without objection, they will be. Senator Sass, you're next up, but we're on the cusp of a vote. So I want to be fair to you. We're going to take a break at this point. I'm going to hope.
I thought we were taking a break and going to go vote, but if you want me to go first, I'm good.
No, I think we ought to go over there and
Okay.
pray that it comes along and we can return quickly. So why don't we declare this break time for 20 minutes, 4:05, back in the room.
So I'm going to come to you first. And with that, we are in another break. You are watching the second day of confirmation hearings for Judge Ketanji Brown Jackson. I'm Amna Nawaz. The Senate Judiciary Committee is now taking another 20-minute short break. With me here at the table is Marcia Coyle of the National Law Journal. Marcia, you've been watching these last few hours with us now. 2 more hours of questions there for Judge Jackson from Senators Lee, Klobuchar, Cruz, and Coons. I think one of the questions we'd all been asking going into this, when you have the woman who could become the first possible Black woman on the Supreme Court, when are questions about race? When are questions about racism going to come up? And she's been explicitly asked about that in previous confirmation hearings for other roles. But you saw that very pointed line of questioning from Senator Cruz there. Tell me about what you noticed about that. What did you take away from that exchange?
Well, first of all, I wasn't surprised because it involved critical race theory, which, as you know, is an academic framework for examining systemic racism. And it's become a really hot topic. It's become part of the culture wars in this country, with many parents involved and believing that their children in the lower levels of their education are being taught critical race theory. But it's always been considered to be a theory that was being examined at the college level or the law school level. Well, Senator Cruz was the one who interjected critical race theory this time, and he did it in an indirect sort of way initially, asking her thoughts about critical race theory and whether it's taught in K through 12 schools. And then he sort of pounced with her membership on the board of a private school, Georgetown Day School, which he said its curriculum was overflowing with critical race theory. And he read off the titles of books and excerpts from the books, and then asked her if she believed in this. And I thought she gave a very thoughtful answer. One, first, she did not believe that any child should be valued less, made to feel they are a victim, or made to believe they are racist. But she also said this was not something that she has reviewed or studied in her position as a judge. And that was why she was before the committee, to be reviewed as a judge. And that sort of shut it down after that. There were other incidents that he raised where she had made references to critical race theory, but I think the attempt to portray her, as an advocate of that really didn't go very far for long. But it was interesting that it came up, and I'm not surprised that it came up because, as I said, it's part of the culture wars now.
This is one of those questions, right, is Can you paint her to be an activist judge? Will you not act as an
Exactly.
so-called activist judge?
Exactly.
If you are confirmed. I know Jeff Bennett has been watching all of this from over at the White House and joins us now. So, Jeff, we heard, of course, critical race theory come up there, references to the 1619 Project. These are all sort of white-hot political issues, rallying cries you often hear in conservative circles that have become umbrella terms for a lot of conversations about racism today. But what have you heard from the White House about how they think that Judge Jackson's been handling the questions?
Well, no, the White House and the team that has been assisting Judge Jackson through this confirmation process, I'm told, they anticipated this sort of line of attack. They prepared for it in large part because they're all too aware that this is an election year and this issue of critical race theory has been something that Republicans had tried to use, and they are using it as a proxy, at least in this setting, for what they view as being a fertile line of attack against Democrats come November. But I think the perspective from those who support Judge Jackson's candidacy is that this idea that she's an activist or that she's soft on crime or that she's some sort of 1619 defender or critical race theory acolyte has nothing to do with her record as a judge, but has everything to do with her race, and that Republicans should be held to account for that, and that no white nominee in this setting has ever been asked about how their race informs their views as a judge. So why is she called to account to explain how her race, being African American, might inform her view in that regard? So I think it is something that she has handled rather deftly. The White House press spokesperson earlier today put out a statement and said that President Biden had watched portions of the proceedings, and I'm just looking at my notes here to get specific about what he'd actually said, but that the president was proud of the way that she was showcasing her extraordinary qualifications, her experiences, and her even-handedness, Amna.
Marcia, you and I talked earlier as well about the fact that in this climate, as Jeff just referenced, we're in a midterm election year. It is very difficult to remove the politics from this process that's meant to be entirely focused on a judicial candidate here.
Absolutely, and this was a very good example. This exchange with Senator Cruz was a very good example of it. And I think, as we just heard, that she was able very deftly to turn this back to why she's before the committee, and that is she's there as a judge, and she needs to be judged on being a judge.
There's also this continued line of questioning about her time on the Sentencing Commission.
Oh, yeah.
Specifically about sentences she has handed down to people convicted of child pornography cases. You saw Senator Cruz there bring out visuals, right? There was a ticking down of sort of sentences she's handed out as they related and compared to the government recommendations for those sentences. Do we expect to see more of that line of questioning moving forward?
I think we will. I think that has been Senator Hawley's main issue with her, and he made it very clear in his opening statement that he would be coming back to it as well. So I was a little surprised that Senator Cruz sort of stole his thunder, so to speak, but as they are both potential presidential candidates, maybe there's a little competition going on there, but I have a feeling she's going to have to answer it again, but she's going to probably say the exact same thing she's been saying all along. And earlier this morning, she gave a very thorough explanation for her sentencing in that area to Senator Durbin, who was the first questioner.
And Jeff, I know you've been following this as well, this idea that the politics of this moment, right, all of these culture wars, as Marcia referenced, these are going to come up again and again in the context of a confirmation hearing for a Supreme Court nominee. You noted that outside the hearing room, there's a lot of activity that's been going on in terms of messaging and tweeting from Republicans and others.
That's right. The official Twitter account of the GOP actually earlier today put out a tweet that had the face of Judge Jackson, her initials KBJ, those initials crossed out, replaced with the initials CRT to suggest that Judge Jackson is in some way an avatar for critical race theory. Think back a few weeks ago when she was first offered up as the nominee, there were some Republicans who suggested that her nomination had little more to do with the fact that maybe she might just sort of be some sort of affirmative action pick, setting aside the fact that she is objectively eminently qualified. So you do see this sort of push and pull, the ways in which this confirmation process in many ways has nothing to do with the actual nominee, but has everything to do with what exists right now in the zeitgeist and what Republicans and Democrats have decided to use as a sort of a political battlefield heading into November, and sort of insert into that wood chipper this process, this what should be an elevated process to nominate someone to sit on the Supreme Court for a lifetime appointment. So there sort of is this sort of disconnect between what should be a revered process and the sort of in the mud everyday politicking that happens here in Washington.
All of that, of course, filtering down into the hearing room. And in that hearing room has been our own Lisa Desjardins. She joins us live now from Capitol Hill during this little break in the proceedings. And Lisa, I'm curious to hear from you about this because you've been talking to lawmakers. We saw probably the most aggressive line of questioning, the most pointed line of questioning when it comes to some of these issues that are absolutely white hot in the political conversations right now from Senator Ted Cruz there. I'm curious what you're hearing from both Republicans and Democrats about how they think that hearing is going.
This moment right now, as I think you're getting the sense of, and you're drawing out from Marcia and from Jeff, this is a very critical moment in terms of what the overall tone of this hearing will be like for the next day and a half, and perhaps the taste that is in everyone's mouths, and I mean Americans' mouths, as they come away from this hearing. Talking to some Republican sources, in fact, there are some questions in their minds as to whether Senator Cruz is going too far, or is he doing this just right in asserting an issue for many in the Republican base who are concerned about how race is taught in schools. I think most of my Republican sources right now on the Hill, and some of them very conservative, are concerned that perhaps this line is going too far, especially because in their impression, Judge Jackson is answering these criticisms directly. So there's a question of when you ask a question, when you make a charge repeatedly, at what point are you harming yourself more than you're harming the person that you might have a critical issue with? So this is a moment where I think Republicans are going to try and figure out, are they going too far or not? Now, on top of this moment is something I continually talk about, is that members of this committee include several who would like to have a higher national profile, specifically several who would like to be U.S. president. Senator Ted Cruz was the second place nominee for the Republicans in 2016. Senator Josh Hawley, who will have his question time approximately 1 hour after we return to the committee room. He's another person who, no secret, would not mind being in the White House. So that is also a factor. It isn't just about what this means for the Republican Party. It's about what it means for these senators personally. And they know to get the Republican nomination, they have to really connect with their base. The question is, are they going too far, and are they hurting sort of the Republican cause, actually helping the nominee by putting things out there that may not be able to be backed up any further? I've seen tons and tons of responses from Democrats just pushing back at the specific quotations they're using. I could go into that, but I think Judge Jackson did that herself in the hearing. So I think it's an important moment. I sense Democrats are starting to feel that anger in their throats that we've had in the past year, that until this moment in the hearing, I hadn't sensed before. It had been very civil, even sort of from joking around between the parties. But I think if this kind of questioning continues, after Judge Jackson has already answered these same concerns, there will be a difference in kind of the tension in the room.
Lisa, we should point out, there's always strategy at play, right, from the senators in that room. We know, of course, Democratic senators are doing what they can. We've seen this even in the morning, trying to give Judge Jackson a break every now and again, right, either to revisit topics she has already spoken on, or even just saying, okay, you can take a break for a minute, as Senator Whitehouse said, and I'm going to kind of run through some things that I needed to say, just so after 3 or 4 hours of questioning, she doesn't have to talk for a moment. But when it comes to these issues, there's probably no one who can speak better to them than Judge Jackson. So do Democrats have a strategy for how to handle these questions moving forward?
They do, and I think we've seen this play out. I think they're going back and forth. If they feel like she needs more time, they are starting right off the bat and giving that to her, as we saw with Senator Coons. His first question was, what else would you like to say in response to Senator Cruz? But you notice that he ended his session with her using the other Democratic strategy, which is, I'm going to give your defense for you. I'm going to also bolster what you say by bragging on you in a way that might be difficult for you to do in as many words, to put out a lot of statistics that we believe refute what Republicans are saying. So they're doing it both ways, giving her more time to speak for herself and then also backing her up in their own words. All of this, though, Amna, it all comes down to the votes, right? In the end, Democrats need 50 votes to get this nominee through. And I spoke to Senator Susan Collins, Republican of Maine. She is one of the Republicans, perhaps the Republicans that Democrats think is most likely to consider voting for Judge Jackson. And we asked her, myself and another reporter, about this idea of her child pornography sentencing, all of these accusations or questions Republicans are raising. Senator Collins said, I don't know of any evidence to believe there's a concern there, and she said she herself, Senator Collins, asked Judge Jackson about her sentencing and whether her sentencing was in line or not. And she is taking Judge Jackson at her word in their personal meeting that her sentencing is in line with all the other judges. And as far as our data shows, that's true. And that's what Susan Collins is looking at. In the end, we can have all these quotes, all of these sound bites from this hearing, but it's votes like Susan Collins that will matter in the end.
And Lisa, before you go, I want to ask you about one more senator specifically, because no one knows this better than you, and you are there in the room. Senator Graham, who has supported Judge Jackson in the past, in her previous confirmation hearing for the D.C. Court of Appeals, has been among the more animated, shall we say, on the in the hearing proceedings today. And earlier this morning was an incredibly heated exchange between Senator Graham and Chairman Durbin about a number of issues, really, but almost you could call it an airing of grievances from the Republican side. I'm curious what your sources are telling you about Senator Graham in this moment, where he stands, whether what we've seen from him so far is an indication of how he'll go moving forward.
Senator Graham does have friends here in the Senate, but he generally keeps his final decision to himself until the end. He is someone who, I've covered him a long time, including when I was a reporter in South Carolina. He is someone who almost prides himself on being willing to make up his mind at the last minute or to go with his gut. And I think that it is impossible to say exactly where he will land on Judge Jackson, except that he also wears his thoughts on his sleeve. He never hides when he's angry, as you say. We know that he is upset about this nomination. He is very openly upset that his nominee of choice, Michelle Childs of South Carolina, was not chosen. He envisioned a beautiful bipartisan world around Michelle Childs. That's not happening. And we know Lindsey Graham is someone who has said in the past, if you do my side wrong, I am going to feel like I can do your side wrong. He said that in the Kavanaugh hearings. So there is a sense that this is a man who says an eye for an eye, and he's unhappy about his nominee not being pushed forward. Now, is he consciously thinking that way? I don't know. Right now, he seems to be indicating he doesn't have a lot of reasons to vote for this nominee, especially in an atmosphere where no other Republican has said that they would. But he does like to be unpredictable. So, and also, Amna, he has voted for every Supreme Court justice that he has had cross his desk in the Senate. This would be his first no. So I'm watching him closely. He's an interesting character to cover. Right now, he does seem to be leaning no, but we'll see.
There is all of that you just mentioned, all of that to keep track of. Lisa Desjardins is doing that for us on Capitol Hill. And Marcia, I know there was a lot covered in the last 2 hours. Of course, I think these issues around critical race theory and so on are probably going to generate a lot more conversation moving forward. But I was particularly struck by an answer that Judge Jackson gave to a Democratic senator about an issue I know you pay a lot of attention to, this shadow docket, right? These are emergency decisions, essentially, that are often unsigned when the judges hand them down, and justices rather. And I'm curious how you think she handled that question, because she is someone who has been very explicit about the need for greater transparency from the bench. Right. These are anything but transparent.
Oh, that's true. And I didn't think that the answer was all that forthcoming. And it may be because she has been careful not to criticize the Supreme Court in any way. And I think that had more to do with it than anything. And to really explain her thoughts on the shadow docket, and if she wanted to say when the court should use it properly, she would have to go into details about the factors that the justices have to consider before agreeing to impose an injunction or a stay as requested by the emergency applicant. And it gets a little bit down in the weeds, and I don't think she was prepared to do that. I think it was more her reluctance to appear to criticize the court as some have, for its use of the shadow docket.
We also heard her say, right, I'd like to be able, if confirmed, I would like to be able to speak with the other justices
Yes.
to hear their reasons for
Right.
this.
She said the same thing about cameras in the courtroom, that she would like to, if confirmed, speak with the other justices about how they feel before she takes a position.
That's right. Did that surprise you? That issue came up as early as it did?
No,
No?
it's a perennial question. And I think it was Senator Grassley who brought it up, and it's an issue that he has pursued in his committee as well. And just about all the nominees say the same thing, except David Souter, who said it would happen over his dead body. He's still alive. Retired, but alive.
In terms of perennial issues that come before the court, we should note she's obviously asked about a lot of issues that are currently with the court.
Yes.
Issues like abortion. And we know that there's a very big case that we could see a decision on later this year, but that would be before Judge Jackson would be seated if confirmed. Is that right?
That's right, it would be. And I was a little surprised that, well, maybe we'll hear more about abortion later today or tomorrow. But and from the Republicans, that's where I would expect it to come from. But they may be feeling somewhat comfortable since all the prognosis is that the Supreme Court is going to overturn its landmark abortion rights rulings, Roe v. Wade and Planned Parenthood versus Casey, in the case they have before them out of Mississippi. So it was just a rather brief exchange with Senator Feinstein and some thoughts about stare decisis, which is the doctrine of standing by precedents, old decisions, and why that's important. And Judge Jackson did respond in the way you would expect, explaining what stare decisis is and how it contributes to stability of the law for all of us. So I was a little surprised it hasn't gotten more traction, but we'll see.
We'll see. Still many hours ahead of us, we
many
should
hours.
note. We are about halfway through the senators on that committee, each having their 30 minutes to ask questions. We're keeping an eye, by the way, on that live picture of the hearing room as people are starting to trickle back in. As soon as the hearings do begin again, of course, we will go there live. I think Jeff Bennett is still with us over at the White House, though. And Jeff, I want to get your take on this because obviously we have heard repeatedly now, I think, from Republicans some central themes. It looks like they're focusing in terms of really trying to challenge Judge Jackson on a few issues when it comes to how she would handle hypotheticals. Would she act as an activist judge? Is she, quote unquote, soft on crime? Are there any lines of questioning folks at the White House have been caught off guard by or surprised haven't come up yet?
No, and the one that they prepared the most for was this notion that Judge Jackson is soft on crime. And in fact, we were told by a White House spokesperson today that President Biden was particularly struck in Judge Jackson's exchange this morning with Senator Leahy, where he basically walked her through her resume. And there was sort of this long recitation of how her work as a public defender was not in any way a detriment, but it was in many ways an asset. And she also talked about how she's from a law enforcement family, and that one of her brothers is a detective, and the other worked his way up through law enforcement. And she knows what it is to have family members out on patrol and not knowing if they're going to come home at night. She also talked about she knows very well the effect that crime has on a community, and the need for law enforcement, as she put it, wasn't some sort of arbitrary concept or a political slogan, that she knows all too well the important role that law enforcement has. And so it was in many ways a way to sort of preemptively neutralize any attack that would come from Republicans. So to answer your question, no, there's been really no line of attack that the White House or the team assisting Judge Jackson feels has landed. And I'll also add that the notion that Republicans, namely Senators Pauley and Cruz, are trying to alternatively paint her as a CRT activist or being soft on crime or somehow being an advocate for child sex offenders, the view from here at the White House is that all of that taken together suggests that Republicans have no serious objection, that all of those different accusations are so laughably unserious. It all speaks to the fact that they can't really pick apart her record and can't pick apart her qualifications. So at least for right now, at almost 4 o'clock Eastern, on a Wednesday, the White House and the team, the Sherpa team, feels pretty good about where things are headed next.
Helps to have a clock nearby. We have to remind ourselves, this is where we are right now. This is where we are. Marshall, well, to that point, though, help to put what we've seen in context. There is strategy at play in the room. We've seen Democrats come forward with sort of a strategy of pre-buttal in some cases, knowing what the lines of attack would be from Republicans and trying to get out ahead of them, having Judge Jackson answer questions before those lines of attack are unraveled. Is there anything different about the tone, about the lines of questioning you're seeing in this particular confirmation hearing to previous ones? And I guess Judge Barrett's is sort of another extenuating circumstances, given it was
There's
virtual.
Several that have had extenuating circumstances. I think, as Lisa has told us, at least up until this point, it's been a relatively low temperature hearing, and that is unusual. Given what we've seen in the last 3-4 hearings, at least the last 3, where it was sort of the flip side. You had Democrats complaining about a stolen seat. The Gorsuch seat was stolen from Judge Merrick Garland. Then you had the Brett Kavanaugh hearings, and with the sexual assault attack there. And Democrats complained about Barrett being rushed through. So it's sort of like the mirror image, at least with the Republicans' complaints about the Democratic handling of confirmation hearings. But at the same time as they make those complaints, they're still being extremely courteous to her. And only at one point when Senator Graham was questioning her about Guantanamo Bay, did it seemed to get really kind of pointed and it slipped through. But he was more angry, I think, about how Guantanamo Bay is being handled than he was about her handling of the detainee representation. And then the cruise was a little, that was very pointed, I thought. But I think for the most part, Amna, it's been going quite well, and I imagine they're pretty pleased so far.
Well, it's been interesting to see that for all the complaining and previous referencing about how previous nominees were treated, all of them were confirmed.
That's right.
And are currently Supreme Court sitting justices. But to the other point about, the politics of this moment, about the way that she is being questioned, it's halfway through. We're halfway through day 1. You have to imagine that they have 11 more senators who have 30 minutes each. Then each of the senators have 20 additional minutes tomorrow. We believe that's how the schedule will go out. It is a lot of time, and there's a lot of room to run. So what other issues do you expect to come up?
Well, I'm thinking that they are going to get into more of her opinions, and we'll see.
It's over 500 to go through, right?
That's right. But we haven't heard much yet about some of the more political opinions, the cases that she handled against the involving the Trump administration. And I imagine there are going to be a number of questions about that. But we also don't know anything about her rulings on the environment, labor law, just consumer affairs. There's a lot of stuff that court handles that she's ruled on that we should learn about. And the other thing I was going to say in terms of the low temperature is that you also have to realize that Judge Jackson is going to be one of the dissenters for the most part on this court. There's a 6-3 conservative majority. And so for the Republicans, this isn't like filling the swing vote seat, where then it's very intense as to who's going to be confirmed to the court.
Her confirmation would not dramatically alter the ideological
it wouldn't.
balance,
It's not to say that it's not an important seat that she takes, or that she won't be influential in some ways, but in terms of actually altering the direction of the court, it won't.
Jeff Bennett over at the White House, I believe you're still with us too. This does bring up the question of what's at stake here, right? And in terms of the Sherpa, former Senator Jones, who is leading her through this, in terms of all the people who've been advising her and coaching and preparing her, yes, she is clearly qualified. There are some tough questions she's already handled, some tough questions sure to come. Is there a point of concern for the White House? Is there something that they're generally worried about that could potentially derail this nomination?
You know, that has not come up in any of the conversations I've had with White House officials. They seem pretty confident that they'll get the 50 votes that they need, even from senators like Kyrsten Sinema of Arizona and Joe Manchin of West Virginia, who have been obstacles for so much of President Biden's domestic agenda. The two of them have voted for all of President Biden's judicial appointments. In fact, that is the one area of success that this White House has really had, and that's getting people confirmed to the federal bench at a fairly fast clip. At President Biden's first year, he had, I think, 40 or 41 people confirmed to the bench, the vast majority of whom were diverse and or women. And it was intentional. It's also true that given President Biden's experience, we've talked about this, his 50-plus years in public life, his vast experience on the Senate Judiciary Committee, but Ron Klain, who serves as White House Chief of Staff, he was also once a staffer for the Judiciary Committee. So you have sort of layers upon layers of experience here at this White House, people who've had a direct hand in Supreme Court confirmation processes, but who've also been really skilled at and experienced in getting confirmations generally through the Senate to nominate people to the bench. And they've been doing it quickly, quietly, and without controversy. And one of the reasons why President Biden ultimately settled on Judge Jackson was because she'd been through this process 3 times before, for an appeals court position, for the Sentencing Commission that she once sat on. And so this is actually her 4th time in sort of going through this sort of gauntlet. Of course, the Supreme Court confirmation process is... And I'll kick it back to you because I can hear Senator Durbin.
That is the gavel. That's right. She's no
Yeah.
stranger to this room. She is back in there now. We're going to go live back now to the hearing.
This, you are 51% done as of this moment, which feels more like curse than blessing, but I meant it as a good thing.
Thank you.
I think I'm number 12 of 22, so you're just past halfway down on the downhill. Thank you as well for spending time with me in my office, and thank you for answering the questions of the committee today and tomorrow. What you've said in public matches what you've said in private, and that's obviously a testament to your character. That also can be helpful to rebuilding public trust. So thank you for the ways you've engaged thus far. Judge, you are likely to go on to serve a lifetime appointment on the Supreme Court, which means that this is very likely the last job interview you ever have.
And the most public, Senator.
Yeah, these processes are a lot like a proctology exam. That means that it's an opportunity for you to explain to the American people how you view a Supreme Court justice's job and the limits and bounds on that job. So I want to go back to a topic that you and I have discussed a few times, which is how you approach cases. You've told this committee and you've told me in private that you don't have a judicial philosophy yet, but that you think of yourself as having more of a judicial methodology. I'd like to understand that a little bit more. And I think it would be helpful for the American people to understand that argument and that distinction a bit more as well. Earlier today, you said that you, quote, do not believe there is a living constitution. And you also said that you're constrained to interpret the text and that, I think you said, sometimes that's enough to resolve the issue. So I think I've heard you pay partial tribute to the judicial philosophy of originalism, but you've not adopted it or embraced it as a philosophy or label that applies to you. So maybe one of the places we could tease that out a little bit more is trying to dig into whose jurisprudence you most admire. We've heard many nominees before, like Senator Grassley, former chairman of this committee. I'm not an attorney, so the farming and ranching people where I come from know that John Kennedy is super smart Rhodes lawyer who kind of pretends to be a, aw shucks kind of guy as he picks your pocket. Grassley and
Do I get equal time, Mr. Chairman?
He always gets unequal time. He always gets bonus time. But I think it might be helpful for us to understand who you most identify with, and past nominees before this committee have talked about the mold of particular justices they thought they followed in. And so if you had to tell the American people who you're closest to, who is that justice, or who are those justices?
Well, thank you for the question, Senator, and I must admit that I don't really have a justice that I've molded myself after or that I would. What I have is a record. I have 570 plus cases in which I have employed the methodology that I described and that shows people how I analyze cases. I, in every case, am proceeding neutrally, from a neutral posture. In every case, I describe thoroughly all of the arguments that are made in the case to me as a judge, because I want, in my lengthy opinions, for people to understand the inputs. This, I say, is what I'm considering, because I lay out in very, detailed way everything that people have argued in all of the cases. And then when I'm doing my interpretation, I am focused on the text of any statute or constitutional provision. I am looking as appropriate to the intentions of the people who wrote the words, because I view statutory interpretation, constitutional interpretation, those exercises consistent with my limited authority. I am conscious of not interpreting those texts consistent with what I believe the policy should be or what I think the outcome should be. I am trying in every case that involves that kind of interpretation to assess what it is that the parties who wrote the text intended. And as a result, because my methodology involves these various pieces, and because of the way in which I do things, I'm reluctant to establish or to adopt a particular label, because the idea of how you interpret is just one part of the entirety of a judge's responsibility. As I mentioned, I'm looking at the facts in a case, and my experience as a trial judge helps me to assess the facts from all of the different perspectives of the parties, because I'm able to do that, I think, having heard from parties in all sorts of cases directly as they present their arguments. That's a part of the judging responsibility that isn't really captured by something like originalism or living Constitution. And I believe that the Constitution is fixed in its meaning. I believe that it's appropriate to look at the original intent, original public meaning of the words when one is trying to assess, because again, that's a limitation on my authority to import my own policy views. But there are times when the meaning, unreasonable searches and seizures, due process, looking at those words are not enough to tell you what they actually mean. You look at them in the context of history, you look at the structure of the Constitution, you look at the circumstances that you're dealing with in comparison to what those words meant at the time that they were adopted, and you look at precedents that are related to this topic. All of those tools judges use, and I have used, is if you look at my cases.
But when you say that you look at the intent of the authors of a statute, sometimes courts have to say the people who wrote this statute, whether they meant to or not, have done something that we, the judiciary, decides, speaking in the voice of you, is unconstitutional. And deciding that something is unconstitutional requires an interpretive framework for how you get there, right? And so you and I talked in my office about the differences between Justices Kagan, Breyer, and Sotomayor's judicial philosophies, and you told me that you needed time to study that issue further. So assuming that you've had a chance to think about that a bit more, I guess I'd ask you again, what are the differences among the three of their judicial philosophies?
With respect, Senator, I have not actually had time with all of my meetings with senators and the work that I've done to appear before you today. I would say that there are differences, as you see from the various opinions that they have issued. I'm not sure which one I would necessarily follow, because it depends on the case. I think their differences indicate that they are looking at different provisions. They are using the various tools that judges use and that I have used in my cases. The idea of striking down a statute as unconstitutional is daunting and should be daunting, I think, for any judge or justice, and would have to be looked at very carefully because of the limited nature of the judicial role and the fact that the policies have been adopted by the branch of government that has that authority under the Constitution.
So I guess I'm surprised after 9 years on the bench that, I mean, you're super smart. Nobody disputes that. And having worked for Justice Breyer and knowing of some of the fights, some of the philosophical arguments he and Justice Kagan had, it just seems surprising that you wouldn't be able to at least not speculate, but reflect a little bit on the nature of those disagreements. Because to say it depends on the particular case, that's fine, but they have different philosophical and hermeneutic approaches to the text. So maybe another way to get at it. I think Justice Breyer, again, for whom you clerked, and Justice Scalia used to travel together and have lively debate circuit conversations. Can you tell the American people a little bit about what Breyer-Scalia roadshow looked like? What were they arguing about?
Well, my understanding is they were arguing, or at least presenting, two different viewpoints as to how the Constitution should be interpreted. And I would say, just as an aside before talking about their positions, that while I have been on the bench for 9+ years, the issue of constitutional interpretation in that sense doesn't come up very often. It comes up to the Supreme Court for sure, but it doesn't come up very often in the lower courts. What Justice Scalia and Justice Breyer, I believe, were debating was Justice Scalia's notion of originalism, meaning that the words of the Constitution should be interpreted as they were written by the founders in the founding era, and that they should not be considered to essentially to establish principles that modern justices could now apply based on their own view of the needs of society. And that Justice Breyer's position was more toward that latter view, that the idea of the Constitution needing to be interpreted in a way that is consistent with modern sensibilities about the principles that the document reflects. And I would just say that it appears now that the Supreme Court has taken Justice Scalia's view that the prevailing interpretive frame for interpreting the Constitution is now very clearly looking back through history. So we see that even in the Heller case, where the justices, even the justices in dissent, were all analyzing the issues in the Second Amendment through a historical lens, what was meant at the time of the founding. So that is now the way in which constitutional interpretation is done.
But do you identify with that position?
I identify with the position insofar as that's how the text is interpreted of the Constitution. That I am a strong believer, as I said, in precedent, in stare decisis, in predictability, in the rule of law, and the way that the law now interprets the Constitution is through this historical frame.
I'm grateful for your last couple of minutes because I think that it's in the American civic interest for us to understand these different schools. Again, non-lawyer here, but my simple way of summarizing some of what I think I heard you just say is that Scalia argues hard that the Constitution has a fixed meaning and justices aren't really free to depart from it without a constitutional amendment passed by the political branches so that the voters get to hire and fire the people or have a role at the state level in the ratification of a constitutional amendment. And Breyer's position seems to me and I won't get it precise enough in technical legal terms, jurisprudential terms probably to satisfy him, but that the Constitution is speaking to more abstract principles, and therefore there's a lot more play in the joints of what a justice's job is. And I think the way you summarized their debate was pretty fair. And I also think it's fair for us to want to understand what your position is about it, because you're obviously, as I've said, incredibly smart and incredibly likable and winsome and on the stage for a lot of Americans to look up to. I'm at the rah-rah, hear side of that debate. At the level of what is a Supreme Court justice's job, I think that's why a lot of us are still trying to tease out the philosophical distinction, which I think is more than just a methodology, but want to thank you for that answer. You've also brought up the Fourth Amendment a number of times in our conversation, and I would like to talk a little bit more about the Constitution and whether its meaning changes. And so I'd like to go back to the Fourth Amendment topic you brought up in my office. You said, I think, that and correct me if I'm missummarizing your position, you said that originalism wouldn't have much to say about the Fourth Amendment because the Founding Fathers never conceived of a tool, a piece of telecommunications equipment like this. And so I think during our conversation, you said that the original meaning of the Fourth Amendment won't tell you much about what to do with a new technology. My guess is that originalists, and Scalia in particular, would disagree. So what do you do if the text of the Fourth Amendment doesn't answer a question? Where do you go next?
Well, Senator, just to clarify what I intended to say, and I may well have misspoken, there is an originalist take, I think, on the question of what happens with a cell phone. As the Supreme Court held in the Riley case, there was a way in which you assess principles of the Constitution, the text of the Constitution, and apply it to modern technology. And you have to, because there's no question that cell phones didn't exist at the time of the founding. So if the originalist principle is we look only at the Constitution as it relates to things that existed at the time of the founding, there would be no answer to what to do about a cell phone. And so what the Supreme Court has said and done is to determine that the principle of the Fourth Amendment with respect to searches is to determine whether there is a reasonable expectation of privacy. They also have looked at property interests with respect to whether or not there's an invasion of privacy, and then determined from history what that reasonable expectation of privacy related to back at the time of the founding, and analogized to current circumstances related to things like cell phones. It's a method of interpretation that allows you to, instead of the alternative, which would be don't worry about the history, just look at the words in the Constitution and say, what do I think is reasonable or unreasonable with respect to police officers searching cell phones? That's not the way the Supreme Court handles it. They try to determine what was unreasonable historically, and then given those principles, historically, it would be unreasonable for police officers to enter someone's home, to rifle through their papers and documents. They then analogize to current circumstances and the fact that a cell phone is like your personal file cabinet. And they say, okay, given what we understood the framers to have intended about the need for a warrant or the need for protection against unreasonable searches, we're going to apply that to modern circumstances. It's still an originalist way of analyzing the current dispute.
So are there non-originalist ways to wrestle through that same question? And what would they be?
One could imagine that rather than referencing history at all, that the court would look at the Constitution. It says no unreasonable searches and seizures, and would just ask in light of modern sensibilities, in light of what we would think would be reasonable today, or what the court itself would think would be reasonable today. We'd apply that modern understanding to the cell phone situation. And the danger, I think Justice Scalia would say, is that that's a kind of framing that permits judges to make a determination based on their own views rather than hewing themselves, as Senator Lee said before, that Justice Barrett pointed out, hewing themselves to the text of the Constitution.
And does Breyer have a different view?
You know, I haven't, I'm just trying to think. My understanding of the living constitutional principle is that it's closer to looking at the needs of modern society. But I'm not well versed in it, in part because the Supreme Court has now so clearly taken the historical perspective, the originalist perspective in its interpretations.
You brought up the cell phone example with me, but I know you have others. What are some other areas of life where the original meaning seems to be 2.5 centuries removed? What are places that the Constitution seems to not speak to?
Well, Senator, I'm reluctant to spell out different circumstances. What I will say is that when you look at the language in the Constitution, there are some provisions that are completely clear on their face without any question of what was intended. The age of the required age of senators, the required age of the minimum age of the president. These kinds of provisions, all you need is the text, and there you are. But there are provisions of the Constitution that are broader than that, and therefore some interpretive frame is necessary. And to the extent, every question the Supreme Court gets that involves new technology, for example, that relates to constitutional provisions will require some kind of analogy, I think. But, I can't speak to anything more than that.
You have described Justice Breyer's constitutional approach as pragmatic. What does that mean?
I understand it to be, and his approach to be about ensuring that the rules that follow from the Supreme Court's determinations are ones that make sense and are workable.
He said recently, explaining his approach to interpreting a statute, you're not going to go outside the words, but it often doesn't give you the answer. And you look at the history, and you look at its purposes, and you'll look at the consequences too, and you'll try to evaluate them from that, the point of view of what a reasonable legislature writing this statute have thought that these words were there to achieve. Do you align yourself with that position?
In the broad sense that what it is that the court is tasked with when statutory interpretation is being undertaken is to achieve the purposes of the legislature. The text is the primary, and in most cases, sole indication of what the legislature intended, as opposed to the court saying, I see this statute, but I'm, uncomfortable with how it's going to turn out or what it's going to mean, and so I'm going to import my own policy perspective. Instead, the court is constrained to say, regardless of what I think the right policy objective should be in this, with respect to this law, my purpose, my requirement is to determine what Congress intended.
But with respect to legislative intent, when a Congress of 535 often distracted people, 100 in this body and 435 in the other, pass something, by a 2-to-1-ish vote, and it's a part of a large piece of legislation, how do you determine what the intent is when it's 535 people doing something that has many, many different purposes for why somebody might vote yes?
Well, you look at the text. I mean, the way in which statutes are interpreted is based on what the legislature says. There are times in which there are statutes in which Congress includes a purpose statement, for example, in the actual text of the statute. You look at the text of the provision. If that isn't clear, you look at the structure of the statute. There are canons of interpretation that courts use to evaluate and interpret statutes. Things like a word that appears in the section that you are interpreting should be defined the same way it is in another section. The same word being used, Congress probably intended for it to have the same meaning. So there are tools in the law that exist to help courts to interpret the text, but again, the goal is to interpret the text as a means of understanding and reflecting what Congress intended. And of course, in statutory interpretation, if Congress decides that the court has gotten it wrong, then, as has happened many times, Congress comes back and clarifies and tells the court, no, this is what the statute means.
I want to go back to an exchange you had with Senator Cornyn. Substantive due process is a doctrine that often allows courts to create new fundamental rights. What's the test for determining a new fundamental right?
The Supreme Court has said in the Glucksberg case that the fundamental rights that are recognized or that are included in substantive due process are those that are deeply rooted in the nation's history and tradition. In a case prior to that, the court had defined it as the rights that are implicit in the ordered concept of liberty or the concept of ordered liberty. So there are standards for the courts to use to identify these types of rights.
So did the Supreme Court use this test in Roe or Casey?
In Roe and Casey, I don't know that the court used that formulation. I know that after Casey, the court has determined not so much that the right to terminate a woman's pregnancy is fundamental. The right exists, and it's subject to the framework in Casey that allows for regulation so long as there's not an undue burden on the exercise of the right pre-viability.
I think some of what we're wrestling with here is the question of, and I think what Senator Cornyn was driving at, is how particular the concept of deeply rooted goes and how that really is a bound on what the judiciary can do. But I want to thank you. We're nearly at time. I want to thank you for engaging in the back and forth. I want to think more about what you've said and look forward to further discussion tomorrow. It still appears to me that there's a very basic difference between a judicial philosophy and a judicial methodology and how you go about applying that when you're interpreting a law and making a determination about constitutionality or non. And I know that you haven't claimed a judicial philosophy at all, but a judicial philosophy of originalism here. But I do think the fact that you've at least nodded to it in the committee hearing today is in and of itself a pretty great testimony to how much of Scalia and Bork's work has moved the legal field. So I'm grateful for the time you're taking with us. I'll look forward to listening tonight and talking with you again tomorrow.
Thank you.
Thank you, Senator Sass. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you, Judge, for your patience and your perseverance. I want to begin just by thanking you also for an extraordinary moment in our history. I think we all, as Americans, feel excitement and pride in really making history here. And the old saying, a picture's worth 1,000 words, as I look at your parents and your husband and your daughters, what I see is America and the best of America. So I think we should all feel that excitement and pride in this moment and the extraordinary journey that has brought you here. You will make the court look more like America, but also think more like America in the obstacles and challenges that you've overcome to be here. We don't know all of them, but you will provide a very important perspective, indeed a unique perspective that the court needs more than ever at this moment in its history. There are a lot of people who are book smart. There are not as many people who are person smart, and you are both. That kind of emotional intelligence is what our courts need, not just our Supreme Court. So I want to really begin by asking you, as a role model for others, to talk a little bit to the young women and girls of America, particularly Black young women and girls, about those challenges and obstacles that you've had to overcome to be here and what's helped you do it.
Thank you, Senator. I am humbled and honored to have the opportunity to serve in this capacity and to be the first and only Black woman to serve on the United States Supreme Court. I stand on the shoulders of generations past who never had anything close to this opportunity, who were the first and the only in a lot of different fields. My parents, as I said, were the first in their families to have the chance to go to college. I've been the first and the only in certain aspects of my life. So I would say that I agree with you that this is a moment that all Americans should be proud.
Now, you've never been a prosecutor. A lot of us on this panel have been prosecutors. I was the U.S. Attorney, the chief federal prosecutor in Connecticut for 4.5 years, and then I was Attorney General of my state for 20 years. But I would say one of the most meaningful cases in my career was as a defense counsel. I was asked by the NAACP Legal Defense Fund to represent a Black man on death row in your home state of Florida. He had been convicted of murder and rape, had been on death row for a number of years. And I took the case because I was asked to do it, and eventually, somewhat to my surprise, found, in fact, he had never done the crime of which he had been convicted. And eventually, we won his freedom because the prosecutor in the case concealed evidence, which was a violation of his constitutional rights. And he was a free man as a result. Your husband, as a surgeon, saves lives. Lawyers don't do it often. But I know from personal experience the importance of having a good representative, an advocate, a counsel, because in that case, he had been denied it when he originally went to trial. And only after years in both state and federal courts was the truth vindicated. So I want you to talk a little bit about why it is important for defendants to be represented by zealous, really aggressive and energetic advocates who tell the truth to the court, put on the evidence, and present the best possible case for a defendant accused of a crime.
Thank you, Senator. The idea is one that is rooted in our Constitution. The framers were concerned about government overreach in a lot of different areas. The provisions of our Constitution are protecting individual liberty from government overreach. This is why we have provisions about limited government. And there are many provisions in the Constitution that are limiting government action when it comes to the deprivation of liberty, because the framers understood how important liberty is to our society. And so there's the Fourth Amendment, there's the Fifth Amendment, there's the Sixth Amendment, there's the Eighth Amendment. These provisions are crucial, and it is zealous defense counsel that ensures that the government is protecting these rights, that ensures that these rights are protected and that people are getting due process in the criminal justice system. And that's to all of our benefit. That helps everyone in America when we ensure that liberty cannot be denied without due process. It's defense counsel, as I said, who are making arguments, and they're not condoning the criminal behavior. They're making arguments on behalf of clients in defense of the Constitution and these constitutional values. And as a judge, I now see how important it is for me to be able to make my decisions after hearing from both sides. That's crucial. We have an adversarial system, which means that judges are presented with arguments from both the prosecution and the defense. And only when I'm able to hear from both sides can I make a just, fair determination. And fairness is the hallmark of our constitutional scheme, and it's what makes us the best criminal justice system in the world.
And it's not only the reality of fairness, but also the perception of fairness, the public's understanding of how courts work, that is essential to the credibility that courts have, correct?
That is correct.
And so I feel very strongly, I know that a number of us on the committee agree, that more transparency, more visibility is important for the public to understand what goes on in the courtroom. I know you feel transparency is a good thing. You've been asked about cameras in the courtroom. I'm a supporter of Senator Grassley's Sunshine in the Courtroom Act, as well as Senator Durbin's Cameras in the Courtroom Act. I am hopeful that the court, the United States Supreme Court, actually will back these proposals because their support would be very important. Tell me how you feel about the basic principle of transparency and more visibility.
Well, Senator, one of the reasons, as I said, that I write such long opinions is because I want everybody to know exactly the arguments I've considered, the facts that I've reviewed, and in pretty fine detail, the course of my reasoning. And I've done this in 570 opinions. I think it's important for public confidence, as you say, for people who are bound by the law and who are affected by the courts to know what the court's views are. With respect to the issue of cameras in the courtroom, I understand that that is something that is proceeding through Congress, and if I was confirmed, I would look forward to talking with my colleagues to understand the positions that people have regarding that issue.
I appreciate that. response. One of the other areas that I think is important to transparency and to public trust and confidence in the court is visibility as to its own decisions, which I think is directly contradicted by the shadow docket. You've been asked about it before, but I just want folks to understand that some of the most important decisions of the Supreme Court have been decided, or at least issues resolved, without oral argument, without briefs, without any public explanation. A controversial travel ban has gone into effect. The first federal execution in 17 years was permitted. Statewide COVID restrictions were enabled. The collection of data in the 2020 United States Census and enforcement of voting restrictions in the 2020 presidential elections, as well as decisions relating to immigration and blocking the Biden administration from enforcing a federal moratorium on evictions imposed because of the COVID-19 epidemic. Americans have a right to an open, full, fair proceeding with a record of the court's reasons for making decisions. So I hope that you will urge your colleagues, when you talk to them about cameras in the courtroom, also to do less on the shadow docket. And I hope that perhaps, if they don't, Congress will take some action. I finally want to ask, so far as this issue of transparency is concerned, about codes of ethics. You have followed a code of ethics as a district court judge and court of appeals judge, correct?
I have.
Does that code of ethics apply to the United States Supreme Court?
My understanding is that it does not.
Correct. And my hope is that you will perhaps urge your colleagues as well to support a code of ethics. They haven't done so as yet, but I think we have an obligation in the Congress to set forth a code of ethics, and I hope they'll support it. Senator Durbin and others of us have supported that kind of measure as well. And I would just ask you whether you'll raise it with your colleagues if you're confirmed.
Senator, certainly if Congress is taking anything up that requires our review, I would absolutely consider it, and even if not, I would consider it.
Thank you.
Talking to them about it.
Thank you. You know, the reason I raise these points is that I respect the United States Supreme Court. I've argued 4 cases before it. I was a law clerk to Justice Blackmun, who, by the way, was from Minnesota, Mr. Chairman. In fact, he was known as one of the Minnesota Twins when he was appointed, because he was thought to be exactly like then Chief Justice Warren Burger, who also was from Minnesota, in his very, very conservative views. And as it happened, Justice Blackmun became one of the most progressive members of the court over the years that he served. He had a capacity for growth and for learning and listening, which I believe you have, and I think it is one of the most important characteristics of anybody who serves on the court. But I do think the court's crisis of legitimacy is the result of divisions within the court, the polarization and politicization that has drawn lines, the process that has happened in recent years in confirmation proceedings. And so I really think that consensus building bridges with your colleagues, will be immensely important. I think that's one of the reasons that the president chose you, having talked to him about it, that you have that kind of persuasive and forceful intellect, but also the personal charm and warmth and depth that will enable you to do it. Maybe you can tell this committee about how you worked on the Sentencing Commission, for example, or in your previous experiences on that kind of consensus building.
Thank you, Senator. Consensus building was one of the things that Justice Breyer was particularly good at in terms of his personality. In the time that I clerked for him, I witnessed the way in which he continually reaches out to colleagues, continually seeks common ground. And it's something that I would hope to be able to emulate if I were to be confirmed. When I worked on the Sentencing Commission, the commission is a 7-member body working on sentencing policy, which is at times a pretty contentious effort because we're talking about criminal justice. As commissioners, we are working on policy issues related to appropriate sentencings, and by statute, the commission is a bipartisan group. And during my 4 years as a commissioner, I was able to work well with other members of the commission to find common ground, to work on issues, to come together. And the vast majority, I heard a statistic that something like 95 or 97% of the votes that the commission took were unanimous. And that happened because of a lot of effort and an intention on the parties, on the part of all involved, to see if we could work together. And that would be the kind of thing that that I would hope to do if I was confirmed to the Supreme Court.
You've mentioned in your previous testimony the challenges of applying the law to evolving and new technology. Obviously, the internet raises exactly those questions. Congress passed the Electronic Communications Privacy Act in 1986, when the internet was barely recognizable. It was nascent, just starting. And now, our nation faces a mental health crisis. It is partly aggravated by the pandemic, the isolation and anxiety that's resulted from it, but also by the internet and by the tech platforms that drive toxic content at children as a result of these black box algorithms that nobody really understands. Literally, no one understands because the tech platforms want to keep them secret. And we are trying to upgrade the law and update it to give parents tools to have greater visibility as to what their children are doing, and to give parents and children tools to protect them against some of the bullying and eating disorder content and even suicidal and substance abuse stuff that they are driven to see. And Senator Blackburn and I have introduced a bipartisan measure, the Kids Online Safety Act, that will provide a more modern solution to a modern problem, to update the law to account for the role of social media in our ongoing and aggravating mental health crisis in this country. Do you agree that it helps the Supreme Court and judges in general to do their job when Congress updates our statutes to account for technological change?
Thank you, Senator. The role of the court is to interpret statutes when there are disputes related to the statutes, and in circumstances in which statutes have not been updated, I don't think it's surprising to note that there are disputes about the meaning of the statute, about how it applies. And so to the extent that Congress undertakes to make amendments and make the changes, I think it helps courts. Maybe there'll be fewer disputes or easier disputes to resolve.
Easier disputes to resolve in the sense that, and I've seen it happen, a judge will say, I don't know what Congress meant to do in this kind of situation because this law was written at a time when none of this stuff now existed. I'm sure you face that situation. I think it's true of social media and the dangers to children as a result of the toxic content that they often find and often seemingly are addicted to use again and again and again because it's part of the business model of those social media and big tech platforms.
Yes, I have faced this situation. One of my cases, the Alliance of Artists and Recording Companies versus General Motors, is a case that I ended up writing a couple of opinions about. It involved a statute of Congress related to digital recording audio devices and whether or not royalties were required for the purchase of those kinds of devices. And it was enacted at a time in which recording technology was at a different stage than it is now. And disputes arose that came before me regarding whether or not to apply the royalty requirement in that statute to modern recording devices, and in particular, the recording devices that are now in automobiles. When you take your CD and you put it in your own car and record onto the hard drive of your car, is that the same thing as putting your CD in one of those machines that records from CD to CD? And you give the second recording to all of your friends? That was what the statute was originally meant to cover. And the question was whether recording to your own car's hard drive counted. And it was a very interesting interpretive exercise. But again, it was the kind of thing in which I was focused on trying to ascertain what, based on the text of the statute and the definitions in the statute, what Congress intended this statute to cover.
And cars, other devices, appliances at home, collect huge amounts of data, don't they? And as consumers, we feel we own that data. It's ours. But it can be bought and sold, exchanged, and mined in a way that right now consumers have no consent over. And it enhances the dominance of just a few of those tech companies, just a few of the corporations. Corporate power is emboldened and enabled in many respects by the amount of data they collect. It's also enabled by forced arbitration. We've had a reference to it already today with respect to complaints about sexual harassment, which fortunately we have addressed. I've been proud to work on the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, which President Biden signed after we passed it just a few weeks ago. I've heard harrowing stories from survivors of sexual assault and victims of workplace harassment who were silenced and denied justice by forced arbitration. But forced arbitration applies as well to everybody who has a cell phone. You have a forced arbitration agreement. Many workers have forced arbitration agreements. Nursing homes have forced arbitration agreements. The point is that you have dedicated your life to access to the courts, the right of a trial, the right to a jury, the right to a judge. None of it is possible where there is a forced arbitration agreement. That's why I've worked on a measure called the FAIR Act that would make any forced pre-dispute arbitration agreement invalid and unenforceable. If both sides want arbitration, that's fine, but access to the courts should be available to everyone. I know that you're limited as to what you can say about measures that are before us and policy issues, but I hope that you will consider the trend that the court has adopted in support of forced arbitration and denial of rights like class action, and review whether they are appropriate. Let me just finish with a couple of quick points. First of all, on the Harvard Law School, Harvard Law Review article on registration of sex offenders, convicted sex offenders. I must say, I read this article several times. In my view, it is analysis, not advocacy. Would you agree?
Absolutely, Senator. As a law school student, I was trying to do what law school students do, which is analyze a new set of legal provisions. These laws were new, and I was trying to assess what criteria courts could use to look at them. I was not making an argument about them at all.
Exactly. And by the way, one of those statutes was in Connecticut. It was challenged on constitutional grounds, double jeopardy. It went to the United States Supreme Court. I defended it there. It was upheld 9-0. I don't know whether your article was cited, but I would put this law review article very much in the category of analysis, the distinction between prevention and punishment. I would call it protection, not punishment or prevention. That's the argument that I made to the Supreme Court. I ask that this article be put in the record, Mr. Chairman.
Without objection.
By the way, it took me 2 or 3 times to get through it, so no disrespect to you or the Harvard Law Review. The issue of child pornography, you mentioned, I think, that in your decisions on these sentencing cases involving child sexual abuse material, which, by the way, I agree is absolutely horrific, abhorrent. It's the reason that Senator Graham and I have actually sponsored a measure called the Earn It Act that addresses it. But you said that you imposed a sentence that matched the recommendation by either the prosecution or the probation office in most of the cases where you did that sentencing. Is that right? Do I have that in mind?
Yes, Senators. In looking back at the records concerning my cases, it looks as though I had 14 cases that involved either child pornography, interstate travel to meet up with a child for sex, the sex crimes related to children. And in 10 of those 14 cases, I imposed a sentence that was consistent with or greater than what either the government or the prosecution requested.
The probation office.
Excuse me, sorry, the government or the probation office.
And let me just ask you, the probation office is an independent arm of the court that investigates the defendant, looks at the crime, the defendant's background, his family situation, all of the relevant factors involved in sentencing, including the sentencing guidelines, and then independently and impartially makes a recommendation, presumably to serve the interests of justice in that particular case based on the individual facts there. Is that roughly a correct description?
That is correct, Senator. The probation office works within the court system. They are independent of the parties, and they investigate and make recommendations in cases concerning what the probation office thinks is an appropriate sentence.
Thank you. Let me just finish by saying Much of America is watching these proceedings on a split screen. On one hand, they are literally seeing the death and destruction in Ukraine, Russia's brutal, barbaric assault on individual rights, basic freedoms that we often take for granted here. And we are exercising those rights right here. You are a teaching lesson. This proceeding is a teaching lesson about the importance of democracy. The people of Ukraine are fighting for it. They are dying in their neighborhoods and streets and their homes. They are huddled in basements. Their men and women are resisting valiantly and bravely against a huge military force that Russia has unleashed and a reign of terror from the skies simply because they believe in the ideals of freedom and law that we are seeking to preserve here. And so on this side of that split screen, I think it's important that we do our best to honor the norms and the rules that you've sought to uphold throughout your life. And I'm proud and excited to be here with you and your family as we go through this process. And I look forward, as I hope many of us do, to a bipartisan majority in support of your candidacy. Thank you. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal. I'd like to bring everyone up to date. We have several considerations. The remaining senators for questions, the endurance of our witness, Judge Jackson, votes on the floor, requests for compassionate release by a number of people in the audience. Here is where we stand. We're going to have Senator Hawley, followed by Senator Hirono. Then we're going to take a 20-minute break because that's when we think there'll be some votes on the floor. We can take care of those and get back in 20 minutes. Then we will return from that break to Senators Cotton and Booker. Then we'll take a 30-minute break or so for dinner. Then it'll be Senator Kennedy, Padilla, and Tillis. And we're going to start off tomorrow with our two Senators Ossoff and Blackburn. So we should finish in the 9 to 10 o'clock hour this evening, God willing. So at this point, I recognize Senator Hawley.
Thank you, Mr. Chairman. Judge, nice to see you again. Thank you again for being here. Congratulations again on your nomination. I want to start where Senator Blumenthal left off. I want to talk with you about some of these cases. I mentioned them yesterday, so I know you know which ones I want to talk about. These 7 cases, child pornography cases, in which you had discretion. They came before you. You had discretion to sentence one way or another in these 7 cases. Not every case, of course, do you have discretion. Sometimes the law requires you to impose a sentence, certain sentence. But in these 7, you had discretion, and in each of these 7, you chose to depart both from the federal guidelines and also from the government's, the prosecutor's recommendations. Senator Lee's asked you a little bit about this. Senator Cruz has asked you about it. He had a chart with the 7 cases on it. Before we jump into those, I just want to correct the record on 1 or 2 things. Senator Coons suggested that in 3 cases, Nickerson, Wynn, and Fife, you actually imposed sentences either within the guidelines or at the same level of the prosecution. But in Nickerson, you didn't have any discretion. That was an 11C1C case. The law bound you. And Wynn wasn't a child porn case, and neither was Fife. Just one other quick thing to clarify. As to these comments about the probation office doesn't issue national guidelines, right? I mean, the probation office doesn't issue sentencing guidelines. They're not public. They're not recommended to all judges. The probation office provides advice to judges case by case, usually in private, usually not available to the public. Is that right, Judge?
Not exactly, Senator. The probation office in criminal cases is assigned by the court to work with respect to the evaluation of cases, in every case consistent with Congress's requirements. The probation office prepares a pre-sentence report in which they review all of the statutory factors concerning sentencing. Congress has a statute
for sentencing. It requires judges to consider the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote various purposes of punishment. There are many purposes listed in the statute, and the probation office is the arm of the court that does factual investigations in every criminal case, unless there are certain cases in which you can waive it, but the background is the probation office's assessment of the facts related to a particular sentence and a particular crime. And the probation office's report, when a court sentences, actually, in most cases, becomes the findings of fact of the court. And so the probation office appears just like the prosecution and the defense. The probation office has written a report and they make a recommendation to the court based on their independent analysis related to the facts of a particular crime and defendant and sentence.
Understood. So they give the court counsel, understood. However, they don't issue guidelines. They're not uniform. It is by its very nature a case-by-case inquiry, as you said. The report goes to the judge. As I understand it, the pre-sentencing report, I'm sorry, the probation reports are not public in all of the cases that we're talking about here. I'd love to see them if they are. But it's not as if there's one set of guidelines that are federal sentencing guidelines and then there's the probation guidelines. The probation office is giving advice to the judge. It varies case by case.
Senator,
but it's not the same.
Sorry, I thought you were done.
No, that's all right. Let me ask you about a specific case. I mean, let's talk about, I listed these 7 cases in which you had discretion and you did not follow the prosecutor's recommendation or the sentencing guidelines, but let's just talk about one of them because we've talked about some of them as a group. Let's talk about United States versus Hawkins. I think that's one you probably remember from 2013. The defendant there was Wesley Hawkins. He was 18 years old at the time. He uploaded 5 video files of child pornography from his computer to YouTube. This is how the police got onto him. He then uploaded another 36 depictions of child porn and other lewd photos of children to his iCloud account. When the police executed a search on his apartment on the premises, they found 17 videos on his laptop and 16 images of child pornography, all of them very graphic, some of them involving very young children. 17 videos in particular. This is from the government sentencing memorandum in this case, just so we understand the facts. Here are some of the videos that the government charged and they recovered. There was a 24-minute, 6-second video depicting a 12-year-old male committing a sexual act. I'm not gonna read exactly what it was. There was a 1-minute and 57-second video depicting an 8-year-old committing a sexual act. There was an 11-minute and 47-second video depicting an 11-year-old committing a sexual act and being raped by an adult male. There was a 15-minute and 19-second video depicting 2 11-year-olds committing sexual acts. There was a 7-minute and 51-second video depicting a 12-year-old committing a sexual act. So, as the government said in this case, and I'm quoting now from the transcript of the sentencing hearing, 17 videos is a lot. And some of the videos, including the ones that are described in the statement of the offense, and I've just related some of them, are very lengthy and include numerous images, numerous views, sometimes collages, sometimes multiple victims. You see the act in progress. The government goes on to describe some of these as sadomasochistic images. So this is a tough case. This is one of those tough cases you were referencing earlier. You talked about it this morning. Said these cases are terrible. This is one of them. This is terrible stuff. This is not a good guy who's doing this stuff. Guidelines recommendation in the case was 97 to 121 months. So if I'm doing my math right, that's up to 10 years. And in this case, the guidelines recommendation was essentially written by Congress because in the PROTECT Act of 2003, Congress specified what they wanted the range to be in these kind of cases. And Congress also specified what they wanted the mandatory minimums to be. I know you remember the PROTECT Act because you've talked about it. You've given lectures on it. And it was enacted, as I said, in 2003. It was 84-0 was the vote here in the Senate. The reason the PROTECT Act was put into place is the Senate was concerned over lenient sentences by judges in child porn cases, which is what you described. You've said about it, there was an increasing perception on Capitol Hill and within DOJ that liberal judges were to blame for the downward pressure on federal sentences and that legislation was necessary to rein them in. That's you in 2011 describing this law. So Congress has set the guidelines here, 84-0 in the Senate. I noticed the chairman voted for it, as did a number of other members of this committee. So the Congress sets the range. Essentially, it's 97 months up to 10 years. Now, the prosecutor in this case, this is in D.C., of course, you're on the federal district court. The prosecutor in this case, it's a liberal administration, I think it's fair to say. This isn't the state of Texas. See my colleague from Texas next to me here. The prosecutor in this case, nevertheless, still asked for 2 full years in prison. You gave the defendant 3 months. Guidelines called for 10 years. Prosecutor wanted at least 2. You gave him 3 months. And when you did, you made a number of arguments and statements in the record, and I'd like to go through some of them because I've read them all. And the first argument you made was that the federal guidelines that punished child porn offenders, the ones that Congress wrote, were, and I'm quoting you now, are in many ways outdated. That's your quote. And you went on to say about why you thought they were outdated. I'm going to quote you again. You say, and I quote, "I don't feel that it's appropriate to increase the penalty on the basis of the number of images or prepubescent victims," meaning little kids, "as the guidelines require, because these circumstances exist in many cases, if not most, and don't signal an especially heinous or egregious child pornography offense," end quote. I just want to ask you about that because I just have to tell you I'm having a hard time wrapping my head around it. We're talking about 8-year-olds and 9-year-olds and 11-year-olds and 12-year-olds. He's got images of these, the government said added up to over 600 images, gobs of video footage of these children, but you say this does not signal a heinous or egregious child pornography offense. Help me understand that. What word would you use if it's not heinous or egregious? How would you describe it?
Thank you, Senator, for letting me address the concern that you've put forward based on the record that you've reviewed. As a judge who is a mom and has been tasked with the responsibility of actually reviewing the evidence that you would not describe in polite company, the evidence that you are pointing to, discussing, addressing in this context is evidence that I have seen in my role as a judge. And it is heinous, it is egregious. What a judge has to do is determine how to sentence defendants proportionately consistent with the elements that the statutes include, with the requirements that Congress has set forward. Unwarranted sentencing disparities is something that the Sentencing Commission has been focused on for a long time in regard to child pornography offenses. All of the offenses are horrible. All of the offenses are egregious. But the guidelines, as you pointed out, are being departed from even with respect to the government's recommendation. The government, in this case and in others, has asked for a sentence that is substantially less than the guideline penalty. And so what I was discussing was that phenomenon, that the guidelines in this area are not doing the work of differentiating defendants, as the government itself indicated in this very case. And so that's what I was talking about, but I want to assure you, Senator, that I take these cases very seriously, that these cases include
the notion by many defendants that the folks at issue, the defendants themselves, are collecting these images on the internet. They're terrible things that have happened, but they're not involved, say the defendants. They're not focused on, what is actually happening to the children. And so part of my sentencings was about redirecting the defendant's attention. It's not just about how much time a person spends in prison. It's about understanding the harm of this behavior. It's about all of the other kinds of restraints that sex offenders are ordered rightly to live under at the end of the day. The sentences in these cases include not only prison time, but restraints on computer use, sometimes for decades, restraints on ability to go near children, sometimes for decades. All of these things judges consider in order to affect what Congress has required, which is a sentence that is sufficient but not greater than necessary to promote the purposes of punishment.
Yeah, well, let me just ask you about that last point, because you've said this a couple of times now, the sentences that Congress require. Congress wanted the guidelines to be mandatory. Congress wrote the guidelines in this case. They wanted them to be mandatory. They gave the courts factors to consider to choose between the sentencing range. Congress wanted you to choose between 97 and 121 months. That's what Congress wanted. The Supreme Court in Booker said that the sentencing guidelines would be discretionary, so the Supreme Court gave you the discretion. But if we're talking about what Congress has wanted, Congress wanted them to be mandatory. My only point in raising that is just to say that you had discretion in these cases, and you used your discretion to choose the sentences that you did. Let me ask you about some of the things, though, that you said, because you said this morning, and I appreciated it, how you want to direct the defendants. You want to get them to own up to what they've done in these cases. And I thought that was powerful, and I thought it was right. But let me just ask you about what you said to this defendant. You said to this defendant, for whom you sentenced to only 3 months in prison, that your collection, I'm quoting you, your collection at the time that you were caught was not actually as large as it seems. The government felt the need to respond to you on the record. They said the government doesn't believe that it's appropriate to just disregard the number of images, that the number of images can be appropriate. And indeed, in this case, the defendant has amassed an extremely large collection of child pornography. But you disregarded that. You also told the defendant, you said this seems to be a case where you were fascinated by sexual images involving what were essentially your peers. And then you went on to say the defendant was merely trying to satisfy his curiosity. Curiosity is your word. One more thing on this, same idea. You said you were viewing, this is you to the defendant, you were viewing sex acts between children who were not much younger than you. And this whole discussion is about why you're only giving him 3 months. Judge, he was 18. These kids are 8. I don't see in what sense they're peers. I've got a 9-year-old, a 7-year-old, and a 16-month-old at home. And I live in fear that they will be exposed to, let alone exploited, in this kind of material. I don't understand you saying to him that they're peers and that therefore you were viewing sex acts between children who are not much younger than you, and that's somehow a reason to only give him 3 months. Help me understand this.
Senator, I don't have the record of that entire case in front of me. What I recall with respect to that case is that unlike the many other child pornography offenders that I had seen as a judge and that I was aware of in my work on the Sentencing Commission, this particular defendant had just graduated from high school. And some of, perhaps not all when you were looking at the records, but some of the materials that he was looking at were older teenagers, were older victims. And the point, Senator, is that you said before the probation office is making recommendations and they do so on a case-by-case basis. That is what Congress requires.
this is not done at the level of
But you had discretion, Judge. You admit that, right? I just want to be clear.
Senator, sentencing is a discretionary act of a judge, but it's not a numbers game. It's not, I understand that Congress wanted the guidelines to be mandatory. The Supreme Court in 2005 determined that they couldn't be, in an opinion by Justice Scalia, determined that they couldn't be, and Congress since then has not come back to amend them or to change them or to make them mandatory again. And so there is discretion at sentencing, and when you look at the sentencing statutes, Congress has given the judges not only the discretion to make the decision, but required judges to do so on an individualized basis, taking into account not only the guidelines, but also various factors, including the age of the defendant, the circumstances of the defendant, the terrible nature of the crime, the harm to the victims. All of these factors are taken into account, and the probation office assists the court in determining what sentence is sufficient but not greater than necessary. And I appreciate, Senator, that you have looked at these from the standpoint of statistics, that you're questioning whether or not I take them seriously or I have some reason to handle them in either a different way than my peers or a different way than other cases. And I assure you that I do not. That if you were to look at the greater body of not only my more than 100 sentences, but also the sentences of other judges in my district and nationwide, you would see a very similar exercise of attempting to do what it is that judges do, attempting to take into account all of the relevant factors and do justice individually in each case.
Well, let's keep talking about this case. You also said to this individual who is an adult, tried as an adult, 18 years old, you also said to him, besides saying that you thought his victims were his peers, you also said there's no reason to think that you are a pedophile. And then you went on to say, again, that's another reason why you weren't going to give him, you're only going to give him 3 months because you had judged that he wasn't a pedophile. And then you said, and this is something I really need your help understanding, then you apologized to him. And I just have to tell you, I can't quite figure this out. You said to him, this is a truly difficult situation. I appreciate that your family's in the audience. I feel so sorry for them and for you and for the anguish this has caused all of you. I feel terrible about the collateral consequences of this conviction. And then you go on to say, sex offenders are truly shunned in our society. I'm just trying to figure out, Judge, is he the victim here or the victims the victims? You're saying that you're apologizing to him. You're saying you're sorry for the anguish this has caused him. There was a victim impact statement in this case. It didn't get read into the record, but it was there. I've described the videos that we have. You say earlier in the case, you talk about how heinous these crimes are, and you describe them to your credit. You describe how heinous it is to your credit, and yet here you are giving him 3 months and apologizing to him and saying you feel sorry for the anguish it's caused him, and also saying you think that sex offenders are truly shunned in our society. So just talk about that. Help me understand. I mean, is he a victim? Is that your view here? Is that why you said this? Is that what you meant by it?
Senator, I again don't have the entire record. I remember in that particular case, I considered it to be unusual, in part for the reasons that I described. I remember in that case that defense counsel was arguing for probation, in part because he argued that here we had a very young man, just graduated from high school. He presented all of his diplomas and certificates and the things that he had done, and argued, consistent with what I was seeing in the record, that this particular defendant had
gotten into this in a way that was, I thought, inconsistent with some of the other cases that I had seen. Part of what a judge is doing, as required by Congress, is thinking about this case, thinking about unwarranted sentencing disparities, that's in the statute, other cases, other determinations that a judge may have made about this. I don't remember in detail this particular case, but I do recall it being unusual. And so my only point to you is that judges are doing the work of assessing in each case a number of factors that are set forward by Congress, all against the backdrop of heinous criminal behavior. But the guidelines are no longer mandatory. Congress has not corrected, as you would say, the Supreme Court's determination about that. Justice Scalia's decision that the guidelines are not mandatory. Congress has not said that. And Congress has given judges factors to consider. This, in my view, was an unusual case that had a number of factors that the defendant was pointing out, that the government was pointing out, that the probation office was pointing out. And I sent this 18-year-old to 3 months in federal prison under circumstances that were presented in this case because I wanted him to understand that what he had done was harmful, that what he had done was unlawful, that what he had done violated the law and needed to be punished, not only by prison, but also by all of the other things that the law requires of a judge who is sentencing in this area.
But Judge, with all due respect, and I'm telling you what, I'll be direct with you. I am questioning your discretion and your judgment. That's exactly what I'm doing. I'm not questioning you as a person. I'm not questioning your excellence as a judge, frankly. But you said it. You had discretion, and that's exactly what I'm doing. I'm questioning how you used your discretion in these cases. And to me, to take a guy who's 18 years old, who has what the government says is an extremely large collection of prepubescent pornography, 8-year-olds, 10-year-olds, 11-year-olds, we're talking about, I mean, gobs of hours of time here that he has. And you say to him, what? That you say that, well, you know, it was just a collection. I mean, he was just viewing it, and it was, you know, essentially they were his peers. You say to him that he's not a pedophile. I don't know how you know that. I don't know why that's relevant to the guidelines, but maybe it is. You say he's not a pedophile. You say that you're very sorry for him and what he suffered, and then you give him 3 months when, frankly, a liberal prosecutor is asking for 2 full years. I mean, it does seem like an extraordinary case to me. It would bother me no matter what. It really bothers me when in every case, child porn case you've had discretion, you've sentenced below the guidelines and below the government's recommendation. And saying that sex offenders are truly shunned in our society, as you said to him, it reminds me, it echoes what you said as early as law school on that Harvard Law Review article Senator Blumenthal was just talking about. There you say, and I'm quoting you now, in the current climate of fear, hatred, and revenge associated with the release of convicted sex criminals, courts must be especially attentive to legislative enactments regarding these sex criminals. I guess like this, the enactment here, the PROTECT Act that Congress enacted. So I want to try to understand here, is it your view that society is too hard on sex offenders? You say they truly are shunned in society. You wrote that many of these laws are products of a climate of fear, hatred, and revenge. So just is that still your view? I mean, do you think that these laws are too tough, that we're too tough on sex offenders? Explain what you meant in this case in 2013, and it seems to be the same thing you said many years ago.
Senator, it's not the same thing I said many years ago. Many years ago, as a law school student, I was evaluating a new set of legislation, state laws about registration, and I was analyzing them as law students do. Wasn't about the sex crime, it was about the characterization of the law. Is it a punitive law? Is it a prescriptive law? And how would a court go about determining that? That was the frame that I used then. It could have been about anything. It was about the characterization of legislation.
But could I'm sorry, I don't mean to interrupt you. I've only got 2.5 minutes left, but I just want to make sure I understand this. I'm quoting from your conclusion now. This is on page 1728 of the Harvard Law Review. This is your conclusion. In the current climate of fear, hatred, and revenge associated with the release of convicted sex criminals, courts need to be especially attentive to legislative enactments. So that's a conclusory statement. You're saying that there is a climate of fear, hatred, and revenge that are informing these laws. And you described some of the laws earlier, I think, Megan's Law and others. Senator Cruz asked you about some of those. I'm trying to understand what you meant by that, because you're saying something similar in the Hawkins case. You're saying that society truly shuns our sex offenders.
Senator, with all due respect, my article is now in the record. People can read it, and they can see that I was evaluating these laws not to determine their constitutionality, not to say that they shouldn't be enacted, but to talk about the ways in which courts make determinations about the character of the law and all of the consequences that follow from them. In law school, I had not had any experience in terms of the criminal justice system, and I was doing what law students do, which is seeking to analyze in a creative way new legislation. With respect to Mr. Hawkins, I was doing what judges do, which is look at the statute, 18 USC 3553A, exercise discretion as Congress has required us to do, take into account all of the various aspects of a particular case, and make a determination consistent with my authority, my judgment, and understanding fully the egregious nature of the crime. As you said, even the prosecutors in these cases are not recommending guideline sentences. The probation office, which is an independent authority looking at these cases and the facts related to them, are not recommending guideline sentences. This is a particular area where the commission has seen an enormous amount of disparity and has in fact asked Congress to come back and address, to help judges who are looking at these cases to be able to rely on the guidelines.
Which Congress has declined to do.
Senator, in that case, we have the statute that Congress has enacted concerning penalties, and we have judges who are doing their level best to make sure that people are held accountable as they need to be in our society in a fair and just way.
Mr. Chairman, my time's expired. Thank you, Judge. I have no further questions at this time.
Just checking with my staff. So the original statute was passed in 2003, the Scalia decision 2005, the Booker decision?
So the original statute that I'm talking about, I'm just thinking, I felt like it was in the 80s.
We think there may
In
have been
2003, I'm all right,
and the
and
decision by
Justice Scalia, the Booker decision made the guidelines advisory, so that even though judges have to calculate them, they are no longer binding. And what it meant in the statute is that the guidelines became one factor among many that judges consider at sentencing.
I'm not going to opine on Justice Scalia and his conduct and decision as it relates to the overall topic. I hope we all agree that we want to do everything in our power, reasonably within our power, to lessen the incidence of pornography and exploitation of children. You have made that clear. That is your position too. But I just want to tell you, Congress doesn't have clean hands in this conversation. We haven't touched this now for 15, 16, or 17 years. And you aren't the only one who faced this kind of a challenge with the cases before you. I said this morning, and it bears repeating, in United States versus Klotz, Trump appointed Judge Sarah Pitlick, Senator Hawley's choice for the Eastern District of Missouri, sentenced an individual convicted of possession of child pornography to only 60 months, well below the 135 to 168 month sentence recommended by the guidelines.
Mr. Chairman, you've mentioned this
Let me
now.
finish. I'll finish, and then of course I'll recognize you. Senator Hawley, you've said some very powerful things in support of this judge, but clearly she faced a situation where she decided she would not follow the guidelines and took a sentence of less than half of what they recommended. We have created a situation because of our inattention and unwillingness to tackle an extremely controversial area in Congress and left it to the judges. And I think we have to accept some responsibility for that, Senator.
I just wanted to say, Chairman Durbin, since you mentioned Judge Pitlick in the Klotz case, she followed the prosecutor's recommendation in that case. As I've said over and over, part of my concern with Judge Jackson is that she has not followed the prosecutor's sentences. She didn't in the Hawkins case we were just talking about, or the guidelines. And I'm happy we can have a policy debate about whether or not the guidelines are too lenient. I would argue in this era of exploding child pornography, they're not too lenient at all. I think you were right the first time when you voted in 2003 to make them tougher.
I will just say that I don't know if you sponsored a bill to change this. I'll be looking for it. But I will tell you that there isn't a long line of people waiting to co-sponsor this controversial issue. If we're going to tackle it, we should, but we should concede in the meantime that we've left judges in the lurch in many of these situations. There is no clarity in this situation, and I think to hold this judge responsible for the overall situation is to ignore our nonfeasance, malfeasance, whatever it might be, and lack of responsibility in dealing with this. Senator Hirono.
Thank you, Mr. Chairman. Judge Jackson, as you may know, I ask the following two preliminary questions of every nominee who appears before any of the committees on which I sit, so I will ask you these two questions first. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
I have not.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
I have not.
Judge Jackson, my colleague from Missouri seems to think that it's appropriate for federal judges to sentence individuals below to sentence individuals below the sentencing guidelines in these kinds of cases, horrific cases. And so I think it's important to offer a couple of clarifications for the record. Judge Jackson, when the U.S. Sentencing Commission first addressed the issue of sentencing in this area in 2012, do you remember that only 40% of convicted offenders in this category were receiving sentences within the guidelines?
Senator, I don't remember exactly the number, but I do know that there was a great deal of variance from the guidelines.
40%. Would you be surprised to learn that the Department of Justice, which prosecutes these cases, sent a letter to the U.S. Sentencing Commission in 2013 stating that the existing sentencing guidelines for child pornography offenses do not accurately reflect the current landscape of child pornography offense conduct?
I don't remember that particular letter, but there was a lot of concern about this guideline from all sides.
And now the Sentencing Commission issued another report just last year on this topic. And do you know that as of that report, an even lower percentage of convicted offenders were receiving sentences within the guidelines? Did you know that?
I'm not surprised.
It was 40% before, now it's even less.
I didn't know, but I'm not surprised.
Did you know that as of last year, it was just 30% of non-production offenders who were sentenced within the guidelines?
I did not know, but I'm not surprised.
My Republican colleagues made a big show yesterday of promising a fair process. And to me, that means ensuring that you are treated no differently than any other federal judges that have nominees that have come before us. See, there was an article recently that highlighted the fact that many of President Trump's circuit court nominees who were previously district court judges had also issued below guideline sentencing to child pornography cases. Judge Ralph Erickson, who was confirmed to the Eighth Circuit in 2017 with support from every Republican member of this committee, who was serving in the Senate at the time, and there are at least 11 cases where he sentenced people to below guideline sentences. Does that surprise you?
It does not, Senator.
I'm not sure if you know Judge Erickson, but do you have any reason to believe he's soft on child pornography based on these sentences?
I don't have any reason to believe that.
Do you think my Republican colleagues are soft on child pornography just because they voted for Judge Erickson to become a federal appellate judge even after he issued these 11 sentences?
Senator, I'm not in a position to evaluate whether your colleagues are soft on crime because of their votes. I have no reason to believe that.
They voted for this person, but I think it would probably be quite unfair to characterize him as being soft on child pornography. I would also like to talk to you about Judge Joseph Bianco, who was confirmed to the Second Circuit in 2019 with support from every Republican member of this committee who was serving in the Senate at the time, including Senator Hawley. In the case United States v. Bowen, Judge Bianco sentenced a defendant to 60 months in prison when his guidelines range was 151 to 188 months. And here's what Judge Bianco said in the sentencing transcript for that case, quote, "And the guidelines here are just way disproportionate under the facts of this case, and I don't view them as particularly helpful in this case. I believe the probation department got it right in terms of the statutory mandatory minimum being sufficient, but not greater than necessary to achieve the factors of sentencing." Quote, I'm not sure if you know Judge Bianco, but do you have any reason to believe that he's soft on child pornography based on that sentence or those comments?
I do not, Senator.
Do you think my Republican colleagues, including Senator Hawley, are soft on child pornography because they voted to confirm Judge Bianco to the Second Circuit even after he issued below guideline sentences and made these comments?
I have no reason to believe that.
Here are some of the other circuit judges that all of my Republican colleagues voted to confirm, despite the fact that they sentenced child pornography defendants to below guideline sentences. Judge Amal Thapar on the Sixth Circuit, Judge Richard Sullivan on the Second Circuit, Judge Andrew Brasher on the 11th Circuit. Again, I'm not sure if you've ever met these judges before, but do you have any reason to believe they don't take child pornography seriously?
I do not.
I would like to note that Senator Cruz referred to a chart that listed 8 cases and the government recommendations and the sentencing guidelines, and that you did not adhere to those sentencing guidelines. What was not included in the chart was what the probation recommendations were. And if you add those probation recommendations, in 5 of the 8 cases, you followed the probation recommendations. In one instance, you were lower, and one instance, you were higher than the probation recommendations. Mr. Chairman, I would like to introduce the complete chart for the record.
Without objection.
You've been asked to answer a lot of questions about your judicial philosophy. Some of my colleagues, particularly on the other side, seem dead set on finding out if you are an originalist, a textualist, if you believe in a living constitution, or various other labels. I don't find these labels particularly useful. Take originalism. Proponents claim you just have to dig deeply enough into the historical record and you'll somehow find the one true meaning of a constitutional provision. The fallacy of this approach is illustrated in District of Columbia versus Heller. There, Justice Scalia's majority opinion and Justice Stevenson's dissenting opinion each applied originalism. Justice Stevens more effectively, in my opinion, and reached completely different conclusions about the scope of the Second Amendment. Take textualism. In Bostock, Judge Gorsuch applied textualism to find that Title VII of the Civil Rights Act protected employees from discrimination based on sexual orientation and gender identity. In dissent, Justice Alito mocked Justice Gorsuch's application of textualism, and he wrote the following, Justice Alito, quote, "The court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation, championed by our late colleague, Justice Scalia. But no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. The theory that courts should update old statutes so that they better reflect the current values of society," end quote. And these are two justices who are usually in agreement. So much for labels. So instead of trying to fix some label on you, I'd rather focus on the fact that you are fair and objective in your approach, that you are even-handed in your application of law to the facts, and that you are independent. During your last confirmation hearing, you spoke about judicial independence, about what you learned during the 3 clerkships and your then 8 years on the bench. You said, and I quote, "I know very well what my obligations are, what my duties are, not to rule with partisan advantage in mind, not to tailor or craft my decisions in order to gain influence or anything of the sort," end quote. Well said. So my question is the following. What do you do to ensure that you maintain independence free of partisanship when you handle a case?
Thank you, Senator. What I do and what I've done in all of my 570 some odd opinions is to apply a methodology that is designed to ensure my impartiality and to respect the limits of my judicial role. What it means is that I am receiving the cases, and at the outset, I am setting aside any personal views that I might have about the parties, about the issues. As I also said in my DC Circuit confirmation, it doesn't matter to me whether the argument is being made by the President of the United States or a death row inmate. What I'm doing is looking at the argument, I'm looking at the facts, I am applying the law in as neutral and consistent a manner as I can, because that is the duty and requirement of the judicial oath. I'm also very conscious of the limits of judicial authority, of the restrictions that exist in the law to prevent me as a judge from becoming a policymaker. This means that I carefully scrutinize my jurisdiction. It means that I look at the text and focus on the text and the intentions of the legislatures that drafted that provision, or the intentions of the framers that put forward that constitutional principle. It means I'm looking at precedent. If I was fortunate enough to be confirmed to the Supreme Court, I would be upholding the principles of stare decisis as I consider the
the precedents and making sure that the court is putting forward consistent and predictable rulings as is important to maintain the rule of law. All of these I see as constraints on judicial authority that I care deeply about in order to maintain my independence as is necessary to ensure public confidence in my rulings as a judge.
Judge Jackson, I have sat on this committee now for a number of years. And as some of my colleagues continue to try to pin labels on the nominees who come before us, frankly, I find your methodology to be as succinct a definition of what would lead a judge to come up with fair and objective results. I thank you for that. As a lower court judge, you were generally bound by the Supreme Court's and the DC Circuit's precedents. That certainly won't be the case if you are confirmed to the Supreme Court. The Supreme Court can overturn its own precedents. That's why I found your analysis in Committee on the Judiciary versus McGahn instructive. In that case, you had a precedent, Committee on the Judiciary v. Myers, that had already confronted the issues you faced. However, it was another district court decision, and you were not bound by it. You nonetheless followed that precedent. Why did you find that opinion so persuasive?
Well, Senator, in the law, there are different kinds of precedent, and by that I mean there's vertical precedent, which is what people are most familiar with. There are cases that are handed down by higher courts, the appellate court, the Supreme Court, and those bind the lower courts so that even if you disagree with them, you have to follow them because they're binding precedent. But there's also horizontal precedent. It too is about maintaining consistency and predictability in the rule of law. And what that means is when you are in a district, there are many judges, and if someone else in your district has handled a case that comes out or that involves the same issues and comes out in a certain way, you as the second judge have to contend with that ruling. You can't ignore the fact that there is precedent in your district that handles a case in a particular way. And with respect to the McGahn case, the precedent wasn't just close, it was nearly identical. The Myers case involved the former White House counsel and the argument by the executive that the former White House counsel had absolute immunity with respect to a request by the legislature that she provide testimony. My case involved a former White House counsel who was claiming absolute immunity at the request of the executive in response to a legislative subpoena. In both cases, not only was the absolute immunity issue on the table, but in both cases, the same threshold issues about whether or not there was jurisdiction in the court because the legislature had standing or didn't have standing, which was the argument that was being made. The same question about whether the court could hear a dispute between the legislature and the executive branch. All of those issues had previously been considered by my colleague in the district court. And he wrote an extensive, I'm talking about Judge Bates, he wrote an extensive opinion analyzing each of the issues. And so at a minimum, as the second judge dealing with these exact same issues, I had to look at what he did and decide. Was it persuasive? Did I agree? And I did.
Judge Jackson, of course, if there had been a vertical precedent, i.e. from the Supreme Court or the Circuit Court that was on point to your McGahn situation, yes, you would have had to follow that precedent, but there wasn't. And so you followed a reasoning by another district judge that made a lot of sense to me, and that certainly makes sense to me. You discussed stare decisis and the importance of precedent in your opinion, and this is what you wrote, quote, "It is interesting to note that the doctrine of stare decisis performs a limiting function that reflects the foundational principles that undergird the federal government's tripartite constitutional system. This is because deciding a legal issue anew each time that same question is presented without any reference to what has been done before nudges a court outside of its established domain of saying what the law is and into the realm of legislating what the law should be." I know that you've been asked the questions about the importance of precedent before, but maybe you can just tell us one more time why precedent is important in our judicial system.
Thank you, Senator. Our judicial system is one that is designed to uphold the rule of law. Unlike other systems in other societies, some other societies, we believe that we have a government of laws and not men, and yet there are men and women who are acting as judges in the context of our system. What precedent does is ensure that there's consistency across the different individuals who are tasked with the solemn responsibility of interpreting the law. It ensures that there's public confidence that the law is what is guiding judges in their decision making and not just their own individual views. And so it's crucial for maintaining public confidence, maintaining stability in the law, establishing a system that has predictability in it, all of which supports confidence in the judiciary, which is the currency of the judicial branch.
Because of the importance of precedents in promoting confidence, et cetera, people need to know what the law is. And so precedent is important on that score. And if you are confirmed to the Supreme Court, what factors would you consider before overturning precedent?
Well, there are many factors that the Supreme Court considers, and not just whether they think a prior precedent is wrong. That is one of the factors. The court has said that a precedent that is egregiously wrong is one that is subject to reconsideration. But in order to actually make the determination about overturning it, in addition to it being wrong, the court considers whether or not there's been reliance on that precedent, and if so, how much. The court considers whether or not the precedent is workable. Sometimes the court will issue a ruling in a case and it turns out that it's not actually functioning in the way that the court intended, and so that might be a reason to revisit it. The court considers whether or not other precedents in the area have shifted such that the foundation for the particular precedent is no longer sustainable. And the court considers whether there are changes in the facts that relate to that precedent or a new understanding of the facts that relate to a precedent. All of those factors are things that that the Supreme Court takes into account when it decides whether or not to revisit a precedent.
Therefore, the court should consider all of those factors. I would say reliance factors loom large, as far as I'm concerned, before overturning a precedent. But basically, if you have 5 members of the court deciding to overturn a precedent, they can do so, right?
Under our scheme, yes, under the Constitution. Mm-hmm.
And so we're seeing more and more precedents being asked to be overturned. An analysis by National Affairs found that since 2017, when Justice Gorsuch was appointed to the court has shown, and I quote, an increasing readiness to overturn precedent, end quote. This is true for both longstanding precedents and those that are just a few years old. For example, in 2018, Janus decision, the court overturned a 41-year-old precedent called Abood. That decision weakened public sector unions. Justice Alito first signaled that he wanted conservative anti-union groups to challenge Abood in his 2012 decision in Knox versus SEIU. This is called signaling, and Justice Alito definitely signaled his desire to revisit the Abood decision. So yes, these groups, they got the message. They brought case after case to meet the criteria that Justice Alito laid out. And although they came close in 2016, Justice Scalia's death left the court stuck in a 4-4 decision in a case called Fredericks v. California Teachers Association. Basically, the minute Justice Gorsuch was confirmed, the court finally had a conservative 5-4 majority to overturn Abood, and the result was Janus. I followed these lines of cases very closely. So that is what happened. They waited for Justice Gorsuch and boom, 5-4 against unions. In another example, the courts acknowledged 4 most conservative justices, Thomas, Alito, Gorsuch, and Kavanaugh, dissented in June Medical, voting to overturn a precedent banning burdensome and unnecessary restrictions placed on abortion providers. This particular precedent was only 4 years old. Now the court is poised to overturn Roe v. Wade, even though women have relied on their constitutional right to have an abortion for nearly 50 years. Of course, I'm not suggesting that Supreme Court decision or precedents are sacrosanct, because I'm thankful the court can and did revisit precedents like Plessy v. Ferguson that were wrong the day they were decided. But justices should not be seen to be advancing their individual political or ideological agendas at the expense of individual rights and precedents that people have relied on. One result of the court's new approach is that people's view of the court is changing for the worst. A recent Pew poll found that 44% of Americans now disapprove of the Supreme Court. This is up 15 points from August 2020, shortly before the late Justice Ruth Bader Ginsburg died and Amy Coney Barrett was appointed to fill her seat. I think court watchers acknowledge there is an ideological split in this current Supreme Court when we are seeing more cases decided on ideological bases, not on the facts and the law. I think it leads to the American people questioning whether the court is a fair and objective arbiter of cases in controversy. You were asked earlier today about your representation of Guantanamo detainees. Just to make it clear, as a federal public defender, you were assigned to represent Guantanamo detainees. Is that right?
That is correct, Senator.
And then while at Morrison and Forster, you also did pro bono work for Guantanamo detainees. Were you assigned to do that work as well?
So there was one detainee who I had represented as a federal public defender who was brought into my firm's practice unbeknownst to me. And when I arrived at the firm, the attorneys who were working on that case recognized that I had previously been a lawyer who had represented this particular detainee and asked if I would help with his habeas petition at that stage.
I think you clarified that earlier today. And you served as counsel of record on amicus briefs related to detention. I think that was brought out today.
Yes.
Were you working on behalf of detainees at that point, or were you working on behalf of other groups or individuals?
I was working on behalf of other groups or individuals with respect.
Were they retired judges?
Yes, there were 3 briefs in total, 2 different cases, and one of the briefs that I filed was on behalf of 20 retired federal judges, including one who was a partner at my firm at the time, and who wanted to make a particular argument to the court concerning the detention process.
And these were judges that were nominated by various presidents, so it must have been a diverse group, and they asked you to do the brief.
And they did, yes.
So as part of your work at the law firm, a responsibility of your employment, you were assigned to work with this diverse group of retired judges and to represent conservative or libertarian organizations such as the Cato Institute and the Rutherford Institute to advocate their views.
Yes, the other 2 briefs that I filed were at the cert stage and then at the merit stage of a case that was eventually mooted. But my clients in those cases were a diverse group of organizations, including the Cato Institute, the Rutherford Institute, and the Constitution Project.
Members of this committee know full well that lawyers are, we have to follow the codes of professional conduct, which says that we have to zealously represent our clients, and that's what you are doing with regard to the detainees. And I would just want to note that some of the very senators who are openly questioning you for representing defendants or detainees have in the past made the argument that judicial nominees should not be opposed for the arguments they make in the course of representing clients. I'm going to quote one of my colleagues. I've been a military lawyer for almost 30 years. I represented people as a defense attorney in the military that were charged with some pretty horrific acts, and I gave them my all. The system of justice that we're so proud of in America requires the unpopular to have an adequate and an advocate. And every time a defense lawyer fights to make the government do their job, that defense lawyer has made us all safer. Do you agree with that?
I do, Senator.
In 2012, prominent conservative lawyers signed a letter defending attorneys who have represented Guantanamo detainees. In part, the letter said, quote, "The American tradition of zealous representation of unpopular clients is at least as old as John Adams's representation of the British soldiers charged in the Boston Massacre. Good defense counsel is key to ensuring that military commissions, federal juries, and federal judges have access to the best arguments and most rigorous factual presentation before making crucial decisions that affect both national security and paramount liberty interests," end quote. So the quote that I read isn't the first time that my colleagues on the other side of the aisle have tried to say that your representation and your work as a public defender somehow, I don't know, disqualifies you or makes you leaning one way or the other. So you've made it very clear that that is not what you are about. I just have one more question in the remaining time. Oh, I'm sorry. I'm over.
Senator, I'm sorry, we're on a roll call.
I'm on such a roll.
You're on a roll and we're on a roll call.
Yes, thank you. I apologize.
Mr. Chairman, before we break, if I could ask one question of the chairman.
Sure.
Senator Hirono just made reference to the recommendations of the probation office in 5 of these cases. To the best of my knowledge, those probation recommendations are not in the record. I haven't seen them. My staff hasn't seen them. And that raises 2 questions. Number one, whether the White House is providing differential material on this nominee's background to Democratic members than Republican members, because I don't know where Senator Hirono would get access to them other than from the White House. But secondly, regardless of whether it's differential, would the chairman agree that there is considerable focus on these cases and the committee, both sides, should have access to the pre-sentence reports and to see the underlying facts? Judge Jackson has said she was following the facts and the factors in those cases.
Senator, you know we've completed discovery before we started this hearing.
Mr. Chairman, how
For
did
you to
Senator
have
Romo, how did
not
Senator
gonna enter-
Hirono get those information that
I'm not gonna-
Republicans have not been
I'm
given?
not going to entertain this. We've been through discovery.
Do you have access to them?
I don't know that I do. I really don't.
Can we ask Senator Hirono how she got access to them?
I'm sorry to interrupt you, Senator, but I want to make an announcement. We're going to have a 10-minute break. Members are going to head to
So
the
you're
floor.
going to keep differential access to this information?
I'm not sure what differential access is. I'll look it up. We have a vote on the floor to take about 10 minutes, so 10 to 15 minutes, relax. And then we're going to come back, and we have two senators, Cotton and Booker, who will be recognized and then take a break for dinner. And then we're going to try to still finish tonight with two remaining senators, Senator Ossoff and Tillis, who are going to be first thing in the morning. So we stand in recess.
There, we've been watching the Senate hearings on whether to confirm Judge Ketanji Brown Jackson as Associate Justice on the Supreme Court. The committee is now taking a short break. Watching the hearing along with me is John Yang. He covers the Supreme Court for us here at the PBS NewsHour. John, we heard Chairman Durbin there say about a 10 or 15-minute break. We should note for audience purposes, time seems to work differently in the U.S. Senate. That could be more, could be longer break than previously noted. But let's talk about what we just heard there. A few more lines of questioning from Senators Hawley and Hirono for Judge Jackson. Senator Hawley had a laser-like focus in his line of questioning, right? We saw previous questions about Judge Jackson's decisions when it comes to sentences and child pornography cases. Senator Hawley really focused in on one particular case. I'm curious what you thought as you saw that line of questioning unfolded and what it revealed to us about Judge Jackson.
Well, I think that this is part of a broader theme of Republicans in the Senate. They're taking on judicial nominees, on Biden judicial nominees. The Biden administration is trying to diversify the people, sorts of people who make it to the federal bench. It's mostly been prosecutors, government attorneys, corporate attorneys, and the Biden Justice Department has asked senators, Democratic senators, for judges who are underrepresented on the federal bench, what they consider to be underrepresented, including public defenders. So there has been a real effort on the part of Judiciary Committee Republicans, especially Senator Hawley, Senator Cruz, and Senator Cotton, to sort of push this line about being soft on crime. I wouldn't be surprised if it sort of it comes back, if we hear this again, some of it in the midterm campaigns at the end of the toward November. But also on this particular issue of Judge Jackson's sentencing decisions on child pornography cases, I think that there is concern among Democrats that it could make some Democrats wary there's concern on Democrats that it could make some Republicans who have been considering breaking ranks and supporting her on the floor not do that. I think that this is essentially they're doing this because they think it's effective. One thing I think is also interesting that we're not hearing from committee Republicans is what we heard when Judge Jackson was originally nominated. We heard talk that this was an affirmative action nomination, that this was a quota, that President Biden saying that he was only going to consider a black woman, that it was a quota nomination. We aren't hearing that anymore. So it says to me that was not an effective line and may have actually been hurting them politically.
Jeff Benn has been watching all this from over at the White House. Jeff, I'd love for you to jump in on that point that John just made about those earlier attacks, those lines we did hear before these hearings ever began about President Biden's decision to commit to naming and nominating a black woman for this seat and calling that affirmative action. None of that has come up in the hearings so far.
It hasn't, and I've talked to some Republican aides who were nervous about that in those early days. One, because it's racist on its face, but two, when compared to all of Judge Jackson's qualifications and her experience, it just doesn't hold up. I'll tell you, though, the White House has been responding quickly to that line of questioning that we heard from Senator Josh Hawley, and they point to the abundance of reporting that exists in their public record, all of the fact checks. And White House officials have said that no independent media outlet has been able to verify the accuracy of what Josh Hawley was accusing Judge Jackson of. And then beyond that, you have White House Deputy Press Secretary Andrew Bates, who said that Hawley was trying to basically signal to right-wing fringe QAnon adherents, and that he was promoting, quote, fabricated lunatic beliefs. And so there is also this notion that Hawley has voted in the past to confirm judges who, as Judge Jackson has sentenced child sex offenders and child pornographers below the sentencing guidelines. We've talked previously about how 70%, I think the reporting is, of judges in similar cases have also sentenced those offenders below the guidelines, and so that she is not in any way an outlier. So the White House is trying to really just reject out of hand anything that he would say to try to land any sort of attack on her. And they also point out that it's important to understand his line of attack in the context of what his motivations are, that he might try to seek the presidency in 2024, but also his recent actions, basically standing in support of those who tried to overturn the 2020 election, raising his fist in support and cheering on the mob that tried to overturn and tried to prevent President Biden from taking office really just hours before a violent mob-laid siege to the U.S. Capitol, an action for which Hawley has not apologized and he has not retracted. And so all of that taken together, the White House feels fairly confident that she will get confirmed with at least 50 votes. The question of whether or not she's able to bring on maybe 2 or 3 Republican votes in support, that still remains to be seen.
So, John, what about this? Who is that line of questioning intended to reach? And I say this because there's already reporting out there from others who are, chasing down senators who are not on the committee on Capitol Hill, asking them what they think of what's going on. The Washington Post is reporting they asked Senator Mitt Romney about what they thought about Senator Hawley's line of questioning, and he said it struck me that it was off course, meaning the attacks were off course that came from some there is no there. And we should say also the context in all of this is that the general public going into these hearings seems to believe that Judge Jackson should be confirmed. It's about half of all Americans polled in the last couple of days believe that she should be confirmed. So when you have, especially with Senator Hawley going into the detail that he did of these heinous, really awful crimes, who is the intended recipient of that message?
Well, I think you have to remember that there are many intended recipients of the messages in a confirmation hearing like this. There's a lot, not just the nominee, not just other senators who are going to have to vote, but also the going over the heads of those people to constituents, to interest groups, to potential supporters, to voters at home. And I think that you do have to consider the fact that the 2 senators who talked about this the hardest and the loudest today, Senators Cruz and Hawley, are potentially have presidential aspirations. I think that they are appealing to the base, that they're sort of trying to generate support, show that what kind of candidates they could be in going after these issues.
John, I know you cover these issues more closely than any of us. And actually, in the last few lines of questioning, we did get into a lot of the nitty-gritty. What Senator Cornyn earlier said, nerding out on some of these issues. You know these issues a lot better than I do, but there was a lot of talk from Senator Blumenthal and going really heavy exchanges about issues of transparency and judicial philosophy and so on. And because that is one of the central questions, right? What do these hearings reveal to us about Judge Jackson's judicial philosophy? What did you take away, especially from some of the talk about technology and the kinds of issues that Supreme Court justices have to deal with today?
Well, it gets down to really this issue of how the justices examine the Constitution and figure out what the law means and what the words of the Constitution mean. Do they go back to the original intent, as many of the conservatives do, try to figure out what the words meant when they were written, what for instance, there's a Second Amendment gun rights case that was argued last fall, and there was a lot of discussion about what the contemporary laws were in the colonies and in the original 13 colonies when the Constitution was framed, versus the sort of more looking at what the effect of the law is today on average Americans. And in many ways, the law, or technology rather, always outpaces the law. The law is always trying to catch up to these developments. It's something that she talked about, that Judge Jackson talked about in her sentencing, the factors that go into her sentencing decisions on child pornography cases. And also she talked about a case that she handled, I believe she talked, I can't remember if it was at the trial level when she was a district court judge or if it was in private practice, about a case against General Motors from the recording industry of America, about what does it mean when you stick your CD into the player in the car. And I think that these are the issues. We haven't heard a lot about this in these hearings, quite frankly, sort of going into the more than 500 decisions that she wrote and opinions that she wrote, most of them on the district court, at the trial court level. And as she said in her opening statement, these decisions are very long and very detailed, and there's a lot there to parse and to go into if you wanted to.
John, I was having flashbacks of my mixtapes on CDs going into my car back in high school there. But look, Jeff, the issue here is absolutely judicial philosophy. That's a lot of the lines of questioning we've seen with specific reference to specific issues. It's also judicial temperament. These hearings are, even though she has been through confirmation hearings before, these are next level. This is about a lifetime appointment. She is moving into hour 10 of questioning here, and there's still a few more senators to go tonight and a whole nother day tomorrow. Talk to me a little bit about what we know about the preparation for something like this. So far, Judge Jackson has been incredibly composed, but later in the day, we started to see in some heated exchanges, her temperament changed a little bit, understandably, moving into 10 hours of questioning. What do we know about how she got here and how she's doing so far in the White House's eyes?
It's certainly a test of endurance, and I think you're right, especially during the exchange with Senator Cruz and later with Senator Hawley. You did start to see her bristle a little bit, I think, just out of frustration that, as she felt, her record was being mischaracterized. But in terms of the preparation, she has been working with the so-called Sherpa team under the direction of former Senator Doug Jones, and they have basically set up mock sessions, a dark room like the one that she has been in for now a day and a half, where she had been peppered with questions. The staffers had looked at the records of the senators. They knew the senators' sort of pet projects and the areas of attacks, lines of attack that would likely come from Republicans, and they really just put her through the ringer for hours-long sessions. And so there were times, I think, where you could see that she was prepared for answers. And in one exchange, she even said to, I think it was Senator Cruz, that she wasn't aware of precisely what he was talking about, but that her only recollection of it was, her preparation in fact, this hearing. And so there's that, and the fact that she has been through this process to various degrees 3 times before. So she's no stranger to Senate confirmations, and that's one of the reasons, I'm told, why she was ultimately chosen as the nominee.
Well, Jeff, she's been there before. She's taken the questions before, but we can't say it enough. This is a whole new ballgame, right? This is a Supreme Court nomination. She is making history as the possible first Black woman to sit on the highest court in the land. And even she referenced it herself, right? I think it was in the questioning with Senator Sass when he mentioned, this is probably going to be the last job you ever have. And she quickly cut in and said, and also the most public. I mean, she's feeling that spotlight. Is there a sense that that she's prepared for that?
Yeah, and I haven't had that specific conversation with her team, and certainly not with her. But imagine the weight on her shoulders, being the first and only. The sense that there is no other choice for her but to be excellent, but to shine. Because she's not just there as a representative of herself and her family, but for women and certainly Black women. And so to have almost a third of this hearing dominated by questions of sentences for child pornographers. Imagine how frustrating that must be to have that be the focus. When she was in high school, she said, as a senior, when she was asked what was your goal for yourself, she said to be a judge and to have a judicial appointment. For all the sacrifices of her parents being born into Jim Crow, both of them having attended HBCUs, started as public educators, her father deciding to go back to law school and ultimately becoming the staff attorney, the chief attorney for the Miami-Dade School Board. And for them to pour into their daughter, for her to excel at every turn, no matter what, and to come into this hearing and to be faced with what I'm sure she views as these bad faith arguments from senators who should know better, to have to deal with that and to also know that she still has no choice but to be excellent and to be graceful. That's a hell of a lot to deal with. And again, one of the reasons, the primary reason why she was chosen was because this White House and President Biden knew that she could deal with it.
And she said herself, in her own words, she is standing on the shoulders of giants in this moment. Lisa Desjardins has been in the room watching all of this unfold. She's walked out to a camera to share with us some of her latest reporting based on what she saw there and folks she's talked to. Lisa, we were talking earlier about that line of questioning from Senator Hawley. I understand you have some news you can share with us about that.
Right, just a few minutes ago, after he finished his questioning, I spoke with Senator Hawley and I asked him a number of questions. My first question was, I have too many questions. I don't know where to start. But I asked him, first of all, if he rejects the notion that she's putting out there that, in fact, her sentencing was in line with either the prosecutors or the probationary officer's recommendations. He told me what he said in the hearing room, which he hasn't seen the probationary officer's recommendations. I said, well, what the Washington Post is reporting. They fact-checked it, and they, in fact, say that she was in line with those probationary officer's recommendations in the vast majority of the cases that you outlined. We moved on, and then I also said, do you also reject the idea that the data shows she was in line with federal judges overall at the time and how they were sentencing these types of cases? We went back and forth over that. And in the end, Amna, he didn't have an answer for that. He said that is data he has not seen. That's data we've talked about on NewsHour for the past couple of days. So I will forward that information to his office. But it indicates, and he said he's read these cases himself, so it's not that he's done no work here. But he's not accepting the argument she is making, and the argument that some other Republicans, frankly, tell me that they are listening to, which is that this was a complicated area of case law in which the guidelines were not clear, they were out of date, and that she sentenced offenders in this area in a way that other federal judges were sentencing them. That's something that he's just rejecting out of hand or refusing to take seriously. But it is a very serious argument that is about a very important part of case law and obviously about this woman's legal career.
Lisa, I think it's fair to say the most sort of pointed lines of questioning have been from Senators Hawley and Cruz so far. And as you recall, when we started the day, you saw all of the senators talking about how they wanted this to be a civil exchange and a civil proceedings. The tone seems to have shifted, but we're watching this all in two dimensions from the outside. You are there in the room watching it all unfold. So just give me a sense of the room. What does it feel like in there right now?
I think this is another one of those moments, this break right now, to determine if Democrats are going to come back with fire in their eyes, feeling that their nominee is being treated unfairly and that essentially they have to be in a more combative posture to protect her. Or is this just the case of two senators, Cruz and Hawley, who likely want to be U.S. president, using this as an opportunity to make their case to America for their candidacies, as well as to make very specific points that they have about this nominee? I think right now we're going to sort out where this hearing lands for the next few hours. But I will tell you, in that hearing room, the atmosphere shifted dramatically during Senator Hawley's questioning. It was very clear that this is a nominee, Judge Jackson, who has weathered a long day of questions, some of them very difficult. And at that point, you could feel frustration, I think, from her and also from many of the people in the audience, including the public around her. It was a different kind of atmosphere in there because of this. And we do have two more senators I think we need to watch for these kinds of style of questioning. One, Senator Tom Cotton. We expect him to have his questions tonight, another presidential candidate potentially. And then also Senator Marsha Blackburn. We expect her to go tomorrow. But they have had pointed questions in the past with this nominee and with others.
Lisa, I want to get you to weigh in on the point Jeff made earlier, which is the absolute history of this moment, and it should not be lost on any of us about what's at stake, about what could potentially happen here, about the weight on Judge Jackson's shoulders. Has any of that resonated in the room, or has it all sort of devolved into the politics of the moment?
No, I'm glad that you said that. I'm glad Jeff's reporting that. That really has been an uplifting spirit in this room. There for most of the time of this hearing today and yesterday, there has been a sense that this is history happening, and not just history that affects one party or one person, but history that is good for this country. You know, and you can see Republicans smiling, especially when Judge Jackson mentions what this means to her, what this means to her family. Even when Democrats talk about the history here, you see Republicans acknowledging that. There is a feeling, a sense of hope about that idea that this is a historic nomination. However, that doesn't change the base politics at play in this country right now, and especially the very sharp politics on the right when you have a nominee from a president on the left.
John Yang, I want to get your take on one case that I'm actually surprised we haven't heard more about so far, and that was a case before Judge Jackson regarding former President Trump's former White House counsel, Don McGahn. It came up in a line of questioning from a Democratic senator, from Senator Mazie Hirono, who was asking, Judge Jackson to kind of unpack her decision-making in that regards to the precedent in that case. I'm curious what you thought of that. Did you think we would hear about it earlier, and what do you make of how she's handled that?
I thought we would hear about it earlier. I thought the Republicans would bring it up. I think that this is the case in which Don McGahn, who is President Trump's White House counsel, was seeking to avoid testifying before the House Judiciary Committee in the impeachment here. No, it was the inquiry into Russian influence in the election. And Judge Jackson ruled that he had to go. He could not exert executive privilege without showing up and exerting executive privilege in person. I thought we would hear more about that. I thought that, it bounced around a lot on procedural grounds, and it was eventually resolved with between the committee and McGahn. But I thought that the Republicans would push that harder and bring it up earlier.
Jeff Bennett, what do you make of that? Because one name I think some people thought we might hear more during these hearings is President Trump. And so far we have heard from several Republicans referencing the previous Supreme Court nominees who are now Supreme Court justices. But we haven't heard that much from Democrats on that. Has that surprised you?
It has, and I really don't have a good reason why it hasn't been broached earlier, except to say that for the Republicans who haven't really sort of tread that ground, that they see as being probably a more fertile line of attack, what happens to just right now be in the sort of cultural zeitgeist, these questions about critical race theory, this notion that being soft on crime, that she as a Democratic nominee would somehow be a proxy for Democrats more broadly, and because in just the sort of last batch of elections, the Virginia gubernatorial race and some other local races, that Republicans have found, they think, better sort of, making more inroads on those issues and less focusing on what happened in 2016 and the Russia investigation and President Trump. Perhaps that's one reason why they've pursued sort of a different lane of questioning with her.
Just a reminder to everyone watching, we're in a short break right now in those Senate confirmation hearings. As soon as the hearings come back into order, and it looks like people are beginning to file into the room now, we're keeping an eye on that picture. As soon as proceedings begin again, we will go back live to that room. Jeff Bennett's been watching it all unfold from the White House and talking to sources there. And Jeff, one other thing that struck me in the last lines of questioning, as we've seen, Democratic senators have been stepping in to try to bolster and hit home some of the points, some of the strengths they see in President Biden's pick here. One of those has been steadiness. One of those has been a reliance on precedent, right? This, I think, a prebuttal, you might consider it, to the argument that she is in any way an activist judge. What do you make of the way some Democratic senators have handled that so far, and also how Judge Jackson has handled that?
Yeah, and in fact, the White House today, in giving us a sense of President Biden's view of all of this, said that very same thing. That President Biden watched portions of the hearings and that he was proud and was struck by what he viewed as the judge's even-handedness, her dignity, her grace, the sense that as he viewed it, that she was in very many ways a continuation of Justice Breyer, who, if she's confirmed, will replace on the court. And so what I also thought was interesting were the ways in which Judge Jackson refused to be boxed in, that she was sort of asked about her judicial philosophy and was very clear that she couldn't really be labeled, that in her view she had a methodology where she would sort of clear her mind, take a neutral stance, survey all of the different inputs, whether it was documents in the case or amicus briefs, that sort of thing, and then make a determination based on interpretation of the facts and the law, and would stay in her lane. That was the phrase that she used a number of times to make clear that her role as a judge was not to create policy, that was the role of the Congress. And so, I think it was important for her to sort of be very clear about that. And the White House, in their messaging, has articulated that as well.
So, Lisa, I know you're going to head back into that room to cover all of this happening live. Before you go, we are next, I think, expecting to hear from Senators Tom Cotton and Cory Booker. What do you think we're going to be hearing? What kinds of lines of questioning? What sort of statements? What's ahead?
Two tall men who have very contrasting styles as politicians. So it will be interesting. I noticed during Senator Hawley's questioning that Senator Cotton had an aide next to him, and they seem to be working on some paperwork, possibly thinking about what he was asking right at that same time as Senator Hawley was asking his question. So I think it'll be interesting to see how sharp Senator Cotton is or not. I also think something that surprised me about this day and about how this day is being covered is how this judge has really talked about textualism and how she interprets the text of the Constitution so much.
And Judge Jackson is back in the chair now. We're going to go live now to the hearing.
It's on. My voice is just soft. I felt like we should finish tonight.
We're trying to.
I know.
Senator, there are a lot of people involved in this discussion. I'm doing my
fully
best.
appreciate that.
And you asked to be on the program tonight, and we're going to put you on the
And
program.
I appreciate
How
that.
about
Thank you.
Okay, good. Senator Cotton.
Mr. Chairman, before we start this questioning, right before the break, I asked the chairman about Senator Hirono had referenced 5 probation reports that were not in the record. I asked the chairman whether the Democrats had access to information about Judge Jackson's judicial record that Republicans did not. You did not answer me at the time, but as we returned...
I can give you an answer.
Okay, well, hold on. Let me finish my question. When we returned and when we walked in, each of the Republicans was handed this piece of paper, which is the first time any of us have ever seen, which is a chart of probation recommendations. We were just told that the White House gave it to Democrats earlier today. I don't know if that's true or not. And what I would ask you is there anything else that Democrats have access to in this case that they're not sharing with Republicans on this committee? And Mr. Chairman, how would you have reacted if, say, during the Kavanaugh confirmation, the White House shared judicial materials with Republicans and did not share it with Democrats? I'm pretty confident you would have expressed extraordinary displeasure at that.
If I recall, there was some discovery issues in the Kavanaugh case involving several years of his performance in the White House, which your own counsel decided we couldn't.
But sure, that's disclosure to the whole committee.
Yes,
and in this case, is there anything else that Democrats have access to of Judge Jackson's record that you have not shared with Republicans on this committee, and in particular, the pre-sentence reports?
No,
I suspect if they were helpful, you would have made them public, so the fact that you haven't raises an inference that they're not helpful to the case you're making.
Senator, you will always draw your own inferences, and I know where most of them head. I will just tell you that the information that we received from the White House, I'm told everyone had access to if they wanted it. And now you have it, just a matter of hours after we've received it. Exactly.
So is there anything else Democrats have that Republicans do not from Judge Jackson's record?
Mr. Chairman, can I ask a question about this? I want to be sure I understand. The handout that I just saw, the White House gave to some of us earlier today, but not all of us?
It was available, I'm told, the information was available to anyone who requested it. The White
So
House.
you had to be clairvoyant
No.
and know they had it?
No, not clairvoyance. I think it's pretty obvious, Senator.
How would you know to request it?
You would know it after Senator Hawley launched his attack on the judge. At that point, all of this information became relevant to countering.
So I would be expected to say, geez, after Senator Hawley asked questions, I better call the White House and see if they can help me research this? That's
No,
not
that's not the
realistic.
point. The point I'm getting to is, and you know as a good lawyer, what you do during discovery. I wasn't aware of the fact that this was available. The White House requested it, received it. We asked for a copy, and within an hour or two, you received the same copy.
When did y'all get, let me finish. When did y'all get your copy?
Sometime today.
Sometime today. That covers a lot of ground, Richard.
I don't have any personal knowledge of this. I'll be honest with you.
You don't have any personal what?
Knowledge.
Does your staff?
Does your staff know?
I
They're
haven't.
standing behind you.
I've talked to them earlier. And they
Mr.
said-
Chairman, I'm so sorry. I just don't want to make this a partisan issue if it doesn't have to be. My staff just says we just got it 10 minutes ago as well, so I'm very upset. I joined Ted Cruz.
Good.
Mr. Chairman?
That's an alliance that's well known.
Yes, yes.
Mr. Chairman? I do think it's significant. We've had now referenced some pre-sentence reports, and we've got this material that references recommendations made by the Office of Adult Probation and Parole.
Reports.
Well, okay, but we've got critical information that is contained within them. The recommendation made by the Office of Adult Probation and Parole in these cases is something that's drawn from the pre-sentence report. It seems to me that if we're going to have a jot-for-jot selective incorporation of information in there, we ought to have access to the whole report. So I respectfully request that we be given access to these reports. They've been made now by a member of the committee in reliance on information that we haven't had access to, and I think we need to be given those. You can't.
Senator, I'd like to draw this to a conclusion. I can tell you what I know. And
well, so would I.
And here's the point. Most of this information was published in the Washington Post 5 days ago, all right? This is not confidential information. When the Hawley attack on the judge started, we requested more information, the White House did, and then shared it with us within the day, and you now have the same copy that we have. End of story.
Is it fair for you to characterize Senator Hawley's questions or the questions raised by any of us as an attack? It's not a personal attack. This is
let me just tell you,
we've raised
difference
a
of
legitimate question regarding sentencing, regarding the most heinous crimes imaginable.
Oh, come on.
So these are legitimate questions, Mr. Chairman. Don't call them attacks.
Well, I can just tell you, I have characterized them as attacks and other things as well. I think it's pretty clear what's going on here, and now you have all the information we have.
So Mr. Chairman, for example, in the questioning about the Hawkins case, Judge Jackson said she relied on the factors, relied on probation's recommendation. We just found out in what you just handed us that in the Hawkins case, the probation office recommended 18 months, and Judge Jackson only sentenced him to 3 months. That's you can get more than that almost for a speeding ticket. And
Senator,
this committee, given that she raised it as the basis for her sentence, it is highly relevant to the committee's analysis to see what the pre-sentence report says. Why did the probation office recommend 18 months and she only sentenced to 3 months?
March 19th, Washington Post. In the case of U.S. versus Hawkins, a sex offender had multiple images of child porn over 18. Sentencing guidelines called for sentence up to 10 years. Judge Jackson sentenced the perpetrator to only 3 months in prison. Printed.
Those facts we knew. It's the probation recommendation. We don't dispute that the guidelines said 10 years and she sentenced him to 3 months.
Sorry, I didn't finish reading it. The government and probation both recommended sentences well below the guidelines. The government recommended 24 months, probation recommended 18 months, and defense recommended 1 day. I'm telling you, it was published in a newspaper. Now,
Well, I can't help what is leaked to the newspaper or not. This committee, you keep referencing discovery. This is not litigation. This is a committee of the United States Senate where both sides of the aisle have a right to access to the record, and we're carrying out our constitutional duty of advice and
I will
consent.
tell you this, for some reason your side didn't request the information.
But how would we know to request? So I'm hereby requesting all other information you magically have that you haven't told us you have and you're not sharing with
So
the other
noted.
side.
So noted, for the record. We'll continue with the questioning now.
And we're
Senator
requesting the pre-sentence reports in particular, which are highly relevant to the issues before
Senator
this
Cotton,
committee.
please proceed. We don't have any pre-sentence reports.
Judge, I'd like to talk about crime. In 2019, there were about 16,000 murders in America. In 2020, there were more than 20,000. It's a 25% increase in 1 year. 2021 data isn't complete, but we know many cities have reached record levels of murder, including Philadelphia, Atlanta, and Milwaukee. At the same time, the prison population has decreased by about 14%, in part from pandemic policies, but also from fewer prosecutions and weaker sentencings. I think it's safe to say that there's a surge in crime, especially violent crime and murder across America. You have noted that some members of your family have law enforcement backgrounds, and I honor them and thank them for their service. Does the United States need more police or fewer police?
Thank you, Senator. As you just noted, I have law enforcement in my background, and I am very familiar with the problems that crime cause in the communities where we live.
Okay, Judge, I'm sorry. We have a few minutes here. You have a lifetime appointment if you're confirmed. I asked a simple either-or question. Does the United States need more or fewer police?
Senator, the determination about whether there should be more or fewer police is a policy decision by another branch of government. It is not something that judges have control over, and I will stay in my lane in terms of the kinds of things that are properly in the judicial branch.
Okay, if you don't want to address whether the United States needs more or fewer police, we'll move on to sentencing, which is certainly in your lane. There's been a lot of talk about criminal justice and sentencing approaches and theories today. In general, is someone more likely or less likely to commit a crime if they know that they will be caught, convicted, and sentenced?
Senator, what is in my lane is the consideration of particular cases of
Judge,
prosecutions.
You've spoken a lot today about criminal sentencing, about the theory of sentencing. You've written a lot about it in your record. It is a very simple question. Is someone more likely or less likely to commit crime if they're more certain that they're going to be caught, convicted, and sentenced?
Senator, I am aware from my work on the Sentencing Commission and not as a judge that there is research into recidivism rates, into rehabilitation, into the factors that go into a determination about whether someone is more or less likely to commit crime. Part of what Congress has taken into account when it determined that one of the purposes of punishment is deterrence is the idea that if someone is convicted and punished, they will be deterred from committing other crimes.
And you've mentioned that, and you've written about that in your writings. There's 4 purposes of punishment. One of those is deterrence. Isn't it inherent in the concept of deterrence that people are less likely to commit crime if they're more likely to get caught, convicted, and sentenced? Why can't you just say that's the case?
Senator, it's not that I'm avoiding saying that's the case.
No, Judge, that's exactly what you're doing. I'm asking a very simple question. In general, is someone more likely or less likely to commit a crime if they know they're going to be caught, convicted, and sentenced?
It's very
the heart of deterrence theory.
It's very difficult to answer questions in general when you're asking about things like phenomena related to crime. It's the theory behind deterrence that by punishing someone, they will be less likely to commit the crime in the future. That is a theory that undergirds.
Do you think that theory is correct?
Senator, there is research that supports that deterrence is something that can occur. Does it occur in every case? I can't say that.
Okay, let's turn to something more concrete then. Do you know how long the average inmate convicted for a murder serves in prison in America?
No, I don't.
The answer is 17 years on average. Is 17 years too long or not long enough for a criminal to spend in prison for murder?
Senator, these are policy questions, whether they're in the province of the Sentencing Commission in terms of recommendations, whether they are in Congress. They're not the kinds of things that I can opine about.
So you don't want to opine on whether 17 years is too long or too short a sentence for murder?
Senator Cotton, the Congress has prescribed a number of factors that judges look at when they sentence. It may, in many cases, not be. I can't answer in the abstract in the way that you.
Well, these are very concrete. Let's turn to rape. Do you know how long the average inmate convicted of rape serves in prison in America?
Well, Senator, rape is not a crime in the federal system that I'm familiar with working with, so I don't know.
It's 7.2 months. Do you think 7.2 months is too long or too short for someone convicted of rape to be sentenced to prison?
Senator, that's a policy question about the egregious crime of rape, and Congress has said that the court is supposed to take into account a number of factors when it sentences.
Okay.
I can't answer in the abstract.
Well, Judge, these are not abstract. These are very concrete. And remember, these are just the length of sentence if you're caught, convicted, and sentenced. Let's look at cases in which people are never caught. As I said, in 2020, murders increased by the fastest rate ever in the United States. Do you know what percentage of murders are solved in America?
Majority of cases.
I do not, Senator.
The answer is about half, 54% in 2020. Do you think we should catch and imprison more murderers or fewer murderers?
Well, Senator, it's very important that people be held accountable for their crimes. So that is a fundamental tenet of the rule of law.
So is that a yes, we should catch more murderers, specifically the 46% of murderers who get away with it?
Senator, I'm not, to the extent you're asking about enforcement or law enforcement, those.
Judge, it's a very simple and common sense question. 46% of all murders go unsolved. Should we catch more of those murderers or should we catch fewer of them?
Senator, we should hold people accountable for their crimes. And so if people are not being held accountable, then that is a problem.
Let's turn to assaults. Do you know how many assaults were solved in this country in 2020?
No, Senator.
44%. So 56% of all assault victims did not receive justice. Do you think we should catch and imprison more criminals who commit assault against innocent people or fewer?
Senator, it's very important that people be held accountable for their crimes. So if they're not, then it would be a problem for the rule of law.
Let's look at sexual assault and rape. Do you know what percentage of sexual assaults and rapes go unsolved in this country?
I do not, Senator.
77%, more than 3/4 of all sexual assaults and rapes go unsolved. Do you think we should catch and imprison more rapists and sex criminals or fewer?
Senator, one of my two uncles was a detective in a sexual crimes and battery unit. So I'm very familiar with that type of crime. It's a horrible type of crime, as are all of these that you are articulating. And it is important for people to be held accountable for criminal behavior. It's fundamental to the rule of law.
Okay. So in 2020 alone, well over 1 million violent crimes went unsolved in America. Do you think we imprison too many violent criminals or not enough?
Senator, it's important for our rule of law to ensure that people are held accountable who are breaking the law in the ways that you mentioned and otherwise.
What do you think the families of all those victims think? Do you think they think that we should arrest and convict and sentence all these criminals who get away with it?
Senator, I know what the families of law enforcement officers think because I'm one of them. I know what crime does to our society. I care deeply about public safety. And as a judge, it's been my duty when I was at the trial level, I'm no longer there, but when I was at the trial level, to ensure that people are held accountable for their crimes.
Okay. Let's turn to the crime of child pornography. I know there's been a lot of talk about it today. I don't want to spend much time on it. A lot of people have tried to explain the various differences in these cases and the pre-sentencing reports and the sentences that they got. So let me just ask you a simple question about it. Should the United States strengthen or weaken sentences for child pornographers?
Senator, that's not a simple question, and the reason is because what this country does in terms of penalties is in Congress's province. You all decide. You all decide what the penalties are. You decide what the factors are that judges use to sentence. If you determine that any set of penalties is insufficient, then it is in your purview to make that determination. There are many crimes that Congress has determined warrant mandatory minimum penalties, warrant other kinds of penalties, and that is in your purview to determine.
I have to say, Judge, I think whether or not we should strengthen or weaken sentences for child pornographers is a pretty simple question, but I'll move on. I think the difference we've heard today gets to this simple fact that a bunch of elite lawyers, whether they're judges or federal prosecutors or public defenders or law professors, think that sentences for child pornography are too harsh. I don't, and I bet a lot of normal Americans don't either. You've said repeatedly that sentencing is a discretionary act, and I understand that and I agree with it. But you always seem to use your discretion in these child pornography cases to reduce the sentences. I have to say, if I had that discretion, I'd probably throw the book at child pornographers. Maybe that's just me. But let's turn to drug crime. Last year, more than 100,000 Americans died from drug overdose. Drug overdose deaths and gang crime have both skyrocketed in recent years. At the same time that a lot of soft-on-crime laws and lower sentences have been advocated, including, on occasions, Judge, by yourself. In general, do you think the United States should weaken or strengthen sentences for fentanyl traffickers? Traffickers, not users.
Senator, whether or not Congress chooses to strengthen or weaken penalties for any crime is a determination of this body, which is ordinarily made after study and review, determination. That is in the province of Congress.
Well, Judge, you've said before that sentencing is a discretionary act, so that is literally the job of the judge in many of these cases, to determine whether to have a shorter or a longer sentence.
Respectfully, Senator, the judge makes that determination not based on one data point in general, which is what you asked me. In general, should we lower or heighten sentences? A judge is making a determination in a particular case, looking at all of the factors. It's discretionary for sure, but we do so within the bounds of a sentencing range that Congress prescribes. And at times in which Congress decides that a penalty needs to be heightened, they impose a mandatory minimum. Then our range is shorter. And when we're looking at the crime, we're not looking as a policy matter across all fentanyl crimes and determining whether the penalty should be increased. As a judge, we are asked in the context of a single prosecution regarding a particular person who has committed a horrible crime, but also, says Congress, is a person who has a life, who has a job, who has all of the other factors that Congress has told judges they have to look at when they decide what penalty to impose in that particular case between the range that Congress sets. So it's not a situation in which I can, in my role as a judge, tell you as a general matter whether penalties should be increased or decreased.
I have to say, I think that not many Americans, especially not the 100,000 Americans who's lost someone to drug overdose, think these are tough questions. But let's move on. Let's talk about retroactivity. When you were on the Sentencing Commission, you repeatedly advocated for retroactively reducing drug trafficking sentences. So this is a case where a drug kingpin who's dealing fentanyl gets sentenced, and then a few years later, he gets lucky. He gets in front of some new judge who's maybe more sympathetic and thinks he got a raw deal, or maybe he just gets in front of the same judge a few years removed from seeing the faces of the victims of his crime. Do you believe that resentencing years after a conviction tends to reduce sentence lengths?
Senator, respectfully, I just wanted to remark on your previous question and your statement that these are not difficult questions. It's not that they're difficult questions, it's that they're not questions for me. I am not the Congress. I am not making policy around sentencing. My job is to look in a particular case and decide what the penalty should be within the range that Congress prescribes.
I understand. You were making policy, though, at the Sentencing Commission, and you're implementing changes to sentencing guidelines. So my question again is, do you believe that resentencing years after a conviction tends to reduce sentence lengths?
I'm not sure I understand your question. Obviously, if you resentence, you're giving the judge another opportunity to look at the circumstances in light of the changed penalties. Sometimes the judge in that new situation will keep the same penalty. A resentencing is just an opportunity for the judge to reevaluate in light of the changed circumstances.
Okay. Almost without exception, retroactively weakening sentencing laws and guidelines lets harden criminals out early. I always hear the argument, I hear it from some of the senators on this panel, I heard a version of it from you earlier, that each case is going to go before a judge and it won't be an automatic release because each judge is going to assess the facts and hear the arguments. In 2014, you said that judges would not likely reduce the sentences in the vast majority of cases if sentencing guidelines for drug trafficking were reduced. I think you missed that one, Judge. Since 2014, when retroactive reduction took effect, approximately 2/3 of all convicted drug traffickers who asked for early release got it. That's 31,614 hardened drug traffickers back on the streets. More than 7,500 of those hardened drug traffickers use weapons in their crimes. So that means that only 1/3 of these drug traffickers who sought to have retroactive reduction of their sentence were denied. Judge, is 1/3 a vast majority?
Senator, it's hard for me to answer questions about these numbers because I'm trying to understand whether this is a retroactive release that was a result of the Sentencing Commission's actions or Congress's. Congress made a decision about retroactive reductions in drug penalties. So I'm just not sure what.
But Judge, in both cases, we always hear the argument, whether it's from members of Congress to include senators on this committee or the Sentencing Commission, that we shouldn't worry, there's going to be individualized case-by-case determination.
And that is my experience. That's when there is a retroactive change. So what happens is that whether it's the guidelines that are changed or the laws that are changed, which happens in Congress, there is a subsequent determination as to whether or not to apply that retroactively, apply that change, so that both the people who get convicted of that penalty moving forward and the people who have already been convicted, both of them get the benefit of the change if the determination is made to make it retroactive. Under that circumstance where you're talking about a penalty change applied to prior people, each one of those prior people goes back before a judge. And a judge, usually the sentencing judge in the first instance, will reevaluate whether or not to, this is generally, there are some exceptions, but generally speaking, the judge will reevaluate whether or not to give that person the benefit of the change. This is an individual assessment. That's what Congress requires in every sentence, and ultimately one that benefits
all of us under the law, because judges are being asked to look at these cases and not make just generalized determinations.
So the 2014 comment was specifically about the Sentencing Commission, but generally, whether it's in front of the Commission or the Congress, we always hear this argument that judges are going to make these individualized cases and not that many people will be released. I'll point out that of the 1/3 that were not reduced, the vast majority of those were not eligible. The percentage of cases in which a sentence is not reduced for public safety reasons because someone is viewed as too dangerous to release early is 1%. It's 1%. Judge, do you remember a man named Keith Young?
Yes.
Good. For the benefit of my colleagues, let me quickly cover the basics of his case. You sentenced him in 2018. Keith Young was a career criminal who had previously been convicted of trafficking cocaine. In 2017, he was running a drug business in his house where his children lived and was found with 2 1-kilogram bricks of heroin worth hundreds of thousands of dollars, along with a gun, ammunition, thousands of dollars in cash, and equipment to cut and package heroin for retail sale. The drug lab also confirmed that there was fentanyl in both bricks of heroin. And in one of the 2 bricks, there was actually more fentanyl than there was heroin. While at the D.C. jail awaiting trial, Young bragged about his arrest and about how he was a kingpin. Those are his words, not mine. Kingpin. He was even recorded calling his wife and brother to give them instructions on collecting drug money from people for him. The prosecutors filed a notice of Young's criminal history, which meant he faced a mandatory minimum of 20 years. You did not seem to like that, Judge. In fact, at his sentencing, you said, this is a quote, that you shared his frustration, that you couldn't give him a lighter sentence. I was shocked to see this in the transcript. I was also shocked that you apologized to this drug kingpin for having to follow the law. You literally said that you didn't think 20 years was fair. This is the quote, "And for this, I am sorry, mostly because I believe in second chances." You apologized to this career criminal, a drug kingpin, in his own words. He was not some low-level first-time drug offender who made a bad choice. That was in 2018. But in 2020, you got a second chance. After Young's sentence, Congress passed something called the First Step Act, which reduced sentences for serious drug traffickers with lengthy criminal records. During the pandemic, lots of criminals like Keith Young tried to twist the First Step Act's compassionate release provision, which was intended for terminally ill elderly inmates to get early release and blame it on COVID. You had none of that, and that's good. You rightly said at his resentencing hearing, quote, "COVID-19 is not only present in prisons," and you said that Young's past as a smoker and his claim of various other health issues did not entitle him to early release. If you had stopped there, I would have cited that as a great example of how you follow the law and made a well-reasoned decision. Unfortunately, you didn't stop there. You said in the resentencing that, quote, "Congress did not make their changes under the First Step Act retroactive. That if they had, then you could have given him a reduced sentence." But then you said, no matter what the law says, and this is a quote, Judge, "The court feels as though in this moment, per Mr. Young's compassionate release motion, the court is being called upon to evaluate the length of his sentence under the revised section of the law in the First Step Act, and so it is almost as if I am sentencing him today. And if I were to do so, he would face a sentence that would be well below the 240 months that Mr. Young received. And so for that reason, I will grant Mr. Young's motion." Judge Jackson, before you granted this fentanyl kingpin's motion to reduce his sentence, did you contact any of the victims from his case?
Senator, thank you for allowing me to address Mr. Young's situation.
I asked a simple question. Did you contact the victims in his case or not?
Senator, Mr. Young was not released. His sentence was reduced, and I did not contact the victims in his case because there were no victims. He committed a crime, a drug crime. There were no identifiable victims in his case.
Drug crime is not a victimless crime. 100,000 Americans were killed by overdoses.
Understood, Senator, but there was no one to contact because there were no identifiable.
Judge, you just acknowledged that you did not release him. You're right, you didn't release him. He filed a motion for compassionate release. You denied that rightly, but you reduced his sentence. He didn't file a motion to reduce his sentence. He wasn't eligible for a reduced sentence under the First Step Act because it wasn't retroactive towards him. You took a motion for compassionate release to get out of prison and turned it into a motion to reduce a sentence. So he's going to be released 7.5 years earlier, years from now. Last week, Judge, when we talked in our office, you talked about a lot about judicial restraint. Is transforming his motion for compassionate release into a motion to reduce a sentence for this drug trafficking kingpin an example of judicial restraint, Judge?
Yes, Senator, it is, and I will explain how. Mr. Young, as you say, was facing originally a sentence of 20 years in prison, which I imposed. I tried Mr. Young, who went to trial, primarily because he was facing such a long penalty. I looked at the evidence in his case. He was absolutely the kingpin that you're talking about. But the way that our laws work, the 20-year sentence that he received for the amount of heroin that he had was increased based on a sentence that he received, I think it was 10 or 15 years before. He had no criminal history between the old sentence. Forgive me, I can't remember exactly what it is, and I'm sure people will look it up. But 10, 15 years before, he had some minor sentence. Then he had this really obviously serious, terrible sentence. And the government filed what is called an 851, which is an enhancement based on his really, really old prior criminal history. I followed the law, which said that he had to go to jail for 20 years. It would have been more like 10 years if the government hadn't taken into account his very old criminal history. But I said, fine, this is the law, I'm following it, you're going to jail for 20 years. In the interim, COVID happens. We get lots of compassionate release motions, and there's a statute that Congress has enacted which allows defendants to seek compassionate release, to seek reduction of their sentence, not just release, reduction, release, some adjustment to their penalty under the law if there are extraordinary and compelling reasons to do so. That's the quote from the statute, extraordinary and compelling reasons. Doesn't say anything more narrow than that, although you do have to look at the guidelines related to compassionate release, all of which I did related to his motion. And he argued several things. He argued his smoking, his asthma. These were reasons, he said, for compassionate release, and I disagreed. What I did find extraordinary and compelling is the fact that between the 20-year sentence that I gave him originally and the compassionate release motion that he filed, Congress changed the law. Congress decided that the old penalty, the old crime, was no longer eligible for the increased, so that a person who was convicted at the time of his compassionate release motion for doing exactly what Mr. Young had done would not get a 20-year sentence. That would not be lawful for a person at that moment. And one of the things that Congress says to the judges is care about unwarranted sentencing disparity. Care about the fact that the person you're sentencing is being treated differently than someone else who committed exactly the same crime. And I understand it wasn't retroactive in the sense that everybody, absent a compassionate release motion, wouldn't have been eligible for resentencing. But here I have a defendant before me and all of the factors that Congress has asked me to take into account, and a compelling argument that there were extraordinary and compelling circumstances, that is, a change in the law,
that would create unwarranted sentencing disparity if I didn't take account of it. And so what I determined under those circumstances is that I would resentence Mr. Young to the penalty that Congress had decided was the appropriate penalty for the conduct that he committed as of the time of his motion.
Judge, Congress did change the law after his sentencing in the First Step Act. That was a terrible mistake. Congress specifically did not make that change retroactively. And you saw that, and you thought it was extraordinary and compelling, even though Congress specifically did not make it retroactive. You chose to rewrite the law because you were sympathetic to a fentanyl drug kingpin whom you had expressed frustration at having sentenced him to his 20-year sentence in the first place. You twisted the law and you rewrote it so you could cut the sentence of a drug kingpin. That's what you did, Judge.
Respectfully, Senator, I disagree. Congress provided judges through the compassionate release motion mechanism with the opportunity to review sentences. Congress, prior to the compassionate release mechanism being enacted, a judge who imposed a sentence would have no opportunity to revisit. In Mr. Young's case, the question was, with this compassionate release motion, under a circumstance in which Congress had changed the law, was that an extraordinary and compelling circumstance to revisit his sentence? And I made a determination that it was.
So I suppose then, if you're confirmed, we can just count on you to always rule in favor of retroactivity, no matter what the facts of the case are, because it was a blatant rewrite of the law here, so you could reduce the sentence of a drug kingpin if you didn't like sentencing to 20 years in the first place.
No, Senator, it was not.
Senator Booker.
Approaching 11 hours now of a long day. And forgive me, I want to go back to one of my early senators, Lindsey Graham. I think he asked you something, and I'd like to just put it this way. On a scale from 1 to 10, how deep is your faith? That I want to ask that question.
You're asking me, or
No,
you won't ask me?
I'm just joking.
Okay.
I won't ask you that. But I do want to go through some of the things that some of my colleagues did on Top Line. And forgive me, I don't want to dwell too much, but some of it I found today just to me really didn't hold water. And I want to start with my friend and colleague, Ted Cruz, who is my friend. He's a Texan. One of my favorite Texans is Brene Brown's, who says it's hard to hate up close, so pull people in. And a lot of times in this culture of tribal politics, the reality is we know each other, we get to know each other over years, and I've had the privilege of working with Ted on a lot of really good policy. So I went back to my office and re-listened to his questioning of you about critical race theory, and he referenced your speech, which I hadn't read. You Harvard folks are so well focused on these things, but I read your speech, and I was very surprised. Ted had a very big chart. I think he needs to give Senator Whitehouse some advice on charts. Senator Whitehouse, this was very small. It was almost as if they were proportionate to their state sizes. But
easy there, New Jersey.
Mr. Chairman, I would request that my colleagues in the Democratic Party would stop interrupting me. But he talked about your speech, and when I read your speech, there's a couple things that jumped out. First of all, he acknowledged it was a very powerful speech, very moving speech about extraordinary black women. I have a criticism, your mother was not in it, but I will leave that alone. But there's some things he honed in on, almost as if they seemed to be accusations, which don't hold merit to me. We have a saying in New Jersey, I felt it was all hat and no cattle. And so he said that you called the woman who wrote the 1619 Project, that you called her provocative. That's not a compliment necessarily if you call someone provocative, is it?
No.
No, I mean, I think Ted Cruz is very provocative. And that doesn't mean I agree with what he's saying, his philosophy, doesn't mean I agree with his statements. But he pointed out you also called the author acclaimed. She won a Pulitzer Prize, correct?
She did.
In journalism. So she is acclaimed.
She is.
But in nowhere are you heralding her as this is reflective of your philosophy. That's true, right?
Correct.
Yeah, so I don't understand that at all. Part of his chart also was a lot of ellipses, skipping out things, but you mentioned critical race theory when you're talking about policies in general. I actually went back to that talk too, and I saw you threw everything in there. You were talking about psychology, economics, all different types of disciplines as touching upon the law. I think there was everything in there, I seem to be, except for astrology. But you understand that you were just listing a list of things that people could say touch the law. They weren't your philosophies at all.
Correct, Senator. And that speech was not related to what I do as a judge. That was talking about sentencing policy and all of the different academic disciplines that might relate to it.
Yeah, and then finally, we're entering an age that is surprising to me in American society where lots of books are being banned and lots of talks about books being read. You're on the board of a private school and you have no supervision or authority over what books the children read in a private school, correct?
Correct.
I really do appreciate that. Jumping really quickly to a lot of talk today about these child exploitation cases. And Senator Durbin, I think that actually Josh Hawley used the word attack when describing his own, so I don't understand what that point of sensitivity was. But individual cases, and we've now heard about 2, you've presided over as a judge more than 10, 15 cases?
I've presided over 14 cases that involve child sex crimes, but over my career as a trial judge, I've presided over more than 100.
Right, and cases are heavily fact-specific, right?
That is true.
Did you remember all the facts of the case that Senator Hawley was?
I did not.
You did not, right. And the facts matter, right?
They do.
And as a judge, you're looking at all of the facts of the case, not just what might be talked about later or what people are honing in. You have to take everything into account and make a decision, correct?
Yes, that's what Congress has required judges to do.
Right, and just to clarify that Congress thing, because again, you went to this elite law school. I went to a gritty inner city law school, Yale. So you know this better than me, but it was actually 1984 that the sentencing laws, the sentencing standards were passed down, correct?
I believe so, yes.
Yeah, it was 1984. And then later in 2002 or 3, things were updated. But that 1984 was before the internet completely. And I just want to clarify also the Booker decision.
Yes.
Could you just clarify for the record, because my mom might be watching, no relation to me whatsoever, correct?
So the Booker decision, which earlier I mentioned that I thought Justice Scalia wrote it. In fact, it was Justice Stevens.
Yes.
But Justice Scalia concurred, so he had a separate opinion, and he had written a previous decision that was very similar.
Yes.
The Booker decision made the guidelines, the sentencing guidelines, advisory.
Why? Why would the Supreme Court, joined by some of the most conservative members, why would they do that?
Well, they determined that, in essence, the Booker, that if the guidelines were mandatory, that it would violate the right to a jury trial to have jurors decide every aspect of your sentencing.
Yeah, it's just sort of the separation of powers, Sixth Amendment.
Yes.
This is really important.
Yes.
And so that gave judges latitude.
Yes.
Now, if you were falling out of the norm, and this is where, you know, I've now read conservative periodicals looking at this line of attack. That's not a negative pejorative. Again, my colleague himself used it, but this line of attack on you, I've seen conservative papers, liberal papers, mainstream papers, all say this doesn't hold water. And the reason is, and again, unlike White House and Cruz, I don't have a chart. I'm uncharted. But I would like to hold this up for you. You are well within the norm nationally for going below the sentencing guidelines because of this problem where you have this incongruency that judges on both sides of that have been pointed by people of both sides of the aisle have seen. I just want to make that very clear. You are well within the norm in the United States of America. I'm a former mayor, and one of my favorite mayor friends used to always say, "In God we trust, but everybody else bring me data." and so the data kind of shows that you're not some outlier. And forgive me, because this is, you're not allowed to do this, but I kind of sat here and was a little insulted about the accusation that somehow this mother of two, confirmed 3 times by the United States Senate, who has victim advocacy groups writing letters for you, who has child victims advocacy groups supporting you, who has presided over fact-specific cases of the most heinous crimes, that somehow the implication that you are somehow out of the norm of other federal judges that we have confirmed where these issues have never come up, who, again, I held up this chart, but the majority of the decisions, a percentage of sentences below guideline range in non-production child pornography cases. In DC, 80% of them are under the guidelines. In Missouri, 77%. In Iowa, 62%. In North Carolina, 77%. In Nebraska, 81%. And so on and so on and so forth, down to Utah, alphabetical order, 71%. And so this implication that somehow your thoughtfulness on these very dense, fact-specific cases is somehow out of the norm, to me, does not hold up, doesn't head water. And then you add that to the endorsements that you have gotten from folks that deal with victim advocacy groups. It is, to me, just a line of attack that it does not hold in no way for me. I'm sorry. In the totality of your career, what you've accomplished and what you've done, I just think it's unfortunate that, unlike the sort of fair arbiters of this on both sides of the aisle who've dismissed it, I appreciate the way you've sat there and addressed all of that stuff. And that really brings me to the larger implication. You talked a lot about your uncles. One of them served in Baltimore, is that right? As a police officer?
My brother was a police officer in Baltimore.
The gentleman over there?
Yes.
Who volunteered to serve in the United States military?
Yes.
And you have talked about that police work, right?
Yes.
I live in Newark. I love my city. If you cut me, I bleed bricks. And I would go with the nickname of our city is Brick City. Your brother and I probably understand something. The majority of murder victims in the United States of America, do you know who the majority of murder victims are?
I don't.
They're black men. I imagine in your conversations with your brother and your 2 uncles, you who patrolled some of these streets, I imagine you feel in a different way about the anguish of what many communities of color struggle with when it comes to crime. Am I right there?
You are right, Senator. It is very anguishing, and it is something that I know all too well.
And you are a person that has that same fear that many mothers have for their daughters who do go out in this world. My mom used to say, when you have a child, it's like your heart going around outside of your body all of a sudden. And I just find it hard to believe, given your law enforcement background, you're a mom, that you take any of this urgency to keep America safe. And then I see that, like, folks I know well. I've worked with the FOP. I began negotiating with them. I have to say, I thought Jim Pasco, before I knew him, it's a whole thing, Brene Brown, bring people close. At first I thought he was an ogre, biggest police union in I had some tough negotiations with my police union. He and I sat down and we shared our stories. And I think we realized we were coming from the same place when we were working on police reform. FOP endorsed you, and they wrote a powerful letter. I won't read it again. The IACP, they represent the largest, that's the rank and file, the FOP. The IACP represents the bosses, the managers. They endorse you. There's another group that maybe my colleagues don't know as well as I do. It's called Noble. Do you know them?
I do.
They're the black law enforcement organization nationally. People like your brother
Yes,
who love their communities,
yes.
who have seen, like I have, too many young men lying with bullet holes, bleeding into our pavements. These are folks who come from communities like your brother knows, where you too often see sidewalk shrines to murdered youth. I've talked to the women and men of Noble so many times. Anybody ever accuse them of being soft on crime? But they understand the complicated factors of crime in our country. And what they have to say to you about you, I won't read it, is just beautiful. Law enforcement family, mother of two, law enforcement organization after law enforcement organization, victims advocacy organizations after victims advocacy organizations, Republican appointed judges, Democratic appointed judges. That's who's in your corner. We're politicians, we have a sworn oath right now. I've just watched you with dignity and grace field what I can only imagine is behind those questions, is this doubt that is being sown. I just want America to know that when it comes to my family's safety, when it comes to Newark, New Jersey, or my state, God, I trust you. I trust you. Now, I brought in your mother, and I have to go back there. My mom has a saying that is awfully embarrassing when she talks about me. She says, she'll introduce me and she'll say, behind every successful child is an astonished parent. But there's something about your mother looking at her is that she doesn't seem all too astonished. She seems like almost just very slyly she knew that a day like this might come. And so I just want to share with you that I have done a lot of hiring. Before I was in a legislative body, I ran New Jersey's largest city. And I could write a book about all the management mistakes I made in my first year and how it made me a really good manager. And the first mistake I made was I was just looking for the most talented, credentialed, skillful, smart people to help me run things. And I soon learned it wasn't enough. I made some mistakes in hiring. And I began to see that those skills, which you have a tremendous amount of, it's been said so many times, if stacking you up against other Supreme Court justices, you have more qualifications, more credentials than many of them. But I learned that you should hire first, that's necessary credentials, but not sufficient, that you should hire for character. That's what made me hire a great team in Newark eventually. And we operated so well. And so I believe I've gotten to know your character over these weeks, but I want America to know a little bit more about your character right now. And so I know my values. Booker T. Washington said it, James Baldwin said it. Children are never good at listening to their elders, but they never fail to imitate them. If I want to know your character, you haven't let me do this yet, but I want to hang out with your parents a little bit. And so let's draw them into this conversation. We won't swear them under oath, but just could you share with me what are their bedrock values that are most a part of your values now that you hope and pray are your grandchildren's, unborn grandchildren's values? What are those most important values you inherited from those two folk over there?
Thank you, Senator. I inherited a number of bedrock values, as you say, from my extraordinary parents. As I mentioned, my parents grew up in a time in this country in which Black children and white children were not allowed to go to school together. They persevered. They were the first in their families to go to college, to have that chance. They each went to historically Black universities, and they taught me hard work. They taught me perseverance. They taught me that anything is possible in this great country. And I think it came, as I said in my introduction, from the sea change that we had in this country from the 1960s when Congress passed 2 Civil Rights Acts and African Americans finally had the chance to become a part of the dream, become a part of the fabric of this wonderful nation. My parents moved to Washington, D.C. because this is where it all started for them in terms of having new freedoms. And I was born here on that hope and dream. I was born here with an African name that my parents gave me to demonstrate their pride in who they were and their pride and hope in what I could be.
And it seems to me, as a guy whose parents came here and you and I both were born here months apart, I would hear my parents' tough stories at the dinner table about facing bigotry. Here in the city, my father told me stories about his early jobs, but I never noticed a hint of bitterness or that hate he saw never generated hate with him. In fact, he just loved people, all people.
That is correct, Senator, and I would say that my wonderful parents went on to become extraordinary public servants. They had new opportunity. They could have done, other things, but each of them decided to give back to the community. My mother was in the public school system. She was a teacher and then became an administrator, became the principal of a magnet school for the arts in Miami, a new school that had started up, and became the sort of beloved principal of New World School of the Arts. And so many of her students continue to see me, meet me, and they know me from my mother, which is fantastic.
And she had diverse students.
She had extraordinarily
And she
diverse.
loved on all those children.
Everyone.
Black, white, Asian.
Everyone.
Well, let me ask you this, because I'm going to push you a little harder, because I have some people I really respect on the other side of the aisle, and they do, my friends and I talk about religion sometimes. Faith is important. I was teasing Lindsey, Senator Graham earlier, but I don't want to ask you anything specific about your faith except for this, because you brought it up in your opening statement. And I have to tell you, I don't think black women have any providence over struggle. People from all backgrounds in America struggle. But I do know often as the trailblazing black women, they have often faced many challenges being the first or being a trailblazer or breaking glass ceilings. But I know on your journey to this moment right now, you have faced very tough moments. Probably you've been knocked down by life. I always say if America hasn't broken your heart, you don't love her enough. You've been heartbroken by something, circumstance. You've been like Zora Neale Hurston, who says, I've been through sorrow's kitchen and I licked out all the pots. You've been like Langston Hughes to that poem, Mother to Son, life for me ain't been no crystal stair. Could you talk to me maybe about one moment or what you do when you get knocked down like that? Where do you get the grit and the guts to get back up and keep on going?
Well, Senator, I think that too is something that I learned from my grandparents, who, as I said, didn't have it easy. My grandparents, who didn't have a lot of formal education, but who were the hardest working people I've ever known, and who just got up every day and put one foot after the other and provided for their families and made sure that their children went to college, even though they never had those opportunities. I reflect on them in the context of this historic moment. I stand on the shoulders of people from that generation, and I focus at times on my faith when I'm going through hard times. Those are the kinds of things that I learned from my grandmother, who used to have those family dinners and bring us all together. And I think that's a common experience of Americans, that when you go through difficult times, you lean into family and you turn to faith. And that's part of my experience as well.
It's, I think, the experience of my colleagues and I on both sides of the aisle, leaning on that faith and that family. I want to give you, there's one thing about your opening statement, and I have to say, I haven't actually shaken your husband's hand yet, but yesterday I was mad at him because when he started tearing up at your remarks about him, it triggered, I don't really have it, but it triggered a sympathetic cry in me as well. So I'm a little upset at him, but I will deal with him individually. But you said something that I found provocative, to use that word one more time. And I felt afterwards, I reflected, I even talked to my staff about it because I thought that statement, it didn't seem congruent to me. And it was, I don't know if it was a profession of humility or overly critical of yourself. But I want to end in my last 5 minutes giving you space to explain yourself to me because much to my mom's chagrin, I am not a parent yet. And I'm looking at somebody that I admire, but you said something that struck me because look, my mom was a working mom. And God, it was tough. My colleagues will not believe this, but there was a time I was very melodramatic. And I was in a bathtub of oatmeal bathtub, and my mom was getting ready to go on a business trip. And I look at her with these sad eyes, and I say, "Mom, if you leave me, I'll die." And she looked at me, knowing that you don't die from the chicken pox. But I still remember her going to the phone, having a long conversation, taking off her business suit and changing into her sweatpants. She would tell me later that that was not a sign of love. She loved me, but a lot of women who love their kids can't stay home because we don't have paid family leave in this country. So you said in your opening remarks that you haven't been as good of a parent, I think if I'm paraphrasing right, as good as a mom as you'd like to be. And I looked at your two girls, and I look at you, and I don't understand that statement. Could you maybe explain for me what you meant, and maybe take one more beat and explain to me what it means to you to be a mom of two young women growing up in America today?
Thank you, Senator. What I said in my statement was that that I had struggled, like so many working moms, to juggle motherhood and career. And it takes a lot of hard work to become a judge, to do the work of a judge, which I've done now for almost 10 years. You have a lot of cases. You don't have all that many resources, comparatively speaking, and it's a lot of early mornings and late nights. And what that means is there will be hearings during your daughter's recitals. There'll be emergencies on birthdays that you have to handle. And I know so many young women in this country, especially who have small kids, who have these momentous events and have to make a choice. You talked about your mom making the choice to make sure that she cared for you in that moment. And there are times when obviously you have to care for your family members. There are other times when there are events that you wish you could be a part of, but here's the emergency case that you have to deal with. And so I said in my opening that girls, you've had to deal with me juggling motherhood and job responsibilities, and I didn't always get the balance right. And so I would hope for them seeing me, hopefully you all will confirm me, seeing me moved to the Supreme Court, that they can know that you don't have to be perfect in your career trajectory and you can still end up doing what you want to do, that you just have to understand that there are lots of responsibilities in the world and that you don't have to be a perfect mom, but if you do your best and you love your children, that things will turn out okay.
Well, I'm sure your mom probably feels she wasn't perfect, but things have turned out okay. And I will tell you this, I'm sure they've said it, and if they haven't, I'm sure they will. The older I get, the more I appreciate my parents. I know they're proud of you, but as a guy who does have faith, and I sit at home in a room of my ancestors where I have generations of my ancestors' pictures up, and they're black folk and white folk. I have a very interesting family tree. I sit there to feel my ancestors sometimes and think about them. I hope right now, in this questions and blistering, that you know that at that desk there are a whole lot of spirits around you with their hands on you. Not only your children and your parents proud, but so are your ancestors. Mr. Chairman, thank you.
Thank you very much, Senator Booker. And Judge Jackson, there are a lot of politicians on this committee, 22 of them. There's only one Cory Booker. And when he does his cross-examination on the human side, I always wait to see, can the witness get through this without a little emotion? There was a little there, as there should have been, as he talked about your family and your parents and your children. Cory, you're one of a kind. We love you. We have 3 more to ask questions tonight. Senator Kennedy, Senator Padilla, Senator Blackburn. We're going to break for 20 minutes, grab a bite to eat, freshen up, come back for the last round.
Thank you.
Senate stands in recess.
And we have been watching the Senate hearings on whether to confirm Judge Ketanji Brown Jackson as Associate Justice on the Supreme Court. The committee is now taking a break for dinner that's expected to last about 30 minutes or so. Those breaks have been running longer than expected. But we're watching the hearing here at PBS. And also watching the hearing in the committee room is my colleague Lisa Desjardins. She has now made her way from the room out to a camera. Talk to us now. Lisa, I know we're going to get into some of those lines of questioning, some of the issues, some of the politics. I just want to extend that moment of sheer humanity at the end of the exchange between Senator Booker and Judge Jackson. I think we probably expected that, right? And knowing what Senator Booker's opening statements were, which were essentially just a reflection on the historic moment we are all witnessing right now and what it means. But just tell me a little bit about what it was like in the room.
Well, I think that probably everyone watching in the room or not in the room needed a dose of humor, which is what Cory Booker did right off the bat. And of course, Senator Booker is an effusive senator, emotional at times, emotional about this nomination, emotional about this judge, her family, how he sees her family reflecting his own family. So it was kind of the flip side of what we had seen for a few hours, where we had gone through some very sharp, difficult questioning, some tension in the room for sure. This was more positive, talking about history, an embrace of the nominee. But I will tell you that for all of that atmosphere that Senator Booker was trying to infuse in the room, bring it back into sort of a more positive place, especially for this nominee, there was only one Republican there listening. That was Senator John Kennedy of Louisiana. All the rest of the Republicans had left, including those who've led some of the sharpest charges against this nominee. So, I don't know if it's going to change how these senators interact with each other or with the nominee in their next round of questioning. But for the people in the room, it was some relief after a very tense few hours.
Lisa, it's now coming up on 8 o'clock here in the evening on the East Coast. Judge Jackson has been sitting there since 9 o'clock this morning. We have seen some really tense interactions, not just between the senators who are posing questions to her, but also between the senators themselves. Just coming back from this last break, there was a very tense moment between Chairman Durbin and several Republican members of the panel. Tell me about what that was about.
Right. When Senator Hawley had asked his questions, one of the charges he was raising against Judge Jackson was the idea that her sentencing on especially cases involving child pornography offenders was too low. that she essentially had given them far smaller sentences than prosecutors had recommended. But as we've been talking about, we know that the probationary office had recommended sentences either between the probationary office and prosecutors' recommendations, that for the vast majority of her cases, that Judge Jackson was actually in line with one of those two recommendations. However, I spoke to Senator Hawley, as we talked about. He said he wasn't aware of data that showed that that was in fact the case. Well, it turns out that the Democrats on the committee decided to provide that data. They put out a small sheet, I have a copy of it, listing her 14 cases, the recommendation by the U.S. Office of Probation for each case and where she stood. And in general, she was in line with those recommendations on all but, I believe, 2 cases on that list of 14. The issue was, Amna, the tension was that Republicans hadn't seen this data before. They were complaining, saying it was secret data, magical data. You heard those words from Senator Cruz. And, you know, and I have to say that I understand their frustration, because all of us want to know the details of what the case is for or against Judge Jackson. But this is something we've seen in the past on behalf of Republicans, where they had information about their nominees, say, for example, now Justice Kavanaugh, that they didn't initially share, or they didn't want public, for example, some of his back documentation from his time at the White House. So this is a part of the process, but it is something that both sides get very roiled and prickly about when they feel like one side is keeping information away from the other. And that was the back and forth. It was technically over documents, over process, but to me it really read as a sign of the tensions just completely lifting in the room, and how we were in danger of this hearing becoming so much more pointed and more of a real collision between the two parties. I think we've narrowly avoided that, at least for the moment.
I noticed, if I'm hearing correctly, I think it was Senator Booker, who never misses a chance to add some levity to the situation, who quickly interjected and said, well, I didn't get the document either until the last hour or so. I joined my colleagues in their protest. But I want to go over to Jeff Bennett now, who's been watching all of this unfold from the White House, and get your take on it. And Jeff, just very quickly, before we get into some of these issues Lisa was just talking about, that last exchange between Senator Booker and Judge Jackson was probably the most humanity-filled moment we have had all day. And it was a reminder, not just of the resume that she comes into these proceedings with, but the person behind them. There was a real effort to remind everyone that this is a human being with all the lived experience and detail that a Black woman in America would have and bring to that table. And I wanted to get you to reflect on that in terms of what it is you think Senator Booker was attempting to do, and also Judge Jackson's response in the moment. It is probably the most emotional we've seen her all day.
That's certainly the case. And I think what Senator Booker was trying to do was to add some depth and dimension to her story. He used a phrase that I think resonated with certain folks in ways that it might not resonate with others. And he said, "You've been sitting here with such dignity and grace as people have tried to sow doubt." And I caught what he meant. What he was suggesting was that here is Judge Jackson, a Black woman, having to deal with these allegations, some of them thinly veiled, racially charged allegations. And he plainly said to her, you know, when it comes to my family and my state, I trust you. I trust you. And she responded to that physically. So there were moments, there were certainly moments, I think, between the two of them that I think Judge Jackson, just looking at her reaction to it, I think cared a lot about and was probably grateful for. But his ability to sort of cast her story in sort of a generational struggle, but also a story of generational success, pointing to her mother and father seated there in the room, her brother, who was a Baltimore detective. It really is a quintessential American story of collective sacrifice, and that her parents, here she is 51, lucky enough to have her senior parents there with her, realizing that their child has basically fulfilled her potential, whether or not she's confirmed or not, to be seated there as part of a Supreme Court nomination process when she, at 17 years old, had identified wanting to be a judge as her life's goal. So I think it was an important moment. having really nothing to do with the confirmation process, but I think it was an important moment for her personally, to be sure.
I will tell you, I think every working parent out there in America felt it in their soul when she was talking about the balance and her children and that strain that so many people feel between wanting to be there and needing to do the job at hand. But there was, of course, very rigorous lines of questioning. And Jeff, I want to play for you just a quick piece of sound from Senator Hawley during his line of questioning. As we mentioned earlier, he focused really laser-like on questions about her sentencing decisions in previous cases involving sexual exploitation of children in video and images. And this is how Judge Jackson responded to one of those questions. Take a listen.
Thank you, Senator, for letting me address the concern that you've put forward based on the record that you've reviewed. As a judge who is a mom and has been tasked with the responsibility of actually reviewing the evidence that you would not describe in polite company, the evidence that you are pointing to, discussing, addressing in this context is evidence that I have seen in my role as a judge. And it is heinous, it is egregious. What a judge has to do is determine how to sentence defendants proportionately consistent with the elements that the statutes include, with the requirements that Congress has set forward. Unwarranted sentencing disparities is something that the Sentencing Commission has been focused on for a long time in regard to child pornography offenses. All of the offenses are horrible. All of the offenses are egregious. But the guidelines, as you pointed out, are being departed from even with respect to the government's recommendation. The government, in this case and in others, has asked for a sentence that is substantially less than the guideline penalty. And so what I was discussing was that phenomenon, that the guidelines in this area are not doing the work of differentiating defendants, as the government itself indicated in this very case. And so that's what I was talking about, but I want to assure you, Senator, that I take these cases very seriously.
Jeff, I will admit I have lost count. I'm not sure exactly how many senators prior to Hawley had asked her about these same issues, with the underlying allegation being that she has been too lenient in some of those sentencing decisions. But I'm curious what you're hearing from your sources at the White House. This was about, I should say, hour 10 or so of her answering questions. There's clearly a bristling there, but what are you hearing from White House sources about how Judge Jackson is managing this moment and the repeated questions about this issue?
Well, the White House makes clear that her response to so many of these questions is really the only response that she can give, that it's not her purview to set sentencing guidelines. That is the work of Congress. And that if there are issues about whether these sentences are too lenient, well, then it's for the Congress to revisit. And the chairman of this committee, Senator Durbin, said it early on. He said that there's been a lot of inaction around this, and you can imagine why. What politician wants to have in his or her record really anything having to do, especially in an election year, having to do with sentencing for matters having to do with child exploitation? That's not something that any politician, it's not something that anyone generally wants to talk a lot about. And so this is an area where not just Judge Jackson, but a host of judges across the country have had to deal with case by case what sentence is appropriate. And in the case of Judge Jackson, this is all out, of course, coming up in the context of a Supreme Court hearing where the questions that she's been asked to answer, in many cases have really nothing to do with her or her candidacy as a nominee, as a potential jurist on the high court, but rather the fact that we're in a midterm election year and there are members of the panel, both Democrat and Republican, who might have designs on higher office. And so all of that context and the sort of moment in which we're living and the partisanship, all of that is present in this moment.
John Yang, you have watched several of these proceedings before, and the context of this moment is absolutely important to how we're understanding and watching what's unfolding in that room today. But the broader context, I think, is also important. So when you look at some of these flare-ups, if you will, you saw tensions rise between Chairman Durbin and some of the Republican senators when we came back from the break this previous time. There have been some relatively sharp exchanges in some instances. Does this seem in any way different to you tonally from previous confirmation hearings, or is this sort of where we are these days?
I think, Anna, you say it. It's where we are, and also as Lisa talked about the divisions in this country. This is become the norm. We have no longer in a world or in a country that is going to confirm Supreme Court nominees by unanimous votes, as we did as recently as the presidency of Ronald Reagan. Speaking personally, it feels recent to me. I realize it's not that recent for a lot of folks, but I think that's where we are. It is become an opportunity for scoring political points, as Jeff has talked about. There are audiences beyond this hearing that these senators are speaking to. And, I want to go back to this point about Senator Cory Booker, lest our viewers think that he only did this very humanizing round of questioning because it's a nominee from his party. It's a nominee who is also black. That I can remember 2 years ago, a similar hour of the night when he questioned then Judge Amy Coney Barrett. And it was the same humanizing, engaging line of questioning. I don't remember the exact details of what he asked her about. What I remember is the body language. I mean, that hearing was very contentious because the Democrats were angry that there was a hearing in an election year when President Obama had been denied a hearing on Merrick Garland. So the Democrats were very, very hard on the Republicans. They were also very hard on her because of concerns about where the abortion jurisprudence was going. And so when the Democrats were asking questions, she was a little braced. She was a little, getting ready for an onslaught. But as Senator Booker drew this line of questioning, she leaned in, she was engaged, she was almost, dare I say it, enchanted by that line of questioning. So this is not just a partisan thing. As the chairman acknowledged, this is that humanizing line of questions is something that Senator Booker does quite routinely.
Senator Booker is who he is. Probably the only senator we're going to hear make a Brene Brown reference during a Supreme Court confirmation hearing. I will say that. But John, I do want to ask you about this other issue that Jeff mentioned as well, about the way Judge Jackson handled some of these difficult questions about previous decisions she made about sentences, which was to say, that's not in my lane. This does go to also directly the line of questioning she took from Senator Cotton, who repeatedly asked her about whether or not certain sentences were appropriate for different crimes that he basically listed and ticked through. Talk to me a little bit about that part of the argument and why she stuck very closely to, I think, what has to be probably the only thing she could answer in this moment about staying in her lane. Why is that crucial for her in consideration of this role?
Well, it's always a tricky thing. It's in Marcia Coyle's book about Chief Justice John Roberts. When he was a White House lawyer, he was the Sherpa for Sandra Day O'Connor, and his advice to her was say nothing specific when it comes to things before the court, but show a mastery of the subject. And I think that Judge Jackson has been doing that all day long. But she's right. This is the question, as Senator Cotton repeatedly asked, is are these sentences long enough? Well, that's not up to her. That's not up to her as a judge. That's not the judge's decision. These sentences are set by Congress. these are things that that Senator Cotton has within his power, and Senator Cotton's colleagues have within their power. She can't talk about a lot of these things because these are things that are going to be involved in cases that will come before her, not just beginning in the fall if she's confirmed, but she's only 51 years old. She's going to be on this court for a very long time, or she could be on the court for a very long time. And she does not want to be seen or have in the record anything that would question her impartiality when it comes to an issue, question her whether she's made up her mind about an issue ahead of time. And so that's why she's walking this very fine line and answering the questions as fully and as completely as she can. But in a lot of these questions, as she said again and again, it's up to Congress.
I want to bring in the perspective now of two folks who've been watching these hearings unfold from very different perspectives outside of my colleagues and I here at the NewsHour. I'm joined now by Dana Bowen Matthew. She is the Dean of the George Washington University School of Law. And also joining us is Kurt Levy. He's the president of the Committee for Justice. That's a nonprofit that advocates for conservative judicial appointments. Welcome to you both, and thank you so much for being with us at this late hour. Dean Matthew, I do want to start with you, and just to start with a sort of broad takeaway, because it has been a historic first day that's not over yet. We still have a few more senators that have their turn asking questions of Judge Jackson. But as you're watching this unfold, I'm wondering what's striking you, what you're taking away from the questions so far and from Judge Jackson herself.
Well, certainly the historicity of it is a striking impression that I walk away with. But the other thing that I am really impressed by is no matter what area of the law the judge is talking about, she's been consistent on two messages. She said, one, I have a methodology, and two, I do not have an ideology. And so she's told us, whether it's antitrust or First Amendment or Second Amendment or Fourth Amendment cases, whether it's the right to vote or what constitutional provision she is looking at, it's always the same. And you heard those phrases over and over again. My methodology is that I operate with constraint and restraint. My ideology is that I have none. I do not get out of my lane, she said. I do not accept the invitation to decide issues of policy or to insert my personal view. So this decision that she has made to display for all to see exactly how she will exercise her judicial authority has been consistent throughout the day.
Kurt Levy, what about you? As you're watching this unfold, as Dean Matthew noted, we've seen extraordinary message discipline from Judge Jackson, but also, we should note, from Republican senators in their lines of questioning. I'm curious what sticks out to you right now.
Well, let me talk about the out of her lane issue. I certainly hope that that is her judicial philosophy, but there's a reason why groups on the left virtually demanded that she be chosen from the initial pool of candidates for this slot and from the short list of three. There were a couple of other people who probably would have been better at persuading conservatives on the court, who had maybe better writing ability. But the one thing that she had going for her, she really was the darling of groups on the left. And these are groups on the left that demand a progressive judicial philosophy, basically a living constitution philosophy. And, we suspect that, that's what she believes in too. I mean, there are signs of it, maybe not conclusive, but signs of it in her record. She did sort of go out of her way to rule against the Trump administration on several occasions. She was asked by Republican senators about substantive due process, which is, basically a form of judges creating new rights that conservatives don't really approve of, and she didn't disown that. So I'm willing to keep an open mind, but, my guess is the groups on the left favored her for a reason.
So I'm willing to go into the weeds with both of you on this because you understand these issues in a way that certainly I don't, many of our viewers may not. Dean Matthew, Kurt Levy raised the issue of substantive due process. Walk us through a little bit. This was something Senator Cornyn really got into the weeds with Judge Jackson about. What was that line of questioning intending to reveal? And what did you make of the way Judge Jackson answered it in terms of revealing anything of her judicial philosophy?
Well, substantive due process is a judicial doctrine about which there is quite a good deal of controversy. It emanates from the 14th Amendment's Due Process Clause and essentially says that if a right is implied in the Constitution and there is a historical reason for it to be recognized, even though if it's not enumerated, it can be recognized as a fundamental right. So the conversation really was about trying to get the judge to accept an invitation, which she declined, and she declined it handily, to suggest she would make up rights out of whole cloth. Whenever she was asked, is something a fundamental right? Voting rights. She would answer, it is, if the Supreme Court has said so. Whenever she was asked whether the substantive due process doctrine would recognize a fundamental right, for example, in the right to bear and keep arms, she said, indeed, see U.S. District of Columbia versus Heller. The Supreme Court has said it. So she relied on precedent. It is clear to me, therefore, that she was not willing to be sucked into a conversation that would have implied that she would make up things based on her own predilections, our own personal views. Instead, she said, I will follow precedent, text, and the statute.
Kurt Levy, if I can ask about some of the questions we have been hearing and your take on them, because there has been an almost relentless focus among Republicans on issues related to crime. And I'm curious what you think the intent of those questions is, what they're meant to reveal about her judicial temperament or philosophy, and how you think those questions are going over. Oh, I apologize. I believe we lost the connection with Kurt Levy. We'll try to get him back into the conversation in just a moment. But Dean Matthew, let me turn to you on this and ask it slightly differently, which is to say, as Republicans have been questioning her about previous decisions she made on sentencing as a judge, I think many are looking at that and saying, well, these are Republicans maybe messaging for a certain audience. But for someone who's meant to be going through a rigorous vetting for this incredibly important job, aren't those fair lines of questioning for senators to be putting to her right now?
It is fair to ask questions about her judicial records, certainly. She's been a judge for nearly 10 years and written 570 opinions, very few of which, I believe 12, have been reversed. So questioning her on her judicial record is exactly fair game. And she has, I think, handled this under a great deal of pressure, but a great deal of grace, no notes, no emotionalism, recall of the law on various subjects, as I say, from antitrust to the Fourth Amendment, to the First Amendment, to the Second Amendment. She is facile in knowing the law, and she is committed to the judicial, I will say, methodology, because that's her word, of deciding the cases immediately before her. So asking her to explain those, yes, I would agree, Amna, that is fair game.
Kurt, I believe, is back with us now. And Kurt, I'm not sure if you heard my question previously. I'll repeat it in shorter form now. I was basically asking for your take on the Republicans' focus on issues related to crime. Please.
You know, they may be a little too focused on it for my taste, but I understand their concern. She is going to be liberal when it comes to criminal defendants and sentencing in particular. She was a public defender. The people who go into that profession, a noble profession, tend to be liberal. And again, she was appointed by a liberal president at the demand of liberal groups. So it's a legitimate concern. I wouldn't focus on it as much. I wish that the White House had released the Sentencing Commission records. I suspect there's a reason they didn't want it released. But I do want to push back about a couple of things. I believe his name was Jeff, said that the whole discussion of crime was racially charged. And I didn't really see that. I grant you there are some issues in sentencing that are like crack versus cocaine, but child pornography, God, I've never really thought of that as a racially charged issue. I would think when people worry about child pornography, they really don't care about the color of the person. So that I don't get. And also, there were a couple of comments about that she recognized that it's up to Congress, not her. But there were cases where she consistently undercut what Congress had wanted in terms of sentencing. Again, I don't think that disqualifies her, but let's call it what it is. She is liberal on crime.
Kurt, I believe you were referring to the analysis of my colleague Jeff Bennett, who is our chief Washington correspondent. Allow me to bring him into the conversation here now.
Sure.
Jeff, you heard what Kurt Levy just had to say. If you'd like to respond.
Yeah, and I'm sorry if he misunderstood my point. What I was saying was that when Senator Booker talked about attacks on Judge Jackson as an effort to sow doubt, what I believe he was pointing to, and I think having spoken to many of Judge Jackson's supporters and people on her Sherpa team, they point to what they view as a pattern of Republicans the day after she was announced as President Biden's nominee, suggesting that her elevation was in many ways an avatar for affirmative action. Fast forward to just today, when the RNC, the GOP, the official campaign arm of the Republican Party, put out a tweet with a picture of Judge Jackson's face, her initials crossed out, replaced with the acronym CRT for critical race theory, to suggest that this woman who has nothing to do with critical race theory and has nothing to do with it in the work of her her work as a jurist would in some way be linked to that. Well, certainly there is a racial aspect to that I think Senator Booker was referring to.
Kurt, what about this issue? It was discussed earlier. I'd like to get your take. Prior to the hearings beginning, we did hear messages from Republicans about the decision by President Biden to commit to nominating a black woman to the court as a form of affirmative action. We haven't heard that since. Do you think that those were misplaced words?
I do have a problem. I don't think it matters what you call it, and she's certainly qualified, but I think they did have a problem with him limiting his pick to about 3% of the legal profession in a relatively arbitrary way. You know, there's never been an Asian on the court, an Indian on the court, a Native American on the court, a male Hispanic. It seemed very political, that there was a particular interest group that he was appealing to. Certainly not illegal. Nobody's ever said that, the president doesn't have full discretion in who he chooses. And to be clear, though, to the extent that that's a problem, it's Biden's problem. It's not her fault. And I think that's why you don't hear it raised. She is qualified to be in the court. I think that, evidence was cited that she was sympathetic to critical race theory. Again, I think it's probably true, but she's not a CRT activist. It's not something that I'm particularly worried about.
I want to talk a little bit about where these messages are all going, and that is out into a public that I think it's fair to say, given the historic nature of these hearings, is paying very close attention to. There's a piece of sound I would love to play from Senator Amy Klobuchar, and she was talking to Judge Jackson about a concern that we've heard both Republicans and Democrats raise and have concerns about, and that is the issue of the public's trust in the Supreme Court. This is that exchange from earlier today.
And I think one of the things your nomination presents is an opportunity to address a decline in the public's confidence in our court. Increasingly many, if you see public opinion polls, see the court as over-politicized or out of touch. At the same time, we've seen an alarming rise in threats targeting members of our judiciary for just doing their jobs. How do you think we can work to maintain the public's confidence in the court? What do you see your role in that?
Thank you, Senator. Public confidence in the court is crucial. As has been said here earlier, the court doesn't have anything else, that is the key to our legitimacy in our democratic system. And I am honored to accept the president's nomination in part because I know it means so much to so many people. It means a lot to me. I am here standing on the shoulders of generations of Americans who never had anything close to this kind of opportunity. From my grandparents, who had just a grade school education, but instilled in my parents the importance of learning. And my parents, who I've mentioned here many times already, who were the first in their families to get to go to college. So this nomination, against that backdrop, is significant to a lot of people. And I hope that it will bring confidence. It will help inspire people to understand that our courts are like them, that our judges are like them, doing the work, being a part of our government. I think it's very important.
Dean Matthew, let's talk a little bit about the public's view of the Supreme Court, to which Judge Jackson is nominated. Even before Justice Breyer announced his retirement, public view of the Supreme Court had already been falling. I think there's now a 54% favorable rating among the public, according to Pew, of the court. Over the last 3 years, though, that favorable rating has seen a 15 percentage point drop. That is the context in which these hearings are unfolding. So talk to me a little bit about how you think Americans are watching this and what they're taking away from these proceedings.
I think one of the most important things for Americans to take away, quite honestly, is that by this nomination and confirmation, we as a nation will have taken a giant step towards a more perfect union. We will have walked in the direction of what our constitutional preamble promises, and that has been denied for so long. Kurt was talking earlier about affirmative action as an inappropriate way to nominate to the court. Well, surprisingly, no one complained for the first 200 years of the court, when the only people that were considered for the court were white and male. Suddenly, we're concerned about making sure that everyone is considered now that we're taking this giant step towards a more perfect union, and including a group of people that have been excluded for the first 115 Supreme Court judges that have been nominated. I find that something that will increase the trust of the country in this court and its legitimacy. And let me also add that the question of Supreme Court legitimacy is not new. As early as when Chief Justice Marshall concerned himself with whether or not the Supreme Court's decision would or would not be followed in cases like Marbury versus Madison, the court has to concern itself with whether or not its methodology and its processes are in fact trustworthy. And until now, they cannot be said to have been, at least with respect to those of us who are African American women in the United States of America.
Kurt Levy, what about that point? We heard Judge Jackson make herself that seeing someone like her on the court, having a court that is better representative of the American public, that adds credibility. That could, in fact, turn around some of these very disappointing numbers in terms of public opinion and favorability when it comes to the Supreme Court. How do you see that?
I don't know if she adds to credibility. She certainly adds to at least one type of diversity. I mean, I was sort of rooting for someone, even though I was a classmate of hers at Harvard, I was sort of rooting for someone who didn't go to Harvard and Yale, because the Supreme Court is so elitist in that sense. And one of the people on the short list, Judge Childs, had a much more modest background, would have been a more moderate pick. It's interesting about the talk about credibility. I've seen polls go up and down, so I'm not sure there's a long-term trend here, but it seems like people talking about credibility now that there's a more conservative Supreme Court. We had decades of the Warren and Burger Court, making up new rights and otherwise being very creative with the Constitution. And nobody said that was a credibility problem. It's only a credibility problem now when a narrow 5-4, maybe 6-3 if you stretch it for Roberts, majority is trying to roll a little bit of that back. Now there's a credibility problem. Look, I was on the Biden's I'm sorry, I was not on. I testified before Biden's Supreme Court Commission, and I was one of the few conservatives that was open to reform. I even said to my fellow conservatives, this is one of the rare times in history where both conservatives and progressives seem to agree that the court has too much power. Maybe this would be a good time for us to get together and institute some reforms to scale back its power a little bit. So, I'm all for looking at reform, but to say that the Supreme Court is suffering a legitimacy crisis, I don't really buy that.
Just a reminder to folks joining us for this special coverage, we're in a dinner break as the Senate Judiciary Committee takes a little bit of a breather from that room, as does Judge Ketanji Brown Jackson. You see folks beginning to file back into the room there, a few senators taking their seats, including the chairman, Dick Durbin, right there. And of course, we'll keep an eye on it as soon as the hearing comes back into session. We'll go back to the room for those final rounds of questions from, I believe, 3 more senators this evening. Lisa Desjardins is out at a camera on Capitol Hill. She will run back into that room as soon as the hearing begins, I know. But Lisa, you've been talking to your sources on the Hill. I'm curious if lawmakers have been sharing their takeaways about how the proceedings have been going, especially in these late hours.
Oh, yes. Lawmakers have many takes on these hearings, that's for sure. One thing that we're hearing from Republicans is that they feel like they did receive one gift unexpectedly from Judge Jackson when she said in response to Senator Cotton, his questioning about sentencing of a drug kingpin responsible for fentanyl, drug selling and possession. And she did say, he said, did you talk to the victims' families? She said there was no victim in that crime. Then she came back very quickly and clarified there was no identifiable victim. But just that small soundbite before she very quickly clarified it is something that Republicans are talking a lot about, something you see on Twitter. They're trying to portray that as though she didn't understand the gravity of the sentencing of this drug kingpin. Of course, her answer to that was no, she completely understood the gravity. And in fact, that was probably one of her longest answers of the day. She very carefully walked everyone through precisely why she made that decision. She had a very clear memory about it. The other thing I hear from Republicans is they believe some of her answers, not the majority, just a few select answers, have not been complete. I think they point, for example, to some of her first answers regarding those child porn offender cases. We know later that she did tell Senator Booker that she didn't remember the details of those cases. That may be why we sort of heard very more general answers when she was asked about those cases specifically, but that's something Republicans have noticed.
Well, we see Judge Jackson returning to the room now, going over to greet some of her guests in the seats behind her, taking her seat. 3 more senators' questions ahead. We're going live now, back to the hearing room.
Will resume, and the questioning is to Senator John Kennedy of Louisiana.
Thank you, Mr. Chairman. Judge, I have enjoyed listening to you today. I find you to be very intelligent and very articulate. I'm still a little uncertain about how you think, how you approach cases, deciding cases, and we'll talk about that in a moment. I'm not going to ask you, nor should I, how would you would decide a case. And I'm not going to ask you, nor should I, to tell me whether you think a particular precedent is a good precedent or not. So, but I am going to talk to you about the law. But first, you don't support efforts to delegitimize the United States Supreme Court, do you?
Senator, I have nothing but esteem for the United States Supreme Court, for my hopefully future colleagues on the court, and the work that the court does.
Can we agree that the calls to pack the court delegitimize the court?
Senator, It would not be appropriate for me, in my view, to comment on calls to pack the court, as you say, to increase the number, to do any structural changes. Those are policy determinations for Congress. What the consequences of those are policy considerations for Congress. I'm just looking forward to working with the brilliant people who are there at whatever size Congress decides if I'm confirmed.
Well, the calls to pack the court don't legitimize the court, do they?
Well, Senator, I think that would be for you to decide.
I'm asking your opinion.
Respectfully, Senator, I'm not in a position to give my opinion on issues that are policy issues concerning the court and not something that a judge would have to consider or should consider in my view.
Yeah, but you're a citizen.
Oh, I am.
And as best I can tell, a very good one. I don't understand why you won't weigh in on this issue. Tell me why you won't weigh in on this issue.
Senator, I feel so strongly about ensuring that judges remain out of political debates. And this is something that is being debated. It is something that other nominees, Justice Barrett was asked about the same sort of thing and also declined to give her opinion. And I think that was the right way to handle this particular issue.
So you think Judge Barrett was right to dodge the question?
I think that each judge has to make a determination when asked about whether they would like to speak to issues, and I know that I'm not comfortable, in part because I'm so committed to making sure that there's confidence in me in terms of public confidence and my ability to stay in my lane, my ability to not speak to contentious political issues.
You have an opinion, though, don't you?
Senator, any opinion that I would have is not something that would ever come up in my work as a judge, something that I would ever rely on. This is a political issue for Congress.
But do you have an opinion, Judge?
Not a strongly held opinion, actually.
But you have an opinion.
I haven't really thought about it, but I hear the arguments on both sides, and I understand it to be a political issue.
Now, Judge, you're very intelligent and you're very articulate, and I know you're very well informed. You're telling me you don't have an opinion about packing the United States Supreme Court.
Senator, I have opinions about a lot of things. I don't have an opinion that I think it appropriate to share. I work very hard to set aside my opinions when I'm thinking about cases, which is the work of a judge. And so this particular issue is one that is very contentious, as you say, one that's in the province of Congress, and one that I think it not appropriate for me to comment on.
I understand that. But I think it would tell us a lot about you if you would answer the question. I'm a little confused about your answer earlier. It's probably more my fault than yours. Do you have an opinion about whether these efforts to pack the United States Supreme Court delegitimize the court? Do you have an opinion?
Senator, I have an opinion about the efforts. It's not an opinion that I think is appropriate for me to share. And so therefore, I don't have anything further to add.
So you do have an opinion, but you don't want to share it? Is that?
I don't think it's appropriate for me as a nominee to comment on a political matter that is in the province of Congress.
Well, in deciding to join the United States Supreme Court, if you're affirmed, wouldn't it make a difference to you whether you're one of 9 or one of 28?
Would it make a difference?
That impacts the judiciary? That involves the judiciary?
Senator, it certainly involves the judiciary. I would be thrilled to be one of however many Congress thought it appropriate to put on the court.
Okay. So you'd be okay if it was 28?
If that's Congress's determination, yes. The Congress makes political decisions like that.
Okay. A couple of my colleagues ask you about the Supreme Court overturning precedent. Now, it doesn't happen every other Thursday, but it's not what's the word I'm searching for, Judge? It's not extraordinary that the Supreme Court overturns precedent, is it? I mean, it happens. I won't say a lot, but it's not once every 50 years. Am I correct?
You're correct that it's more frequent than once every 50 years, for sure. Yes.
And so it happens.
Yes.
And you talked earlier briefly about the different factors that the court considers
Yes.
in deciding. Give me a couple of those. Hit that another lick for me and just give me a couple.
Whether the decision is egregiously wrong, whether there's been reliance on the decision that is being revisited, whether the decision is workable or unworkable, the one that they're looking at, whether the facts are, new facts have come to light, or the facts have, the circumstances are such that there's now a new understanding of the prior facts, and whether the case law in the area has shifted.
And in fact, those are the factors that the Supreme Court listed 3 years ago in Janus, are they not?
Those are the factors. I don't have the Janus opinion in front of me, but those are the factors that the court uses when it determines.
Janus overruled, I think Senator Hirono talked about it. Janus overruled Abood.
Yes.
Dealing with whether labor unions can require non-members to pay dues. Remember that case?
Yes.
Is the age of the case a factor in whether the Supreme Court will overrule a precedent?
I think age relates to the reliance factor. I think the longer an opinion has been in effect, the court has considered that to be relevant to its determination of reliance.
But sometimes the court looks at it not just in terms of reliance, they look at it from the other side of the age issue, and that is that maybe facts and circumstances and science have changed. Do they not?
I believe that is part of the changed circumstances factor.
So the Supreme Court is more likely to overturn a case, which would not be that extraordinary, if the precedent were 49 years old as opposed to 4.9 years old.
I'm sorry. Can you repeat the question? I'm just.
Well, you said that the older the case is, one could make an argument that the reliance interest would be great. But you also said, I think, I don't mean to put words in your mouth, but the older the case is, the more facts and circumstances and science could have changed. So that would argue in favor of overruling it because of a change of circumstances. Did I get?
It might. These are all different circumstances that the court could consider under this multi-factor test.
Okay. But all things being equal, let's say decision's 49 years old versus 3 years old, like Janus. The older decision is more likely to be overturned, you think, based on your experience?
Oh, I don't know that I could make that prediction. I'm just saying that one of the factors, the reliance factor, the age of the opinion and how long people have been relying on it
Yes, ma'am.
can be relevant to, it is one of the factors that the court considers.
Right, okay. Let me jump gears here. I took some notes. You talked earlier about how you decide cases. I'm going to kind of summarize this. You said you clear your mind of any bias. You read everything. You read the briefs and the record, and then you apply the law. That's your methodology. You said you're not an activist judge. You said, am I right?
Yes,
You said judges are not politicians,
that is true.
and judges should stay in their lane.
Yes, sir.
Tell me again what you mean by stay in your lane.
What I mean is that in our system of government, under the Constitution, we have a separation of powers, and each branch has their own sphere of responsibility. To say stay in your lane is the shorthand that I'm using for indicating that judges should not be policymakers, that those responsibilities are left to the elected branches, and that judges are to interpret the law, not make the law. And I use it to refer to the part of my methodology that is mindful of the constraints on judicial authority.
Okay. Well put. So let me ask you. We can go to the Constitution, let's say the Bill of Rights, to narrow the discussion, and read about our explicit rights. Religious freedom, our right not to be unreasonably searched or seized, freedom of speech, they're right there. That's why they call them explicit. But the court has ruled we have a bunch of unenumerated rights. Am I correct?
The court has determined there are certain personal rights related to individual autonomy that are implicit in the concept of ordered liberty or deeply rooted in our nation's history or tradition.
But they're unenumerated.
Yes.
Okay. Should these unenumerated rights that only Supreme Court justices can see, should they be decided by the people through their elected representatives or by the unelected federal judiciary?
Well, Senator, the Supreme Court has interpreted the 14th Amendment to have a substantive component, and I'm not in a position to critique the court in terms of its precedents. That is the precedent of the Supreme Court.
Right, right. Well, let me ask you this. What is a fundamental right?
The court has interpreted the 14th Amendment's due process clause to include a substantive component and not just a procedural component, meaning the 14th Amendment guarantees due process, and the court has interpreted it to mean that with respect to certain rights, individual rights concerning intimacy, certain things like the right to contraception, the right to child rearing. There was a case of the Supreme Court that talked about making decisions for children in terms of visitation with respect to conflicts with grandparents, marriage.
Right. I'm with you.
These sorts of rights, the court has found, are implicit in ordered liberty, as I said, or deeply rooted in our nation's history and tradition.
The right to assisted suicide, is that one of those enumerated or unenumerated rights?
I believe the court found that it was not.
Which body do you think is better able to make that decision, the Congress or the federal judiciary?
Well, Senator, the Supreme Court has interpreted the Constitution, and the Supreme Court has the authority under our constitutional system to interpret the law.
Right.
And they've made the determination that the Constitution includes those unenumerated rights.
Yeah, but here's the thing, Judge. Maybe a better example, it's a very hot topic today, the right of a transgender woman to compete in women's sports. Do you think Congress, the people ought to get to decide that through Congress, or the judge can just find it as an unenumerated right, a penumbra of the Constitution?
Well, Senator, that the topic that you raised is something that is, as you say, a hot topic today and could certainly be litigated. So I'm not in a position to say more about whether or not it's actually one of the unenumerated rights.
Well, I don't want to ask you how you'd rule, but would you have any problem saying, okay, if that case that is litigated, saying this is a political question? Whoa, stop. I'm staying in my lane. Congress needs to decide this case. The people need to decide that through their elected representatives. Would that be appropriate?
Well, respectfully, Senator, that is a decision. In other words, you say, I'm not asking you to decide it, but in every case, the determination about whether or not something is a political question or whether or not the court has or has not jurisdiction is an issue for judges, and so I'm not able to speak to it.
Okay. All right, well, here's the thing about the fundamental rights. That's why I asked you about the definition of them. These are unenumerated rights now. I'm not talking about right to free speech and freedom of religion. The court has said repeatedly that there is no test for a unenumerated fundamental right, that the determination has not been reduced to a formula. Am I right?
Well, they've given those standards in the cases in which they have been evaluated.
In some cases. Sometimes the court talks about these unenumerated fundamental rights have to be deeply rooted in the nation's history and traditions. Sometimes the court says, they change the language, these unenumerated rights, like the right to assisted suicide we talked about, it's a potential unenumerated right. The right has to be implicit in the concept of ordered liberty. But you've read Obergefell. In Obergefell, I think Justice Kennedy wrote that opinion. He didn't bite. In fact, he cited with approval Justice Harlan's dissent in Poe v. Ullman. And Justice Harlan said, look, there's no formula here. Justice Harlan always said, you have to go case by case. Can you understand why some Americans go, wait a minute, are justices, these are unenumerated rights, are justices interpreting the Constitution, or are they just deciding a right when they get 5 votes and it's just a moral conviction?
Yes, Senator, I do understand.
Okay. Well, when you talk about judicial restraint, where does the restraint start with fundamental right? Let's take the 9th Amendment, okay? What's it say? I know you know because you talked about it earlier.
Well, it says that it indicates that there are rights that, the fact that there are some enumerated rights in the Constitution doesn't mean that there aren't others.
And how are we supposed to determine what others there are?
I think the Supreme Court has not found any others coming from that particular constitutional provision.
Could they?
I can't speak to that, Senator.
I mean, it's possible, right? If they get 5 votes, right?
Well, anytime the Supreme Court has 5 votes, then they have a majority for whatever opinion they determine.
Yeah. But do you think that would be a prudent course of action to start creating fundamental rights through the Ninth Amendment, unenumerated now, without consulting Congress?
Senator, I can't speak to a hypothetical about whether or not it would be a prudent course of action for the Supreme Court to hold that there were other rights in the Ninth Amendment. That's
Well, the reason I'm asking, Judge, is you've talked a lot today about judicial restraint. And that's kind of like being for children and prosperity. We're all for children and prosperity and judicial restraint. But the rubber meets the road when you get down to, well, what does that mean? What does that mean?
what it's meant for me, Senator, is what you've seen in my opinions in the way that I've approached issues that have been before me, in my fidelity to the restraints that exist in the law in terms of the exercise of judicial authority. That adherence to precedent, for example, is something that I do, and even in cases, as you heard me discuss earlier, in which they're not binding precedents, I find that the court needs to take into consideration what has previously been determined and not be a policymaker in my decisions.
Okay. Well, here's what's bothering me is too strong of a word. Sounds pejorative. Here's what I'm uncertain about. And please don't take this the wrong way. How do we know? I'm not saying you would do it, but how do we know that, since I can't seem to flesh out this judicial restraint and the limits of it for you, how do we know that if you get on the court, you won't say, well, you know, Congress can't get anything done, and there are all these issues that we need to address. And so I think the United States Supreme Court ought to create all these rights through the Ninth Amendment. What would you say to that if somebody made that allegation?
Well, Senator, I think that I have a record as a judge in terms of having been given responsibility, having looked at cases, having decided issues, and that my record demonstrates how I handle cases. I'm not in a position to hypothesize a circumstance in which a case appeared that raised a question about the recognition of an unenumerated right and whether I would say under those circumstances that I couldn't find such a right because that's a hypothetical, because I decide cases and controversies that come before me, because I'm a nominee and I can't speak to hypothetical scenarios about how I might rule in the future with respect to cases.
Boy, the time goes fast. Let me ask you one other question.
Yes.
This business of having unenumerated rights through substantive due process, there's no textual basis for that. The court just started doing it, okay? I'm not asking you whether you think it was good or bad, because it's clear to me you don't want to share your thoughts on that, and I get it. I'd feel better if you would, but I get it. But don't you think the fact that our founders included a way to amend the Constitution is a testament to the fact that they were saying, here are your rights, we're writing them down. You can all go to the Bill of Rights and read them. And if you want more, we put in a way to amend the Constitution.
I do understand that argument, and there are people who argue that. The Supreme Court has determined that the due process clause
Yes, ma'am.
includes a substantive component.
Okay.
And I understand the critiques of that view.
I'm gonna try to get in two more. Boy, the time flies. When does life begin, in your opinion?
Senator, I don't know.
Ma'am?
I don't know.
Do you have a
don't-
belief?
I have personal, religious, and otherwise beliefs that have nothing to do with the law in terms of when life begins.
Do you have a personal belief, though, about when life begins?
I have a religious view
Religious belief?
that I set aside when I am ruling on cases.
Okay. When does equal protection of the laws attach to a human being?
Well, Senator, I believe that the Supreme Court, actually, I actually don't know the answer to that question. I'm sorry. I don't.
Okay. All right. You're familiar with the warrant requirement, I know.
Yes.
Okay. What if Louisiana said, we don't want to follow the warrant requirement? Would that be legal?
Are you positing a statute of Louisiana that we're not following, or individual law?
Yeah, it's called a statute.
Well, Senator, I'm thinking about all of the potential legal arguments that could be made. I can't answer the hypothetical about whether or not it would be lawful or unlawful.
Can you think of an instance where a state could say, we're not going to follow the warrant requirement. We're going to write our own warrant requirement?
I've never heard of that happening.
Yeah. What if Article 1, Section 5 of the Louisiana Constitution is our state unreasonable searches and seizures? Couldn't we say, we're not going to follow the federal interpretation? We're going to make it stricter under the state constitution.
Well, the state can also.
And in fact, under the state constitution, we're going to say a warrant is required in every instance. Don't give me this stuff about plain view and hot pursuit. You search somebody, you better go stop and get a warrant. Now, I'm not saying Louisiana would do that, you understand? And I'm not saying they should or shouldn't. They can do that, can't they, under their own state constitution?
They can provide more protection than the federal government, yes.
Well, how can they get away with that under the supremacy clause? You got to go fast because Durbin's about to cut me off.
Yes, I'm sorry. How can they get away with providing more protections for people?
Yeah, under the supremacy clause.
Because it would depend on whether or not it conflicted with federal law. It doesn't conflict, I think, if the state provides more protection.
We call that the adequate and independent state ground doctrine, right?
Yes.
Okay. All right, I'm over, but only about 22 seconds. So I'm going to land this plane, and we'll take off again tomorrow.
Thank you.
Thank you.
Thanks, Senator Kennedy. Senator Padilla.
Thank you, Mr. Chairman. Judge Jackson,
Good evening,
how you
Senator.
doing?
I'm good.
It's been a
Thank
long
you.
day.
It has. Thank you for spending it with me. I understand it's your birthday.
Yes, so I'll cut to the chase on my first question. Now, and look, I've been reading up a lot about you since the nomination. I've studied your record. We've had an opportunity to meet in my office, spent some time there, and I've been listening pretty closely to today's hearings. And my first question may be the highest stakes. What would you say to a member of this committee who is sitting here like you for about 12 hours now on his or her birthday?
I would say happy birthday and
Great
thank
answer.
you.
We're off to a great start here. I actually only asked that question half jokingly because I was moved by your opening statement yesterday as well, especially moved by my colleague, Reverend Booker here, a little while ago when he uplifted your commentary about the struggle you clearly feel and that I share about being a working parent. And I couldn't help but think to myself how I've had to grow, and Angela and I remind each other of this pretty regularly, try to give good advice to our children. We're trying to raise 3 gentlemen, not trying to raise 3 boys, we're trying to raise 3 gentlemen. And it's not always perfect, but we give them the advice of just, try your best to be your best, right? We're not expecting perfection. And sometimes parents need to remind themselves of that too. Can't expect perfection. We just got to try our best to be our best. It's also, dawned on me that we've been here for more than 12 hours, and there's a very fundamental question that hasn't been asked. You've given thoughtful answers throughout the day, but fundamentally what this hearing is today, it's a job interview. It's a very public and very thorough job interview, as it should be. If you're confirmed, you could potentially serve on the Supreme Court for decades, helping shape the direction of American law and American life in profound and lasting ways. So it's appropriate that over the course of this interview, you should be asked some in-depth questions about your background, about your experiences, and your approach to the law. But before I get to some of those questions that I have, the first question I have for you is, so why would you want this job? And now with the added flavor of, why would you want this job? You have a great one now while we're thinking on a daily basis how we try to find that right balance that is often elusive between work and family and other obligations.
Thank you, Senator. I've spoken many times about the fact that I came to love the law starting as early as 4 years old, watching my dad study when he went back to law school when I was a child. And I honestly never thought that there was anything else that one could really do because I was so enamored of my father and so proud of his decision to follow his dream after I was born. And so if you're a lawyer and if you believe in public service, which was a core family value for my family, then becoming a judge is certainly an option that one pursues. And then, of course, being on the Supreme Court is the capstone of a life in public service. And I would just be so honored to have the opportunity to use my time and talents in this way.
So, thank you. Thank you for that. And now to some of the more specific questions. Now, as I mentioned, I've been listening closely throughout the day. Your knowledge of the law, your even temperament, your charm, and clearly your endurance is impressive. They all shine through. But I acknowledge that at times this hearing has been a little frustrating. Not because of your answers, but I actually point to the process itself. There's probably a whole lot of questions that everybody watching would really love to hear answers to, but they're questions that you can't directly answer. Questions like a woman's right to choose, questions like the Second Amendment, questions like expanding the Supreme Court. Now, to be clear, this is not a criticism of you. Let me explain. When you're asked a question that comes close to asking your views on a pending case or on an issue that may come before you, you've declined to answer as to not prejudge the issue. And I'll remind the committee, I believe that's been the approach taken by every Supreme Court nominee for the last 3 decades. So for the benefit of the people watching at home, can you explain why you and other judicial nominees have followed this approach? Why is it important?
Yes, thank you, Senator. The approach is consistent with the requirement of judicial independence, with the duty to have and keep an open mind when you are considering cases. Judges, unlike policymakers, are not supposed to be forming opinions in, as my mother would say, in the ether, right? Judges are supposed to be waiting until a dispute is presented that they can hear in the context of the case, and then with an open mind, receiving the arguments that are made in the context of that case, applying the law and making a decision. The concern is that if you are engaged in a public forum like this and you start talking about issues that are being litigated in the courts, the concern is that it will erode public confidence in your ability to be open-minded, hear and consider only the facts and circumstances in the cases that are presented. People might think that you are ruling based on conversations that you had with Senator Kennedy or discussions that I have with you. And so judges tend to not speak publicly about issues that are being litigated, and especially judges who are being considered for the Supreme Court, because at the end of the day, a lot of these issues will come before that forum, and you want people to know that you have an open mind, that you haven't prejudged any issue, and that you are waiting and staying in your appropriate constitutional lane.
Great. Confidence in the judiciary and the justice system. Clearly important. I think I'll be coming back to that in a minute, but maybe as a segue, I want to raise the similar concern about confidence in the electoral process and discuss for a minute democracy and voting rights. Now, I approach this conversation not as a lawyer, but as a former elections official. For 6 years, I served as California's chief elections officer. And my objective during that time was to, yes, ensure that our elections were safe and secure, but also to help facilitate the participation of as many eligible Californians as possible, as we are guided by, or as we're guided to do by the National Voter Registration Act. And frankly, I relished in that responsibility because I believe in the right of every eligible voter to be able to register to vote, cast their ballot, have their voice heard in our democracy. So you can appreciate my outrage when I've watched the Supreme Court play a role in dismantling one of the crowning achievements of our democracy, the Federal Voting Rights Act of 1965. Over the course of 5 decades, the Federal Voting Rights Act protected voters from unnecessary obstacles and barriers to the ballot. In fact, the Voting Rights Act was authorized and reauthorized 5 times with overwhelming bipartisan support. The Voting Rights Act helped dramatically increase Black voter participation in the South in the post-Jim Crow era. And in states like Arizona, Texas, California, and others, Latino voters have benefited from the Act's voter protections. And across the country, Native voters, Asian American voters, and members of language minority communities have all achieved greater access to the polls because of the Act's prohibition of discrimination on the basis of race or language minority status. But in 2013, the Supreme Court gutted the teeth of the Voting Rights Act. In Shelby County versus Holder, the court struck down the pre-clearance provisions that had required states with a known history of voter disenfranchisement to prove that any changes to their voting laws wouldn't harm voters. And last year, the Supreme Court drastically restricted the reach of Section 2, which prohibits discrimination in voting on the basis of race. Now, I find it hard to see the outcome of any of this as anything but counter to the spirit of the movement that led to the Voting Rights Act. Not on any specific case, but I know earlier in this hearing, you've acknowledged that the Supreme Court's precedence that the right to vote is fundamental and must be protected has been acknowledged. So can you just share for a couple of minutes what you believe the role or responsibility of the Supreme Court might be in protecting this fundamental right to vote and, by extension, our democracy?
Thank you, Senator. The right to vote is protected by our Constitution. The Constitution makes clear that no one is to be discriminated against in terms of their exercise of voting. And the Congress has used its constitutional authority to enact many statutes that are aimed at voting protection. There are also laws that relate to ensuring that there is not only voting access, but ensuring that there isn't fraud in terms of voting. These concerns are embodied by various laws and provisions, and there are disputes at times over the concerns and the balances that are being made across the country relating to the exercise of voting. And those disputes come to court and then eventually to the Supreme Court that interprets the laws that pertain to the fundamental right to vote, which, as you say, the Supreme Court has acknowledged is a fundamental right.
So, thank you. On a different topic, not unique to California, but proud that California is home to the largest Native American population in the country. More than 1 in 10 Native Americans call California home, and California is home to 109 federally recognized tribes who have a nation-to-nation relationship with the United States of America. As a senator from California, I believe that respect for tribal sovereignty is paramount. That's why after your nomination, as part of the homework that I was doing, I carefully considered your record on tribal issues. And for the most part, it seems that you haven't had to deal with too many cases involving the rights of Native peoples or tribes. The cases you've had so far, such as McKinnick versus Jewell, ultimately dealt more with questions of administrative procedure rather than fundamental issues of Native and tribal rights. If you're confirmed, though, I have no doubt that you'll eventually have to weigh in on major questions related to tribal sovereignty, treaty rights, tribal resource preservation, and the federal government's trust responsibility. Now, there's already at least one major case related to Indian law on the Supreme Court's docket for the next term, and it deals with the constitutionality of the Indian Child Welfare Act of 1976. Now, I'm not going to ask you to comment on that case specifically, or any case that may come before you, but as a general matter, can you just share what your understanding is of the federal government's legal and moral trust responsibility and relationship with tribal governments?
Yes, Senator. It is established in the law, the Supreme Court has established that there is a special trust relationship between Indian tribes and the federal government. Indian tribes are, as a general matter, considered to be sovereigns, and the relationship is a sovereign-to-sovereign relationship, but it's one in which the federal government it has some responsibilities related to the Indian nation. And it's very, very important care and trust responsibility that the federal government has in terms of making sure that the tribes are recognized and cared for in the context of our system.
All right. Look forward to our ongoing conversation on that area of the law as well. Want to now revisit something that's been a theme throughout yesterday's opening statements and a lot of today's questions from members, and that's the general appreciation for diversity. Right? We're celebrating history and what the more than potential impact it would be for somebody like you to join the United States Supreme Court. I know some of my colleagues have touched on this already, so I'm going to take it to another level. While judges are certainly the face of the judicial branch, their work, as you can appreciate, is significantly supported by the work of law clerks. Now, typically, these clerks are well-credentialed, talented young lawyers who spend a year or two working closely with a judge who hires them, who helps them conduct research the law, and write legal opinions. Now, clerkships at the district court, the Court of Appeals, and even especially the Supreme Court are often a launching pad for a successful legal career. Many former clerks are leaders in the profession. They serve as law firm partners, public interest lawyers, public sector attorneys, and yes, federal judges. In fact, 7 of the 9 current Supreme Court justices were federal clerks once upon a time. And 6 of the 9 justices clerked at the Supreme Court itself. So it's no wonder that many law students and recent graduates compete pretty intensely for these coveted positions. But like the judiciary itself, the ranks of federal clerks are not particularly diverse. According to a February 2021 bulletin by the National Association of Law Placement, only 21% of federal clerks from the class of 2019 were people of color. And at the Supreme Court, the statistics are similar, with the National Law Journal reporting in 2017 indicating that since 2005, only 15% of clerks were people of color, and only 1/3 were women. These are unacceptably low figures for what has become a de facto pipeline for federal judges. With such low clerkship selection rates, minorities and women lawyers are denied an early credential that can be of significant help later in their legal career. I believe creating more avenues for diverse candidates to participate in clerkships is critical to diversifying the legal profession in the long run. Judge Jackson, I'd just like you to maybe share with the committee your clerkship experience and maybe how that affected the trajectory of your career, and if you believe the judiciary would be better served by a more diverse pool of law clerks.
Thank you, Senator. I think there's very little question that my law clerks changed the trajectory, my law clerkships, changed the trajectory of my career. Through that opportunity, I was able to work for 3 extraordinary jurists. I got to see what it was like to be a judge. I got to understand how judges think as they evaluate cases, which for a young lawyer is an extraordinary training opportunity. And you're correct that it is something that is career-changing in a lot of ways. I have tried in my time on the bench to do a significant amount of outreach to young people. I go to law schools whenever I'm asked. I speak in a lot of places. You've heard some of my speeches get referenced because I'm often asked to go, and I try to go every time I am asked because I know how important it is for people to see that people like me are in the judicial branch and for people to hear about clerkships. One of the things that I often get when I go to law schools is surprise from some groups and some people about the chance to clerk. They weren't even really aware that that was something that they can do or should try to do. So it's been a part of my practice to go to schools, to reach out to young people, to tell them about clerking, to try to get them to apply to me if I can, and to show them that this is something that's possible. If I could do it, they can do it. And I think it's to the benefit of us all to have as many different law students seeking clerkships as possible.
I think you can expect some more invitations from California law schools, colleges, and maybe even some high schools in the near future. And I'm happy to go with you. Now, another theme that's been pretty consistent throughout the day has touched on the right to counsel. You've been asked questions about your work as a public defender. Some have criticized you for providing a defense to certain clients who could not afford an attorney. I want to talk to you about this issue, but I also don't want to assume that everybody watching at home is a criminal law scholar. And so as a senator from California, which is home to Hollywood and the entertainment industry, I'll make the reference that whether it's a TV show or a movie, most people have heard a law enforcement officer on a screen while making an arrest recite what we know as the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Now, the Miranda rights are not a Hollywood invention. These and other rights afforded to all individuals, including those accused of a crime, come from the 4th, 5th, and 6th Amendments to the Constitution. They come from over half a century's worth of Supreme Court precedents. To Judge Jackson, while many Americans know how critical these rights are to our systems of liberty and justice, not everyone does. So for those who may not fully understand, can you reiterate why the Constitution protects these fundamental rights?
Yes, Senator. The Constitution protects these rights because the Constitution is designed to protect liberty. That's one of the values that the framers were focused on when they set up our system of government. The federal government is limited in its powers in part because the framers wanted to preserve liberty, did not want the federal government to encroach on individual freedoms. And there's no bigger sphere of encroachment than the federal government or even state governments using their power to deprive people of liberty in the context of the criminal justice system. So the Constitution says that when the government seeks to deprive someone of liberty because they accuse them of a crime, they have to afford certain rights to the individual. They have to make sure that the person is processed fairly. Criminal defense lawyers protect those constitutional rights by ensuring that the government is doing what the Constitution says the government has to do when they seek to deprive someone of liberty. It's the criminal defense lawyer who makes the objection to prosecutorial overreach in a case, or who makes sure that all of the rights that the framers put into the Constitution are being observed in actual practice by the government. And it's also really important, one of the things that you said, the Miranda rights say, if you can't afford a lawyer, one will be appointed to you. The person who appoints is the court. The court is appointing lawyers for criminal defendants because the court, the judges know that in order to be able to do our jobs, in order to be able to make sure that criminal processes are fair, we have to get arguments, not only from the prosecution, but also from competent counsel who is making arguments for the defense. So it's the court that appoints lawyers for people who can't afford them to make sure that justice is being done in the cases that come to court.
And it's just as a follow-up, as much as we hope the process is always fair, doesn't mean that it's always understood. Now, you shared earlier today, and when you were in my office, you shared your observation from your time as a public defender, that many defendants going through the criminal justice process don't always understand what it is exactly that's happening to them. Can you explain what the impact of this is on our criminal justice system and how your experience, through your experience, it affirms the need for a constitutional right to counsel through the eyes of a defendant?
Yes, Senator. In my experience, one of the things that is important for our entire system of government is that people are being held accountable if they commit crimes. That's the point of the criminal justice system. And what I noticed as a federal public defender is that the process of ensuring that there's accountability, there's responsibility, there's rehabilitation is impeded if the people who are in the system aren't actually understanding the process. That one of the purposes of punishment, one of the goals of our system is to ensure that consequences are handed down for criminal behavior, and then as a result, that people stop committing crimes. And so the obligation to make sure that people understand what's happening, I've seen, aids in that goal. That the person who is receiving the punishment is more likely to be able to reflect on their own contribution, to be able to realize that they made a mistake, that they committed a crime, that here are the consequences, this is a horrible thing, and I'm not going to do it again, if they understand the process, that this is justice in our system. If they go through and they don't understand, if people aren't explaining, if they feel they haven't been heard in the process, it's my experience that instead they feel bitter, they feel victimized, and are less likely to be rehabilitated in the long run. And so as a judge, I took that observation and tried to ensure that not only that criminal defendants understood what was happening, but that they understood the harms that they had caused, with an eye toward making sure that rehabilitation was happening in the long run as a result of my sentences.
Thank you. And I'd share that I think it's part of the comprehensive work we need to do to buttress the confidence in the justice system as a result. Now, our criminal justice system is imperfect and too often unfair. But when we talk about the virtues and the promises of our criminal justice system, we include the constitutional right to an attorney. Just in closing, Mr. Chair, we include the constitutional right to an attorney, talk about Miranda rights, and the right to an impartial jury of one's peers. We talk about the Fourth, Fifth, and Sixth Amendments. And through the lens not of a particular case or defendant, but the system as a whole, the work of public defenders is not just the work of defending the accused. It's the work of upholding the fundamental legal principles that make up our Bill of Rights. So anybody who may criticize Judge Jackson for providing a constitutionally required defense to any individual accused of a crime, I'd suggest that the criticism is not of Judge Jackson, but of the Constitution itself. And just in closing, not an additional question, but Judge Jackson, I've listened to you respond to questions now for the last 12 hours, and I've watched some of my colleagues take some of your work and some of your views out of context to try unsuccessfully to paint you as someone that you are not. I've been struck by your thoughtfulness, your temperament, and your integrity in responding to these questions. And I really hope that America is watching today, because if they are, they've seen the perfect example of what the temperament of a judge should be: thoughtful, balanced, and very, very patient. Thank you, Mr. Chair.
Thanks, Senator Padilla. Senator Blackburn.
Thank you, Mr. Chairman. And Judge, thank you again for your time. I made a note earlier. Senator Blumenthal had mentioned that to do this job that you are before us wanting to take on, it takes book smarts and people smarts. And I think that's a very appropriate summation. And as we have spent the past few weeks going through your records, getting to know you, reading letters that have come in about you, hearing from people, I've kind of looked at it and said, okay, she has been richly blessed with God-given talents. And then she has experiences and education, and then coupling with that hopes, desires, and a lot of drive that really make you the person that you are. And we have heard from your friends about how you are a friend, and you've been a mentor. And as one of my friends would say, and I bet you kind of feel this void, you're the answer lady for a lot of issues that friends would bring to you. You love your family, and they obviously love you. And I wish you could see your dad's face. It is wonderful. He beams when you talk about the things that he has taught you. But all of that has been repeated time and again in letters for you. But it's important that we know this, and it's why we continue to ask you about your views on issue, because all of that goes into forming who you are and your worldview, and it all is applicable to the job that you've done in the past, and likewise the job that you are going to do in the future. And it does have bearing on different issues. And it's been so interesting to me to get text messages from friends at home that are watching this. I had one from a friend from church. And she said, you know, she seems really likable, but I'm not sure I agree with her on the issues. And this is someone who is incredibly pro-life. And she's about my age, so she's a mom and a grandmom. And this is a question that is important to her, to look at life. And Senator Feinstein talked about that issue with you a little earlier today. You've also said today that it would be inappropriate for you to share your views on political issues or issues that might come before the court, like abortion. But I want to go to you on something you said when you were in private practice. You made your views on pro-life and the pro-life movement very clear. And in fact, you attacked pro-life women. And this was in a brief that you wrote, you described them, and I'm quoting, hostile, noisy crowd of in-your-face protesters, end quote. And you advocated against these women's First Amendment right to express their sincerely held views regarding the sanctity of each individual life. And I'm a pro-life woman. 79% of the American women support restrictions of some type on abortion. And so I find it incredibly concerning that someone who is nominated to a position with life tenure on the Supreme Court holds such a hostile view toward a view that is held as a mainstream belief that every life is worth protecting. So how do you justify that incendiary rhetoric against pro-life women?
Thank you, Senator. The brief that you're referring to was a brief that I filed on behalf of clients who were clients of my law firm. This is in, I believe, 1999 or 2000, maybe 2000 or 2001.
Yeah.
I was an associate at a law firm, and I had appellate experience because I had just finished my Supreme Court law clerk position. And in the context of my law firm, I was asked to work on a brief concerning a buffer zone issue. In Massachusetts at the time, there were laws protecting women who wanted to enter clinics, and there was a First Amendment question about the degree to which there had to be room around them to enter the clinic.
Right.
And
I understand all of that. I'm asking about the rhetoric.
Senator, I drafted a brief along with the partners in my law firm who reviewed it, and we filed it on behalf of our client.
Okay.
To advance our clients' arguments that they wanted to make in the case.
Let me ask you this. When you go to church and knowing there are pro-life women there, do you look at them, thinking of them in that way, that they're noisy, hostile, in your face? Do you think of them? Do you think of pro-life women like me that way?
Senator, that was a statement and a brief made
Okay.
an argument for my client. It's not the way that I think of or
Okay.
characterize people.
All right. Thank you for the clarification on that, because I think even zealous advocacy doesn't allow that type of rhetoric on a free speech issue. You know, Roe v. Wade, let's talk a little bit about that. It's come up touch today. In my opinion, that was an awful act of judicial activism and has cost the lives of over 63 million unborn children. And nearly 50 years later, this shameful ruling remains binding precedent, but the battle is being fought in the courts. And as you know, and as we discussed when we visited, the Supreme Court is reconsidering whether the Constitution protects the right to an abortion in Dobbs. And if you're confirmed, you will be in a position to apply the court's decision in Dobbs, whatever that decision is going to be. And you've talked about following precedent and what the court decides. So do you commit to respecting the court's decision if it rules that Roe was wrongly decided and that the issue of abortion should be sent back to the states?
Senator, whatever the Supreme Court decides in Dobbs will be the precedent of the Supreme Court. It will be worthy of respect in the sense that it is the precedent, and I commit to treating it as I would any other precedent of the
There's
Supreme
one other thing. One of the central issues in the Dobbs case is about whether the Constitution protects the right to an abortion. So let's talk about that. Can you explain to me on a constitutional basis the court's decision in Roe, and where is abortion protected in the Constitution?
Senator, abortion is a right that the Supreme Court has recognized is one of the kinds of rights that is unenumerated. It is in that same category of rights that the Supreme Court has recognized.
But the text of the Constitution does not mention abortion.
That is true.
That is true. That is correct. So you agree that the Constitution does not mention the right to an abortion, and yet, through one of the most brazen acts of judicial activism, our Supreme Court created the right through Roe v. Wade. This is why Americans, this is why so many women that I've talked to are really concerned about who sits on the federal bench. We need a justice who will adhere to the text of the Constitution. You've talked a little bit about that today as you talked about historical context. And they don't want justices who are going to invent rights out of whole cloth to serve a political interest. Let's move on. I want to go to when you were at Harvard, your thesis entitled "The Hand of Oppression: Plea Bargaining Processes." In that piece, you argued that judges have, and I'm quoting, I brought this up yesterday, personal hidden agendas that influence how they decide cases. So what personal hidden agendas do you harbor, or do you think other judges harbor?
Thank you, Senator. That line, to the extent it appears in my thesis, was written by someone who had not gone to law school and was senior in college, who had spent a summer at an internship working in making observations in the context of a criminal justice internship. It is not a view that I hold.
What led you to that belief?
I'm thinking back, it's been 30 years, but the summer before my senior year, I interned at a public defender's office in New York. And I was part of a team of, there was lawyers and interns on this team, and they were handling misdemeanor cases. And
So it was from an internship experience?
Yes, before I became a lawyer.
All right. Let's go to something else. Senator Cruz was discussing with you, and I think this is important. It's something that parents all across the country are worried about, and that is the progressive indoctrination of their children and the pushing of critical race theory in the schools. And you told Senator Cruz that as a board member of the Georgetown Day School, you didn't have any control over what was taught at the school, no control over curriculum, and you weren't aware that the school was pushing CRT. But I would think that there would have been parents that came to you and said, have you seen these books? Are you aware that this is being taught, being on that school board?
No, Senator.
No one ever mentioned it.
Georgetown Day School is a private school. It's not a public school.
I'm fully aware. And you mentioned that you said that you meant, you thought he meant that critical race theory isn't being taught in public schools, correct?
Yes.
Okay. But we know that's not the case. We know that CRT is being pushed in our K through 12 schools. And I've got a letter here, Mr. Chairman, that Senator Tuberville and I wrote last year to the National Education Association on this issue. I'd like to submit that to the record because it's relevant to our discussion.
Without objection.
And we had admonished the NEA for adopting pro-CRT materials during their annual organizing meeting and proposing to spend $127,000 in teachers' dues to combat opponents of CRT. And there are countless reports of CRT being pushed in the public school system. And a lot of parents that I work with every day, every week, don't have the funds to send their child to a private school. They're relying on the school systems, the public school systems, and it is important to them to have a Supreme Court that is going to protect parental rights to teach these children as parents see fit to have their children taught. And I will tell you too, with Georgetown Day School, I found it astounding that it teaches kindergartners, 5-year-old children, and I've got grandchildren. And they teach them that they can choose their gender. So is this what you were praising when you applauded the, and I'm quoting you, transformative power of Georgetown Day School's progressive education? Do you agree that our schools should teach children that they can choose their gender?
Senator, I'm not remembering exactly what quote you're referencing, but Georgetown Day School is
It was in a book, and you gave the quote.
Georgetown Day School is a private school.
Yes.
That.
Yeah, I'm asking, do you agree that schools should teach children that they can choose their gender?
Senator, I'm not making comments about
All right.
what schools can teach.
Let me ask you this then. United States versus Virginia, the Supreme Court struck down VMI's male-only admission policy. Writing for the majority, Justice Ginsburg stated, supposed inherent differences are no longer accepted as a ground for race or national origin classifications. Physical differences between men and women, however, are enduring. The two sexes are not fungible. A community made up exclusively of one sex is different from a community composed of both. Do you agree with Justice Ginsburg that there are physical differences between men and women that are enduring?
Senator, respectfully, I am not familiar with that particular quote or case,
Okay.
so it's hard for me to comment as to whether
All right, I'd love to get your opinion on that, and you can submit that. Do you interpret Justice Ginsburg's meaning of men and women as male and female?
Again, because I don't know the case, I don't know how I interpret it. I need to read the whole
Okay.
thing.
Can you provide a definition for the word woman?
Can I provide a definition? No,
Yeah,
I can't.
you can't?
Not in
Okay.
this context.
So you
I'm not a
believe the
biologist.
meaning of the word woman is so unclear and controversial that you can't give me a definition?
Senator, in my work as a judge, what I do is I address disputes. If there's a dispute about a definition, people make arguments, and I look at the
All right.
law and I decide. So I'm not.
The fact that you can't give me a straight answer about something as fundamental as what a woman is underscores the dangers of the kind of progressive education that we are hearing about. Just last week, an entire generation of young girls watched as our taxpayer-funded institutions permitted a biological man to compete and beat a biological woman in the NCAA swimming championships. What message do you think this sends to girls who aspire to compete and win in sports at the highest levels?
Senator, I'm not sure what message that sends. If you're asking me about the legal issues related to it, those are topics that are being hotly discussed, as you say, and could come to the court. So I'm not
And
able to.
I think it tells our girls that their voices don't matter. I think it tells them that they're second-class citizens, and parents want to have a Supreme Court justice who is committed to preserving parental autonomy and protecting our nation's children. So let's move on. I want to go to the child porn issue, and I know that we've discussed this today on several different times. What's troublesome to me is your consistent pattern of sentencing these predators below the sentences recommended by the government and the sentencing guidelines. And Senator Cruz, Senator Hawley have laid out some of these disparities. I know Senator Blumenthal mentioned the Kids Online Safety Act that he and I are working on. You have talked about how horrifying it was to get some of that information. As we have held these hearings, that too has been horrifying. We've had moms from all over the country call us and tell us their story of how these pedophiles, these child abusers, these pornographers are using technology. And that technology has really advanced. And unfortunately, we know that online right now, it is more dangerous for kids than ever. Here's a couple of stats for you. In 21, NCMEC's cyber tip line received nearly 30 million reports of online child sexual abuse material, which is a 35% increase over 2020. Those 30 million tips contained 44.8 million videos and 39.9 million images. And as a mom and a grandmom, this is an issue of tremendous concern. I have grandsons that are 12 and 13 years old. And these are things that concern me, how these people work. I find the discussion that you made, the distinction you made between pedophiles who produce child pornography and those who are only collectors to be one without a difference. You said, and I'm quoting you, that it was a mistake to assume that child pornography offenders are pedophiles. Do you believe that it matters to the children and their parents who suffer abuse, what motivation those abusers had?
Thank you, Senator. As you said, and as I've said, these cases are among the most difficult.
They are.
For judges who have to deal with the evidence, judges who, like me, are parents.
My question, Judge, do you think it matters to the kids and their parents, the motives of the abuser, of the pornographer?
Senator, it does not matter to the victims in these cases what the motivation is. The quote, I'm not exactly sure where it came from. I know that what Senator Cruz showed me before was questions that I was asking in the context of a hearing to...
Okay. Well, I've got some serious concerns about that. I do want to go to your judicial philosophy and back to the Ninth Amendment. President Biden said he was looking for a judicial nominee with a judicial philosophy that is more of one that suggests that there are unenumerated rights in the Constitution and all the amendments mean something, including the Ninth Amendment. You told Senator Lee that you didn't discuss this statement with President Biden, but I want to know whether you agree with it. Do you share the judicial philosophy that President Biden is looking for? And Senator Kennedy tried to walk through some of this with you. Do you believe that the Ninth Amendment is a source of unenumerated rights?
Senator, the Supreme Court has not found any unenumerated rights that derive from the Ninth Amendment. And so that's not the precedent of the court. And there aren't any rights that have been established under that provision of the Constitution.
Okay. White House Chief of Staff Ron Klain has written that the Supreme Court should intervene whenever the nation's conscience and laws need a jolt in a progressive direction. Presumably, that is what he and his boss, President Biden, expect a justice to do. So do you believe that the role of the court is to intervene whenever we need a jolt in a progressive direction? And would you do that through the unenumerated rights? Would you do it on issues like abortion or any other issue?
Senator, the role of a judge is to decide cases and controversies based on the facts and the law, mindful of their obligation to rule impartially and to remain in consideration of only the law and their constraints under the Constitution.
Okay. A lot of special interest groups have come out in support of your nomination. One of those is Demand Justice, and they are a progressive dark money group that has launched a $1 million ad buy to push for your confirmation. Demand Justice is also pushing for radical changes to the structure of our country and our Constitution, including a demand that Democrats pack the Supreme Court. One of Demand Justice's board members has urged Senate Democrats to add 10 more justices to the court. It's clear that Demand Justice believes that if the issue of court packing were to come before you on the Supreme Court, you would rule in their favor. Are they wrong to believe that you would rule in their favor?
Senator, it's very unlikely that the issue of court packing would come before the Supreme Court. That question is in the province of Congress. It's a political question.
Okay. Let's see. I want to follow up on this Make the Road New York issue that has come up a couple of times today. Congress granted DHS sole and unreviewable discretion to determine which illegal immigrants should be deported. This means DHS's decision was unreviewable by a federal judge, and any attempt to challenge DHS's decision should have been dismissed by the court. And yet, you did the very opposite. You didn't dismiss it. You inexplicably construed the law to permit a judicial challenge to DHS's immigration decision, despite the plain language of the statute. The D.C. Circuit, where you sit, reversed you. It noted that it could hardly imagine a more definitive expression of congressional intent than the one in the law at issue. And it questioned how you could have come to any other conclusion based on the text of the statute. So I'd like to know what was ambiguous about the immigration law that we enacted, and we explicitly stated that DHS's decision was unreviewable. What more could we possibly have said or have made clear that you were not authorized to review DHS's decision?
Thank you, Senator. When Congress strips the court of jurisdiction, Congress, in many cases, does so explicitly.
it says something other than sole and unreviewable. It says things like, no court shall hear, there's no jurisdiction to consider. There are ways that Congress clarifies that judges have no authority or no jurisdiction to hear a particular case. The DC Circuit considered jurisdiction with respect to this statute and this dispute and determined that the court did have jurisdiction, and the question was whether there was a cause of action to proceed. What I determined in looking at the statutes at issue in this particular case is that sole and unreviewable meant that DHS had the sole power to make a decision
Right.
about.
Not to interrupt you, my time is going to run out, and I want to be respectful of getting you out of here tonight. But we were clear in what we said on that, and I heard your explanation on that earlier today. That's why I wanted to come back to it tonight, because this is the kind of judicial activism that really concerns Tennesseans. These issues that I've been through with you today, the statements that I gave back to you last night in my opening, things that you had said, decisions that you had made, these cause concern. So we'll take up a little bit more of it tomorrow. Thank you for your graciousness, Mr. Chairman. Thank you for the time.
Thank you very much, Senator Blackburn. I want to thank Judge Jackson for this long day and part of it under tough circumstances. You were a model of grace under pressure. At times, things were said about you which turned out to be inaccurate. It was said you called President Bush and Secretary Rumsfeld war criminals. That didn't happen. It was said you also always sentence criminals too lightly. That's not exactly true. It was said you apologized to a defendant in a child pornography case without any sympathy for the victims, and that wasn't true either. The truth is you've been a judge for nearly 10 years. You've sentenced more than 100 defendants, some to decades in prison. And even the child pornography cases my colleagues continue to raise over and over with you, your sentences were in line with the recommendations of the government or probation office in the vast majority of the cases that you heard. We invited a number of people to come here today, and one special guest was a lady who cleans our office at night. She works the midnight shift, but she wanted to be here today to see you and hear you and stand by your side. And she said afterwards that it was a great moment for her to be in this room today. But she asked my staff, why are some people so mean? Well, I have to tell you, the overwhelming majority on both sides of the aisle were not mean. They were constructive and positive and really raised the important questions that we all care about. Some are always going to be a little disappointing. That's the nature of human life. Tomorrow morning, we're going to gather at 9 a.m. for John Ossoff and Tom Tillis. I don't know if America is ready. I know this committee will be ready, and thank you very much. And this meeting of the Senate Judiciary Committee will stand in recess.
And with that gavel, the chairman of the Senate Judiciary Committee, Senator Dick Durbin, ends day 2 of the confirmation hearings of Judge Ketanji Brown Jackson. Over 13 hours of questions she fielded from senators on that panel today, from over 20 of those senators. As you heard Senator Durbin there say, 2 more senators remain. Senators Ossoff and Tillis. We will hear from them tomorrow. Each of them get their 30 minutes before we begin again. And each senator gets another 20 minutes of questions with Judge Jackson. A long day, a historic day. But that is it for us tonight. That concludes our special live coverage of day 2 of the Senate Judiciary Committee hearings to consider Judge Ketanji Brown Jackson for the Supreme Court. Thank you to all of our correspondents and our guests who joined us today. I'm Amna Nawaz. You can find more coverage of today's hearings online. That's at pbs.org/newshour. And join us again here tomorrow for day 3 of the hearings. Those begin at 9 a.m. Eastern. For all of us here at the PBS NewsHour, thank you for joining us. We will see you soon.
This program was made possible by the Corporation for Public Broadcasting and by contributions to your PBS station from viewers like you. Thank you.
You're watching PBS.